Political law defined. That branch of public law which deals with the organization and operation of the government organs of the state and defines the relations of the state with the inhabitants of its territory. Political law has been defined as that branch of public law which deals with the organization and operation of the governmental organs of the state and defines the relations of the state with the inhabitants of its territory. The Philippines as a state. State defined. A state is a politically organized sovereign community, independent of outside control, bound by ties of nationhood, legally supreme within its territory, and acting through government functioning under a regime of law. A state is a community of persons, more or less numerous, permanently occupying a fixed territory and possessed of an independent government organized for political ends to which the great body of inhabitants render habitual obedience. The elements of a state are territory, people, sovereignty, government. People refers simply to the inhabitants of the state. Territory is the fixed portion of the surface of the earth inhabited by the people of the state. Government is the agency or instrumentality through which the will of the state is formulated, expressed and realized. Sovereignty is the supreme and uncontrollable power inherent in a state by which that state is governed. People. As a requisite for statehood, the people comprising the state must be adequate enough for self-sufficiency and defense. Furthermore, they must be of both sexes in order that they may perpetuate themselves. The national territory. Article I, 1987 Constitution. The national territory comprises the Philippine archipelago, with all the islands and waters embraced therein, and all other territories over which the Philippines has sovereignty or jurisdiction, consisting of its terrestrial, fluvial, and aerial domains, including its territorial sea, the seabed, the subsoil, the insular shelves, and other submarine areas. The waters around, between, and connecting the islands of the archipelago, regardless of their breadth and dimensions, form part of the internal waters of the Philippines. In short, the Philippine territory consists of 1. The Philippine archipelago, and 2. All territories over which the Philippines has sovereignty or jurisdiction. The Philippine archipelago. Basis of Article I of the 1987 Constitution. All the waters within the limits set forth in the A. Treaty of Paris of December 10, 1898, cession of the Philippine Islands by Spain to the U.S. B. Between Spain and U.S., the Treaty of Spain and U.S. at Washington, November 1, 1900, Cagayan, Sulu and Cebuto. C. Treaty between U.S. and Great Britain, January 2, 1930, Turtle and Manzi Islands. 1. All the waters around, between and connecting the various islands of the Philippine archipelago, irrespective of their width or dimension, have always been considered as necessary appurtenances of the land territory, forming part of the inland or internal waters of the Philippines. 2. All the waters beyond the outermost islands of the archipelago but within the limits of the boundaries set forth in the aforementioned treaties comprise the territorial sea of the Philippines. 3. The baselines from which the territorial sea of the Philippines is determined consist of straight lines joining the appropriate points of the outermost islands of the archipelago, straight baseline method. The definition of the baselines of the territorial sea of the Philippine archipelago is without prejudice to the delineation of the baselines of the territorial sea around the territory of Sabah, situated in North Borneo, over which the Republic of the Philippines has acquired dominion and sovereignty. Archipelagic doctrine. Outermost points of the archipelago shall be connected by straight baselines and all islands and waters therein are regarded as one integrated unit. The archipelagic doctrine has a twofold purpose: 1. Economic reasons, 2. National security. The archipelagic doctrine is the principle that it is an integrated unit, everything within it comprises the archipelago. The constitutional provisions embodying this doctrine are: 1. Archipelago, with all the island and waters embraced therein. 2. The waters around, between, and connecting the islands of the archipelago, regardless of the breadth and dimensions, form part of internal water. Method of determining the baselines. 1. R. A. 3046, June 17, 1961. Determine appropriate points of the outermost islands of the archipelago, then connect them by means of a straight line until all islands are surrounded or enclosed by the imaginary straight lines. The baselines from which the territorial sea of the Philippines is determined consist of straight lines joining appropriate points of the outermost islands of the archipelago. Fifth Whereas Clause 2. RA 5446, September 8, 1968. Section 2 of the Act provides that the definition of the territorial sea of the Philippine archipelago as provided in this Act is without prejudice to the delineation of the baselines of the territorial sea around the territory of Sabah, situated in North Borneo, over which the Republic of the Philippines has acquired dominion and sovereignty. Uses of the baseline. A. Determine what is internal water, all waters inside the baseline, whether or not more than 12 miles from the shore. B. Determine the 200 miles. C. Archipelagic doctrine. Government. Government is that institution or aggregate of institutions by which an independent society makes and carries out those rules of action which are necessary to enable men to live in a social state or which are imposed upon the people forming that society by those who possess the power or authority of prescribing them. Government is the aggregate of authorities which rule a society. U.S. v. Storr, 2 Phil 332, 339. The government performs two kinds of functions, to wit, the constituent and the ministrant. Constituent functions constitute the very bonds of society and are therefore compulsory. Ministrant functions are those undertaken to advance the general interests of society, such as public works, public charity, and regulation of trade and industry. Doctrine of Prince Patriae. One of the important tasks of the government is to act for the state as Prince Patriae, or guardian of the rights of the people. This prerogative of Prince Patriae is inherent in the supreme power of every state, whether that power is lodged in a royal person or in the legislature, and has no affinity to those arbitrary powers which are sometimes exerted by irresponsible monarchs to the great detriment of the people and the destruction of their liberties. De jure and de facto governments. A de jure government has rightful title but no power or control, either because this has been withdrawn from it or because it has not yet actually entered into the exercise thereof. A de facto government, on the other hand, is a government of fact, that is, it actually exercises power or control but without legal title. The three kinds of de facto government are as follows. 1. The government that gets possession and control of, or usurps, by force or by the voice of the majority, the rightful legal government and maintains itself against the will of the latter. 2. That established as an independent government by the inhabitants of a country who rise in insurrection against the parent state. 3. That which is established and maintained by military forces who invade and occupy a territory of the enemy in the course of war, and which is denominated as a government of paramount force, like the Second Republic of the Philippines established by the Japanese belligerent. The characteristics of this third kind of de facto government are: A. Its existence is maintained by active military power within the territories, and against the rightful authority of an established and lawful government. B. During its existence, it must necessarily be obeyed in civil matters by private citizens who, by acts of obedience rendered in submission to such force, do not become responsible, as wrongdoers, for those acts, though not warranted by the laws of the rightful government. Sovereignty. The supreme power of the state to govern persons and things within its territory. Sovereignty is the supreme and uncontrollable power inherent in a state by which the state is governed. There are two kinds of sovereignty, to wit, legal and political. Legal sovereignty is the authority which has the power to issue final commands, whereas political sovereignty is the power behind the legal sovereign, or the sum total of the influences that operate upon it. Sovereignty may also be internal or external. Internal sovereignty refers to the power of the state to control its domestic affairs. External sovereignty, which is the power of the state to direct its relations with other states, is also known as independence. Theory of auto-limitation is the property of the state force due to which a state has exclusive legal competence of self-limitation and self-restriction, Janek. Dominium and imperium. Imperium refers to the state's authority to govern. It covers such activities as passing laws governing a territory, maintaining peace and order over it, and defending it against foreign invasion. When the state acts in this capacity jure imperii, it generally enjoys sovereign immunity. Dominium refers to the capacity of the state to own property. It covers such rights as title to land, exploitation and use of it, and disposition or sale of the same. The Regalian doctrine whereby all lands of the public domain belong to the state, and anyone claiming title has the burden to show ownership, comes within this concept. In this capacity jure gestum, the state descends to the status of ordinary persons and thus becomes liable as such. Distinguish sovereignty from dominion. Sovereignty is the right to exercise the functions of a state to the exclusion of any other state. It is often referred to as the power of imperium, which is defined as the government authority possessed by the state. On the other hand, dominion, or dominium, is the capacity of the state to own or acquire property such as lands and natural resources. Separate opinion, Kapunen, J. Inazagani Cruz vs. Secretary of Denr, GR number 135385, December 6, 2000, N. Bank, see footnote 86. Is sovereignty really absolute? While sovereignty has traditionally been deemed absolute and all-encompassing on the domestic level, it is however subject to restrictions and limitations voluntarily agreed to by the Philippines, expressly or impliedly, as a member of the family of nations. In its Declaration of Principles and State Policies, the Constitution adopts the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation and amity, with all nations. By the doctrine of incorporation, the country is bound by generally accepted principles of international law, which are considered to be automatically part of our own laws. One of the oldest and most fundamental rules in international law is pacta sunt servanda. International agreements must be performed in good faith. A treaty engagement is not a mere moral obligation but creates a legally binding obligation on the parties. A state which has contracted valid international obligations is bound to make in its legislations such modifications as may be necessary to ensure the fulfillment of the obligations undertaken. Canada vs. Ongara, 272 SCRA 18. Kinds of sovereignty. Legal. Refers to the authority that has the power to issue final commands, that is the Congress. Political. Refers to the power behind legal sovereignty, that is, the different sectors that mold public opinion. Internal. Refers to the power of the state to control its domestic affairs. External. Refers to the power of the state to direct its relations with other states aka independence. Generally, under the concept of jure regalia, private title to land must be traced to some grant, express or implied, from the Spanish crown or its successors, the American colonial government, and thereafter, the Philippine Republic. The belief that the Spanish crown is the origin of all land titles in the Philippines has persisted because title to land must emanate from some source where it cannot issue forth from nowhere. In its broad sense, the term jure regalia refers to royal grants, or those rights which the king has by virtue of his prerogatives. In Spanish law, it refers to a right which the sovereign has over anything in which a subject has a right of property or proprietad. These were rights enjoyed during feudal times by the king as the sovereign. The theory of the feudal system was that title to all lands was originally held by the king, and while the use of lands was granted out to others who were permitted to hold them under certain conditions, the king theoretically retained the title. By fiction of law, the king was regarded as the original proprietor of all lands, and the true and only source of title, and from him all lands were held. The theory of jure regalia was therefore nothing more than a natural fruit of conquest. The Regalian theory, however, does not negate native title to lands held in private ownership since time immemorial. In the landmark case of Carino vs. Insular Government, 41 Phil. 935, 212 U.S. 449, 53 liters. Ed. 594 1909, the United States Supreme Court, reversing the decision of the pre-war Philippine Supreme Court, made the following pronouncement. Every presumption is and ought to be taken against the government in a case like the present. It might, perhaps, be proper and sufficient to say that when, as far back as testimony or memory goes, the land has been held by individuals under a claim of private ownership, it will be presumed to have been held in the same way from before the Spanish conquest, and never to have been public land. The above ruling institutionalized the recognition of the existence of native title to land, or ownership of land by Filipinos by virtue of possession under a claim of ownership since time immemorial and independent of any grant from the Spanish crown, as an exception to the theory of jure regalia. Carino was decided by the U.S. Supreme Court in 1909, at a time when decisions of the U.S. Court were binding as precedent in our jurisdiction. Section 10, Philippine Bill of 1902. We applied the Carino Doctrine in the 1946 case of Ocho v. Director of Lands, 75 Phil. 890 1946, where we stated that quote-unquote, all lands that were not acquired from the government either by purchase or by grant, belong to the public domain, but an exception to the rule would be any land that should have been in the possession of an occupant and of his predecessors in interest since time immemorial, for such possession would justify the presumption that the land had never been part of the public domain or that it had been private property even before the Spanish conquest. Dominium was the basis for the early Spanish decrees embracing the theory of jure regalia. The declaration in Section 2, Article 12 of the 1987 Constitution that all lands of the public domain are owned by the state is likewise founded on dominium. If dominium, not imperium, is the basis of the theory of jure regalia, then the lands which Spain acquired in the 16th century were limited to non-private lands, because it could only acquire lands which were not yet privately owned or occupied by the Filipinos. Hence, Spain acquired title only over lands which were unoccupied and unclaimed, that is, public lands. Territorial, personal, and extraterritorial jurisdiction. Jurisdiction is the manifestation of sovereignty. The jurisdiction of the state is understood as both its authority and the sphere of the exercise of that authority. Cinca 26. A. Territorial jurisdiction is the authority of the state to have all persons and things within its territorial limits to be completely subject to its control and protection. B. Personal jurisdiction is the authority of the state over its nationals, their persons, property, and acts, whether within or outside its territory. The Civil Code provision that prohibitory and mandatory laws follow citizens wherever they go is an example. C. Extraterritorial jurisdiction is the authority of the state over persons, things or acts, outside its territorial limits by reason of their effects to its territory. Article 2 of the RPC is a classic example of this. Doctrine of state immunity from suit basis. I. Constitutional, Article 16, Section 3. The state may not be sued without its consent. 2. Jurisprudence. Positivist theory. There can be no legal right as against the authority that makes the laws on which the right depends. Holmes and Co. v. Poly blank. Sociological theory. If the state is amenable to suits, all its time would be spent defending itself from suits and this would prevent it from performing its other functions. Republic v. Villasser, 54 SCRA 83. The doctrine is also available to foreign states insofar as they are sought to be sued in the courts of the local state. The added basis in this case is the principle of the sovereign equality of states, under which one state cannot assert jurisdiction over another in violation of the maxim par imperum non habet imperium. To do so would unduly vex the peace of nations. Cruz. Basis of the doctrine of state immunity. Ethical. As to a local state. As to a foreign state. As to a local state. There can be no legal right against the authority that makes the law on which the right depends. As to a foreign state. Par imperum non habet imperium. Doctrine of sovereign equality of all states. Practical. The state will be busy defending itself from lawsuits. Doctrine of incorporation. The local country is bound by generally accepted principles of international law, which are considered to be automatically part of their own laws. Doctrine of pacta sunt servanda. International agreements must be performed in good faith. A treaty engagement is not a mere moral obligation but creates a legally binding obligation on the parties. A state which has contracted valid international obligations is bound to make in its legislations such modifications as may be necessary to ensure the fulfillment of the obligations undertaken. The Holy See vs. Rosario, 238 SCRA 524, December 1, 1994, N. Bank Quiescen. In Article 31A of the Convention, a diplomatic envoy is granted immunity from the civil and administrative jurisdiction of the receiving state over any real action relating to private immovable property situated in the territory of the receiving state which the envoy holds on behalf of the sending state for the purposes of the mission. If this immunity is provided for a diplomatic envoy, with all the more reason should immunity be recognized as regards the sovereign itself, which in this case is the Holy See. The issue of petitioner's non-suability can be determined by the trial court without going to trial in the light of the pleadings, particularly the admission of private respondent. Besides, the privilege of sovereign immunity in this case was sufficiently established by the memorandum and certification of the Department of Foreign Affairs. As the department tasked with the conduct of the Philippines' foreign relations, Administrative Code of 1987, Book 4, Title I, Section 3, the Department of Foreign Affairs has formally intervened in this case and officially certified that the Embassy of the Holy See is a duly accredited diplomatic mission to the Republic of the Philippines, exempt from local jurisdiction and entitled to all the rights, privileges and immunities of a diplomatic mission or embassy in this country. Rollo, pages 156 to 157. The determination of the executive arm of government that a state or instrumentality is entitled to sovereign or diplomatic immunity is a political question that is conclusive upon the courts. International Catholic Migration Commission vs. Calleja, 190 SCRA 130 1990. Where the plea of immunity is recognized and affirmed by the executive branch, it is the duty of the courts to accept this claim so as not to embarrass the executive arm of the government in conducting the country's foreign relations. World Health Organization vs. Aquino, 48 SCRA 242 1972. As an International Catholic Migration Commission and in World Health Organization, we abide by the certification of the Department of Foreign Affairs. When the suit is against the state and when it is not. A suit is against the state, regardless of who is named as the defendant, if it produces adverse consequences to the public treasury in terms of disbursement of public funds and loss of government property. When the suit is against the state, it cannot prosper unless the state has given its consent. In the following cases, however, the suit is not really against the state. 1. When the purpose of the suit is to compel an officer charged with the duty of making payments pursuant to an appropriation made by law in favor of the plaintiff to make such payment. For in this case, the suit is not really against the state having acknowledged its liability to the plaintiff through the enactment of an appropriation law. Rather, the suit is intended to compel performance of a ministerial duty. Bagiso vs. PVA, 32 SCRA 466 and Del Mar vs. PVA, 51 SCRA 340, both involving the War Widow Benefits Law due the veterans. 2. When from the allegations in the complaint, it is clear that the respondent is a public officer sued in a private capacity. 3. When the action is not in personam with the government as the named defendant, but an action in rem that does not name the government in particular. Republic vs. Sandoval, 220 SCRA 124, March 19, 1993, N. Bank Campos. When is suit deemed suit against the state? Liabilities of public officers who exceeded their authority. Some instances when a suit against the state is proper are: 1. When the Republic is sued by name. 2. When the suit is against an unincorporated government agency. 3. When the suit is on its face against a government officer but the case is such that ultimate liability will belong not to the officer but to the government. 4. when the suit is against a foreign state or embassy. As early as 1954, this court has pronounced that an officer cannot shelter himself by the plea that he is a public agent acting under the color of his office when his acts are wholly without authority. Until recently in 1991, Chavez v. Sandiganbayan, 193 SCRA 282-1991, this doctrine still found application, this court saying that immunity from suit cannot institutionalize irresponsibility and non-accountability nor grant a privileged status not claimed by any other official of the Republic. While it is true that nothing is better settled than the general rule that a sovereign state and its political subdivisions cannot be sued in the courts except when it has given its consent, it cannot be invoked by both the military officers to release them from any liability, and by the heirs and victims to demand indemnification from the government. The principle of state immunity from suit does not apply, as in this case, when the relief demanded by the suit requires no affirmative official action on the part of the state nor the affirmative discharge of any obligation which belongs to the state in its political capacity, even though the officers or agents who are made defendants claim to hold or act only by virtue of a title of the state and as its agents and servants. This court has made it quite clear that even a high position in the government does not confer a license to persecute or recklessly injure another. The inescapable conclusion is that the state cannot be held civilly liable for the deaths that followed the incident. Instead, the liability should fall on the named defendants in the lower court. In line with the ruling of this court in Schaaf v. Court of Appeals, 191 SCRA 713-1990, herein public officials, having been found to have acted beyond the scope of their authority, may be held liable for damages. DA v. NLRC, 227 SCRA 693, November 11, 1993. Can government properties be levied to satisfy judgment against the state? Waiver under Act No. 3083. Waiver of state immunity. The traditional rule of immunity exempts a state from being sued in the courts of another state without its consent or waiver. This rule is a necessary consequence of the principle of independence and equality of states. However, the rules of international law are not petrified, they are constantly developing and evolving. And because the activities of states have multiplied, it has been necessary to distinguish them, between sovereign and governmental acts, jure imperii, and private, commercial and proprietary acts, jure gestionis. The result is that state immunity now extends only to acts jure imperii. The restrictive application of state immunity is proper only when the proceedings arise out of commercial transactions of the foreign sovereign, its commercial activities or economic affairs. Stated differently, a state may be said to have descended to the level of an individual and can thus be deemed to have tacitly given its consent to be sued only when it enters into business contracts. It does not apply where the contracts relate to the exercise of its sovereign functions. Lawson v. C.A., GR No. 102667, February 23, 2000, 2nd Div. Quijoming suits against public officers. The doctrine of state immunity from suit applies to complaints filed against public officials for acts done in the performance of their duties. The rule is that the suit must be regarded as one against the state where the satisfaction of the judgment against the public official concerned will require the state itself to perform a positive act, such as appropriation of the amount necessary to pay the damages awarded to the plaintiff. The rule does not apply where the public official is charged in his official capacity for acts that are unlawful and injurious to the rights of others. Public officials are not exempt, in their personal capacity, from liability arising from acts committed in bad faith. Neither does it apply where the public official is clearly being sued not in his official capacity but in his personal capacity, although the acts complained of may have been committed while he occupied a public position. C. When public officials can be sued personally. 1. To require him to do a duty required by law. 2. To restrain him from doing an act alleged to be unconstitutional or illegal. 3. To recover from him taxes unlawfully assessed or collected. Amendments or revisions of the Constitution. Article 17, 1987 Constitution. Section 1. Any amendment to, or revision of, this Constitution may be proposed by 1. The Congress, upon a vote of 3/4 of all its members, or 2. A Constitutional Convention. Section 2. Amendments to this Constitution may likewise be directly proposed by the people through initiative upon a petition of at least 12% of the total number of registered voters, of which every legislative district must be represented by at least 3% of the registered voters therein. No amendment under this section shall be authorized within 5 years following the ratification of this Constitution nor oftener than once every 5 years thereafter. The Congress shall provide for the implementation of the exercise of this right. R.A. No. 6735 is now a valid law for people's initiative. Section 3. The Congress may, by a vote of 2/3 of all its members, call a constitutional convention, or by a majority vote of all its members, submit to the electorate the question of calling such a convention. Section 4. Any amendment to, or revision of, this Constitution under Section 1 hereof shall be valid when ratified by a majority of the votes cast in a plebiscite which shall be held not earlier than 60 days nor later than 90 days after the approval of such amendment or revision. Any amendment under Section 2 hereof shall be valid when ratified by a majority of the votes cast in a plebiscite which shall be held not earlier than 60 days nor later than 90 days after the certification by the Commission on Elections of the sufficiency of the petition. Lambino v. Cumlec, Gr. No. 174153, October 25, 2006. Held. Article 17 of the Constitution speaks of 3 modes of amending the Constitution. The first mode is through Congress upon 3/4 vote of all its members. The second mode is through a constitutional convention. The third mode is through a people's initiative. Section 1 of Article 17, referring to the first and second modes, applies to any amendment to, or revision of, this Constitution. In contrast, Section 2 of Article 17, referring to the third mode, applies only to amendments to this Constitution. There can be no mistake about it. The framers of the Constitution intended, and wrote, a clear distinction between amendment and revision of the Constitution. The framers intended, and wrote, that only Congress or a constitutional convention may propose revisions to the Constitution. The framers intended, and wrote, that a people's initiative may propose only amendments to the Constitution. Where the intent and language of the Constitution clearly withhold from the people the power to propose revisions to the Constitution, the people cannot propose revisions even as they are empowered to propose amendments. Ambon v. Cumlec, 35 SCRA 28, 1970. Held. Congress, when acting as a constituent assembly pursuant to Article 15 of the Constitution, now Article 17, has full and plenary authority to propose constitutional amendments or to call a convention for the purpose, by a 3/4 vote of each House in joint session assembled but voting separately. The grant to Congress as a constituent assembly of such plenary authority to call a constitutional convention includes, by virtue of the doctrine of necessary implication, all other powers essential to the effective exercise of the principal power granted, such as the power to fix the qualifications, number, apportionment, and compensation of the delegates as well as appropriation of funds to meet the expenses for the election of delegates and for the operation of the Constitutional Convention itself, as well as all other implementing details indispensable to a fruitful convention. While the authority to call a constitutional convention is vested by the present Constitution solely and exclusively in Congress acting as a constituent assembly, the power to enact the implementing details, which are now contained in Resolutions Nos. 2 and 4 as well as in RA No. 6132, does not exclusively pertain to Congress acting as a constituent assembly. Such implementing details are matters within the competence of Congress in the exercise of its comprehensive legislative power, which power encompasses all matters not expressly or by necessary implication withdrawn or removed by the Constitution from the ambit of legislative action. And as long as such statutory details do not clash with any specific provision of the Constitution, they are valid. Consequently, when Congress, acting as a constituent assembly, Amidst to provide for such implementing details after calling a constitutional convention, Congress, acting as a legislative body, can enact the necessary implementing legislation to fill in the gaps, which authority is expressly recognized in Section 8 of Res. Number 2 as amended by Res. Number 4. The fact that a bill providing for such implementing details may be vetoed by the President is no argument against conceding such power in Congress as a legislative body nor present any difficulty, for it is not irremediable as Congress can override a presidential veto or Congress can reconvene as a constituent assembly and adopt a resolution prescribing the required implementing details. Gonzalez v. Kumlek, 21 SCRA 774, 1967. Doctrines. 1. Proposal of amendments is not a political but a justiciable question subject to judicial review. This doctrine is reaffirmed in Sanidad v. Kumlek. 2. The choice as to whether to propose amendments or to call a constitutional convention for that purpose or to do both was a question of wisdom and not of authority and hence was a political question not subject to review by the courts. 3. The constituent power, or the power to amend or revise the Constitution, is different from the lawmaking power of Congress. Sanidad v. Cuenco, 100 Phil 1101. Doctrine. The courts can inquire into whether or not the prescribed procedure for amendment has been observed. Amendment isolated or piecemeal change. Revision, revamp or rewriting of the entire instrument. Lambino v. Kumlek, GR number 174153, October 25, 2006. Held, courts have long recognized the distinction between an amendment and a revision of a constitution. Revision broadly implies a change that alters a basic principle in the Constitution, like altering the principle of separation of powers or the system of checks and balances. There is also revision if the change alters the substantial entirety of the Constitution, as when the change affects substantial provisions of the Constitution. On the other hand, amendment broadly refers to a change that adds, reduces, or deletes without altering the basic principle involved. Revision generally affects several provisions of the Constitution, while amendment generally affects only the specific provision being amended. In California, where the initiative clause allows amendments but not revisions to the Constitution just like in our Constitution, courts have developed a two-part test, the quantitative test and the qualitative test. The quantitative test asks whether the proposed change is so extensive in its provisions as to change directly the substantial entirety of the Constitution by the deletion or alteration of numerous existing provisions. The court examines only the number of provisions affected and does not consider the degree of the change. The qualitative test inquires into the qualitative effects of the proposed change in the Constitution. The main inquiry is whether the change will accomplish such far-reaching changes in the nature of our basic governmental plan as to amount to a revision. Whether there is an alteration in the structure of government is a proper subject of inquiry. Thus, a change in the nature of the basic governmental plan includes change in its fundamental framework or the fundamental powers of its branches. A change in the nature of the basic governmental plan also includes changes that jeopardize the traditional form of government and the system of check and balances. Under both the quantitative and qualitative tests, the Lambino Group's initiative is a revision and not merely an amendment. Quantitatively, the Lambino Group's proposed changes overhaul two articles, Article V on the legislature and Article 7 on the executive, affecting a total of 105 provisions in the entire Constitution. Qualitatively, the proposed changes alter substantially the basic plan of government, from presidential to parliamentary, and from a bicameral to a unicameral legislature. A change in the structure of government is a revision of the Constitution, as when the three great co-equal branches of government in the present Constitution are reduced into two. This alters the separation of powers in the Constitution. A shift from the present bicameral presidential system to a unicameral parliamentary system is a revision of the Constitution. Merging the legislative and executive branches is a radical change in the structure of government. The abolition alone of the office of the President as the locus of executive power alters the separation of powers and thus constitutes a revision of the Constitution. Likewise, the abolition alone of one chamber of Congress alters the system of checks and balances within the legislature and constitutes a revision of the Constitution. By any legal test and under any jurisdiction, a shift from a bicameral presidential to a unicameral parliamentary system, involving the abolition of the office of the President and the abolition of one chamber of Congress, is beyond doubt a revision, not a mere amendment. On the face alone of the Lambino Group's proposed changes, it is readily apparent that the changes will radically alter the framework of government as set forth in the Constitution. Father Joaquin Bernas, S.J., a leading member of the Constitutional Commission, writes, "An amendment envisages an alteration of one or a few specific and separable provisions. The guiding original intention of an amendment is to improve specific parts or to add new provisions deemed necessary to meet new conditions or to suppress specific portions that may have become obsolete or that are judged to be dangerous. In revision, however, the guiding original intention and plan contemplates a re-examination of the entire document, or of provisions of the document which have overall implications for the entire document, to determine how and to what extent they should be altered. Thus, for instance, a switch from the presidential system to a parliamentary system would be a revision because of its overall impact on the entire constitutional structure. So would a switch from a bicameral system to a unicameral system be because of its effect on other important provisions of the Constitution. Emphasis supplied. Where the proposed change applies only to a specific provision of the Constitution without affecting any other section or article, the change may generally be considered an amendment and not a revision. For example, a change reducing the voting age from 18 years to 15 years is an amendment and not a revision. Similarly, a change reducing Filipino ownership of mass media companies from 100% to 60% is an amendment and not a revision. Also, a change requiring a college degree as an additional qualification for election to the presidency is an amendment and not a revision. The changes in these examples do not entail any modification of sections or articles of the Constitution other than the specific provision being amended. These changes do not also affect the structure of government or the system of checks and balances among or within the three branches. These three examples are located at the far green end of the spectrum, opposite the far red end where the revision sought by the present petition is located. However, there can be no fixed rule on whether a change is an amendment or a revision. A change in a single word of one sentence of the Constitution may be a revision and not an amendment. For example, the substitution of the words Republican with monarchic or theocratic in Section 1, Article 2 of the Constitution radically overhauls the entire structure of government and the fundamental ideological basis of the Constitution. Thus, each specific change will have to be examined case by case, depending on how it affects other provisions, as well as how it affects the structure of government, the carefully crafted system of checks and balances, and the underlying ideological basis of the existing Constitution, political law. Since a revision of a constitution affects basic principles, or several provisions of a constitution, a deliberative body with recorded proceedings is best suited to undertake a revision. A revision requires harmonizing not only several provisions, but also the altered principles with those that remain unaltered. Thus, constitutions normally authorize deliberative bodies like constituent assemblies or constitutional conventions to undertake revisions. On the other hand, constitutions allow people's initiatives, which do not have fixed and identifiable deliberative bodies or recorded proceedings, to undertake only amendments and not revisions. Doctrine of proper submission. The entire Constitution must be submitted for ratification at one plebiscite only. Submission for ratification of piecemeal amendments disallowed. Lambino vs. Cumlec, GR number 174153, October 25, 2006. Held, the essence of amendments directly proposed by the people through initiative upon a petition is that the entire proposal on its face is a petition by the people. This means two essential elements must be present. First, the people must author and thus sign the entire proposal. No agent or representative can sign on their behalf. Second, as an initiative upon a petition, the proposal must be embodied in a petition. These essential elements are present only if the full text of the proposed amendments is first shown to the people who express their assent by signing such complete proposal in a petition. Thus, an amendment is directly proposed by the people through initiative upon a petition only if the people sign on a petition that contains the full text of the proposed amendments. The full text of the proposed amendments may be either written on the face of the petition, or attached to it. If so attached, the petition must state the fact of such attachment. This is an assurance that every one of the several millions of signatories to the petition has seen the full text of the proposed amendments before signing. Otherwise, it is physically impossible, given the time constraint, to prove that every one of the millions of signatories had seen the full text of the proposed amendments before signing. Citizenship. Citizenship is membership in a political community with all its concomitant rights and responsibilities. Whether natural-born or naturalized, this status confers upon the individual certain prerogatives which may be denied the alien, although both of them come under the term person as protected by the Due Process and Equal Protection Clauses. Thus, the citizen enjoys certain exclusive rights, such as the rights to vote, to run for public office, to exploit natural resources, to operate public utilities, to administer educational institutions, and to manage the mass media. Article 4, 1987 Constitution. Section 1. The following are citizens of the Philippines. 1. Those who are citizens of the Philippines at the time of the adoption of this Constitution. 2. Those whose fathers or mothers are citizens of the Philippines. 3. Those born before January 17, 1973, of Filipino mothers, who elect Philippine citizenship upon reaching the age of majority, and 4. Those who are naturalized in accordance with law. Section 2. Natural-born citizens are those who are citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. Those who elect Philippine citizenship in accordance with paragraph 3, Section 1 hereof shall be deemed natural-born citizens. Section 3. Philippine citizenship may be lost or reacquired in the manner provided by law. Section 4. Citizens of the Philippines who marry aliens shall retain their citizenship, unless by their act or omission they are deemed, under the law, to have renounced it. Section 5. Dual allegiance of citizens is inimical to the national interest and shall be dealt with by law. 3 methods of acquiring citizenship. 1. Jus sanguinis, citizenship is conferred by virtue of blood relationship. 2. Jus soli, citizenship is conferred by virtue of the place of birth. 3. Naturalization, the legal act of adopting an alien and clothing him with the privilege of a native-born citizen. Vales v. Cumlag, 337 SCRA 543, August 9, 2000, and Bank Purism Jus sanguinis principle, renunciation of Philippine citizenship, application of res judicata in citizenship issues. Jus sanguinis principle. The Philippine law on citizenship adheres to the principle of jus sanguinis. Thereunder, a child follows the nationality or citizenship of the parents regardless of the place of his/her birth, as opposed to the doctrine of jus soli which determines nationality or citizenship on the basis of place of birth. The principle of jus sanguinis does not apply to adopted children, it applies only to children of natural filiations. Renunciation of Philippine citizenship. The mere fact that private respondent Rosalind Basco Lopez was a holder of an Australian passport and had an alien certificate of registration are not acts constituting an effective renunciation of citizenship and do not militate against her claim of Filipino citizenship. For renunciation to effectively result in the loss of citizenship, the same must be express. As held by this court in the aforecited case of Asner, an application for an alien certificate of registration does not amount to an express renunciation or repudiation of one's citizenship. The application of the herein private respondent for an alien certificate of registration, and her holding of an Australian passport, as in the case of Mercado v. Monzano, were mere acts of assertion of her Australian citizenship before she effectively renounced the same. Thus, at the most, private respondent had dual citizenship. She was an Australian and a Filipino, as well. Moreover, under Commonwealth Act 63, the fact that a child of Filipino parents was born in another country has not been included as a ground for losing one's Philippine citizenship. Since private respondent did not lose or renounce her Philippine citizenship, petitioners claim that respondent must go through the process of repatriation does not hold water. Application of res judicata in citizenship issues. Petitioner is correct insofar as the general rule is concerned, that is, the principle of res judicata generally does not apply in cases hinging on the issue of citizenship. However, in the case of Burke v. Republic, 51 SCRA 248 1973, an exception to this general rule was recognized. The court ruled in that case that in order that the doctrine of res judicata may be applied in cases of citizenship, the following must be present. 1. A person's citizenship be raised as a material issue in a controversy where said person is a party. 2. The Solicitor General or his authorized representative took active part in the resolution thereof, and 3. The finding on citizenship is affirmed by this court. Texan v. Cumlec, 424 SCRA 277, 2004. Held, Section 2, Article 7, of the 1987 Constitution expresses, no person may be elected president unless he is a natural-born citizen of the Philippines, a registered voter, able to read and write, at least 40 years of age on the day of the election, and a resident of the Philippines for at least 10 years immediately preceding such election. The term natural-born citizens is defined to include those who are citizens of the Philippines from birth without having to perform any act to acquire or perfect their Philippine citizenship. The date, month and year of birth of FPJ appeared to be August 20, 1939 during the regime of the 1935 Constitution. Through its history, four modes of acquiring citizenship, naturalization, jus soli, res judicata and jus sanguinis, had been in vogue. Only two, that is, jus soli and jus sanguinis, could qualify a person to being a natural-born citizen of the Philippines. Jus soli, Peroa v. Collector of Customs, 1912, did not last long. With the adoption of the 1935 Constitution and the reversal of Roa and Tan Chong v. Secretary of Labor, 1947, jus sanguinis or blood relationship would now become the primary basis of citizenship by birth. Documentary evidence adduced by petitioner would tend to indicate that the earliest established direct descendant of FPJ was his paternal grandfather Lorenzo Poe, married to Marta Reyes, the father of Alan F. Poe. While the record of birth of Lorenzo Poe had not been presented in evidence, his death certificate, however, identified him to be a Filipino, a resident of San Carlos, Pangasinan, and 84 years old at the time of his death on September 11, 1954. The certificate of birth of the father of FPJ, Alan F. Poe, showed that he was born on May 17, 1915 to an Espanol father, Lorenzo Poe, and a mestiza Espanol mother, Marta Reyes. Introduced by petitioner was an uncertified copy of a supposed certificate of the alleged marriage of Alan F. Poe and Paulita Gomez on July 5, 1936. The marriage certificate of Alan F. Poe and Bessie Kelly reflected the date of their marriage to be on September 16, 1940. In the same certificate, Alan F. Poe was stated to be 25 years old, unmarried, and a Filipino citizen, and Bessie Kelly to be 22 years old, unmarried, and an American citizen. The birth certificate of FPJ would disclose that he was born on August 20, 1939 to Alan F. Poe, a Filipino, 24 years old, married to Bessie Kelly, an American citizen, 21 years old and married. Petitioner would have it that even if Alan F. Poe were a Filipino citizen, he could not have transmitted his citizenship to respondent FPJ, the latter being an illegitimate child. According to petitioner, prior to his marriage to Bessie Kelly, Alan F. Poe, on July 5, 1936, contracted marriage with a certain Paulita Gomez, making his subsequent marriage to Bessie Kelly bigamous and respondent FPJ an illegitimate child. The veracity of the supposed certificate of marriage between Alan F. Poe and Paulita Gomez could be most doubtful at best. But the documentary evidence introduced by no less than a respondent himself, consisting of a birth certificate of a respondent and a marriage certificate of his parents, showed that FPJ was born on August 20, 1939 to a Filipino father and an American mother who were married to each other a year later, or on September 16, 1940. Birth to unmarried parents would make FPJ an illegitimate child. Petitioner contended that as an illegitimate child, FPJ so followed the citizenship of his mother, Bessie Kelly, an American citizen, basing his stand on the ruling of this court in Morano v. Vivo 20 SCRA 562, citing Cunbian v. De Leon 82 Phil. 771, and Serra v. Republic, 91 Phil. 914. On the above score, the disquisition made by amicus curiae Joaquin G. Bernas, S.J., is most convincing. He states dash. We must analyze these cases and ask what the lis moda was in each of them. If the pronouncement of the court on jus sanguinis was on the lis moda, the pronouncement would be a decision constituting doctrine under the rule of stare decisis. But if the pronouncement was irrelevant to the lis moda, the pronouncement would not be a decision but a mere obiter dictum which did not establish doctrine. I therefore invite the court to look closely into these cases. First, Morano v. Vivo. The case was not about an illegitimate child of a Filipino father. It was about a stepson of a Filipino, a stepson who was the child of a Chinese mother and a Chinese father. The issue was whether the stepson followed the naturalization of the stepfather. Nothing about jus sanguinis there. The stepson did not have the blood of the naturalized stepfather. Second, Cunbian v. De Leon. This case was not about the illegitimate sons of a Filipino father. It was about a legitimate son of a father who had become Filipino by election to public office before the 1935 Constitution pursuant to Article 4, Section 1-2 of the 1935 Constitution. No one was illegitimate here. Third, Serra v. Republic. The case was not about the illegitimate sons of a Filipino father. Serra was an illegitimate child of a Chinese father and a Filipino mother. The issue was whether one who was already a Filipino because of his mother who still needed to be naturalized. There is nothing there about invidious jus sanguinis. Finally, Pa v. Chan 21 SCRA 753, this is a more complicated case. The case was about the citizenship of Quinton Chan, who was the son of Leoncio Chan. Quinton Chan claimed that his father, Leoncio, was the illegitimate son of a Chinese father and a Filipino mother. Quinton therefore argued that he got his citizenship from Leoncio, his father. But the Supreme Court said that there was no valid proof that Leoncio was in fact the son of a Filipino mother. The court therefore concluded that Leoncio was not Filipino. If Leoncio was not Filipino, neither was his son Quinton. Quinton therefore was not only not a natural-born Filipino but was not even a Filipino. The court should have stopped there. But instead it followed with an obiter dictum. The court said obiter that even if Leoncio, Quinton's father, were Filipino, Quinton would not be Filipino because Quinton was illegitimate. This statement about Quinton, based on a contrary-to-fact assumption, was absolutely unnecessary for the case. It was obiter dictum, pure and simple, simply repeating the obiter dictum in Morano v. Vivo. Aside from the fact that such a pronouncement would have no textual foundation in the Constitution, it would also violate the Equal Protection Clause of the Constitution not once but twice. First, it would make an illegitimate distinction between a legitimate child and an illegitimate child, and second, it would make an illegitimate distinction between the illegitimate child of a Filipino father and the illegitimate child of a Filipino mother. The doctrine on constitutionally allowable distinctions was established long ago by People v. Kayat, 68 Phil. 12. I would grant that the distinction between legitimate children and illegitimate children rests on real differences. But real differences alone do not justify invidious distinction. Real differences may justify distinction for one purpose but not for another purpose. What is the relevance of legitimacy or illegitimacy to elective public service? What possible state interest can there be for disqualifying an illegitimate child from becoming a public officer? It was not the fault of the child that his parents had illicit liaison. Why deprive the child of the fullness of political rights for no fault of his own? To disqualify an illegitimate child from holding an important public office is to punish him for the indiscretion of his parents. There is neither justice nor rationality in that. And if there is neither justice nor rationality in the distinction, then the distinction transgresses the Equal Protection Clause and must be reprobated. The other amici curiae, Mr. Justice Vicente Mendoza, a former member of this court, Professor Ruben Balain and Dean Martin Magalona, at bottom, have expressed similar views. The thesis of petitioner, unfortunately hinging solely on pure obiter dicta, should indeed fail. Where jurisprudence regarded an illegitimate child as taking after the citizenship of its mother, it did so for the benefit of the child. It was to ensure a Filipino nationality for the illegitimate child of an alien father in line with the assumption that the mother had custody, would exercise parental authority and had the duty to support her illegitimate child. It was to help the child, not to prejudice or discriminate against him. The fact of the matter, perhaps the most significant consideration, is that the 1935 Constitution, the fundamental law prevailing on the day, month and year of birth of respondent FPJ, can never be more explicit than it is. Providing neither conditions nor distinctions, the Constitution states that among the citizens of the Philippines are those whose fathers are citizens of the Philippines. There utterly is no cogent justification to prescribe conditions or distinctions where there clearly are none provided. In ascertaining, in GR number 161824, whether grave abuse of discretion has been committed by the COMELEC, it is necessary to take on the matter of whether or not respondent FPJ is a natural-born citizen, which, in turn, depended on whether or not the father of respondent, Alan F. Poe, would have himself been a Filipino citizen and, in the affirmative, whether or not the alleged illegitimacy of respondent prevents him from taking after the Filipino citizenship of his putative father. Any conclusion on the Filipino citizenship of Lorenzo Poe could only be drawn from the presumption that having died in 1954 at 84 years old, Lorenzo would have been born sometime in the year 1870, when the Philippines was under Spanish rule, and that San Carlos, Pangasinan, his place of residence upon his death in 1954, in the absence of any other evidence, could have well been his place of residence before death, such that Lorenzo Poe would have benefited from the en masse Filipinization that the Philippine Bill had effected in 1902. That citizenship, of Lorenzo Poe, if acquired, would thereby extend to his son, Alan F. Poe, father of respondent FPJ. The 1935 Constitution, during which regime respondent FPJ has seen first light, confers citizenship to all persons whose fathers are Filipino citizens regardless of whether such children are legitimate or illegitimate. Application for admission to the Philippine Bar, Vicente D. Ching, Bar Matter No. 914, October 1, 1999, and Bank Kapunan failure to elect Philippine citizenship upon reaching the age of majority. Under Article 4, Section 1-3 of the 1935 Constitution, the citizenship of a legitimate child born of a Filipino mother and an alien father followed the citizenship of the father, unless, upon reaching the age of majority, the child elected Philippine citizenship. The phrase reasonable time has been interpreted to mean that the election should be made within 3 years from reaching the age of majority. Philippine citizenship can never be treated like a commodity that can be claimed when needed and suppressed when convenient. One who is privileged to elect Philippine citizenship has only an inchoate right to such citizenship. As such, he should avail of the right with fervor, enthusiasm and promptitude. Bengzon, 3 vs. Ret, GR number 142840, May 7, 2001, and Bank Kapunan natural-born Philippine citizenship, effect of repatriation, naturalization and repatriation. There are two ways of acquiring citizenship, 1, by birth, and 2, by naturalization. These ways of acquiring citizenship correspond to the two kinds of citizens, the natural-born citizen, and the naturalized citizen. A person who at the time of his birth is a citizen of a particular country, is a natural-born citizen thereof. As defined in the Constitution, natural-born citizens are those citizens of the Philippines from birth without having to perform any act to acquire or perfect his Philippine citizenship. On the other hand, naturalized citizens are those who have become Filipino citizens through naturalization, generally under Commonwealth Act No. 473, otherwise known as the Revised Naturalization Law, which repealed the former Naturalization Law, Act No. 2927, and by Republic Act No. 530. To be naturalized, an applicant has to prove that he possesses all the qualifications and none of the disqualifications provided by law to become a Filipino citizen. The decision granting Philippine citizenship becomes executory only after 2 years from its promulgation, when the court is satisfied that during the intervening period, the applicant has 1. Not left the Philippines, 2. Has dedicated himself to a lawful calling or profession, 3. Has not been convicted of any offense or violation of government promulgated rules, or 4. Committed any act prejudicial to the interest of the nation or contrary to any government-announced policies. Section 1, RA 530. Filipino citizens who have lost their citizenship may reacquire the same in the manner provided by law. Commonwealth Act No. 63 enumerates the three modes by which Philippine citizenship may be reacquired by a former citizen: 1. By naturalization, 2. By repatriation, and 3. By direct act of Congress. Naturalization is a mode for both acquisition and reacquisition of Philippine citizenship. As a mode of initially acquiring Philippine citizenship, naturalization is governed by Commonwealth Act No. 473, as amended. On the other hand, naturalization as a mode for reacquiring Philippine citizenship is governed by Commonwealth Act No. 63, an act providing for the ways in which Philippine citizenship may be lost or reacquired, 1936. Under this law, a former Filipino citizen who wishes to reacquire Philippine citizenship must possess certain qualifications and none of the disqualifications mentioned in Section 4 of CA 473. Repatriation, on the other hand, may be had under various statutes by those who lost their citizenship due to 1. Desertion of the armed forces, Section 4, CA No. 63, 2. Service in the armed forces of the Allied forces in World War II, Section 1, Republic Act No. 965 1953, 3. Service in the armed forces of the United States at any other time, Section 1, Republic Act No. 2630 1960, 4. Marriage of a Filipino woman to an alien, Section 1, Republic Act No. 8171 1995, and 5. Political and economic necessity, IBID. As distinguished from the lengthy process of naturalization, repatriation simply consists of the taking of an oath of allegiance to the Republic of the Philippines and registering said oath in the local civil registry of the place where the person concerned resides or last resided. Moreover, repatriation results in the recovery of the original nationality. This means that a naturalized Filipino who lost his citizenship will be restored to his prior status as a naturalized Filipino citizen. On the other hand, if he was originally a natural-born citizen before he lost his Philippine citizenship, he will be restored to his former status as a natural-born Filipino. Angat v. Republic, GR No. 132244. September 14, 1999. Vitug repatriation under RA 8171. RA No. 8171, which has lapsed into law on October 23, 1995, is an act providing for the repatriation, a. of Filipino women who have lost their Philippine citizenship by marriage to aliens and, b. of natural-born Filipinos who have lost their Philippine citizenship on account of political or economic necessity. An application for repatriation could be filed with the Special Committee on Naturalization chaired by the Solicitor General with the Undersecretary of Foreign Affairs and the Director of the National Intelligence Coordinating Agency as the other members. Mercado vs. Manzano, 307 SCRA 630, May 26, 1999, and Bank Mendoza. Dual citizenship and dual allegiance. Dual citizenship arises when, as a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by the said states. For instance, such a situation may arise when a person whose parents are citizens of a state which adheres to the principle of jus sanguinis is born in a state which follows the doctrine of jus soli. Such a person, ipso facto and without any voluntary act on his part, is concurrently considered a citizen of both states. Dual allegiance, on the other hand, refers to a situation in which a person simultaneously owes, by some positive act, loyalty to two or more states. While dual citizenship is involuntary, dual allegiance is the result of an individual's volition. Hence, the phrase dual citizenship in RA number 7160, section 40D, Local Government Code, must be understood as referring to dual allegiance. Consequently, persons with mere dual citizenship do not fall under this disqualification. Unlike those with dual allegiance, who must be subject to strict process with respect to the termination of their status, for candidates with dual citizenship, it should suffice if, upon the filing of their certificate of candidacy, they elect Philippine citizenship to terminate their status as persons with dual citizenship, considering that their condition is the unavoidable consequence of conflicting laws of different states. Instances when a Philippine citizen may possess dual citizenship. 1. Those born of parents whose country adopts the jus sanguinis principle inferior in countries which follows the jus soli principle. 2. Those born in the Philippines of Filipino mothers and an alien father, if by the laws of their father's country such children are citizens of that country. 3. Those who marry aliens if by the laws of the latter's country, the former are considered citizens, unless, by their act or omission they are deemed to have renounced Philippine citizenship. Principles and Policies of the Philippine Government Preamble. We, the sovereign Filipino people, imploring the aid of Almighty God, in order to build a just and humane society and establish a government that shall embody our ideals and aspirations, promote the common good, conserve and develop our patrimony, and secure to ourselves and our posterity the blessings of independence and democracy under the rule of law and a regime of truth, justice, freedom, love, equality, and peace, do ordain and promulgate this Constitution. A preamble has two functions: 1. Identify the authors of the Constitution, and 2. State the general principles upon which the Constitution is founded. Sets the tone for the succeeding provisions. Does not confer rights nor impose duties. Not a source of power or right for any department of government. It only sets down the origin, scope, and purpose of the Constitution. As such, it is useful as an aid in ascertaining the meaning of ambiguous provisions in the body of the Constitution. Sovereignty of its people and republicanism. Article 2, Section 1. The Philippines is a democratic and republican state. Sovereignty resides in the people and all government authority emanates from them. Under this principle, the Philippines is a democratic state, that is, a government for, of, and by the people. But it is not a pure democracy. Thus, while it is true that the people are the possessors of sovereign power, it is equally the case that they cannot exercise the powers of government directly, but only through the medium of their duly elected representatives. Their participation in government consists of 1. Suffrage, electing the officials to whom they delegate the right of government. 2. Plebiscite. A. Ratifying the Constitution. B. Approving any amendment thereto. C. With respect to local matters, approving any changes in boundaries, mergers, divisions, and even abolition of local offices. D. Creating metropolitan authorities, and E. Creating autonomous regions. 3. Initiative and referendum, enacting or proposing laws, local or national, in a referendum. 4. Recall, under the Local Government Code. Features of republicanism. 1. It is a government of laws and not of men. 2. There is periodic holding of elections. 3. There is observance of principle of separation of powers and of checks and balances. 4. There is observance of the rule that the legislature cannot pass or enact irrepealable laws. Adherence to international law. Article 2, Section 2. The Philippines renounces war as an instrument of national policy, adopt the generally accepted principles of international law as part of the law of the land, and adheres to the policy of peace, equality, justice, freedom, cooperation, and amity with all nations. Adopts the generally accepted principles of international law means the Philippines uses the incorporation theory, doctrine of incorporation. Without need of statute, these principles of international law become part of the Philippine body of laws from the municipal point of view. Civilian Supremacy Clause. Section 3, Article 2, 1987 Constitution. Section 3. Civilian authority is, at all times, supreme over the military. The armed forces of the Philippines is the protector of the people and the state. Its goal is to secure the sovereignty of the state and the integrity of the national territory. The supremacy of civilian rule over the military is ensured by, I, the installation of the President, the highest civilian authority, as the Commander-in-Chief of the military, 2, the requirement that members of the AFP swear to uphold and defend the Constitution, which is the fundamental law of the civil government, 3, the professionalization of the service and the strengthening of the patriotism and nationalism, and respect for human rights, of the military, 4, insulation of the AFP from partisan politics, v. prohibition against the appointment to a civil position, vi. compulsory retirement of officers, no overstaying of officers, so as to avoid propagation of power, 7, a 3-year limitation on the term of duty of the Chief of Staff, which although extendable in case of emergency by the President, depends on a congressional declaration of emergency, 8, requirement of professional recruitment, so as to avoid any regional clique from forming within the AFP, as well as, 9, the establishment of a police force that is not only civilian character but also under the local executives. IBP vs. Zamora, GR number 141284, August 15, 2000, and Bank Kapunan. The deployment of the Marines does not constitute a breach of the Civilian Supremacy Clause. The calling of the Marines in this case constitutes permissible use of military assets for civilian law enforcement. The limited participation of the Marines is evident in the provisions of the law itself, which sufficiently provides the metes and bounds of the Marines' authority. It is noteworthy that the local police forces are the ones in charge of the visibility patrols at all times, the real authority belonging to the plug-and-play. In fact, the Metro Manila Police Chief is the overall leader of the plug-and-play Philippine Marines Joint Visibility Patrols. Under the law, the police forces are tasked to brief or orient the soldiers on police patrol procedures. It is their responsibility to direct and manage the deployment of the Marines. It is, likewise, their duty to provide the necessary equipment to the Marines and render logistical support to these soldiers. In view of the foregoing, it cannot be properly argued that military authority is supreme over civilian authority. It is worth mentioning that military assistance to civilian authorities in various forms persists in Philippine jurisdiction. The Philippine experience reveals that it is not averse to requesting the assistance of the military in the implementation and execution of certain traditionally civil functions. Some of the multifarious activities wherein military aid has been rendered, exemplifying the activities that bring both the civilian and the military together in a relationship of cooperation, are 1. Elections. 2. Administration of the Philippine National Red Cross. 3. Relief and rescue operations during calamities and disasters. 4. Amateur sports promotion and development. 5. Development of the culture and the arts. 6. Conservation of natural resources. 7. Implementation of the Agrarian Reform Program. 8. Enforcement of customs laws. 9. Composite civilian-military law enforcement activities. 10. Conduct of licensure examinations. 11. Conduct of nationwide tests for elementary and high school students. 12. Anti-drug enforcement activities. 13. Sanitary inspections. 14. Conduct of census work. 15. Administration of the Civil Aeronautics Board. 16. Assistance in installation of weather forecasting devices. 17. Peace and order policy formulation in local government units. Academic freedom. UP Board of Regents vs. CA, GR number 134625, August 31, 1999, 2nd Div Mendoza. Academic freedom of institutions of higher learning is a freedom granted to institutions of higher learning which is thus given a wide sphere of authority certainly extending to the choice of students. If such institution of higher learning can decide who can and who cannot study in it, it certainly can also determine on whom it can confer the honor and distinction of being its graduates. Where it is shown that the conferment of an honor or distinction was obtained through fraud, a university has the right to revoke or withdraw the honor or distinction it has thus conferred. This freedom of a university does not terminate upon the graduation of a student, for it is precisely the graduation of such a student that is in question. Isabello Jr. vs. Perpetual Help College of Rizal Incorporated, 227 SCRA 595, November 8, 1993 Vitug. The essential freedoms subsumed in the term academic freedom encompassing not only the freedom to determine on academic grounds who may teach, what may be taught, and how it shall be taught, but likewise who may be admitted to study. Social Justice and Human Rights. The Indigenous Peoples' Rights Act. RA number 8371. An act to recognize, protect and promote the rights of indigenous cultural communities/indigenous peoples, creating a National Commission on Indigenous Peoples, establishing implementing mechanisms, appropriating funds therefor, and for other purposes. Izagani Cruz vs. Section of DENR, GR number 135385, December 6, 2000, N. Bank, Puno, and Kapunan, separate opinions. The IPRA recognizes the existence of the indigenous cultural communities or indigenous peoples, ICC's IPs, as a distinct sector in Philippine society. It grants these people the ownership and possession of their ancestral domains and ancestral lands, and defines the extent of these lands and domains. The ownership given is the indigenous concept of ownership under customary law which traces its origin to native title. Within their ancestral domains and ancestral lands, the ICC's IPs are given the right to self-governance and empowerment, Sections 13 to 20, Social Justice and Human Rights, Sections 21 to 28, the right to preserve and protect their culture, traditions, institutions and community intellectual rights, and the right to develop their own sciences and technologies, Sections 29 to 37. Ancestral domains are all areas belonging to ICC's IPs held under a claim of ownership, occupied or possessed by ICC's IPs by themselves or through their ancestors, communally or individually since time immemorial, continuously until the present, except when interrupted by war, force majeure or displacement by force, deceit, stealth or as a consequence of government projects or any other voluntary dealings with government and/or private individuals or corporations. Ancestral lands are lands held by the ICC's IPs under the same conditions as ancestral domains except that these are limited to lands and that these lands are not merely occupied and possessed but are also utilized by the ICC's IPs under claims of individual or traditional group ownership. The rights of the ICC's IPs to their ancestral domains and ancestral lands may be acquired in two modes: 1, by native title over both ancestral lands and domains, or 2, by torrents title under the Public Land Act and the Land Registration Act with respect to ancestral lands only. Separate opinion, Puno, J. in Izagani Cruz vs. Secretary of DENR, et al., GR number 135385, December 6, 2000, N. Bank. Concept of native title. Native title refers to ICC's IP's pre-conquest rights to lands and domains held under a claim of private ownership as far back as memory reaches. These lands are deemed never to have been public lands and are indisputably presumed to have been held that way since before the Spanish conquest. The rights of ICC's IPs to their ancestral domains, which also include ancestral lands, by virtue of native title shall be recognized and respected. Section 11, IPRA. Formal recognition, when solicited by ICC's IPs concerned, shall be embodied in a Certificate of Ancestral Domain Title, CADT, which shall recognize the title of the concerned ICC's IPs over the territories identified and delineated. The Regelian theory, however, does not negate native title to lands held in private ownership since time immemorial. In the landmark case of Carino versus Insular Government, 41 Phil. 935, 212 U.S. 449, 53 liters. Ed. 594-1909, the United States Supreme Court, reversing the decision of the pre-war Philippine Supreme Court, made the following pronouncement. Every presumption is and ought to be taken against the government in a case like the present. It might, perhaps, be proper and sufficient to say that when, as far back as testimony or memory goes, the land has been held by individuals under a claim of private ownership, it will be presumed to have been held in the same way from before the Spanish conquest, and never to have been public land. Carino versus Insular Government, Supernote 75, at 941. The above ruling institutionalized the recognition of the existence of native title to land, or ownership of land by Filipinos by virtue of possession under a claim of ownership since time immemorial and independent of any grant from the Spanish crown, as an exception to the theory of jure regalia. Carino was decided by the U.S. Supreme Court in 1909, at a time when decisions of the U.S. Court were binding as precedent in our jurisdiction. Section 10, Philippine Bill of 1902. We applied the Carino Doctrine in the 1946 case of Ocho v. Director of Lands, 75 Phil. 890-1946, where we stated that all lands that were not acquired from the government either by purchase or by grant, belonged to the public domain, but an exception to the rule would be any land that should have been in the possession of an occupant and of his predecessors in interest since time immemorial. For such possession would justify the presumption that the land had never been part of the public domain or that it had been private property even before the Spanish conquest. Separate opinion, Kapunan, J. in Azagani Cruz v. Secretary of Denver, GR No. 135385, December 6, 2000, N. Bank. The Filipino First Policy. Section 10, Article 12, 1987 Constitution. Section 10. The Congress shall, upon recommendation of the Economic and Planning Agency, when the national interest dictates, reserve to citizens of the Philippines or to corporations or associations at least 60% of whose capital is owned by such citizens, or such higher percentage as Congress may prescribe, certain areas of investments. The Congress shall enact measures that will encourage the formation and operation of enterprises whose capital is wholly owned by Filipinos. In the grant of rights, privileges, and concessions covering the national economy and patrimony, the state shall give preference to qualified Filipinos. The state shall regulate and exercise authority over foreign investments within its national jurisdiction and in accordance with its national goals and priorities. Manila Prince Hotel vs. Xis, 267 SCRA 408 1997 Belozalo. When the Constitution speaks of national patrimony, it refers not only to the natural resources of the Philippines, as the Constitution could have very well used the term natural resources, but also to the cultural heritage of the Filipinos. Where a foreign firm submits the highest bid in a public bidding concerning the grant of rights, privileges and concessions covering the national economy and patrimony, thereby exceeding the bid of a Filipino, there is no question that the Filipino will have to be allowed to match the bid of the foreign entity. And if the Filipino matches the bid of a foreign firm, the award should go to the Filipino. It must be so if we are to give life and meaning to the Filipino First Policy provision of the 1987 Constitution. For, while this may neither be expressly stated nor contemplated in the bidding rules, the constitutional fiat is omnipresent to be simply disregarded. To ignore it would be to sanction a perilous skirting of the basic law. From its very words, the provision does not require any legislation to put it in operation. It is per se judicially enforceable. When our Constitution mandates that in the grant of rights, privileges, and concessions covering the national economy and patrimony, the state shall give preference to qualified Filipinos, it means just that, qualified Filipinos must be preferred. Ownership/acquisition of lands by aliens. Section 7, Article 12, 1987 Constitution. Section 7. Save in cases of hereditary succession, no private land shall be transferred or conveyed except to individuals, corporations, or associations qualified to acquire or hold lands of the public domain. Section 8, Article 12, 1987 Constitution. Section 8. Notwithstanding the provisions of Section 7 of this article, a natural-born citizen of the Philippines who has lost his Philippine citizenship may be a transferee of private lands, subject to limitations provided by law. The right of the people to a balanced and healthful ecology. Section 16, Article 2, 1987 Constitution. Section 16. The state shall protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. Oposa vs. Factorin Jr., 224 SCRA 792 1993 Davide. The concept of intergenerational responsibility. While the right to a balanced and healthful ecology is to be found under the Declaration of Principles and State Policies and not under the Bill of Rights, it does not follow that it is less important than any of the civil and political rights enumerated in the latter. Such a right belongs to a different category of rights altogether, for it concerns nothing less than self-preservation and self-perpetuation, the advancement of which may even be said to predate all governments and constitutions. As a matter of fact, these basic rights need not even be written in the Constitution, for they are assumed to exist from the inception of humankind. If they are now explicitly mentioned in the Fundamental Charter, it is because of the well-founded fear of its framers that unless the rights to a balanced and healthful ecology and to health are mandated as state policies by the Constitution itself, thereby highlighting their continuing importance and imposing upon the state a solemn obligation to preserve the first and protect and advance the second, the day would not be too far when all else would be lost, not only for the present generation, but also for those to come, generations which stand to inherit nothing but parched earth incapable of sustaining life. The right to a balanced and healthful ecology carries with it the correlative duty to refrain from impairing the environment. Their personality to sue in behalf of the succeeding generations can only be based on the concept of intergenerational responsibility insofar as the right to a balanced and healthful ecology is concerned. Such a right, as hereinafter expounded, considers the rhythm and harmony of nature. Nature means the created world in its entirety. Needless to say, every generation has a responsibility to the next to preserve that rhythm and harmony for the full enjoyment of a balanced and healthful ecology. The preferential right of marginal and subsistence fishermen. Section 7, Article 13, 1987 Constitution. Section 7. The state shall protect the rights of subsistence fishermen, especially of local communities, to the preferential use of local marine and fishing resources, both inland and offshore. It shall provide support to such fishermen through appropriate technology and research, adequate financial, production, and marketing assistance, and other services. The state shall also protect, develop, and conserve such resources. The protection shall extend to offshore fishing grounds of subsistence fishermen against foreign intrusion. Fish workers shall receive a just share from their labor in the utilization of marine and fishing resources. The preferential right of subsistence or marginal fishermen to the use of marine resources is not absolute. In accordance with the Regalian doctrine, marine resources belong to the state, and, pursuant to the first paragraph of Section 2, Article 12 of the Constitution, their exploration, development and utilization shall be under the full control and supervision of the state. Moreover, their mandated protection, development and conservation imply certain restrictions on whatever right of enjoyment there may be in favor of anyone. What must be borne in mind is the state policy enshrined in the Constitution regarding the duty of the state to protect and advance the right of the people to a balanced and healthful ecology in accord with the rhythm and harmony of nature. Section 16, Article 2. Tano vs. Socrates, GR number 110249, August 21, 1997. The right of the state to recover properties unlawfully acquired by public officials or employees. Section 15, Article 11, 1987 Constitution. Section 15. The right of the state to recover properties unlawfully acquired by public officials and employees, from them or from their nominees or transferees, shall not be barred by prescription, laches, or estoppel. Presidential Ad Hoc Fact-Finding Committee on Behest Loans, et al. Versus Desirdo. GR number 130140, October 25, 1999, N. Bank Davide. Section 15, Article 11, 1987 Constitution provides that the right of the state to recover properties unlawfully acquired by public officials or employees, from them or from their nominees as transferees, shall not be barred by prescription, laches, or estoppel. From the Proceedings of a Constitutional Commission of 1986, however, it was clear that this provision applies only to civil actions for recovery of ill-gotten wealth, and not to criminal cases. Thus, the prosecution of offenses arising from, relating or incident to, or involving ill-gotten wealth contemplated in Section 15, Article 11 of the Constitution may be barred by prescription. Structure and powers of the national government. Separation of powers. Cruz, purpose. The doctrine of separation of powers is intended to prevent a concentration of authority in one person or group of persons that might lead to an irreversible error or abuse in its exercise to the detriment of our republican institutions. More specifically, according to J. Laurel, the doctrine is intended to secure action, to forestall overaction, to prevent despotism and to obtain efficiency. Blending of powers. There are instances under the Constitution when powers are not confined exclusively within one department but are in fact assigned to or shared by several departments. As a result of this blending of powers, there is some difficulty now in classifying some of them as definitely legislative, executive or judicial. As J. Holmes put it vividly when he remarked that the great ordinances of the Constitution do not establish and divide fields of black and white. Even the more specific of them are found to terminate in a penumbra shading gradually from one extreme to another. The powers of government may not at all times be contained with mathematical precision in watertight compartments because of their ambiguous nature. For example, the power of appointment, which can rightfully be exercised by each department over its own administrative personnel. Issue: may the government, through the PCGG, validly bind itself to cause the dismissal of all cases against the Marcos heirs pending before the Sandiganbayan and other courts in a compromise agreement entered into between the former and the latter? Held, this is a direct encroachment on judicial power, particularly in regard to criminal jurisdiction. Well settled is the doctrine that once a case has been filed before a court of competent jurisdiction, the matter of its dismissal or pursuance lies within the full discretion and control of the judge. In a criminal case, the manner in which the prosecution is handled, including the matter of whom to present as witnesses, may lie within the sound discretion of the government prosecutor, but the court decides, based on the evidence proffered, in what manner it will dispose of the case. Jurisdiction, once acquired by the trial court, is not lost despite a resolution, even by the Justice Secretary, to withdraw the information or to dismiss the complaint. The prosecution's motion to withdraw or to dismiss is not the least binding upon the court. On the contrary, decisional rules require the trial court to make its own evaluation of the merits of the case, because granting such motion is equivalent to effecting a disposition of the case itself. Thus, the PCGG, as the government prosecutor of ill-gotten wealth cases, cannot guarantee the dismissal of all such criminal cases against the Marcoses pending in the courts, for said dismissal is not within its sole power and discretion. Chavez vs. PCGG, 299 SCRA 744, December 9, 1998. Panganiban. Delegation of powers. Potestas delegatas non delegaribus est. What has been delegated cannot be further delegated. Section 23, Article Vi, 1987 Constitution. Section 23. 1. The Congress, by a vote of 2/3 of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. 2. In times of war or other national emergency, the Congress may, by law, authorize the President, for a limited period and subject to such restrictions as it may prescribe, to exercise powers necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of the Congress, such powers shall cease upon the next adjournment thereof. Delegation of emergency powers to the President. Article Vi, Section 23, Constitution. 2. In times of war or other national emergency, the Congress may, by law, authorize the President, for a limited period and subject to such restrictions as it may prescribe, to exercise powers necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of Congress, such powers shall cease upon the next adjournment thereof. Conditions for a valid delegation of emergency powers to the President. 1. There must be a law. 2. There must be a war or other national emergency. Other national emergency may include rebellion, economic crisis, pestilence, or epidemic, typhoon, flood or other similar catastrophe or nationwide proportions or effect. 3. The delegation must be for a limited period only. 4. The delegation must be subject to congressional limitations and restrictions. 5. The power must be exercised to carry out a national policy declared by Congress. Tests of a valid delegation of power: empowering the Comlec, an administrative body exercising quasi-judicial functions, to promulgate rules and regulations is a form of delegation of legislative authority. However, in every case of permissible delegation, there must be a showing that the delegation itself is valid. It is valid only if the law, a, is complete in itself, setting forth therein the policy to be executed, carried out, or implemented by the delegate, and, b, fixes a standard, the limits of which are sufficiently determinate and determinable, to which the delegate must conform in the performance of his functions. A sufficient standard is one which defines legislative policy, marks its limits, maps out its boundaries and specifies the public agency to apply it. It indicates the circumstances under which the legislative command is to be effected. Santiago v. Comlec, 270 SCRA 106, March 19, 1997. The Legislative Department. Legislative power, authority to make laws and to alter and repeal them. Advantages of bicameralism. 1. Allows for a body with a national perspective to check the parochial tendency of representatives elected by district. 2. Allows a more careful study of legislation. 3. Makes the legislature less susceptible to control by the executive, and 4. Serves as a training ground for national leaders. Advantages of unicameralism. 1. Simplicity of organization resulting in economy and efficiency. 2. Facility in pinpointing responsibility for legislation, and 3. Avoidance of duplication. Kinds of legislative power. 1. Original, possessed by the sovereign people. 2. Derivative, that which has been delegated by the sovereign people to legislative bodies, Congress, and is subordinate to the original power of the people. Also. 1. Constituent, power to amend and revise the Constitution. 2. Ordinary, power to pass ordinary laws. The people, through the amendatory process, exercise constituent power, and, through initiative and referendum, ordinary legislative power. Kinds of limits on legislative power. 1. Substantive limits, curtail the contents of the law X. No law may be passed which impairs freedom of speech. 2. Procedural limits, curtail the manner of passing laws. X. A bill must generally be approved by the President before it becomes a law. The power of Congress to legislate is plenary, that is, it may legislate on any subject matter. Congress may not pass irrepealable laws. The power of present and future legislatures must remain plenary. Legislative power may be delegated either by a specific constitutional provision or by the immemorial practice of it being delegated to local governments. Composition, qualifications, and term of office. A. Senate. Composition: 24 senators elected at large by qualified voters. Qualifications: citizenship, natural-born citizen. Age on the day of election, 35. Education, able to read and write. Registered voter, in the Philippines. Residence, 2 years, immediately preceding the election. Term of office, 6 years. No senator shall serve for more than 2 consecutive terms, and for this purpose, no voluntary renunciation of the office for any length of time shall be considered for the purpose of interrupting the continuity of his service for the full term for which he was elected. Article VI, Section 4. B. House of Representatives. Composition: not more than 250 members, unless otherwise fixed by law, elected from a. legislative districts. 80% of the seats shall be allotted to district representatives. B. Party list system of registered national, regional, and sectoral parties or organizations. Section 5(2). The districts are to be determined according to the following rules: 200 districts or 80%. 1. The districts are to be apportioned among the provinces, cities, and Metro Manila. Section 5(1). 2. The apportionment must be based on the number of inhabitants, using a uniform and progressive ratio. Within 3 years following the return of every census, Congress shall make a reapportionment of legislative districts, based on the standards herein provided, to make it representative and more responsive to the people. Section 5(4). 3. Each legislative district must comprise as far as practicable, contiguous, compact, and adjacent territory, to avoid gerrymandering, or putting together of areas where a candidate is strong, even if these are not contiguous. Section 5(3). 4. Each city with a population of at least 250,000 must have at least 1 representative. Section 5(3). 5. Each province, regardless of population, must have at least 1 representative. Section 5(3). Qualifications: citizenship, natural-born citizen. Age on the day of election, 25. Education, able to read and write. Registered voter, in the district, if district representative. Residence, 1 year in the district. Immediately preceding the election. Term of office, 3 years. No member of the House shall serve for more than 3 consecutive terms. No voluntary renunciation of the office for any length of time shall be considered an interruption in the continuity of his service for the full term for which he was elected for the purpose of circumventing this 3-term limitation. Article VI, Section 7. Romualdez Marcos vs. Cumlec, 248 SCRA 300, 1995. Held, residence, in its ordinary conception, implies the factual relationship of an individual to a certain place. It is the physical presence of a person in a given area, community or country. The essential distinction between residence and domicile in law is that residence involves the intent to leave when the purpose for which the resident has taken up his abode ends. One may seek a place for purposes such as pleasure, business, or health. If a person's intent be to remain, it becomes his domicile. If his intent is to leave as soon as his purpose is established at his residence. It is thus, quite perfectly normal for an individual to have different residences in various places. However, a person can only have a single domicile, unless, for various reasons, he successfully abandons his domicile in favor of another domicile of choice. In Unzu vs. Republic, 95 Phil. 890, we laid this distinction quite clearly. There is a difference between domicile and residence. Residence is used to indicate a place of abode, whether permanent or temporary, Domicile denotes a fixed permanent residence to which, when absent, one has the intention of returning. A man may have a residence in one place and a domicile in another. Residence is not domicile, but domicile is residence coupled with the intention to remain for an unlimited time. A man can have but one domicile for the same purpose at any time, but he may have numerous places of residence. His place of residence is generally his place of domicile, but it is not by any means necessarily so, since no length of residence without intention of remaining will constitute domicile. In Co vs. Electoral Tribunal of the House of Representatives, 199 SCRA 692, this court concluded that the framers of the 1987 Constitution obviously adhered to the definition given to the term residence in election law, regarding it as having the same meaning as domicile. Domino vs. Kumlek, 310 SCRA 546, 1999. Held, it is doctrinally settled that the term residence, as used in the law prescribing the qualifications for suffrage and for elective office, means the same thing as domicile, which imports not only an intention to reside in a fixed place but also personal presence in that place, coupled with conduct indicative of such intention. Domicile denotes a fixed permanent residence to which, whenever absent for business, pleasure, or some other reasons, one intends to return. Domicile is a question of intention and circumstances. In the consideration of circumstances, three rules must be borne in mind, namely, 1. That a man must have a residence or domicile somewhere, 2. When once established it remains until a new one is acquired, and 3. A man can have but one residence or domicile at a time. A person's domicile once established is considered to continue and will not be deemed lost until a new one is established. To successfully effect a change of domicile, one must demonstrate an actual removal or an actual change of domicile, a bona fide intention of abandoning the former place of residence and establishing a new one, and definite acts which correspond with the purpose. In other words, there must basically be animus manandi coupled with animus non revertendi. The purpose to remain in or at the domicile of choice must be for an indefinite period of time, the change of residence must be voluntary, and the residence at the place chosen for the new domicile must be actual. As a general rule, the principal elements of domicile, physical presence in the locality involved and intention to adopt it as a domicile, must concur in order to establish a new domicile. No change of domicile will result if either of these elements is absent. Intention to acquire a domicile without actual residence in the locality does not result in acquisition of domicile, nor does the fact of physical presence without intention. The Party List System. The Party List Law, RA number 7941, an act providing for the election of party list representatives through the party list system, and appropriating funds therefor. Angbagong Bayani, OFW Labour Party vs. Kumlek, GR number 147589, June 26, 2001, and Bank Pangandiban. Held, the party list system is a social justice tool designed not only to give more law to the great masses of our people who have less in life, but also to enable them to become veritable lawmakers themselves, empowered to participate directly in the enactment of laws designed to benefit them. It intends to make the marginalized and the underrepresented not merely passive recipients of the state's benevolence, but active participants in the mainstream of representative democracy. The party list system seeks to enable certain Filipino citizens, specifically those belonging to marginalized and underrepresented sectors, organizations and parties, to be elected to the House of Representatives. Inviolable parameters in party list system, Republic Act No. 7941. 1. The 20% allocation. The combined number of all party list congressmen shall not exceed 20% of the total membership of the House of Representatives, including those elected under the party list. 2. The 2% threshold. Only those garnering a minimum of 2% of the total valid votes cast for the party list system are qualified to have a seat in the House of Representatives. 3. The 3-seat limit. Each qualified party, regardless of the number of votes it actually obtained, is entitled to a maximum of 3 seats, that is, 1 qualifying and 2 additional seats. 4. Proportional representation. The additional seats which a qualified party is entitled to shall be computed in proportion to their total number of votes. Method of allocating PL seats. A. Rank all the participating parties from the highest to the lowest based on the number of votes they each received. B. The ration for each party is computed by dividing its votes by the total votes cast for all the parties participating in the system. C. All the parties with at least 2% of the total votes cast for PLS are guaranteed 1 seat each. Only these parties shall be considered in the computation of additional seats. Registration. Any organized group of persons may register as a party, organization or coalition for purposes of the party list system by filing with the COMELEC not later than 90 days before the election a petition verified by its president or secretary stating its desire to participate in the party list system as a national, regional or sectoral party or organization or a coalition of such parties or organizations, attaching thereto its constitution, bylaws, platform or program of government, list of officers, coalition agreement and other relevant information as the COMELEC may require, provided that the sector shall include labor, peasant, fisher folk, urban poor, indigenous cultural communities, elderly, handicapped, women, youth, veterans, overseas workers, and professionals. The COMELEC shall publish the petition in at least two national newspapers of general circulation. The COMELEC shall, after due notice and hearing, resolve the petition within 15 days from the date it was submitted for decision but in no case not later than 60 days before election. Disqualifications. The COMELEC may, motu proprio or upon verified complaint of any interested party, refuse or cancel, after due notice and hearing, the registration of any national, regional or sectoral party, organization or coalition on any of the following grounds. 1. It is a religious sect or denomination, organization or association organized for religious purposes. 2. It advocates violence or unlawful means to seek its goal. 3. It is a foreign party or organization. 4. It is receiving support from any foreign government, foreign political party, foundation, organization, whether directly or through any of its officers or members or indirectly through third parties for partisan election purposes. 5. It violates or fails to comply with laws, rules or regulations relating to elections. 6. It declares untruthful statements in its petition. 7. It has ceased to exist for at least one year, or 8. It fails to participate in the last two preceding elections or fails to obtain at least 2% of the votes cast under the party list system in the two preceding elections for the constituency in which it has registered. Nomination of party list representatives. Each registered party, organization or coalition shall submit to the COMELEC not later than 45 days before the election a list of names, not less than 5, from which party list representatives shall be chosen in case it obtains the required number of votes. A person may be nominated in one list only. Only persons who have given their consent in writing may be named in the list. The list shall not include any candidate for any elective office or a person who has lost his bid for an elective office in the immediately preceding election. No change of names or alteration of the order of nominees shall be allowed after the same shall have been submitted to the COMELEC except in cases where the nominee dies, or withdraws in writing his nomination, becomes incapacitated, in which case the name of the substitute nominee shall be placed last in the list. Incumbent sectoral representatives in the House of Representatives who are nominated in the party list system shall not be considered resigned. Qualifications of party list nominees. No person shall be nominated as party list representative unless 1. He is a natural-born citizen of the Philippines. 2. A registered voter. 3. A resident of the Philippines for a period of not less than one year immediately preceding the day of the election. 4. Able to read and write. 5. a bona fide member of the party or organization which he seeks to represent for at least 90 days preceding the day of the election. 6. At least 25 years of age on the day of the election. Guidelines for screening party list participants, Angbagong Bayani, OFW. Labour Party vs. Kumlek. 1. The political party, sector, organization or coalition must represent the marginalized and underrepresented groups identified in Section 5 of RA 7941. In other words, it must show, through its constitution, articles of incorporation, bylaws, history, platform of government and track record, that it represents and seeks to uplift marginalized and underrepresented sectors. Verily, majority of its membership should belong to the marginalized and underrepresented. And it must demonstrate that in a conflict of interest, it has chosen or is likely to choose the interest of such sectors. 2. While even major political parties are expressly allowed by RA 7941 and the Constitution to participate in the party list system, they must comply with the declared statutory policy of enabling Filipino citizens belonging to marginalized and underrepresented sectors to be elected to the House of Representatives. In other words, while they are not disqualified merely on the ground that they are political parties, they must show, however, that they represent the interests of the marginalized and underrepresented. 3. In view of the objections directed against the registration of Ang Buhay Hyang Umabong, which is allegedly a religious group, the court notes the express constitutional provision that the religious sector may not be represented in the party list system. Furthermore, the Constitution provides that religious denominations and sects shall not be registered. Section 25, Article 9c, the prohibition was explained by a member of the Constitutional Commission in this wise: the prohibition is on any religious organization registering as a political party. I do not see any prohibition here against a priest running as a candidate. That is not prohibited here, it is the registration of a religious sect as a political party. 4. A party or an organization must not be disqualified under Section 6 of RA 7941, which enumerates the grounds for disqualification as follows. 1. It is a religious sect or denomination, organization or association organized for religious purposes. 2. It advocates violence or unlawful means to seek its goal. 3. It is a foreign party or organization. 4. It is receiving support from any foreign government, foreign political party, foundation, organization, whether directly or through any of its officers or members or indirectly through third parties for partisan election purposes. 5. It violates or fails to comply with laws, rules or regulations relating to elections. 6. It declares untruthful statements in its petition. 7. It has ceased to exist for at least one year, or 8. It fails to participate in the last two preceding elections or fails to obtain at least 2% of the votes cast under the party list system in the two preceding elections for the constituency in which it had registered. Note should be taken of paragraph 5, which disqualifies a party or group for violation of or failure to comply with election laws and regulations. These laws include Section 2 of RA 7941, which states that the party list system seeks to enable Filipino citizens belonging to marginalized and underrepresented sectors, organizations and parties to become members of the House of Representatives. A party or organization, therefore, that does not comply with this policy must be disqualified. 5. The party or organization must not be an adjunct of, or a project organized or an entity funded or assisted by, the government. By the very nature of the party list system, the party or organization must be a group of citizens, organized by citizens and operated by citizens. It must be independent of the government. The participation of the government or its officials in the affairs of a party list candidate is not only illegal and unfair to other parties, but also deleterious to the objective of the law, to enable citizens belonging to marginalized and underrepresented sectors and organization to be elected to the House of Representatives. 6. The party must not only comply with the requirements of the law, Its nominees must likewise do so. 7. Not only the candidate party or organization must represent marginalized and underrepresented sectors, so also must its nominees. To repeat, under Section 2 of RA 7941, the nominees must be Filipino citizens who belong to marginalized and underrepresented sectors, organizations and parties. Surely, the interests of the youth cannot be fully represented by a retiree, neither can those of the urban poor or the working class, by an industrialist. To allow otherwise is to betray the state policy to give genuine representation to the marginalized and underrepresented. 8. While lacking a well-defined political constituency, the nominee must likewise be able to contribute to the formulation and enactment of appropriate legislation that will benefit the nation as a whole. Does the Constitution require all such allocated seats to be filled up all the time and under all circumstances? The Constitution simply states that the party list representatives shall constitute 20% of the total number of representatives including those under the party list. We rule that a simple reading of Section 5, Article VI of the Constitution, easily conveys the equally simple message that Congress was vested with the broad power to define and prescribe the mechanics of the party list system of representation. The Constitution explicitly sets down only the percentage of the total membership in the House of Representatives reserved for party list representatives. In the exercise of its constitutional prerogative, Congress enacted RA 7941. As said earlier, Congress declared therein a policy to promote proportional representation in the election of party list representatives in order to enable Filipinos belonging to the marginalized and underrepresented sectors to contribute legislation that would benefit them. It however deemed it necessary to require parties, organizations and coalitions participating in the system to obtain at least 2% of the total votes cast for the party list system in order to be entitled to a party list seat. Those garnering more than this percentage could have additional seats in proportion to their total number of votes. Furthermore, no winning party, organization or coalition can have more than 3 seats in the House of Representatives. Considering the foregoing statutory requirements, it will be shown that Section 5(2), Article VI of the Constitution is not mandatory. It merely provides a ceiling for party list seats in Congress. Veterans Federation Party vs. Cumlec, GR number 136781, October 6, 2000, and Bank Panganiban. Special elections to fill up vacancy. The law that governs and lays down the details concerning the special congressional elections is Rep. Act No. 6645, December 28, 1987. Under the law, no special election will be called if the vacancy occurs, I, less than 18 months before the next regular election in the case of the Senate, or, 2, less than 1 year before the next regular election in the case of the House. In these cases, we will just have to wait for the next regular election, for practical reasons. When the vacancy occurs during the period when special elections are allowed to be conducted, 18 or 12 months or more before the next regular election, the particular House of Congress must pass either a resolution by the House concerned, if Congress is in session, or a certification by the Senate President or the Speaker of the House, if Congress is not in session, a. declaring the existence of the vacancy and, b. calling for a special election to be held within 45 to 90 days from the date of calling of the special election, that is, from the date of the resolution or certification. But the senator or member of the House thus elected shall serve only for the unexpired portion of the term. Article VI, Section 9. Funds certified by the Cumlec as necessary to defray the expenses for holding regular and special elections, plebiscites, initiatives, referenda, and recalls, shall be provided in the regular or special appropriations and, once approved, shall be released automatically upon certification by the chairman of the Cumlec. Article 9c, Section 11. Salaries. While it is Congress, through a salary law, that determines the salary to be received by its members, the Constitution mandates that no increase in said compensation shall take effect until after the expiration of the full term of all the members of the two houses approving such increase. purpose of the provision, the reason for this rule, the court said, is to place a legal bar to the legislators yielding to the natural temptation to increase their salaries. Not that the power to provide for higher compensation is lacking, but with the length of time that has to elapse before an increase becomes effective, there is a deterrent factor to any such measure unless the need for it is clearly felt. Filconsa vs. Mathey, 18 SCRA 300. Illustration: if a salary law is passed in 1988 increasing the salary of members of Congress, the same law can only take effect for the term that begins at noon of June 30, 1992, but if a salary is passed in 1988 decreasing the salary of members of Congress, the law can take effect right away, since the Constitution prohibits only the increase. If another salary law is passed in 1993 to increase the salary, the same can take effect not in the term beginning at noon of June 30, 1995. The top 12 senators elected on the second Monday of May, 1992 would still be holding office then. It can only take effect in 1998. Effectively, therefore, such law can take effect only after the expiration of the longest term of a senator, which is 6 years, even if the term of the representative who voted for the law is only 3 years. Parliamentary Immunities and Privileges. Section 11, Article Vi, 1987 Constitution. Section 11. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years' imprisonment, be privileged from arrest while the Congress is in session. No member shall be questioned nor be held liable in any other place for any speech or debate in the Congress or in any committee thereof. Freedom from arrest. Elements of the privilege. 1. Congress must be in session, whether regular, Section 15, or special, supra. It does not matter where the member of Congress may be found, attending the session, socializing in a private party, or sleeping at home, so long as Congress is in session, freedom from arrest holds. 2. The crime for which the member is to be arrested is punishable by 6 years of imprisonment or less. Punishable refers to the maximum possible penalty which a penal statute attaches to the offense. It follows too that if the crime is punishable by 6 years and 1 day of prison or more, the member can be arrested, even if he is in session in the halls of Congress. People v. Giles Joes, 324 SCRA 689, February 3, 2000, and Banquiners Santiago. Held. The immunity from arrest or detention of senators and members of the House of Representatives arises from a provision of the Constitution. The history of the provision shows that the privilege has always been granted in a restrictive sense. The provision granting an exemption as a special privilege cannot be extended beyond the ordinary meaning of its terms. It may not be extended by intendment, implication or equitable considerations. The members of Congress cannot compel absent members to attend sessions if the reason for the absence is a legitimate one. The confinement of a congressman charged with a crime punishable by imprisonment of more than 6 years is not merely authorized by law, it has constitutional foundations. Speech and Debate Clause. This privilege protects the member concerned from any libel suit that may be filed against him for a speech made in the halls of Congress or in any of its committees. Speech is not confined to traditional speech but even to the casting of votes, the making of reports, a debate or discussion, even communicative actions, and any other form of expression. The speech, however, must be made in Congress in the discharge of legislative duty. Jimenez v. Kabang, 17 SCRA 876, 1966. Held. Scope of parliamentary freedom of speech and debate. Said expression refers to utterances made by congressmen in the performance of their official functions, such as speeches delivered, statements made, or votes cast in the halls of Congress, while the same is in session, as well as bills introduced in Congress, whether the same is in session or not, and other acts performed by congressmen, either in Congress or outside the premises housing its offices, in the official discharge of their duties as members of Congress and of congressional committees duly authorized to perform its functions as such, at the time of the performance of the acts in question. The provision protects the member of Congress only from being held liable outside of Congress. In any other place, it does not protect him from liability inside Congress, that is, from possible disciplinary measures that his peers may impose upon him. For as mentioned above, his speech may constitute disorderly behavior as in Osmeena v. Pendleton, 109 Phil 863, and this may be penalized with censure, suspension for 60 days, or expulsion, the latter two upon concurrence of 2/3 of the membership. It is important to note that this privilege is not absolute. The rule provides that the legislator may not be questioned in any other place, which means that he may be called to account for his remarks by his own colleagues in Congress itself, and when warranted, punished for disorderly behavior. Thus, in the case of Osmeena v. Pendleton, the president himself who had been vilified by the petitioner could not file any civil or criminal action against him because of this immunity. Nonetheless, the majority of the members of the House of Representatives in which the questioned speech was delivered were not precluded from demonstrating their loyalty to the chief executive by declaring Osmeena guilty of disorderly behavior and suspending him in the exercise of their disciplinary power. Now Article V, Section 16(3). Illustration: if Congressman X makes an oral abuse against Congressman Y in the halls of Congress, he cannot be arrested nor prosecuted for slander because of the speech clause. But he can be punished by his peers for disorderly behavior. But if Congressman X, in the course of heated debate, assaults Congressman Y and inflicts physical injuries, he can be criminally prosecuted for direct assault with grave or less grave physical injuries, because although a verbal assault is immune, a physical assault is not immune. But although he can be prosecuted, he cannot be arrested while Congress is in session, because while he is not immune from prosecution, he is immune from arrest, assuming the penalty does not exceed prison correctional. The court must thus wait for the recess of Congress before it can order his arrest. Q. Does the privilege extend to agents of congressmen or senators? A. Yes, provided that the agency consists precisely in assisting the legislator in the performance of legislative action. Byrne is citing Gravel v. U.S. 90 LW 5053. Disqualifications. Incompatible offices. Article V, Section 13. No senator or member of the House of Representatives may hold any other office or employment in the government, or any subdivision, agency, or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries, during his term without forfeiting his seat. An incompatible office is a post which a member cannot accept unless he waives or forfeits his seat in Congress. A sensu contrario, if he waives or forfeits his seat, he may accept the other post, since the incompatibility arises only because of his simultaneous membership in both. Note: no forfeiture shall take place if the member of Congress holds the other government office in an ex officio capacity, for example membership in the Board of Regents of the Chairman, Committee on Education, in the Senate. Forbidden offices. Article V, Section 13. Neither shall he be appointed to any office which may have been created or the emoluments thereof increased during the term for which he was elected. A forbidden office is one to which a member cannot be appointed even if he is willing to give up his seat in Congress. The effect of his resignation from the Congress is the loss of his seat therein, but his disqualification for the forbidden office nevertheless remains. The prohibition lies in the fiduciary nature of the relationship involved. Such a member cannot resign in anticipation of the passage of the law creating such office or increasing its emolument as a way of circumventing the prohibition. However, the prohibition is not forever, as in the Jones Law. It is for the term for which he was elected. Other prohibitions. I, personally appearing as counsel before any court of justice, the electoral tribunal, quasi-judicial bodies, and other administrative bodies. 2. Being interested financially in any, a, contract with, or, b, franchise or special privilege granted by, the government, its subdivision, agency or instrumentality, a government-owned or controlled corporation, or its subsidiary. The prohibition is for the duration of his term of office. 3. Intervening in any matter before any office of the government for his pecuniary benefit. 4. Intervening in any matter where he may be called upon to act on account of his office. What the Constitution prohibits in the case of members of Congress who are also members of the bar is their personal appearance before any of these bodies. This is not a prohibition against the practice of law in any court. Thus, a member may still sign and file his pleadings, give legal advice, continue as partner, and have a partner or associate appear for him in court. Internal government of Congress. Election of officers. First order of business, election by each House of the President of the Senate and the Speaker of the House, and such other officers that the rules of each House may provide. A majority vote of all the respective members is required to elect these two officers. Upon the election of the President and the Speaker, the Constitution deems the Houses organized. Article Vi, Section 19. Santiago vs. Quinona, 298 SCRA 756, 1998. Held, while the Constitution is explicit on the manner of electing a Senate President and a House Speaker, it is, however, dead silent on the manner of selecting the other officers in both chambers of Congress. All that the Charter says is that each House shall choose such other officers as it may deem necessary. To our mind, the method of choosing who will be such other officers is merely a derivative of the exercise of the prerogative conferred by the aforequoted constitutional provision. Therefore, such method must be prescribed by the Senate itself, not by this court. In this regard, the Constitution vests in each House of Congress the power to determine the rules of its proceedings. Pursuant thereto, the Senate formulated and adopted a set of rules to govern its internal affairs. Pertinent to the instant case are Rules 1 and 2 thereof, which provide. Rule I. Elective officers. Section 1. The Senate shall elect, in the manner hereinafter provided, a President, a President pro tempore, a Secretary, and a Sergeant at Arms. These officers shall take their oath of office before entering into the discharge of their duties. Rule 2. Election of officers. Section 2. The officers of the Senate shall be elected by the majority vote of all its members. Should there be more than one candidate for the same office, a nominal vote shall be taken, otherwise, the election shall be by viva voce or by resolution. Notably, the rules of the Senate do not provide for the positions of majority and minority leaders. Neither is there an open clause providing specifically for such offices and prescribing the manner of creating them or of choosing the holders thereof. At any rate, such offices, by tradition and long practice, are actually extant. But, in the absence of constitutional or statutory guidelines or specific rules, this court is devoid of any basis upon which to determine the legality of the acts of the Senate relative thereto. On grounds of respect for the basic concept of separation of powers, courts may not intervene in the internal affairs of the legislature. It is not within the province of courts to direct Congress how to do its work. Paraphrasing the words of Justice Florentino P. Feliciano, this court is of the opinion that where no specific, operable norms and standards are shown to exist, then the legislature must be given a real and effective opportunity to fashion and promulgate as well as to implement them, before the courts may intervene. Needless to state, legislative rules, unlike statutory laws, do not have the imprints of permanence and obligatoriness during their effectivity. In fact, they are subject to revocation, modification or waiver at the pleasure of the body adopting them. Being merely matters of procedure, their observance are of no concern to the courts, for said rules may be waived or disregarded by the legislative body at will, upon the concurrence of a majority. In view of the foregoing, Congress verily has the power and prerogative to provide for such officers as it may deem. And it is certainly within its own jurisdiction and discretion to prescribe the parameters for the exercise of this prerogative. This court has no authority to interfere and unilaterally intrude into that exclusive realm, without running afoul of constitutional principles that it is bound to protect and uphold, the very duty that justifies the court's being. Constitutional respect and a becoming regard for the sovereign acts of a co-equal branch prevents this court from prying into the internal workings of the Senate. Quorum. The quorum required to conduct business is a majority, half plus one, of all the members. But to pass a law, only the votes of the majority of those present in the session, there being a quorum, are required. This is known as the shifting majority. To illustrate, 13 members of the Senate are sufficient to constitute a quorum. If only 13 members are present, a vote by 7 in favor of a bill is sufficient to pass it. But as the number of those present increases, the number of votes needed to pass a bill would correspondingly increase, that is, shift. When a quorum cannot be had, a smaller number may adjourn from day to day, and compel the attendance of the absent, recalcitrant, members by the means of arrest or such other measures and penalties as the House may provide in its rules. In Avellino v. Cuenco, 83 Phil 17, the ruling then was, the quorum was computed on the number of senators over whom the Senate has jurisdiction at the time of session. Rules of Proceedings. Each House or its committees may determine the rules of its proceedings. These rules include the procedure to be followed in inquiries in aid of legislation. The House may set aside the rules it adopted as it sees fit, because these rules are only of a temporary nature. The rules of the Commission on Appointments concerning its internal business could be reviewed by the courts, that is, it is a justiciable matter, when a certain construction of such rules would defeat the right of the individual to a public office. Payset v. Section of the Commission on Appointments, 40 SCRA 58, 1971. Q. May the SC intervene in the implementation of the rules of either House of Congress? A. On matters affecting only internal operation of the legislature, the legislature's formulation and implementation of its rules is beyond the reach of the courts. When, however, the legislative rule affects private rights, the courts cannot altogether be excluded. Byrne is citing U.S. v. Smith, 286 U.S. 6. Discipline of members. Each House may punish its members for disorderly behavior. What constitutes disorderly behavior is solely within the discretion of the House concerned. Although a member of either House cannot be held accountable in any other place for any speech he make in the Congress or in any committee thereof, he can be found guilty of disorderly behavior by his own peers, so ruled the court in Osmina v. Pendleton. 109 Phil. 863, 1960. The penalty may consist of, I, censure, or upon a 2/3 vote of all the members of the House, 2, suspension, not exceeding 60 days, or, 3, expulsion. Journal and Congressional Records. The journal is only a resume of minutes of what transpired during a legislative session. The record is the word-for-word transcript of the proceedings taken during the session. Probative value of the journal. The journal is conclusive on the courts as to its contents, so the SC ruled in U.S. v. Pons, 34 Phil. 729, 1916. Pons, in this case was prosecuted under a criminal statute. He contended, however, that the statute was passed past the midnight after February 28, 1914, the last day of session of the legislative body, but that the members stopped the clock at midnight, to pass the law. The SC rejected this claim, ruling that the probative value of the journal could not be questioned, otherwise proof of legislative action would be uncertain and would now have to depend on the imperfect memory of men. Matters required to be entered in the journal. The Constitution requires that the following matters be contained in the journal. A. The yeas and nays on third and final reading of a bill. Article Vi, Section 26(2). B. Veto message of the President, that is, his objection to a bill when he vetoes it. Article Vi, Section 27(1). C. The yeas and nays on the repassing of a bill vetoed by the President. Article Vi, Section 27(1). D. The yeas and nays on any question at the request of 1/5 of the members present. Article Vi, Section 16(4). In addition, the journal contains the summary of the proceedings. A record, on the other hand, contains the verbatim transcript of all proceedings of the House or its committees. The Constitution is silent as to what the record must contain. However, in Article 11, Section 3(3), The Constitution speaks of the vote of each member of the House either affirming a favorable or overriding its contrary resolution of the impeachment complaint to be recorded. Arroyo v. de Venecia, 277 SCRA 268, August 14, 1997. Mendoza held, the journal is regarded as conclusive with respect to matters that are required by the Constitution to be recorded therein. With respect to other matters, in the absence of evidence to the contrary, the journals have also been accorded conclusive effects. Thus, in United States v. Pons, 34 Phil. 729, 735 1916, quoting Ex-Rel. Herron v. Smith, 44 Ohio 348 1886, this court spoke of the imperatives of public policy for regarding the journals as public memorials of the most permanent character. Thus, they should be public, because all are required to conform to them. They should be permanent, that rights acquired today upon the faith of what has been declared to be law shall not be destroyed tomorrow, or at some remote period of time, by facts resting only in the memory of individuals. Journal Entry Rule vs. Enrolled Bill Theory. As to matters required by the Constitution to be placed in the journal is conclusive. But aside from these four matters, any other matter does not enjoy such conclusiveness. The Enrolled Bill Doctrine. Once a bill has been approved by both houses, the bill is engrossed or enrolled, and this enrolled copy of the bill bears the certification of the presiding officer of the House, either Senate President or Speaker of the House, that this bill is enrolled is the version passed by each House. The purpose of the certification is to prevent attempts at smuggling in riders. The enrolled copy is then sent to the President for his action. Sessions. Regular Sessions. Article Vi. Section 15. The Congress shall convene once every year on the fourth Monday of July for its regular session, unless a different date is fixed by law, and shall continue to be in session for such number of days as it may determine, until 30 days before the opening of its next regular session, exclusive of Saturdays, Sundays and legal holidays. Section 16(5) Neither House during the session of the Congress shall, without the consent of the other House, adjourn for more than 3 days, nor to any other place than that in which the two houses shall be sitting. Place as here used refers not to the building but to the political unit where the two houses may be sitting. Special Sessions. Special sessions are held in the following instances. A. When the President calls for a special session at any time, Article Vi, Section 15. B. To call a special election due to a vacancy in the offices of President and Vice President, Article 7, Section 10, in which Congress shall convene at 10 a.m. of the third day after the vacancy, without need of a call. C. To decide on the disability of the President because the Cabinet, majority, has disputed his assertion that he is able to dispose his duties and powers. This takes place not when the Cabinet first sends a written declaration about the inability of the President, but after the President has disputed this initial declaration, Article 7, Section 11. Congress shall convene, if it is not in session, within 48 hours, without need of call. D. To revoke or extend the presidential proclamation of martial law or suspension of the writ of habeas corpus, Article 7, Section 18. Congress, if not in session, shall, within 24 hours following such proclamation or suspension, convene, without need of a call. In the last three cases, Congress convenes without need of a call. These are exceptions to the general rule in the first case that when Congress is not in session, it can only meet in special session called by the President. Joint Session. When both houses meet jointly, they generally vote separately. The reason is obvious: there are only 24 senators, while there are at least 250 representatives. It would be bad policy to give one vote to a senator, who is elected at large, and the same weight of vote to a representative, who is either elected only by one legislative district or a party list. Joint session and separate voting take place in the following instances. A. Voting separately. A. When Congress, while acting as the canvasser of votes for the President and Vice President, has to break the tie between two or more candidates for either position having an equal and the highest number of votes, Article 7, Section 4, Paragraph 5. b. When it decides, by two-thirds vote, on the question of the President's inability to discharge the powers and duties of his office, Article 7, Section 11, Paragraph 4. c. Whenever there is a vacancy in the office of the VP, when it confirms the nomination of a VP by the President from among the members of Congress, such person shall assume office upon confirmation by a majority vote of all the members of both houses, voting separately, Article 7, Section 9. d. When it declares, by two-thirds vote, the existence of a state of war, Article Vi, Sec. 23(1). e. When it proposes to amend the Constitution, three-fourths vote of the members, Article 17, Section 1(1). b. Voting jointly. There is one exceptional instance when the two houses meet and vote jointly, when there has been a proclamation of martial law or a suspension of the writ by the President, and Congress has to decide whether to revoke or to extend such proclamation or suspension. Majority vote of all members, voting jointly, Article 7, Section 18. The Electoral Tribunals. Section 17, Article Vi, 1987 Constitution. Section 17. The Senate and the House of Representatives shall each have an electoral tribunal which shall be the sole judge of all contests relating to the election, returns, and qualifications of their respective members. Each electoral tribunal shall be composed of 9 members, 3 of whom shall be justices of the Supreme Court to be designated by the Chief Justice, and the remaining 6 shall be members of the Senate or the House of Representatives, as the case may be, who shall be chosen on the basis of proportional representation from the political parties and the parties or organizations registered under the party list system represented therein. The senior justice in the electoral tribunal shall be its chairman. Pimentel v. Ret. 393 SCRA 227, 2002. Held, the Constitution expressly grants to the House of Representatives the prerogative, within constitutionally defined limits, to choose from among its district and party list representatives those who may occupy the seats allotted to the House in the Ret and the CA. Section 18. Article Vi of the Constitution explicitly confers on the Senate and on the House the authority to elect among their members those who would fill the 12 seats for senators and 12 seats for House members in the Commission on Appointments. Under Section 17, Article Vi of the Constitution, each chamber of Congress exercises the power to choose, within constitutionally defined limits, who among their members would occupy the allotted 6 seats of each chamber's respective electoral tribunal. Thus, even assuming that party list representatives comprise a sufficient number and have agreed to designate common nominees to the Ret and the CA, their primary recourse clearly rests with the House of Representatives and not with this court. Under Sections 17 and 18, Article Vi of the Constitution, party list representatives must first show to the House that they possess the required numerical strength to be entitled to seats in the Ret and the CA. Only if the House fails to comply with the directive of the Constitution on proportional representation of political parties in the Ret and the CA can the party list representative seek recourse to this court under its power of judicial review. Under the doctrine of primary jurisdiction, prior recourse to the House is necessary before petitioners may bring the instant case to the court. Consequently, petitioners' direct recourse to this court is premature. The discretion of the House to choose its members to the Ret and the CA is not absolute, being subject to the mandatory constitutional rule on proportional representation. However, under the doctrine of separation of powers, the court may not interfere with the exercise by the House of this constitutionally mandated duty, absent a clear violation of the Constitution or grave abuse of discretion amounting to lack or excessive jurisdiction. Otherwise, the doctrine of separation of powers calls for each branch of government to be left alone to discharge its duties as it sees fit. Neither can the court speculate on what action the House may take if party list representatives are duly nominated for membership in the Ret and the CA. Request of Justices Melenchon Herrera, Cruz and Feliciano to be relieved as members of the Ret, Res. March 19, 1991. In said request, the 3 justices asked to be relieved from membership in the threat. According to them, political factors which have nothing to do with the merits of the case, were blocking the accomplishment of their constitutionally mandated task. They therefore suggested that there should be a provision in the Constitution that upon designation to membership in the Electoral Tribunal, those so designated should divest themselves of affiliation with their respective political parties, to ensure their independence and objectivity as they sit in tribunal deliberations. The SC resolved to direct them to return to their duties in the tribunal. According to the court, in view of the sensitive constitutional functions of the electoral tribunals as the sole judge of all contests relating to the election, returns and qualifications of the members of Congress, all members of these bodies should be guided only by purely legal considerations in the decision of the cases before them, and that in the contemplation of the Constitution, the members legislators, thereof, upon assumption of their duties therein, sit in the tribunal no longer as representatives of their respective political parties but as impartial judges. To further bolster the independence of the tribunals, the term of office of every member thereof should be considered coextensive with the corresponding legislative term and may not be legally terminated except only by death, resignation, permanent disability, or removal for a valid cause, not including political disloyalty. As judges, the members of the House Electoral Tribunal must be non-partisan. They must discharge their functions with complete detachment, impartiality, and independence, even independence from the political party to which they belong. Hence, disloyalty to party and breach of party discipline are not valid grounds for the expulsion of a member of the tribunal. Bondoc v. Pineda Gr. No. 97710. September 26, 1991. Status. In Angara v. Electoral Commission, the SC held that the then Electoral Commission was an independent body, although attached to Congress. In Swears v. Chief Accountant, the Commission on Audit, then under the 1935 Constitution, as adjunct of Congress, was ruled to be an independent body, although attached to Congress, and so the salary of its staffers need not be the same as those of the Senate. Independence of the electoral tribunals. Although the electoral tribunals are predominantly legislative in membership and the provision creating them is found in Article Virgin Islands on the Legislative Department, it is not correct to say that they are mere adjuncts of the Congress of the Philippines. In fact, in the discharge of their constitutional duties, they are independent of the legislature, and also of the other departments for that matter. Organization, Article VI, Section 19. The Electoral Tribunal shall be constituted within 30 days after the 2 houses shall have been organized with the election of the President and the Speaker. Functions, id. Section 17. The Senate and the House of Representatives shall each have an electoral tribunal which shall be the sole judge of all contests relating to the I. Election, 2. Returns, and 3. Qualifications of their respective members. Under Section 17 of Article V of the 1987 Constitution, the Senate and the House of Representatives shall have an electoral tribunal which shall be the sole judge of all contests relating to the election, returns and qualifications of their respective members. The electoral tribunal clearly assumes jurisdiction over all contests relative to the election, returns and qualifications of candidates for either the Senate or the House only when the latter become members of either the Senate or the House of Representatives. A candidate who has not been proclaimed and who has not taken his oath of office cannot be said to be a member of the House of Representatives subject to Section 17 of Article V of the Constitution. While the proclamation of a winning candidate in an election is ministerial, BP 881 in conjunction with Section 6 of RA. 6646 allows suspension of proclamation under circumstances mentioned therein. Thus, petitioner's contention that after the conduct of the election and, petitioner, has been established the winner of the electoral exercise from the moment of election, the Comlec is automatically divested of authority to pass upon the question of qualification finds no basis in law, because even after the elections the Comlec is empowered by Section 6, in relation to Section 7, of RA 6646 to continue to hear and decide questions relating to qualifications of candidates. Aquino v. Comlec, 248 SCRA 400, September 18, 1995, and Bankapunan. As to the House of Representatives Electoral Tribunal's supposed assumption of jurisdiction over the issue of petitioners' qualifications after the May 8, 1995 elections, suffice it to say that RET's jurisdiction as the sole judge of all contests relating to the elections, returns and qualifications of members of Congress begins only after a candidate has become a member of the House of Representatives. Petitioner not being a member of the House of Representatives, it is obvious that the RET at this point has no jurisdiction over the question. Romualdez Marcos vs. Cumlec, 248 SCRA 300. While the Cumlec is vested with the power to declare valid or invalid a certificate of candidacy, its refusal to exercise that power following the proclamation and assumption of the position by Farinas is a recognition of the jurisdictional boundaries separating the Cumlec and the Electoral Tribunal of the House of Representatives, HRET. Under Article V, Section 17 of the Constitution, the RET has sole and exclusive jurisdiction over all contests relative to the election, returns, and qualifications of members of the House of Representatives. Thus, once a winning candidate has been proclaimed, taken his oath, and assumed office as a member of the House of Representatives, Cumlec's jurisdiction over election contests relating to his election, returns, and qualifications ends, and the RET's own jurisdiction begins. Thus, the Cumlec's decision to discontinue exercising jurisdiction over the case is justifiable, in deference to the RET's own jurisdiction and functions. Guerrero vs. Cumlec, 336 SCRA 458. Lebanon vs. RET, 283 SCRA 520, December 22, 1997. Vitug, no appeal from decisions of the Electoral Tribunal. The Constitution mandates that the House of Representatives Electoral Tribunal and the Senate Electoral Tribunal shall each, respectively, be the sole judge of all contests relating to the election, returns and qualifications of their respective members. The court has stressed that so long as the Constitution grants the RET the power to be the sole judge of all contests relating to the election, returns and qualifications of members of the House of Representatives, any final action taken by the RET on a matter within its jurisdiction shall, as a rule, not be reviewed by this court. The power granted to the Electoral Tribunal excludes the exercise of any authority on the part of this court that would in any wise restrict it or curtail it or even affect the same. The court did recognize, of course, its power of judicial review in exceptional cases. In Robles vs. RET, 181 SCRA 780, the court has explained that while the judgments of the tribunal are beyond judicial interference, the court may do so, however, but only in the exercise of this court's so-called extraordinary jurisdiction upon a determination that the tribunal's decision or resolution was rendered without or in excess of its jurisdiction, or with grave abuse of discretion, or paraphrasing Morero vs. Spokart 66 Phil. 429, upon a clear showing of such arbitrary and improvident use by the tribunal of its power as constitutes a denial of due process of law, or upon a demonstration of a very clear unmitigated error, manifestly constituting such grave abuse of discretion that there has to be a remedy for such abuse. The court does not venture into the perilous area of correcting perceived errors of independent branches of the government. It comes in only when it has to vindicate a denial of due process or correct an abuse of discretion so grave or glaring that no less than the Constitution itself calls for remedial action. The Commission on Appointments. Section 18 and 19, Article V, 1987 Constitution. Section 18. There shall be a Commission on Appointments consisting of the President of the Senate, as ex officio chairman, 12 senators, and 12 members of the House of Representatives, elected by each House on the basis of proportional representation from the political parties or organizations registered under the party list system represented therein. The chairman of the Commission shall not vote, except in case of a tie. The Commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The Commission shall rule by a majority vote of all the members. Section 19. The electoral tribunals and the Commission on Appointments shall be constituted within 30 days after the Senate and the House of Representatives shall have been organized with the election of the President and a Speaker. The Commission on Appointments shall meet only while the Congress is in session, at the call of its chairman or a majority of all its members, to discharge such powers and functions as are herein conferred upon it. The provision of Section 18 on proportional representation is mandatory in character and does not leave any discretion to the majority party in the Senate to disobey or disregard the rule on proportional representation. Otherwise, the party with a majority representation in the Senate or the House of Representatives can by sheer force of numbers impose its will on the hapless minority. By requiring a proportional representation in the Commission on Appointments, Section 18 in effect works as a check on the majority party in the Senate and helps to maintain the balance of power. No party can claim more than what it is entitled to under such rule. To allow it to elect more than its proportional share of members is to confer upon such a party a greater share in the membership in the Commission on Appointments and more power to impose its will on the minority, who by the same token, suffers a diminution of its rightful membership in the Commission. No party can claim more than what it is entitled to under such rule. Section 18 also ensures representation in the CA of any political party who succeeds in electing members to the Senate, provided that the number of senators so elected enables it to put a representative in the CA. Therefore, in the Senate, a political party must at least have 2 duly elected senators for every seat in the CA. Gingona v. Gonzalez Gr. No. 106971. October 20, 1992. Function, Article 7, Section 16. The Commission shall confirm or approve nominations made by the President of certain public officers named by the Constitution or by law. 1. Heads of the executive departments. 2. Ambassadors, other public ministers, and consuls. 3. Officers of the armed forces from the rank of colonel or naval captain. 4. Other officers whose appointments are vested in him in this Constitution. A. Chairman and members of 3 constitutional commissions. B. Regular members of the Judicial and Bar Council. C. Members of the Regional Consultative Council. Sessions and Procedure, Section 18 and 19. The Commission on Appointments shall meet to discharge its powers and functions only while the Congress is in session. The meeting may be called by A. the chairman, or B. a majority of all its members. The chairman of the Commission does not vote, except to break a tie. The Commission shall act on all appointments submitted to it within 30 session days of the Congress from their submission. The Commission rules by a majority vote of all its members. Inquiry in aid of legislation, legislative investigations. Section 21, Article Vi, 1987 Constitution. Section 21. The Senate or the House of Representatives or any of its respective committees may conduct inquiries in aid of legislation in accordance with its duly published rules of procedure. The rights of persons appearing in or affected by such inquiries shall be respected. The power of Congress to conduct investigations exists for the primary purpose of enabling it to discharge its legislative functions wisely and effectively to guide and aid Congress in the enactment of laws, their amendments and as well as their repeal. Each House or any of its committees may conduct inquiries in aid of legislation according to its duly published rules of procedures. Legislative investigations are carried out in order to ascertain a. What new legislation is needed, b. The existing law to be repealed and c. Whether a new legislation is effectively accomplishing its purpose with a view of amending it. But in addition to obtaining facts that may be useful in enacting laws, the power of inquiry may be utilized by Congress for the scrutiny of executive action as well as the formation of public opinion. Congressional investigations have the salutary effect of keeping the public informed of what is happening in their government since congressional investigations are given wide publicity by media. To enforce this right, the SC upheld the power of Congress to hold in contempt a person required to appear before Congress or its committee and answer questions relevant to a matter of legislative interest in the Arno cases. Senate of the Phil. Versus Ermita, GR number 169777, April 20, 2006. The power of inquiry. Held, the power of inquiry, with process to enforce it, is an essential and appropriate auxiliary to the legislative function. A legislative body cannot legislate wisely or effectively in the absence of information respecting the conditions which the legislation is intended to affect or change, and where the legislative body does not itself possess the requisite information, which is not infrequently true, recourse must be had to others who do possess it. Experience has shown that mere requests for such information are often unavailing, and also that information which is volunteered is not always accurate or complete, so some means of compulsion is essential to obtain what is needed. That this power of inquiry is broad enough to cover officials of the executive branch may be deduced from the same case. The power of inquiry, the court therein ruled, is coextensive with the power to legislate. The matters which may be a proper subject of legislation and those which may be a proper subject of investigation are one. It follows that the operation of government, being a legitimate subject for legislation, is a proper subject for investigation. Section 21, Article V likewise establishes crucial safeguards that prescribe the legislative power of inquiry. The provision requires that the inquiry be done in accordance with the Senate or House's duly published rules of procedure, necessarily implying the constitutional infirmity of an inquiry conducted without duly published rules of procedure. Section 21 also mandates that the rights of persons appearing in or affected by such inquiries be respected, an imposition that obligates Congress to adhere to the guarantees in the Bill of Rights. These abuses are, of course, remediable before the courts, upon the proper suit filed by the persons affected, even if they belong to the executive branch. Nonetheless, there may be exceptional circumstances, none appearing to obtain at present, wherein a clear pattern of abuse of the legislative power of inquiry might be established, resulting in palpable violations of the rights guaranteed to members of the executive department under the Bill of Rights. In such instances, depending on the particulars of each case, attempts by the executive branch to forestall these abuses may be accorded judicial sanction. Even where the inquiry is in aid of legislation, there are still recognized exemptions to the power of inquiry, which exemptions fall under the rubric of executive privilege. Executive privilege. Schwartz defines executive privilege as the power of the government to withhold information from the public, the courts, and the Congress. Similarly, Rosell defines it as the right of the President and high-level executive branch officers to withhold information from Congress, the courts, and ultimately the public. Executive privilege is, nonetheless, not a clear or unitary concept. It has encompassed claims of varying kinds. Tribe, in fact, comments that while it is customary to employ the phrase executive privilege, it may be more accurate to speak of executive privileges since presidential refusals to furnish information may be actuated by any of at least three distinct kinds of considerations, and may be asserted, with differing degrees of success, in the context of either judicial or legislative investigations. One variety of the privilege, Tribe explains, is the state secrets privilege invoked by U.S. presidents, beginning with Washington, on the ground that the information is of such nature that its disclosure would subvert crucial military or diplomatic objectives. Another variety is the informer's privilege, or the privilege of the government not to disclose the identity of persons who furnish information of violations of law to officers charged with the enforcement of that law. Finally, a generic privilege for internal deliberations has been said to attach to intragovernmental documents reflecting advisory opinions, recommendations and deliberations comprising part of a process by which governmental decisions and policies are formulated. That a type of information is recognized as privileged does not, however, necessarily mean that it would be considered privileged in all instances. For in determining the validity of a claim of privilege, the question that must be asked is not only whether the requested information falls within one of the traditional privileges, but also whether that privilege should be honored in a given procedural setting. In this jurisdiction, the doctrine of executive privilege was recognized by this court in Almonte v. Vasquez. Almonte used the term in reference to the same privilege subject of Nixon. It quoted the following portion of the Nixon decision which explains the basis for the privilege. The expectation of a president to the confidentiality of his conversations and correspondences, like the claim of confidentiality of judicial deliberations, for example, has all the values to which we accord deference for the privacy of all citizens and, added to those values, is the necessity for protection of the public interest in candid, objective, and even blunt or harsh opinions in presidential decision-making. A president and those who assist him must be free to explore alternatives in the process of shaping policies and making decisions, and to do so in a way many would be unwilling to express except privately. These are the considerations justifying a presumptive privilege for presidential communications. The privilege is fundamental to the operation of government and inextricably rooted in the separation of powers under the Constitution. Arno vs. Nazarno Gr. L. 3820. July 18, 1950. Legislative contempt. Held, no person can be punished for contumacy as a witness before either house unless his testimony is required in a matter into which that house has jurisdiction to inquire. Once an inquiry is admitted or established to be within the jurisdiction of a legislative body to make, the investigating committee has the power to require a witness to answer any question pertinent to the subject of the inquiry, subject of the course to his constitutional privilege against self-incrimination. The materiality of a question that it may be propounded to a witness is determined by its direct relation to the subject of the inquiry and not by its indirect relation to any proposed or possible legislation. Authority of either House of Congress to commit a witness for contempt. Beyond period of legislative session. There is no sound reason to limit the power of the legislative body to punish for contempt to the end of every session and not to the end of the last session terminating the existence of that body. While the existence of the House of Representatives is limited to 4 years, that of the Senate is not so limited. The Senate is a continuing body which does not cease to exist upon the periodical dissolution of the Congress or of the House of Representatives. There is no limit as to time to the Senate's power to punish for contempt in cases where that power may constitutionally be exerted. Norejo v. Sang. Panlunzado Dumagat, 155 SCRA 421, 1987. Held, a line should be drawn between the powers of Congress as the repository of the legislative power under the Constitution, and those that may be exercised by the legislative bodies of local government unit. For example the Sangguniang Panlungsod of Dumagat which, as mere creatures of law, possess delegated legislative power. The exercise by the legislature of the contempt power is a matter of self-preservation as that branch of the government vested with the legislative power, independently of the judicial branch, asserts its authority and punishes contempts thereof. The contempt power of the legislature is, therefore, sui generis, and local legislative bodies cannot correctly claim to possess it for the same reasons that the national legislature does. The power attaches not to the discharge of legislative functions per se but to the character of the legislature as one of the 3 independent and coordinate branches of government. The same thing cannot be said of local legislative bodies which are creations of law. However, the rights of the persons, a, appearing in, or, b, affected by such inquiries shall be respected. Notable among these rights is the right against self-incrimination. Usually, immunity is granted to those who are compelled to appear. Bengzon v. Senate Blue Ribbon Committee, 203 SCRA 767, 1991. Held, the power of both houses of Congress to conduct inquiries in aid of legislation is not, therefore, absolute or unlimited. Its exercise is circumscribed by the aforequoted provision of the Constitution. Thus, as provided therein, the investigation must be in aid of legislation in accordance with its duly published rules of procedure and that the rights of persons appearing in or affected by such inquiries shall be respected. It follows then that the rights of persons under the Bill of Rights must be respected, including the right to due process and the right not to be compelled to testify against oneself. The power to conduct formal inquiries or investigations is specifically provided for in Section 1 of the Senate Rules of Procedure governing inquiries in aid of legislation. Such inquiries may refer to the implementation or re-examination of any law or in connection with any proposed legislation or the formulation of future legislation. They may also extend to any and all matters vested by the Constitution in Congress and/or in the Senate alone. As held in Ginellas-Nault v. Leon Nazareno, et al., the inquiry, to be within the jurisdiction of the legislative body making it, must be material or necessary to the exercise of a power in it vested by the Constitution, such as to legislate or to expel a member. Under Section 4 of the aforementioned rules, the Senate may refer to any committee or committees any speech or resolution filed by any senator which in its judgment requires an appropriate inquiry in aid of legislation. In order therefore to ascertain the character or nature of an inquiry, resort must be had to the speech or resolution under which such an inquiry is proposed to be made. The critical element is the existence of, and the weight to be ascribed to, the interest of the Congress in demanding disclosures from an unwilling witness. We cannot simply assume, however, that every congressional investigation is justified by a public need that overbalances any private rights affected. To do so would be to abdicate the responsibility placed by the Constitution upon the judiciary to ensure that the Congress does not unjustifiably encroach upon an individual's right to privacy nor abridge his liberty of speech, press, religion or assembly. Question Hour. Article Vi, Section 22. The heads of departments may upon their own initiative with the consent of the President, or upon the request of either House, as the rules of each House shall provide, appear before and be heard by such House on any matter pertaining to their departments. Written questions shall be submitted to the President of the Senate or the Speaker of the House of Representatives at least 3 days before their scheduled appearance. Interpellations shall not be limited to written questions, but may cover matters related thereto. When the security of the state or the public interest so requires and the President so states in writing, the appearance shall be conducted in executive session. Senate of the Philippines v. Ermita, Gr. No. 169777, April 20, 2006. Held, a distinction was thus made between inquiries in aid of legislation and the question hour. While attendance was meant to be discretionary in the question hour, it was compulsory in inquiries in aid of legislation. Sections 21 and 22, therefore, while closely related and complementary to each other, should not be considered as pertaining to the same power of Congress. One specifically relates to the power to conduct inquiries in aid of legislation, the aim of which is to elicit information that may be used for legislation, while the other pertains to the power to conduct a question hour, the objective of which is to obtain information in pursuit of Congress oversight function. When Congress merely seeks to be informed on how department heads are implementing the statutes which it has issued, its right to such information is not as imperative as that of the President to whom, as chief executive, such department heads must give a report of their performance as a matter of duty. In such instances, Section 22, in keeping with the separation of powers, states that Congress may only request their appearance. Nonetheless, when the inquiry in which Congress requires their appearance is in aid of legislation under Section 21, the appearance is mandatory for the same reasons stated in Arno. In fine, the oversight function of Congress may be facilitated by compulsory process only to the extent that it is performed in pursuit of legislation. This is consistent with the intent discerned from the deliberations of the Constitutional Commission. Ultimately, the power of Congress to compel the appearance of executive officials under Section 21 and the lack of it under Section 22 find their basis in the principle of separation of powers. While the executive branch is a co-equal branch of the legislature, it cannot frustrate the power of Congress to legislate by refusing to comply with its demands for information. When Congress exercises its power of inquiry, the only way for department heads to exempt themselves therefrom is by a valid claim of privilege. They are not exempt by the mere fact that they are department heads. Only one executive official may be exempted from this power, the President on whom executive power is vested, hence, beyond the reach of Congress except through the power of impeachment. It is based on her being the highest official of the executive branch, and the due respect accorded to a co-equal branch of government which is sanctioned by a long-standing custom. By the same token, Members of the Supreme Court are also exempt from this power of inquiry. Unlike the presidency, judicial power is vested in a collegial body, hence, each member thereof is exempt on the basis not only of separation of powers but also on the fiscal autonomy and the constitutional independence of the judiciary. Executive privilege. While there is no Philippine case that directly addresses the issue of whether executive privilege may be invoked against Congress, it is gathered from Chavez v. P. that certain information in the possession of the executive may validly be claimed as privileged even against Congress. Thus, the case holds. There is no claim by P that the information demanded by petitioner is privileged information rooted in the separation of powers. The information does not cover presidential conversations, correspondences, or discussions during closed-door cabinet meetings which, like internal deliberations of the Supreme Court and other collegiate courts, or executive sessions of either House of Congress, are recognized as confidential. This kind of information cannot be pried open by a co-equal branch of government. A frank exchange of exploratory ideas and assessments, free from the glare of publicity and pressure by interested parties, is essential to protect the independence of decision-making of those tasked to exercise presidential, legislative and judicial power. This is not the situation in the instant case. Section 3 of EO 464, therefore, cannot be dismissed outright as invalid by the mere fact that it sanctions claims of executive privilege. This court must look further and assess the claim of privilege authorized by the order to determine whether it is valid. While the validity of claims of privilege must be assessed on a case-to-case basis, examining the ground invoked therefore and the particular circumstances surrounding it, there is, in an implied claim of privilege, a defect that renders it invalid per se. By its very nature, and as demonstrated by the letter of Respondent Executive Secretary quoted above, the implied claim authorized by Section 3 of EO 464 is not accompanied by any specific allegation of the basis thereof, for example, whether the information demanded involves military or diplomatic secrets, closed-door cabinet meetings, etc. While Section 2A enumerates the types of information that are covered by the privilege under the challenged order, Congress is left to speculate as to which among them is being referred to by the executive. The enumeration is not even intended to be comprehensive, but a mere statement of what is included in the phrase confidential or classified information between the President and the public officers covered by this executive order. Certainly, Congress has the right to know why the executive considers the requested information privileged. It does not suffice to merely declare that the President, or an authorized head of office, has determined that it is so, and that the President has not overturned that determination. Such declaration leaves Congress in the dark on how the requested information could be classified as privileged. That the message is couched in terms that, on first impression, do not seem like a claim of privilege only makes it more pernicious. It threatens to make Congress doubly blind to the question of why the executive branch is not providing it with the information that it has requested. A claim of privilege, being a claim of exemption from an obligation to disclose information, must, therefore, be clearly asserted. Absent then a statement of the specific basis of a claim of executive privilege, there is no way of determining whether it falls under one of the traditional privileges, or whether, given the circumstances in which it is made, it should be respected. Due respect for a co-equal branch of government, moreover, demands no less than a claim of privilege clearly stating the grounds therefor. Upon the other hand, Congress must not require the executive to state the reasons for the claim with such particularity as to compel disclosure of the information which the privilege is meant to protect. A useful analogy in determining the requisite degree of particularity would be the privilege against self-incrimination. The claim of privilege under Section 3 of EO 464 in relation to Section 2B is thus invalid per se. It is not asserted. It is merely implied. Instead of providing precise and certain reasons for the claim, it merely invokes EO 464, coupled with an announcement that the President has not given her consent. It is woefully insufficient for Congress to determine whether the withholding of information is justified under the circumstances of each case. It severely frustrates the power of inquiry of Congress. In fine, Section 3 and Section 2b of EO 464 must be invalidated. Executive privilege, as already discussed, is recognized with respect to information the confidential nature of which is crucial to the fulfillment of the unique role and responsibilities of the executive branch, or in those instances where exemption from disclosure is necessary to the discharge of highly important executive responsibilities. The doctrine of executive privilege is thus premised on the fact that certain informations must, as a matter of necessity, be kept confidential in pursuit of the public interest. The privilege being, by definition, an exemption from the obligation to disclose information, in this case to Congress, the necessity must be of such high degree as to outweigh the public interest in enforcing that obligation in a particular case. In light of this highly exceptional nature of the privilege, the court finds it essential to limit to the President the power to invoke the privilege. She may of course authorize the Executive Secretary to invoke the privilege on her behalf, in which case the Executive Secretary must state that the authority is by order of the President, which means that he personally consulted with her. The privilege being an extraordinary power, it must be wielded only by the highest official in the executive hierarchy. In other words, the President may not authorize her subordinates to exercise such power. There is even less reason to uphold such authorization in the instant case where the authorization is not explicit but by mere silence. Section 3, in relation to Section 2b, is further invalid on this score. It follows, therefore, that when an official is being summoned by Congress on a matter which, in his own judgment, might be covered by executive privilege, he must be afforded reasonable time to inform the President or the Executive Secretary of the possible need for invoking the privilege. This is necessary in order to provide the President or the Executive Secretary with fair opportunity to consider whether the matter indeed calls for a claim of executive privilege. If, after the lapse of that reasonable time, neither the President nor the Executive Secretary invokes the privilege, Congress is no longer bound to respect the failure of the official to appear before Congress and may then opt to avail of the necessary legal means to compel his appearance. Right to information. E.O. 464 is concerned only with the demands of Congress for the appearance of executive officials in the hearings conducted by it, and not with the demands of citizens for information pursuant to their right to information on matters of public concern. Petitioners are not amiss in claiming, however, that what is involved in the present controversy is not merely the legislative power of inquiry, but the right of the people to information. There are, it bears noting, clear distinctions between the right of Congress to information which underlies the power of inquiry and the right of the people to information on matters of public concern. For one, the demand of a citizen for the production of documents pursuant to his right to information does not have the same obligatory force as a subpoena duces tecum issued by Congress. Neither does the right to information grant a citizen the power to exact testimony from government officials. These powers belong only to Congress and not to an individual citizen. Thus, while Congress is composed of representatives elected by the people, it does not follow, except in a highly qualified sense, that in every exercise of its power of inquiry, the people are exercising their right to information. To the extent that investigations in aid of legislation are generally conducted in public, however, any executive issuance tending to unduly limit disclosures of information in such investigations necessarily deprives the people of information which, being presumed to be in aid of legislation, is presumed to be a matter of public concern. The citizens are thereby denied access to information which they can use in formulating their own opinions on the matter before Congress, opinions which they can then communicate to their representatives and other government officials through the various legal means allowed by their freedom of expression. Thus holds Valmonte v. Belmonte. It is in the interest of the state that the channels for free political discussion be maintained to the end that the government may perceive and be responsive to the people's will. Yet, this open dialogue can be effective only to the extent that the citizenry is informed and thus able to formulate its will intelligently. Only when the participants in the discussion are aware of the issues and have access to information relating thereto can such bear fruit. The impairment of the right of the people to information as a consequence of EO 464 is, therefore, in the sense explained above, just as direct as its violation of the legislature's power of inquiry. Conclusion. Congress undoubtedly has a right to information from the executive branch whenever it is sought in aid of legislation. If the executive branch withholds such information on the ground that it is privileged, it must so assert it and state the reason therefor and why it must be respected. The infirm provisions of EO 464, however, allow the executive branch to evade congressional requests for information without need of clearly asserting a right to do so and or proffering its reasons therefor. By the mere expedient of invoking said provisions, the power of Congress to conduct inquiries in aid of legislation is frustrated. That is impermissible. 4. What Republican theory did accomplish. Was to reverse the old presumption in favor of secrecy, based on the divine right of kings and nobles, and replace it with a presumption in favor of publicity, based on the doctrine of popular sovereignty. Resort to any means then by which officials of the executive branch could refuse to divulge information cannot be presumed valid. Otherwise, we shall not have merely nullified the power of our legislature to inquire into the operations of government, but we shall have given up something of much greater value, our right as a people to take part in government. Question hour, Article Vi, Section 22, and Legislative Investigation, id., Section 21. A. As to persons who may appear. 22. Only a department head. 21. Any person. B. As to who conducts the investigation. 22. Entire body. 21. Committees. C. As to subject matter. 22. Matters related to the department only. 21. Any matter for the purpose of legislation. Act as Board of Canvassers for presidential and vice presidential elections. Article 7, Section 4. The returns of every election for president and vice president, duly certified by the Board of Canvassers of each province or city, shall be transmitted to the Congress, directed to the President of the Senate. Upon receipt of the certificates of canvass, the President of the Senate shall, not later than 30 days after the day of election, WC is the second Tuesday of June, open all the certificates in the presence of the Senate and House of Representatives in joint public session, and the Congress, upon determination of the authenticity and due execution thereof in the manner provided by law, canvass, that is, tally the certificates of canvass, the votes. The persons having the highest number of votes shall be proclaimed elected. But in case two or more shall have an equal and highest number of votes, tie, one of them shall forthwith be chosen by the vote of a majority of all the members of Congress, voting separately. The Congress shall promulgate its rules for the canvassing of the certificates. Power of impeachment. The following are subject to impeachment. Article 11, Section 2. A. President. B. Vice President. C. Justices of the Supreme Court. D. Members of the Constitutional Commissions. E. Ombudsman. Grounds for impeachment. Article 11, Section 2. A. Culpable violation of the Constitution. B. Treason, RPC. C. Bribery, RA 3019. D. Graft and corruption, RA 3019. E. Other high crimes. F. Betrayal of public trust. Limitation: no impeachment proceeding shall be initiated against the same official more than once within a period of 1 year. Article 11, Section 3(5). 4. The House of Representatives shall have the exclusive power to initiate all cases of impeachment. Article 11, Section 3(1). Procedure for impeachment. Article 11, Section 3. A. Initiation stage. 1. If initiated by less than 1/3. Section 3(2). 4. A. A verified complaint for impeachment is filed with the House of Representatives by I. A member of the House of Representatives, or 2. Any citizen upon a resolution of endorsement by any member of the House. B. The complaint must be included in the order of business within 10 session days upon receipt thereof. The purpose is to prohibit any delay. C. Not later than 3 session days after, including the complaint and the order of business, it must be referred, by the Speaker, to the proper committee, usually, the Committee on Justice and Order. D. The committee has 60 session days from receipt of the referral to conduct hearings, to see if there is probable cause, to vote by an absolute majority, and to submit report and its resolution to the House. E. The resolution shall be calendared for consideration and general discussion by the House within 10 session days from receipt thereof. F. After the discussion, a vote is taken, with the vote of each member recorded. A vote of at least 1/3 of all the members of the House is needed to affirm a favorable resolution with the articles of impeachment of the committee, or to override its contrary resolution. If the committee made a favorable recommendation, that is, it recommended that the complaint be sent over to the Senate, 1/3 of all the members are needed to approve such recommendation. If the committee made a contrary recommendation, that is, it recommended the dismissal of the complaint, 1/3 of all the members are needed to disapprove or override this report. In other words, so long as 1/3 of the lower house votes to proceed with the trial, then the case would be sent to the Senate, regardless of the committee recommendation, and regardless of the number who vote, which could even be as high as 66% of the entire House, that it should not be sent to the Senate for trial. The reason is that the initiation stage does not determine the guilt or innocence of the officer being impeached. It merely determines whether there is a prima facie case against the officer that merits a full-blown trial in the Senate. 2. If initiated by 1/3 Article 11, Section 3(4). If the verified complaint or resolution of impeachment is filed by at least 1/3 of all the members of the House, the same shall constitute the articles of impeachment, and trial by the Senate shall forthwith proceed. This means that the entire process is cut short. There is no need for a committee report and discussion anymore, since the end result is that 1/3 of the members of the House have decided to send the case for trial. B. Trial stage. A. The articles of impeachment of the committee is forwarded to the Senate, which has the sole power to try and decide all cases of impeachment, for trial. B. When sitting for the purpose of trying an impeachment case, the senator shall be on oath or affirmation. C. As a general rule, the President of the Senate presides over an impeachment trial. But when it is the President of the Philippines who is on trial, the Chief Justice of the Supreme Court shall be the presiding officer, but he shall not vote. D. To carry out a conviction, the vote of 2/3 of all the members of the Senate, 16 senators, is required. If less than 2/3 vote that the officer is guilty, the effect is acquittal. E. The judgment of the Senate, like the judgment of the House on whether to initiate, is a political question that cannot be reviewed by the court. Romulo v. Iniguez. Unlike a law that can be reviewed by the courts because of the existence of constitutional standards, this judgment cannot be reviewed, for the Constitution itself has granted the discretion to this co-equal branch to appreciate the case as presented. Consequences of impeachment. Article 11, Section 3, 7. Article 11, Section 3, 7. Judgment in cases of impeachment shall not extend further than removal from office and disqualification to hold any office under the Republic of the Philippines, but the party convicted shall nevertheless be liable and subject to prosecution, trial, and punishment according to law. In case of acquittal, the President continues in office, because pending the impeachment trial, he remains in office. Acquittal does not only mean the dismissal of the impeachment case, but also a bar from any criminal action on the same offense that may be filed later on. In case of conviction, judgment in cases of impeachment shall not extend further than I. Removal from office and 2. Disqualification to hold any office under RP. But a person convicted shall nevertheless be liable and subject to prosecution, trial, and punishment according to law, RPC, Anti-Graft and Corrupt Practices Act, and other penal laws. The courts cannot review the judgment on the impeachment case, and ultimately the removal from office and the disqualification, because these are political questions. But it can review the judgment in the criminal case. Must impeachment precede filing of criminal case? In Lekrich v. Sandigan Bayan, 128 SCRA 324, the SC said that the broad power of the Constitution vests the respondent courts with jurisdiction over public officers and employees, including those in GOCs. There are exceptions, however, like the constitutional officers, particularly those declared to be removable by impeachment. In their case, the Constitution prescribes removal from office by any other method, otherwise, to allow a public officer who may be removed solely by impeachment to be charged criminally while holding his office with an offense that carries the penalty of removal from office, would be violative of the clear mandate of the fundamental law. Judgment in cases of impeachment shall be limited to removal from office and disqualification to hold any office of honor, trust or profit under the Republic of the Philippines, but the party convicted shall nevertheless be liable and subject to prosecution, trial, and punishment, in accordance with law. The effect of impeachment is limited to the laws of position and disqualification to hold any office of honor, trust or profit under the Republic of the Philippines. The party thus convicted may be proceeded against, tried and thereafter punished in accordance with law. The clear implication is, the party convicted in the impeachment proceeding shall nevertheless be liable and subject to prosecution, trial and punishment according to law, and that if the same does not result in conviction and the official is not thereby removed, the filing of a criminal action in accordance with law may not prosper. Constitutional officers are not entitled to immunity from liability for possible criminal acts. But there is a fundamental procedural requirement that must be observed before such liability may be determined and enforced. They must first be removed from office via the constitutional route of impeachment, Article 11, Section 2 and 3. Should they be impeached, they may then be held to answer either criminally or administratively for any wrong or misbehavior that may be proven against them in appropriate proceedings. Therefore a fiscal or prosecuting officer should forthwith and motu proprio dismiss any charges brought against constitutional officers. The remedy of a person with a legitimate grievance is to file impeachment proceedings. The legislative process. Bills that shall originate exclusively in the House of Representatives. Article V, Section 24. All appropriations, revenue or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills shall originate exclusively in the House of Representatives, but the Senate may propose or concur with amendments. The above-mentioned bills are supposed to be initiated by the House or Representatives because it is more numerous in membership and therefore also more representative of the people. Moreover, its members are presumed to be more familiar with the needs of the country in regard to the enactment of the legislation involved. Cruise. An appropriation bill is one the primary and specific purpose of which is to authorize the release of funds from the public treasury. A revenue bill is one that levies taxes and raises funds for the government, while a tariff bill specifies the rates or duties to be imposed on imported articles. A bill increasing the public debt is illustrated by one floating bonds for public subscription redeemable after a certain period. A bill of local application is one involving purely local or municipal matters, like a charter of a city. Private bills are illustrated by a bill granting honorary citizenship to a distinguished foreigner. Tolentino vs. Secretary of Finance, 235 SCRA 632, 1994. Held, indeed, what the Constitution simply means is that the initiative for filing revenue, tariff, or tax bills, bills authorizing an increase of the public debt, private bills and bills of local application must come from the House of Representatives on the theory that, elected as they are from the districts, the members of the House can be expected to be more sensitive to the local needs and problems. On the other hand, the senators, who are elected at large, are expected to approach the same problems from the national perspective. Both views are thereby made to bear on the enactment of such laws. To begin with, it is not the law, but the revenue bill, which is required by the Constitution to originate exclusively in the House of Representatives. It is important to emphasize this, because a bill originating in the House may undergo such extensive changes in the Senate that the result may be a rewriting of the whole. The possibility of a third version by the Conference Committee will be discussed later. At this point, what is important to note is that, as a result of the Senate action, a distinct bill may be produced. To insist that a revenue statute, and not only the bill which initiated the legislative process culminating in the enactment of the law, must substantially be the same as the House bill would be to deny the Senate's power not only to concur with amendments but also to propose amendments. It would be to violate the co-equality of legislative power of the two houses of Congress and in fact make the House superior to the Senate. The one subject, one title rule. Section 26(1), Article VI, 1987 Constitution. Section 26. 1. Every bill passed by the Congress shall embrace only one subject which shall be expressed in the title thereof. De Guzman v. Kumlek, Gr. No. 129118, July 19, 2000, N. Bank Purisima. The objectives of Section 26(1), Article VI of the 1987 Constitution, that every bill passed by the Congress shall embrace only one subject which shall be expressed in the title thereof, are 1. To prevent hodgepodge or log-rolling legislation. To prevent surprise or fraud upon the legislature by means of provisions in bills of which the titles gave no information, and which might therefore be overlooked and carelessly and unintentionally adopted, and 2. To fairly apprise the people, through such publication of legislative proceedings as is usually made, of the subjects of legislation that are being considered, in order that they may have opportunity of being heard thereon by petition or otherwise if they shall so desire. Section 26(1) of Article VI of the 1987 Constitution is sufficiently complied with where, as in this case, the title is comprehensive enough to embrace the general objective it seeks to achieve, and if all the parts of the statute are related and germane to the subject matter embodied in the title or so long as the same are not inconsistent with or foreign to the general subject and title. The title of the bill is not required to be an index to the body of the act, or to be as comprehensive as to cover every single detail of the measure. It has been held that if the title fairly indicates the general subject, and reasonably covers all the provisions of the act, and is not calculated to mislead the legislature or the people, there is sufficient compliance with the constitutional requirement. PJA v. Prado, 227 SCRA 703. Moreover, a liberal construction of the one title one subject rule has been invariably adopted by this court so as not to cripple or impede legislation. Thus, in Sumya Long v. Kumlek, 73 Phil. 288 1941, we ruled that the constitutional requirement as now expressed in Article VI, Section 26(1) should be given a practical rather than a technical construction. It should be sufficient compliance with such requirement if the title expresses the general subject and all the provisions are germane to that general subject. Tobias v. Abalos, 239 SCRA 106. In any case, a title must not be so uncertain that the average person reading it would not be informed of the purpose of the enactment or put on inquiry as to its contents, or which is misleading, either in referring to or indicating one subject where another or a different one is really embraced in the act, or in omitting any expression or indication of the real subject or scope of the act. The constitutional requirement that every bill shall embrace only one subject which shall be expressed in the title thereof is sufficiently complied with if the title be comprehensive enough to include the general purpose which a statute seeks to achieve. It is not necessary that the title express each and every end that the statute wishes to accomplish. The requirement is satisfied if all the parts of the statute are related, and are germane to the subject matter expressed in the title, or as long as they are not inconsistent with or foreign to the general subject and title. An act having a single general subject, indicated in the title, may contain any number of provisions, no matter how diverse they may be, so long as they are not inconsistent with or foreign to the general subject, and may be considered in furtherance of such subject by providing for the method and means of carrying out the general object. The rule also is that the constitutional requirement as to the title of a bill should not be so narrowly construed as to cripple or impede the power of legislation. It should be given a practical rather than technical construction. Shio v. VRB, 151 SCRA 208, 1987. Lambino v. Kumlek, GR number 174153, October 25, 2006. Held, under American jurisprudence, the effect of log rolling is to nullify the entire proposition and not only the unrelated subject matter. Thus, in Fine v. Firestone, 448 So.2d 984, 994, 1984, the Supreme Court of Florida declared, combining multiple propositions into one proposal constitutes log rolling, which, if our judicial responsibility is to mean anything, we cannot permit. The very broadness of the proposed amendment amounts to log rolling because the electorate cannot know what it is voting on. The amendment's proponent's simplistic explanation reveals only the tip of the iceberg. The ballot must give the electorate fair notice of the proposed amendment being voted on. The ballot language in the instant case fails to do that. The very broadness of the proposal makes it impossible to state what it will affect and violates the requirement that proposed amendments embrace only one subject. Emphasis supplied. Log rolling confuses and even deceives the people. In Ude-Alaska v. McAlpine, 698 p.2d 1173, 1184, the Supreme Court of Alaska warned against inadvertence, stealth and fraud in log rolling. Whenever a bill becomes law through the initiative process, all of the problems that the single-subject rule was enacted to prevent are exacerbated. There is a greater danger of log rolling, or the deliberate intermingling of issues to increase the likelihood of an initiative's passage, and there is a greater opportunity for inadvertence, stealth and fraud in the enactment by initiative process. The drafters of an initiative operate independently of any structured or supervised process. They often emphasize particular provisions of their proposition, while remaining silent on other, more complex or less appealing, provisions, when communicating to the public. Indeed, initiative promoters typically use simplistic advertising to present their initiative to potential petition signers and eventual voters. Many voters will never read the full text of the initiative before the election. More importantly, there is no process for amending or splitting the several provisions in an initiative proposal. These difficulties clearly distinguish the initiative from the legislative process. Emphasis supplied. How a bill becomes a law. 3 readings on separate days. No bill passed by either house shall become a law unless it has passed 3 readings. Article VI, Section 26(2). On first reading, the title of the bill, without the provisions, is read before the body. The presiding officer then refers the bill to the proper committee, for example, to the Committee on Local Governments. Congress generally works through its committees, not as one body. After consideration of the bill or resolution, the committee returns the same to the body together with its amendments, objections or recommendations. Where the report is favorable, the bill is placed on the proper calendar. If the report is unfavorable, the matter shall be laid on the table, unless the body on the whole decides otherwise. On second reading, the bill or resolution is read in full before the floor, with such amendments as the committee may have proposed. Then, it is subjected to debate, discussion and amendments. When this is through, a motion to close the general debate is made, then a vote is taken by the membership on whether to pass the bill or not on the basis of the amendments or discussions. The bill as amended and approved is the printed in final form, and its copies are, as a general rule, distributed to the members at least 3 days before its passage. Section 26(2). The purpose of the 3-day requirement is to enable the members to check if the bill reflects the text and amendments approved on second reading, and to see if riders have been introduced. As an exception, however, the Constitution allows the 3-day and printed copy requirement to be dispensed with when the President certifies to the necessity of the immediate enactment of the bill to meet a public calamity or emergency. Section 26(2). In this case, therefore, the 3 readings may be made in less than 3 days without the bill being printed. On the third and final reading, the bill is called by its name or title, then a vote is taken right away, with the yeas and nays entered in the journal. No more amendment is allowed. Section 26(2). As a general rule, the 3 readings must be conducted on separate days. Section 26(2). The exception is found in Article 7, Section 10, when Congress convenes to call a special election to elect the President and Vice President. The bill calling such special election shall be deemed certified under Paragraph 2, Section 26, Article Vi, meaning, the three readings can be done on the same day. Tolentino v. Secretary of Finance, 235 SCRA 632, 1994. Held. The presidential certification dispensed with the requirement not only of printing but also that of reading the bill on separate days. The phrase "except when the President certifies to the necessity of its immediate enactment," etc. in Article Vi, 26(2) qualified the two stated conditions before a bill can become a law: I. The bill has passed three readings on separate days, and 2. It has been printed in its final form and distributed 3 days before it is finally approved. In other words, the unless clause must be read in relation to the except clause, because the two are really coordinate clauses of the same sentence. To construe the except clause as simply dispensing with the second requirement in the unless clause, that is, printing and distribution 3 days before final approval, would not only violate the rules of grammar, it would also negate the very premise of the except clause, the necessity of securing the immediate enactment of a bill which is certified in order to meet a public calamity or emergency. For if it is only the printing that is dispensed with by presidential certification, the time saved would be so negligible as to be of any use in ensuring immediate enactment. It may well be doubted whether doing away with the necessity of printing and distributing copies of the bill 3 days before the third reading would ensure speedy enactment of a law in the face of an emergency requiring the calling of a special election for President and Vice President. Under the Constitution, such a law is required to be made within 7 days of the convening of Congress in emergency session. That upon the certification of a bill by the President the requirement of 3 readings on separate days and of printing and distribution can be dispensed with is supported by the weight of legislative practice. The Bicameral Conference Committee. A bill can be passed jointly, when it is a joint session, supra, or separately. In the latter case, it can be passed simultaneously, when a bill is taken up by both houses separately but at the same time, or sequentially, when a bill originates from one house and goes to the other house. There is no problem if the bill is passed jointly. But if it is passed separately, the bill approved by one house goes to the other house, which can amend such bill. Once the other house approves the bill, this is called the other house's version of the bill. A bicameral conference committee is then organized, composed of equal number of members from the Senate and the House, to make recommendations to the respective chambers on how to reconcile the two versions of the bill. The respective members are usually granted blanket authority to negotiate and reconcile the bills. At the end of the process, the committee comes up with a conference committee report, which is then submitted to the respective chambers for approval. Tolentino v. Section of Finance, 235 SCRA 632, 1994. Held. As to the possibility of an entirely new bill emergency out of a conference committee, it has been explained. Under congressional rules of procedure, conference committees are not expected to make any material change in the measure at issue, either by deleting provisions to which both houses have already agreed or by inserting new provisions. But this is a difficult provision to enforce. Note the problem when one house amends a proposal originating in either house by striking out everything following the enacting clause and substituting provisions which make it an entirely new bill. The versions are now altogether different, permitting a conference committee to draft essentially a new bill. The result is a third version, which is considered an amendment in the nature of a substitute, the only requirement for which being that the third version be germane to the subject of the House and Senate bills. Indeed, this court recently held that it is within the power of a conference committee to include in its report an entirely new provision that is not found either in the House bill or in the Senate bill. 17 If the committee can propose an amendment consisting of one or two provisions, there is no reason why it cannot propose several provisions, collectively considered as an amendment in the nature of a substitute, so long as such amendment is germane to the subject of the bills before the committee. After all, Its report was not final but needed the approval of both houses of Congress to become valid as an act of the legislative department. The charge that in this case the Conference Committee acted as a third legislative chamber is thus without any basis. Nor is there any reason for requiring that the committee's report in these cases must have undergone 3 readings in each of the 2 houses. If that be the case, there would be no end to negotiation since each house may seek modifications of the compromise bill. The nature of the bill, therefore, requires that it be acted upon by each house on a take-it-or-leave-it basis, with the only alternative that if it is not approved by both houses, another conference committee must be appointed. But then again the result would still be a compromise measure that may not be wholly satisfying to both houses. Article VI, 26(2) must, therefore, be construed as referring only to bills introduced for the first time in either house of Congress, not to the Conference Committee report. For if the purpose of requiring 3 readings is to give members of Congress time to study bills, it cannot be gainsaid that H. number 11,197 was passed in the House after 3 reading, that in the Senate it was considered on first reading and then referred to a committee of that body, that although the Senate committee did not report out the House bill, it submitted a version, S. number 1630, which it had prepared by taking into consideration the House bill, that for its part the Conference Committee consolidated the 2 bills and prepared a compromise version, that the Conference Committee report was thereafter approved by the House and the Senate, presumably after appropriate study by their members. We cannot say that, as a matter of fact, the members of Congress were not fully informed of the provisions of the bill. The allegation that the Conference Committee usurped the legislative power of Congress is, in our view, without warrant in fact and in law. PJA v. Prado, 227 SCRA 703, November 11, 1993, and Bank Cruz. Held, a conference committee may deal generally with the subject matter or it may be limited to resolving the precise differences between the 2 houses. Even where the conference committee is not by rule limited in its jurisdiction, legislative custom severely limits the freedom with which new subject matter can be inserted into the conference bill. But occasionally a conference committee produces unexpected results beyond its mandate. These excursions occur even where the rules impose strict limitations on conference committee jurisdiction. This is symptomatic of the authoritarian power of conference committee. The Enrolled Bill Doctrine. Engrossment or enrollment of the bill. Once the bill is approved by both houses, the bill is engrossed or enrolled. The enrolled copy of the bill bears the certification by the presiding officers, Senate President and Speaker of the House, that this enrolled copy is the version passed by each house. Arroyo v. de Venecia, 277 SCRA 268, August 14, 1997 Mendoza. Held, under the Enrolled Bill Doctrine, the signing of H. Bill No. 7189 by the Speaker of the House and the President of the Senate and the certification by the Secretaries of both Houses of Congress that it was passed on November 21, 1996 are conclusive of its due enactment. To be sure, there is no claim either here or in the decision in the Avat cases, Tolentino v. Secretary of Finance, that the Enrolled Bill embodies a conclusive presumption. In one case, Astorga v. Villegas, 56 SCRA 714 1974, we went behind an enrolled bill and consulted the journal to determine whether certain provisions of a statute had been approved by the Senate. But, whereas here there is no evidence to the contrary, this court will respect the certification of the presiding officers of both houses that a bill has been duly passed. Under this rule, this court has refused to determine claims that the 3/4 vote needed to pass a proposed amendment to the Constitution had not been obtained, because a duly authenticated bill or resolution imports absolute verity and is binding on the courts. This court has refused to even look into allegations that the enrolled bill sent to the President contained provisions which had been surreptitiously inserted in the conference committee. Tolentino v. Secretary of Finance. It has refused to look into charges that an amendment was made upon the last reading of a bill in violation of Article VI, Section 26(2) of the Constitution, that upon the last reading of a bill, no amendment shall be allowed. Philippine Judges Asin vs. Prado, 227 SCRA 703, 710 1993. In other cases, this court has denied claims that the tenor of a bill was otherwise than as certified by the presiding officers of both houses of Congress. The enrolled bill doctrine, as a rule of evidence, is well established. It is cited with approval by text writers here and abroad. The enrolled bill rule rests on the following considerations. As the President has no authority to approve a bill not passed by Congress, an enrolled act in the custody of the Secretary of State, and having the official attestations of the Speaker of the House of Representatives, of the President of the Senate, and of the President of the United States, carries, on its face, a solemn assurance by the legislative and executive departments of the government, charged, respectively, with the duty of enacting and executing the laws, that it was passed by Congress. The respect due to co-equal and independent departments requires the judicial department to act upon that assurance, and to accept, as having passed Congress, all bills authenticated in the manner stated, leaving the court to determine, when the question properly arises, whether the act, so authenticated, is in conformity with the Constitution. Marshall Field and Company v. Clark, 143 U.S. 649, 672, 36 liters. Ed. 294, 303 1891. The approval of the President and presidential veto. The bill as approved by Congress and certified by its presiding officers is then presented to the President. Generally, there are three ways for the bill to become a law. 1. When it is approved by the President. 2. When the vote of the President is overridden by 2/3 vote of all the members of both houses. 3. Upon failure of the President to veto the bill and to return it with his objections, to the House where it originated, within 30 days after the date of receipt. Section 27(1). But there are two cases when a bill becomes a law without the signature of the President. 1. When the veto of the President is overridden by 2/3 vote of all the members of both houses, and 2. When the bill is one calling a special election for President and Vice President under Article 7, Section 10. Here the bill becomes law upon third and final reading. The acting President is not required to sign, for he may have an interest in the question. Veto power of the President. Message veto versus pocket veto. There is only one way for the President to veto a bill, by disapproving it, and returning it to the House where the bill originated, together with his veto message, explaining his objections to the bill, which message shall be entered in the journal within 30 days after receipt. Section 27(1). No pocket veto in the Philippines. In this regard, there is no pocket veto in the Philippines. What is a pocket veto? Compare with Article I, Section 7 of U.S. Constitution. Article I, Section 7. If any bill shall not be returned by the President within 10 days, Sundays excepted, after it shall have been presented to him, the same shall be a law, in like manner as if he had signed it, unless the Congress by their adjournment prevent its return, in which case it shall not be a law. The United States Constitution. A pocket veto, as in the U.S., requires two concurring elements: 1. Failure to act on the bill, and 2. The reason he does not return the bill to Congress is that Congress is not in session. Thus, if the U.S. Congress is in session, failure by the President to act will not result in the veto of the bill. In the Philippines, there is no such provision. Inaction by the President for 30 days never produced a veto. If Congress is not in session, the President must still act in order to veto the bill. Only he needs to communicate the veto to Congress without need of returning the vetoed bill with his veto message. Section 27, Article V, 1987 Constitution. Section 27. 1. Every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it, otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. If, after such reconsideration, 2/3 of all the members of such House shall agree to pass the bill, it shall be sent, together with the objections, to the other house, by which it shall likewise be reconsidered, and if approved by 2/3 of all the members of that house, it shall become a law. In all such cases, the votes of each house shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in its journal. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof, otherwise, it shall become a law as if he had signed it. 2. The President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which he does not object. Veto message. When the President vetoes a measure, he should return the measure to the House of origin, indicating his objections thereto in what is commonly known as a veto message, so that the same can be studied by the members for a possible overriding of his veto. Is partial veto allowed under the Constitution? The general rule is that the President must approve entirely or disapprove in toto. The exception applies to appropriation, revenue and tariff bills, any particular item or items of which may be disapproved without affecting the item or items to which he does not object. Gonzalez v. McCarrig Gr. No. 87636. November 19, 1990. Held, paragraph 1, refers to the general veto power of the President and if exercised would result in the veto of the entire bill, as a general rule. Paragraph 2, is what is referred to as the item veto power or the line veto power. It allows the exercise of the veto over a particular item or items in an appropriation, revenue, or tariff bill. As specified, the President may not veto less than all of an item of an appropriations bill. In other words, the power given the executive to disapprove any item or items in an appropriations bill does not grant the authority to veto a part of an item and to approve the remaining portion of the same item. Explicit is the requirement that a provision in the appropriations bill should relate specifically to some particular appropriation therein. The challenged provisions fall short of this requirement. Firstly, the vetoed provisions do not relate to any particular or distinctive appropriation. They apply generally to all items disapproved or reduced by Congress in the appropriations bill. Secondly, the disapproved or reduced items are nowhere to be found on the face of the bill. Consequently, Section 55, Fee 89, and Section 16, Fee 90, although labeled as provisions, are actually inappropriate provisions that should be treated as items for the purpose of the President's veto power. An item in a bill refers to the particulars, the details, the distinct and severable parts of the bill. It is an indivisible sum of money dedicated to a stated purpose. The United States Supreme Court, in the case of Bengtson v. Secretary of Justice, declared that an item of an appropriation bill obviously means an item which in itself is a specific appropriation of money, not some general provision of law, which happens to be put into an appropriation bill. Bengtson v. Drillon, 208 SCRA 133, April 15, 1992, and Bank Gutierrez. Held, the veto power of the President is not absolute. The executive must veto a bill in its entirety or not at all. However, when it comes to appropriation, revenue or tariff bills, the administration needs the money to run the machinery of government. And it cannot veto the entire bill even if it may contain objectionable features. This is the reason for the item veto power. The Constitution provides that only a particular item or items may be vetoed. The power to disapprove any item or items in an appropriate bill does not grant the authority to veto a part of an item and to approve the remaining portion of the same item. The terms item and provision are different. An item refers to the particulars, the details, the distinct and severable parts of the bill. It is an indivisible sum of money dedicated to a stated purpose. An item obviously means an item which in itself is a specific appropriation of money, and not some general provision of law. In this case, the President did not veto an item. She vetoed the methods or systems placed by Congress to ensure that permanent and continuing obligations to certain officials will be paid when they fall due. In this case, the vetoed portions are not items but are provisions. The augmentation of specific appropriations found inadequate to pay retirement payments, by transferring savings from other items of appropriations is a provision and not an item. It gives the SC Chief Justice the power to transfer funds from one item to another. There is no specific appropriation of money involved. Neither may the veto power be exercised as a means of repealing existing laws. This is arrogating unto the presidency legislative powers which are beyond its authority. Sir vs. CDA, 185 SCRA 329, 1990. Held. An item in a revenue bill does not refer to an entire section imposing a particular kind of tax, but rather to the subject of the tax and the tax rate. In the portion of a revenue bill which actually imposes a tax, a section identifies the tax and enumerates the persons liable therefor with the corresponding tax rate. To construe the word item as referring to the whole section would tie the President's hand in choosing either to approve the whole section at the expense of also approving a provision therein which he deems unacceptable, or veto the entire section at the expense of foregoing the collection of the kind of tax altogether. The evil which was sought to be prevented in giving the President the power to disapprove items in a revenue bill would be perpetrated, rendering that power inutile. See Commonwealth Ex Rel. Ulkin vs. Farnett, 199 pascals. 161, 55 LRA 882-1901. Filconsa vs. Enriquez, 235 SCRA 506, 1994. Held. As the Constitution is explicit that the provision which Congress can include in an appropriations bill must relate specifically to some particular appropriation therein and be limited in its operation to the appropriation to which it relates, it follows that any provision which does not relate to any particular item, or which extends in its operation beyond an item of appropriation, is considered an inappropriate provision which can be vetoed separately from an item. Also to be included in the category of inappropriate provisions are unconstitutional provisions and provisions which are intended to amend other laws, because clearly these kind of laws have no place in an appropriations bill. These are matters of general legislation more appropriately dealt with in separate enactments. Former Justice Irene Cortes, as amicus curiae, commented that Congress cannot by law establish conditions for and regulate the exercise of powers of the President given by the Constitution, for that would be an unconstitutional intrusion into executive prerogative. The doctrine of inappropriate provision was well elucidated in Henry v. Edwards, supra, thus. Just as the President may not use his item veto to usurp constitutional powers conferred on the legislature, neither can the legislature deprive the governor of the constitutional powers conferred on him as chief executive officer of the state by including in a general appropriation bill matters more properly enacted in separate legislation. The governor's constitutional power to veto bills of general legislation cannot be abridged by the careful placement of such measures in a general appropriation bill, thereby forcing the governor to choose between approving unacceptable substantive legislation or vetoing items of expenditures essential to the operation of government. The legislature cannot by location of a bill give it immunity from executive veto. Nor can it circumvent the governor's veto power over substantive legislation by artfully drafting general law measures so that they appear to be true conditions or limitations on an item of appropriation. Otherwise, the legislature would be permitted to impair the constitutional responsibilities and functions of a co-equal responsibilities and functions of a co-equal branch of government in contravention of the separation of powers doctrine. We are no more willing to allow the legislature to use its appropriation power to infringe on the governor's constitutional right to veto matters of substantive legislation than we are to allow the governor to encroach on the constitutional powers of the legislature. In order to avoid this result, we hold that, when the legislature inserts inappropriate provisions in a general appropriation bill, such provisions must be treated as items for purposes of the governor's item veto power over general appropriation bills. Legislative control cannot be exercised in such a manner as to encumber the general appropriation bill with veto-proof log-rolling measures, special interest provisions which could not succeed if separately enacted, or riders, substantive pieces of legislation incorporated in a bill to ensure passage without veto. Overriding the veto. Upon consideration of the objections raised by the President in his veto message, the House from which the bill originated shall reconsider the bill. If after such reconsideration, 2/3 of all the members of such house shall agree to pass the bill. It shall be sent together with the objections of the President, to the other house by which it shall likewise be reconsidered. If approved by 2/3 of all the members of that house, it shall become a law. In all such cases, the votes of each house shall be determined by yeas or nays, and the names of the members voting for or against shall be entered in the journal. Article Vi, Section 27(1). Judicial review of a presidential veto. Filconsa vs. Enriquez, 235 SCRA 506, 1994. Held, we rule that a member of the Senate, and of the House of Representatives for that matter, has the legal standing to question the validity of a presidential veto or a condition imposed on an item in an appropriation bill. Where the veto is claimed to have been made without or in excess of the authority vested on the President by the Constitution, the issue of an impermissible intrusion of the executive into the domain of the legislature arises. Notes, Congressional standing to challenge executive action, 122 University of Pennsylvania Law Review 1366 1974. To the extent the powers of Congress are impaired, so is the power of each member thereof, since his office confers a right to participate in the exercise of the powers of that institution. Coleman v. Miller, 307 U.S. 433 1939, Holtzman v. Schlesinger, 484 F. 2d 1307 1973. An act of the executive which injures the institution of Congress causes a derivative but nonetheless substantial injury, which can be questioned by a member of Congress. Kennedy v. Jones, 412 F. Sup. 353 1976. In such a case, any member of Congress can have a resort to the courts. Former Chief Justice Enrique M. Fernando, as amicus curiae, noted. This is, then, the clearest case of the Senate as a whole or individual senators as such having substantial interest in the question at issue. It could likewise be said that there was requisite injury to their rights as senators. It would then be futile to raise any locus standi issue. Any intrusion into the domain appertaining to the Senate is to be resisted. Similarly, if the situation were reversed, and it is the executive branch that could allege a transgression, its officials could likewise file the corresponding action. What cannot be denied is that a senator has standing to maintain inviolate the prerogatives, powers and privileges vested by the Constitution in his office. Memorandum, page 14. It is true that the Constitution provides a mechanism for overriding a veto, Article Vi, Section 27(1). Said remedy, however, is available only when the presidential veto is based on policy or political considerations but not when the veto is claimed to be ultra vires. In the latter case, it becomes the duty of the court to draw the dividing line where the exercise of executive power ends and the bounds of legislative jurisdiction begin. Legislative vetoes? The Congress cannot deem a draft submitted by an executive agency passed as law by its mere inaction within a certain period. It must go through the 3 readings and the submission of the bill to the President, as required by the Constitution. In Miller v. Mardo, 2 SCRA 298, 1961, the SC struck down as unconstitutional Section 6 of RA 997, which provided that the reorganization plan drafted by the Department of Labor and submitted to President for approval shall be deemed as approved by Congress after its adjournment, unless in the meantime, Congress by resolution disapproved the plan. It struck down as well the reorganization plan drafted pursuant to this law. In so holding, the court ruled that the approval of a bill cannot be made by Congress by mere silence, adjournment or concurrent resolution. The Constitution requires the 2 houses to hold separate session for deliberation, and to submit the determination of one to the separate determination of the other, unless a joint session is provided for. This method of passing a law amounts to an abdication by Congress of its legislative prerogatives to the executive. Effectivity of laws. Article 2. Laws shall take effect after 15 days following the completion of their publication in the Official Gazette, unless it is otherwise provided. Civil Code. When a bill becomes a law through any of the 3 means mentioned above, the law does not become effective at once. according to the ruling upon reconsideration in Canada versus Devra, 136 SCRA 27, 1985, in addition to the date fixed either by the effectivity clause of the statute, or, in its absence, by Article 2 of the Civil, 15 days after its publication, there must first be a publication of the law either in the Official Gazette or in the Newspaper of General Circulation EO 200. Otherwise, there is a violation of due process. This requirement for publication applies to any kind of law, even laws which are not of general application, private laws, for example law granting citizenship to X, laws of local application, and rules and regulations of substantive character. Initiative and referendum. Initiative is the power of the people to propose bills and laws, and to enact or reject them at the polls, independent of the Legislative Assembly. It is the right of a group of citizens to introduce a matter for legislation either to the legislature or directly to the voters. Referendum is the right reserved to the people to adopt or reject any act or measure which has been passed by a legislative body and which in most cases would without action on the part of the electors become a law. It is a method of submitting an important legislative measure to a direct vote of the whole people, the submission of a law passed by the legislature for their approval or rejection. Appropriations Law. General Principle. No money shall be paid out of the Treasury except in pursuance of an appropriation made by law. Article Vi, Section 29(1). All appropriation, revenue or tariff bills, bills authorizing increase of the public debt, bills of local application, and private bills, shall originate exclusively in the House, but the Senate may propose or concur with amendments. Section 24. The reason is that the House is the more popular chamber of Congress. General Appropriation. The President shall submit to Congress, within 30 days from the opening of its regular session, as the basis of the General Appropriations Bill, a budget of a. expenditures, and b. sources of financing, including receipts from existing and proposed revenue measures. Article 7, Section 22. The form, content, and manner of preparation of the budget shall be prescribed by law. Article Vi, Section 25(1), second sentence. The Congress may not increase the appropriations recommended by the President for the operation of the government as specified in the budget, but may decrease said budget. No provision or enactment shall be embraced in the General Appropriations Bill unless it relates specifically to some particular appropriation therein. Any such provision or enactment shall be limited in its operation to the appropriation to which it relates. Article Vi, Section 25(2). The procedure in approving appropriations for the Congress shall strictly follow the procedure for approving appropriations for other departments and agencies. If, by the end of the fiscal year, the Congress shall have failed to pass the General Appropriations Bill for the ensuing fiscal year, the General Appropriations Law for the preceding fiscal year shall be deemed reenacted, and shall remain in force and effect until the General Appropriations Bill is passed by the Congress. Article Vi, Section 25(7). Special Appropriation. A special appropriations bill shall, a. specify the purpose for which it is intended, and, b. supported by funds, actually available as certified by the National Treasurer, or to be raised by a corresponding revenue proposal therein. Article Vi, Section 25(4). A special appropriations bill may be proposed to supply a lack or meet a new need, like a special election. In the case of a special law to elect the President and Vice President. However, the requirements of the sections are specifically exempted by the Constitution in Article 7, Section 10. Transfer of funds already appropriated. No law shall be passed authorizing any transfer of appropriations. However, the President, President of the Senate, Speaker of the House, the Chief Justice of the Supreme Court, and the heads of the Constitutional Commission may, by law, be authorized to augment any item in the General Appropriations Law for their respective offices, from savings in other items of their respective appropriations. Article Vi, Section 25(5). Discretionary funds appropriated for particular officials shall be disbursed only for public purposes, to be supported by appropriate vouchers, and subject to such guidelines as may be prescribed by law. Article Vi, Section 25(6). In Demetria v. Alba, Supra, it was held that Section 44 of the Budget Act of 1977, BP 1177, granting the President the blanket authority to transfer funds from one department to another, with or without savings, is unconstitutional. Prohibited appropriation to enforce the separation of church and state. No public money or property shall be appropriated, applied, paid, or employed, directly or indirectly, for the use, benefit, or support of any religion, sect, church, denomination, sectarian institution, or any system of religion, or of any priest, preacher, minister, other religious teacher, or religious dignitary. Exception, when such priest, et al., is assigned to a. the AFPB, any penal institution, c. any government orphanage, or d. any leprosarium. Article Vi, Section 29(2). Appropriations laws, the spending powers of Congress, id. Section 25, are tied up with tax laws, the power to raise revenues, id. Section 28. They are two indispensable sides of a coin. They are tied up by the principle that no money shall be paid out of the Treasury except in pursuance of an appropriation made by law, id. Section 29(1). The Executive Department. Qualifications of President, Article 7, Section 2. 1. Natural-born citizen of the Philippines. 2. Registered voter. 3. Able to read and write. 4. 40 years of age on the day of election. 5. Resident of the Philippines for at least 10 years immediately preceding the election. Regular election and term. The President and Vice President, who shall be elected with and in the same manner as the President, shall be elected by direct vote of the people for a term of 6 years, which shall begin on the noon of June 30th next following the day of election. The regular election for President and Vice President shall be held on the second Monday of May. Article 7, Section 4 Pars. 1 and 3. Re-election. The President shall not be eligible for any re-election. Furthermore, no person who has succeeded as President and has served as such for more than 4 years, shall be qualified for any election to the same office, the Presidency, at any time. Article 7, Section 4, Paragraph 1. The person who succeeds as President and not just in an acting capacity, could either be I. the Vice President, or 2. one who was elected President in a special election. In both cases, if he has served for more than 4 years, he is ineligible for re-election as President. If he served for 4 years or less, he can run for re-election, since a. the term succeeded encompasses election and b. the general rule prohibiting the President to run for re-election refers to the President elected during the regular election. The Vice President on the other hand, shall not serve for more than 2 successive terms. And for this purpose, a voluntary, but not involuntary, renunciation of office for any length of time, shall not be considered an interruption in the continuity of the service for the full terms for which he was elected. Article 7, Section 4, Paragraph 2. Electoral Tribunal for the election of the President and Vice President. The Supreme Court, sitting en banc, shall be the sole judge of all contests relating to the election, returns, and qualifications of the President or Vice President, and may promulgate its rules for that purpose. Article 7, Section 4, Paragraph 7. Prohibitions, Article 7, Section 13. Prohibition against the President, Vice President, members of the Cabinet, and their deputies or assistants. A. They shall not hold any other office or employment during their tenure, unless otherwise provided by this Constitution. B. They shall not practice any other profession. C. They shall not participate in any business. D. They shall not be financially interested in any contract with, or in any franchise or special privilege granted. Exceptions to rule prohibiting executive officials from holding additional positions. A. President. 1. The President can assume a cabinet post, because the departments are mere extensions of his personality, according to the doctrine of qualified political agency, so no objection can be validly raised based on Article 7, Section 13. 2. The President is the chairman of NATA. Article 12, Section 9. B. Vice President. Article 7, Section 3. The Vice President may be appointed as member of the Cabinet. Such appointment requires no confirmation. C. Cabinet. 1. The Secretary of Justice shall be an ex officio member of the Judicial and Bar Council. Article 8, Section 8(1). 2. Unless otherwise allowed by law or by the primary functions of his position, appointive officials shall not hold any other office or employment in the government or any subdivision, agency or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. Article 9, B, 7, Paragraph 2. Article 7, Section 13 talks of unless otherwise provided by the Constitution. In the case of cabinet members, this refers to Article 9, B, 7, Paragraph 2. Thus, the Constitution allows a cabinet member to hold another office provided either, 1, such as necessitated by the primary functions of his position, for example Secretary of Trade and Industry as chairman of NDC, Secretary of Agrarian Reform as chairman of the Land Bank, or, 2, is allowed by law. Civil Liberties Union, CLU, versus Executive Secretary, 194 SCRA 317, 1991. Held, by ostensibly restricting the no. of positions that cabinet members, under secretaries or secretaries may hold in addition to their primary position to not more than 2 positions in the government. And Goops, EO 284 actually allows them to hold multiple offices or employment in direct contravention of the express mandate of Article 8, Section 13 prohibiting them from doing so, unless otherwise provided in the 1987 Constitution itself. If maximum benefits are to be derived from a department head's ability and expertise, he should be allowed to attend to his duties and responsibilities without the distraction of other government offices or employment. The stricter prohibition applied to the President and his official family under Section 13, Article 7 as compared to the prohibition applicable to appointive officials in general under Article 9, B, Section 7, Paragraph 2 are proof of the intent of the 1987 Constitution to treat them as a class by itself and to impose upon said class stricter prohibitions. Thus, while all other appointive officials in the civil service are allowed to hold other office or employment in the government during their tenure when such is allowed by law or by the primary functions of their positions, members of the cabinet, their deputies and assistants may do so only when expressly authorized by the Consti. itself. However, the prohibition against holding dual or multiple offices or employment under Article 7, Section 13 must not be construed as applying to posts occupied by the executive officials specified therein without additional compensation in an ex officio capacity as provided by law and as required by the primary functions of said official's office. The reason is that these posts do not comprise any other office within the contemplation of a constitutional prohibition but are properly an imposition of additional duties and function on said officials. The term ex officio means from office, by virtue of office. It refers to an authority derived from official character merely, not expressly conferred upon the individual character, but rather annexed to the official position. Ex officio likewise denotes an act done in an official character, or as a consequence of office, and without any other appointment or authority than that conferred by the office. An ex officio member of a board is one who is a member by virtue of his title to a certain office, and without further warrant or appointment. To illustrate, by express provision of law, the Secretary of Transportation and Communications is the ex officio chairman of the board of the Philippine Ports Authority and the Light Rail Transit Authority. The ex officio position being actually and in legal contemplation part of the principal office, it follows that the official concerned has no right to receive additional compensation for his services in the said position. The reason is that these services are already paid for and covered by the compensation attached to his principal office. Presidential succession. Temporary or permanent vacancy in the presidency before the term. 1. If the president-elect cannot assume his post at the beginning of his term because he has not qualified as yet, for example he had an operation and so he could not take his oath of office on June 30th, 2, or a president has not been chosen and qualified as yet, for example there is a tie and Congress has not yet broken the tie, then the vice president shall act as president until the president-elect shall have qualified, or shall have been chosen, and qualified, as the case may be. Article 7, Section 7, Pars. 2 and 3. 2. If the president-elect dies, or 2, becomes permanently disabled at the beginning of the term of the president, that is, before the term, then the vice president-elect shall become the president. Id. Paragraph 4. 3. If both president and vice president, have not been chosen or, 2, have not qualified, or, 3, die, or, 4, become permanently disabled, then the President of the Senate, or in case of his inability, the Speaker of the House, shall act as President until a President or a Vice President shall have been chosen and qualified. Id. Paragraph 5. In case both the President of the Senate and the Speaker of the House are unable to act as President, then Congress shall by law, provide for the manner of selecting the one who will act as President until a President or Vice President shall have been either chosen or elected pursuant to the special election referred to in Article 7, Section 10, and qualified. Permanent vacancy in the presidency during the term, Article 7, Section 8. 1. In case of the President's death, 2, permanent disability, 3, removal from office, the only way is by impeachment, or, 4, resignation, the Vice President shall become President for the unexpired portion of the term. Paragraph 1. 2. In case of both the President's and Vice President's death, permanent disability, removal from office, by impeachment, or resignation, then the Senate President or, in case of his inability, the Speaker of the House, shall act as President until the President or Vice President shall have been elected, pursuant to the special election in Article 7, Section 10, and qualified. Paragraph 1. When the acting President, that is, the Senate President, or Speaker of the House, dies, becomes permanently disabled, or resigns, but is not removed, because there is no need to impeach him, his stay being temporary, then the Congress shall by law, provide who shall be acting President until the President or Vice President shall have been elected, pursuant to the special election in Article 7, Section 10, and qualified. This acting President shall be subject to the same restrictions of powers and disqualifications. Paragraph 2. Estrada vs. Desierto, Gr. Nos. 146,710-15, March 2, 2001, N. Bank Puno. Held, resignation is a factual question and its elements are beyond quibble. There must be an intent to resign and the intent must be coupled by acts of relinquishment. The validity of a resignation is not governed by any formal requirement as to form. It can be oral. It can be written. It can be expressed. It can be implied. As long as the resignation is clear, it must be given legal effect. Consequently, whether or not petitioner resigned has to be determined from his acts and omissions before, during and after January 20, 2001 or by the totality of prior, contemporaneous and posterior facts and circumstantial evidence bearing a material relevance on the issue. Using this totality test, we hold that petitioner resigned as President. In sum, we hold that the resignation of the petitioner cannot be doubted. It was confirmed by his leaving Malacanang. In the press release containing his final statement, 1. He acknowledged the oath-taking of the respondent as President of the Republic albeit with reservation about its legality. 2. He emphasized he was leaving the palace, the seat of the presidency, for the sake of peace and in order to begin the healing process of our nation. He did not say he was leaving the palace due to any kind of inability and that he was going to reassume the presidency as soon as the disability disappears. 3. He expressed his gratitude to the people for the opportunity to serve them. Without doubt, he was referring to the past opportunity given him to serve the people as president. 4. He assured that he will not shirk from any future challenge that may come ahead on the same service of our country. Petitioner's reference is to a future challenge after occupying the office of the president which he has given up, and, 5. He called on his supporters to join him in the promotion of a constructive national spirit of reconciliation and solidarity. Certainly, the national spirit of reconciliation and solidarity could not be attained if he did not give up the presidency. The press release was petitioner's valedictory, his final act of farewell. His presidency is now in the past tense. Temporary vacancy in the presidency during the term, Article VI, Section 11, Supra. A vacancy in the presidency arising from his disability can occur in any of the following ways. 1. A written declaration by the president. 2. Written declaration by the cabinet. 3. Finding by Congress by 2/3 vote that the president is disabled. In all these cases, the vice president temporarily acts as the president. Voluntary declaration of inability by president. A. When the president transmits to the Senate president and the speaker his written declaration that he is unable to discharge the powers and duties of his office, such powers and duties shall be discharged by the vice president as acting president. B. The vice president shall so act until the president transmits to the Senate president and the speaker a written declaration that he is no longer unable to discharge his office. Contested inability of the president. A. When majority of all the members of the cabinet transmit to the Senate president and speaker their written declaration that the president is unable to discharge his office, then the vice president shall immediately assume the presidency in an acting capacity. B. The president can contest this by sending his own written declaration to the Senate president and speaker that no inability exists. Upon such transmittal, the president shall automatically assume his office. C. Should the majority of the cabinet insist on their original stand by transmitting a second written declaration of the president's inability within 5 days from resumption of office of the president, then Congress shall step in. D. Upon receipt of the second declaration by the cabinet, Congress shall convene, if it is not in session, within 48 hours, without need of call, in accordance with its rules. If it is already in session, it must meet right away, as glimpsed from the fact that they only have 10 days to decide, whereas if it is not in session, it must convene in 2 days and decide before the 12th day. E. Congress shall determine the president's inability within 10 days after receipt of the second written declaration by the cabinet if it is in session, or within 12 days after it is required to assemble by its respective presiding officer if it is not in session. F. If the president, by a 2/3 vote of both houses voting separately, determined to be unable to discharge his office, then the vice president shall act as president. If less than 2/3 find him unable, then the president shall continue exercising the powers and duties of his office. Serious illness of the president. Article 7, Section 12. In case of serious illness of the president, the public shall be informed of the state of his health. The members of the cabinet in charge of national security and foreign relations and the chief of staff of the armed forces of the Philippines, shall not be denied access to the president during such illness. Call a special election in case of vacancy in the offices of President and Vice President, Article 7, Section 10. When a vacancy occurs in the offices of the President and Vice President, more than 18 months before the date of the next regular presidential election, the Congress shall convene at 10 a.m. of the third day after the vacancy, in accordance with its rules, without need of call. The convening of Congress cannot be suspended. Within 7 days after it convenes, it shall enact a law calling for a special election to elect a president and vice president, to be held between 45 to 60 days from the day of such call. The holding of the special election cannot be postponed. Not later than 30 days after the election, Congress shall again act as Board of Canvassers, see infra, since Article 7, Section 4 paragraph A talks of every election for president and vice president. Thus, the timetable is: Day 0, vacancy occurs. Day 3, Congress convenes without need of call. Day 10, Congress passes the special election law, if it has not passed before this date. Day 55 to 70, election is held. Day 85 to 100, as the case may be, canvassing by Congress, if it has not done so earlier. Under the Constitution then a vacancy is filled by the 100th day from the vacancy at the latest. The law so passed is exempted from the following. 1. Certification under Article VI, Section 26, Paragraph 2. Thus, the 3 readings can be done all on the same day. 2. Approval by the President, for obvious reasons. The bill automatically becomes a law, then, upon its approval on third and final reading. 3. Certification by the National Treasurer of the availability of funds, or revenue-raising measure under Article VI, Section 25(4). Appropriations for the special election shall be charged against any current appropriations. Immunity from suit of the President. The SC has affirmed time and again the doctrine of the President's immunity from suit. In a resolution in Carrillo vs. Marcos, April 1981, and in the later case of Enrique Bermudez, October 1986, the court said that it is elementary that incumbent presidents are immune from suit or from being brought to court during the period of their incumbency and tenure. 3 reasons for such immunity. 1. The singular importance of the presidency and his high visibility. 2. The distraction that suits would bring to such an important official laden with enormous responsibility. 3. The consequence that the president might hesitate at the moment of greatest peril to the nation if he knows that he would be held liable later on. Estrada vs. Desierto, Gr. Nos. 146,710-15, March 2, 2001, N. Bank Puno. Held, the cases filed against petitioner Estrada are criminal in character. They involve plunder, bribery and graft and corruption. By no stretch of the imagination can these crimes, especially plunder which carries the death penalty, be covered by the alleged mantle of immunity of a non-sitting president. Petitioner cannot cite any decision of this court licensing the president to commit criminal acts and wrapping him with post-tenure immunity from liability. It will be anomalous to hold that immunity is an inoculation from liability for unlawful acts and omissions. The rule is that unlawful acts of public officials are not acts of the state and the officer who acts illegally is not acting as such but stands in the same footing as any other trespasser. Indeed, a critical reading of current literature on executive immunity will reveal a judicial disinclination to expand the privilege, especially when it impedes the search for truth or impairs the vindication of the right. David vs. Macapagal Arroyo, Gr. No. 171396, May 3, 2006. Held, incidentally, it is not proper to implead President Arroyo as respondent. Settled is the doctrine that the president, during his tenure of office or actual incumbency, may not be sued in any civil or criminal case, and there is no need to provide for it in the Constitution or a law. It will degrade the dignity of the high office of the president, the head of state, if he can be dragged into court litigations while serving as such. Furthermore, it is important that he be freed from any form of harassment, hindrance or distraction to enable him to fully attend to the performance of his official duties and functions. Unlike the legislative and judicial branch, only one constitutes the executive branch, and anything which impairs his usefulness in the discharge of the many great and important duties imposed upon him by the Constitution necessarily impairs the operation of the government. However, this does not mean that the president is not accountable to anyone. Like any other official, he remains accountable to the people, but he may be removed from office only in the mode provided by law, and that is by impeachment. Sullivan vs. Mocage, Beltran vs. Mocage, 167 SCRA 393, 1988. Held, the rationale for the grant to the President of the privilege of immunity from suit is to assure the exercise of presidential duties and functions free from any hindrance or distraction, considering that being the chief executive is a job that, aside from requiring all of the officeholders' time, also demands undivided attention. But this privilege of immunity from suit pertains to the president by virtue of the office and may be invoked only by the holder of the office, not by any other person in the president's behalf. Thus, an accused in a criminal case where the president is a complainant cannot raise the presidential privilege as a defense to prevent the case from proceeding against the accused. Moreover, there is nothing in our laws that would prevent the president from waiving the privilege. The president may shed the protection afforded by the privilege and submit to the court's jurisdiction. The choice of whether to exercise the privilege or to waive it is solely the president's prerogative. It is a decision that cannot be assumed and imposed by another person. Q. Does the president's immunity from suit extend even beyond his term? A. Yes. So long as the act was done during his term. Q. Does the president's immunity from suit extend to his alter egos? A. No. Estrada vs. Desierto, Gr. Nos. 146,710-15, March 2, 2001, N. Bank Puno. Can former President Estrada still be prosecuted criminally considering that he was not convicted in the impeachment proceedings against him? Held. We reject his argument that he cannot be prosecuted for the reason that he must first be convicted in the impeachment proceedings. The impeachment trial of Petitioner Estrada was aborted by the walkout of the prosecutors and by the events that led to his loss of the presidency. Indeed, on February 7, 2001, the Senate passed Senate Resolution No. 83 recognizing that the impeachment court is functus officio. Since the impeachment court is now functus officio, it is untenable for petitioner to demand that he should first be impeached and then convicted before he can be prosecuted. The plea, if granted, would put a perpetual bar against his prosecution. Such a submission has nothing to commend itself, for it will place him in a better situation than a non-sitting president who has not been subjected to impeachment proceedings and yet can be the object of a criminal prosecution. To be sure, the debates in the Constitutional Commission make it clear that when impeachment proceedings have become moot due to the resignation of the president, the proper criminal and civil cases may already be filed against him. This is in accord with our ruling in Enri, Saturnino Bermudez that incumbent presidents are immune from the suit or from being brought to court during the period of their incumbency and tenure but not beyond. Considering the peculiar circumstance that the impeachment process against the petitioner has been aborted and thereafter he lost the presidency, Petitioner Estrada cannot demand as a condition sine qua non to his criminal prosecution before the Ombudsman that he be convicted in the impeachment proceedings. Powers and functions of the President. Executive power. Article 7, Section 1. The executive power shall be vested in the President of the Philippines. Id. Section 17. The President shall have control of all the executive departments, bureaus, and offices. He shall ensure that the laws be faithfully executed. The executive function is essentially the duty to implement the laws within the standards imposed by the legislature. Under the Constitution, this power is exercised by the President. Thus, when the Cabinet and other branches of the executive department implement the law, they are acting under the control of the President. The first section of Article 7 of the Constitution, dealing with the executive department, begins with the enunciation of the principle that the executive power shall be vested in the President of the Philippines. This means that the President of the Philippines is the executive of the government of the Philippines, and no other. The heads of the executive departments occupy political positions and hold office in an advisory capacity, and, in the language of Thomas Jefferson, should be of the President's bosom confidence and, in the language of Attorney General Cushing, are subject to the direction of the President. Villena vs. Section of Interior, 67 Phil. 451, 1939. Marcos vs. Manglipus, 177 SCRA 668, 178 SCRA 760. Facts. This is a petition for mandamus asking the court to order the respondents to issue travel documents to Mr. Marcos and his immediate family and to enjoin the implementation of the President's decision to bar their return to the Philippines. The issue is whether or not, in the exercise of executive power, The President may prohibit the Marcoses from returning to the Philippines. Held, the Constitution provides that the executive power shall be vested in the President, Article 7, Section 1. However, it does not define what is meant by executive power, although in the same article it touches on the exercise of certain powers by the President, that is the power of control over all executive debts, bureaus and offices, the power to execute the laws, the appointing power, the powers under the Commander-in-Chief Clause, the power to grant reprieves, commutations, pardons, the power to grant amnesty with the concurrence of Congress, the power to contract or guarantee foreign loans, the power to enter into treaties or international agreements, the power to submit the budget to Congress and the power to address Congress. 7. Section 1423. The inevitable question is whether by enumerating certain powers of the President, did the framers of the Constitution intend that the President shall exercise those specific powers and no other? According to the SC, that although the 1987 Constitution imposes limitations on the exercise of specific powers of the President, it maintains intact what is traditionally considered as within the scope of executive power. Corollarily, the powers of the President cannot be said to be limited only to the specific power enumerated in the Constitution. In other words, executive power is more than the sum of specific powers so enumerated. In this case, the President has the power to bar the Marcoses from returning to the Philippines. She has the obligation to protect the people, promote their welfare and advance the national interest. She has to balance the general welfare and the common good against the exercise of rights of certain individuals. The power involved is the President's residual power to protect the general welfare of the people. It is founded on the duty of the President, as steward of the people. Resolution on motion for reconsideration. It cannot be denied that the President, upon whom executive power is vested, has unstated residual powers which are implied from the grant of executive power and which are necessary for her to comply with her duties under the Constitution. The powers of the President are not limited to what are expressly enumerated in the article on the Executive Department and in scattered provisions of the Constitution. The control power of the President. Section 17, Article 7, 1987 Constitution. Section 17. The President shall control of all the executive departments, bureaus and offices. He shall ensure that the laws be faithfully executed. Faithful Execution Clause or Take Care Clause, Sec. 17, Article 7. The President shall ensure that laws are faithfully executed. It is not for him to determine the validity of a law, since this is a question exclusively addressed to the judiciary. Thus, until and unless a law is declared unconstitutional, the President has the duty to execute it regardless of his doubts on its validity. A contrary opinion would allow him to negate the will of the legislature and to encroach upon the prerogative of the judiciary. Nakura, pages 224 to 225. Control is the power to substitute one's own judgment in that of a subordinate. The doctrine of qualified political agency. All executive and administrative organizations are adjuncts of the executive department. The heads of the various executive departments are assistants and agents of the chief executive, and except in cases where the chief executive is required by the Constitution or law to act in person or the exigencies of the situation demand that he act personally, the multifarious executive and administrative functions of the chief executive are performed by and through the executive departments, and the acts of the secretaries of such departments, performed and promulgated in the regular course of business, are, unless disapproved or reprobated by the chief executive, presumptively the acts of the chief executive. Under the qualified political agency doctrine, the different executive departments are mere adjuncts of the President. The secretaries are the alter ego of the President, men of his bosom confidence whom he designated to assist him in his otherwise physically impossible multifarious functions, the extension of the President in the particular field in which they act. Their acts are presumptively acts of the President, until countermanded or reprobated by him. The President can substitute his will over those of the secretaries, and they cannot complain. Furthermore, they hold their office subject to the discretion of the President, who can replace them anytime once he loses his confidence in them. Josen vs. Torres, 290 SCRA 279, May 20, 1998. Puno. Held, control is said to be the very heart of the power of the presidency. As head of the executive department, the president, however, may delegate some of his powers to the cabinet members except when he is required by the Constitution to act in person or the exigencies of the situation demand that he acts personally. The members of cabinet may act for and in behalf of the president in certain matters because the president cannot be expected to exercise his control, and supervisory, powers personally all the time. Each head of a department is, and must be, the president's alter ego in the matters of that department where the president is required by law to exercise authority. The president's power of general supervision over local governments. Section 4, Article X, 1987 Constitution. Section 4. The President of the Philippines shall exercise general supervision over local governments, provinces with respect to component cities and municipalities, and cities and municipalities with respect to component barangays shall ensure that the acts of their component units are within the scope of their prescribed powers and functions. General supervision means the mere overseeing of a subordinate to make sure that they do their duties under the law. But this does not include the power to overrule their acts, if these acts are within their discretion. Article X, Section 16. The President shall exercise general supervision over autonomous regions to ensure that laws are faithfully executed. The grant of mere supervisory power over local governments and autonomous regions is in line with the policy of the state to promote the autonomy of local governments and autonomous regions. There can be no real local autonomy while the national government controls the local governments. Ganzen vs. CA, 200 SCRA 271, 1991. The petitioners question the power of the President, acting through the Secretary of Local Government, to suspend and/or remove local officials. Held, it is the considered opinion of the court that notwithstanding the change in the Constitution, the Charter did not intend to divest the legislature of its right, or the President of her prerogative as conferred by existing legislation to provide administrative sanctions against local officials. The omission of as may be provided by law, Section 4, Article X, signifies nothing more than to underscore local government's autonomy from Congress and to break Congress' control over local government affairs. The Constitution did not, however, intend for the sake of local autonomy, to deprive the legislature of all authority over municipal corporations, in particular, concerning discipline. Petitioners are under the impression that the Constitution has left the President mere supervisory powers, which supposedly excludes the power of investigation, and denied her control, which allegedly embraces disciplinary authority. This is a mistaken impression because legally supervision is not incompatible with disciplinary authority. Control has been defined as the power of an officer to alter, modify or nullify or set aside what a subordinate officer had done in the performance of his duties and to substitute the judgment of the former for that of the latter. Supervision on the other hand means overseeing or the power or authority of an officer to see that subordinate officers perform their duties. Baitoanan vs. Fernandez, 350 SCRA 732, January 31, 2001, 3rd Division Gonzaga Reyes. Held, the power of supervision is defined as the power of a superior officer to see to it that lower officers perform their functions in accordance with law. This is distinguished from the power of control or the power of an officer to alter or modify or set aside what the subordinate officer had done in the performance of his duties and to substitute the judgment of the former for the latter. On many occasions in the past, this court has had the opportunity to distinguish the power of supervision from the power of control. In Tal vs. Santos, we held that the chief executive wielded no more authority than that of checking whether a local government or the officers thereof perform their duties as provided by statutory enactments. He cannot interfere with local governments provided that the same or its officers act within the scope of their authority. Supervisory power, when contrasted with control, is the power of mere oversight over an inferior body. It does not include any restraining authority over such body. Officers in control lay down the rules in the doing of an act. If they are not followed, it is discretionary on his part to order the act undone or redone by his subordinate, or he may even decide to do it himself. Supervision does not cover such authority. Supervising officers merely sees to it that the rules are followed, but he himself does not lay down such rules, nor does he have the discretion to modify or replace them. If the rules are not observed, he may order the work done or redone to conform to the prescribed rules. He cannot prescribe his own manner for the doing of the act. Drilon vs. Lim, 235 SCRA 135, August 4, 1994, and Bank Cruz. Held, the difference between control and supervision was further delineated. Officers in control lay down the rules in the performance or accomplishment of an act. If these rules are not followed, they may, in their discretion, order the act undone or redone by their subordinates, or even decide to do it themselves. On the other hand, supervision does not cover such authority. Supervising officials merely see to it that the rules are followed, but they themselves do not lay down such rules, nor do they have the discretion to modify or replace them. If the rules are not observed, they may order the work done or redone, but only to conform to such rules. They may not prescribe their own manner of execution of the act. They have no discretion on this matter except to see to it that the rules are followed. Josen vs. Torres, 290 SCRA 279, May 20, 1998. Puno. Held, the power of supervision means overseeing or the authority of an officer to see that the subordinate officers perform their duties. If the subordinate officers fail or neglect to fulfill their duties, the official may take such action or step as prescribed by law to make them perform their duties. The President's power of general supervision means no more than the power of ensuring that laws are faithfully executed, or that subordinate officers act within the law. Supervision is not incompatible with discipline. And the power to discipline and ensure that the laws be faithfully executed must be construed to authorize the President to order an investigation of the act or conduct of local officials when in his opinion the good of the public service so requires. The appointing power of the President. Appointment may be defined as the selection, by the authority vested with the power, of an individual who is to exercise the functions of a given office. Cruz. Appointment is the selection, by the authority vested with the power, of an individual who is to exercise the functions of a given office. It is distinguished from designation in that the latter simply means the imposition of additional duties, usually by law, on a person already in the public service. It is also different from the commission in that the latter is the written evidence of the appointment. Nakura. The power of appointment is, according to the SC in Concepcion vs. Paredes, the most eminently executive power, because it is through his appointees that the President can execute laws. The power of appointment by the President under the 1987 Constitution has been significantly curbed. It can be classified as follows. I. Permanent or temporary. Permanent appointments are those extended to persons possessing the requisite eligibility and are thus protected by the constitutional guarantee of security of tenure. Temporary appointments are given to persons without such eligibility, revocable at will and without the necessity of just cause or a valid investigation, made on the understanding that the appointing power has not yet decided on a permanent appointee and that the temporary appointee may be replaced at any time a permanent choice is made. A temporary appointment and a designation are not subject to confirmation by the Commission on Appointments. Such confirmation, if given erroneously, will not make the incumbent a permanent appointee. Valencia vs. Peralta, 8 SCRA 692. In Binamira vs. Carrijo, 188 SCRA 154. It was held that where a person is merely designated and not appointed, the implication is that he shall hold the office only in a temporary capacity and may be replaced at will by the appointing authority. In this sense, a designation is considered only an acting or temporary appointment which does not confer security of tenure on a person named. 2. Regular or ad interim. A regular appointment is one made by the President while Congress is in session, takes effect only after confirmation by the Commission on Appointments, and once approved, continues until the end of the term of the appointee. An ad interim appointment is one made by the President while Congress is not in session, takes effect immediately, but ceases to be valid if disapproved by the Commission on Appointments or upon the next adjournment of Congress. In the latter case, the ad interim appointment is deemed bypassed through inaction and deemed disapproved by the Commission on Appointments. The ad interim appointment is intended to prevent a hiatus in the discharge of official duties. An ad interim appointment is a permanent appointment payment to G. Lungsod Ng Manila vs. Intermediate Appellate Court, 140 SCRA 22. Steps in the appointing process. 1. Nomination by the President. 2. Confirmation by the Commission on Appointments. 3. Issuance of the Commission. 4. Acceptance by the appointee. In Lacson v. Romero, 84 Phil 740, the Supreme Court declared that an appointment is deemed complete only upon its acceptance. Pending such acceptance, which is optional to the appointee, the appointment may still be validly withdrawn. Appointment to a public office cannot be forced upon any citizen except for the purposes of defense of the state under Section 4, Article 2, as an exception to the rule of voluntary servitude. Discretion of appointing authority. Appointment is essentially a discretionary power and must be performed by the officer in which it is vested according to his best lights, the only condition being that the appointee should possess the minimum qualification requirements prescribed by law for the position. See Luego v. Civil Service Commission, 143 SCRA 327, Lay Pined v. Civil Service Commission, 197 SCRA 106, Pabra v. Mendieta, 224 SCRA 738. Presidential appointees under the Constitution. A. Heads of the Executive Departments, Article 7, Section 16. B. Ambassadors, other public ministers and consuls, id. C. Officers of the Armed Forces of the Philippines with the rank of colonel or naval captain, because these are officers of a sizable command enough to stage a coup, id. D. Other officers whose appointments are vested in the President in the Constitution. I. Chairmen and Commissioners of the Constitutional Commissions. 2. Regular members of the Judicial and Bar Council, composed of the IBP representative, professor of law, retired SC Justice, and representative of the private sector. Note the ex officio members, Chief Justice, Secretary of Justice, and representative of Congress. 3. Sectoral representatives, now an obsolete provision. 4. Regional Consultative Commission. Upon recommendation of the Judicial and Bar Council. A. Members of the Supreme Court and all other courts. B. Ombudsman and his 5 deputies, for Luzon, Visayas, Mindanao, general and military. Appointment of Vice President as member of the Cabinet. Appointments solely by the President. 1. Those vested by the Constitution on the President alone, for example appointment of Vice President to the Cabinet, Article 7, Section 3(2). 2. Those whose appointments are not otherwise provided by law. 3. Those whom he may be authorized by law to appoint. 4. Those other officers lower in rank whose appointment is vested by law in the President, alone. Section 16, Article 7, 1987 Constitution. Section 16. The President shall nominate and, with the consent of the Commission on Appointments, appoint the heads of the executive departments, ambassadors, other public ministers and consuls, or officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. He shall also appoint all other officers of the government whose appointments are not otherwise provided for by law, and those whom he may be authorized by law to appoint. The Congress may, by law, vest the appointment of other officers lower in rank in the President alone, in the courts, or in the heads of departments, agencies, commissions, or boards. The President shall have the power to make appointments during the recess of the Congress, whether voluntary or involuntary, but such appointments shall be effective only until after disapproval by the Commission on Appointments or until the next adjournment of the Congress. Sarmiento vs. Misson, 156 SCRA 549. Held, under Section 16, Article 7, of the Constitution, there are 4 groups of officers of the government to be appointed by the President. 1. The heads of the executive departments, ambassadors, other public ministers and consuls, officers of the armed forces from the rank of colonel or naval captain, and other officers whose appointments are vested in him in this Constitution. 2. All other officers of the government whose appointments are not otherwise provided for by law. 3. Those whom the President may be authorized by law to appoint. 4. Officers lower in rank whose appointments the Congress may by law vest in the President alone. It is well settled that only presidential appointees belonging to the first group require the confirmation by the Commission on Appointments. Calderon v. Carrill, 208 SCRA 254, April 22, 1992, and Bank Padilla. Held, from the cases of Sarmiento III v. Misson, 156 SCRA 549, Mary Concepcion Bautista v. Salonga, 172 SCRA 160, and Teresita Quindosdales, et al. Versus the Commission on Constitutional Commission, et al., 177 SCRA 259, these doctrines are deducible. 1. Confirmation by the Commission on Appointments is required only for presidential appointees mentioned in the first sentence of Section 16, Article 7, including those officers whose appointments are expressly vested by the Constitution itself in the President, like sectoral representatives to Congress and members of the Constitutional Commissions of Audit, Civil Service and Election. 2. Confirmation is not required when the President appoints other government officers whose appointments are not otherwise provided for by law or those officers whom he may be authorized by law to appoint, like the Chairman and members of the Commission on Human Rights. Also, as observed in Misson, when Congress creates inferior offices but omits to provide for appointment thereto, or provides in an unconstitutional manner for such appointments, the officers are considered as among those whose appointments are not otherwise provided for by law. Manalo v. Sistosa, 312 SCRA 239, August 11, 1999, and Bank Purisima. Held, unconstitutional are Sections 26 and 31 of Republic Act 6975, Dilg Act, which empower the Commission on Appointments to confirm the appointments of public officials whose appointments are not required by the Constitution to be confirmed. The police force is different from and independent of the armed forces, and the ranks in the military are not similar to those in the Philippine National Police. Thus, directors and chief superintendents of the plug-and-play do not fall under the first category of presidential appointees requiring confirmation by the Commission on Appointments. Bermudez v. Executive Secretary, GR No. 131429, August 4, 1999, 3rd Division VITUG. Held, this question would pivot on the proper understanding of the provision of the Revised Administrative Code of 1987, Book 4, Title 3, Chapter 2, Section 9, to the effect that all provincial and city prosecutors and their assistants shall be appointed by the President upon the recommendation of the Secretary. Petitioners contend that an appointment of a provincial prosecutor mandatorily requires a prior recommendation of the Secretary of Justice endorsing the intended appointment. When the Constitution or the law clothes the President with the power to appoint a subordinate officer, such conferment must be understood as necessarily carrying with it an ample discretion of whom to appoint. It should be here pertinent to state that the President is the head of government whose authority includes the power of control over all executive departments, bureaus and offices. Control means the authority of an empowered officer to alter or modify, or even nullify or set aside, what a subordinate officer has done in the performance of his duties, as well as to substitute the judgment of the latter, as and when the former deems it to be appropriate. Expressed in another way, the President has the power to assume directly the functions of an executive department, bureau and office. It can accordingly be inferred therefrom that the President can interfere in the exercise of discretion of officials under him or altogether ignore their recommendations. It is the considered view of the court that the phrase "upon recommendation of the Secretary," found in Section 9, Chapter 2, Title 3, Book 4, of the Revised Administrative Code, should be interpreted to be a mere advice, exhortation or endorsement, which is essentially persuasive in character and not binding or obligatory upon the party to whom it is made. The recommendation is here nothing really more than advisory in nature. The President, being the head of the executive department, could very well disregard or do away with the action of the departments, bureaus or offices even in the exercise of discretionary authority, and in so opting, he cannot be said as having acted beyond the scope of his authority. Limitations on the appointing power of the President. Section 13, Second Part, Article 7, 1987 Constitution. The spouse and relatives by consanguinity or affinity within the fourth civil degree of the President shall not during his tenure be appointed as members of the constitutional commissions, or the office of the Ombudsman, or as secretaries, undersecretaries, chairmen or heads of bureaus or offices, including government-owned or controlled corporations and their subsidiaries. Section 15, Article 7. 1987 Constitution. Section 15. 2 months immediately before the next presidential elections and up to the end of his term, a president or acting president shall not make appointments, except temporary appointments to executive positions when continued vacancies therein will prejudice public service or endanger public safety. In re, Honorable Mateo A. Valenzuela and Honorable Plachita B. Vallarta, 298 SCRA 408, November 9, 1998, and Bank Narvasa. Held, Section 15, Article 7 is directed against two types of appointments: 1. Those made for buying votes and, 2. Those made for partisan considerations. The first refers to those appointments made within 2 months preceding the presidential election and are similar to those which are declared election offenses in the Omnibus Election Code, while the second consists of the so-called midnight appointments. The SCN clarified this when it held. Section 15, Article 7 has a broader scope than the Tano ruling. It may not unreasonably be deemed to contemplate not only midnight appointments, those made obviously for partisan reasons as shown by their number and the time of their making, but also appointments presumed made for the purpose of influencing the outcome of the presidential election. Durama v. C.A., 353 SCRA 94, February 28, 2001. And Banquiners Santiago, Section 15, Article 7, 1987 Constitution applies only to presidential appointments. There is no law that prohibits a local chief executive from making appointments before her term ends. Held, the records reveal that when the petitioner brought the matter of recalling the appointments of the 14 private respondents before the CSC, the only reason he cited to justify his action was that these were midnight appointments that are forbidden under Article 7, Section 15 of the Constitution. However, the CSC ruled, and correctly so, that the said prohibition applies only to presidential appointments. In truth and in fact, there is no law that prohibits local elective officials from making appointments during the last days of his or her tenure. Petitioner certainly did not raise the issue of fraud on the part of the outgoing mayor who made the appointments. Neither did he allege that the said appointments were tainted by irregularities or anomalies that breached laws and regulations governing appointments. His solitary reason for recalling these appointments was that they were, to his personal belief, midnight appointments which the outgoing mayor had no authority to make. The CSC correctly ruled, however, that the constitutional prohibition on so-called midnight appointments, specifically those made within 2 months immediately prior to the next presidential elections, applies only to the president or acting president. Exception: temporary appointments, to executive positions, when continued vacancies therein will, 1. Prejudice public service, for example postmaster, or, 2. Endanger public safety, for example chief of staff. Regular and recess, ad interim, appointments. Article 7, Section 16. The President shall have the power to make appointments during the recess of Congress, whether voluntary or compulsory, but such appointment shall be effective only until disapproval by the Commission on Appointments or until the next adjournment of the Congress. Appointments requiring confirmation are of two kinds: I. Regular, if the CA, that is, Congress, is in session, or, 2. During the recess of Congress, because the Commission shall meet only while Congress is in session. Article VI, Section 19. Regular appointments require confirmation before the appointee can take his post. The President nominates, Congress receives the nomination and forwards this to the CA for confirmation, then the office of the President issues a commission, at which point the appointee can assume his office. Recess appointments, on the other hand, need no confirmation to be effective, albeit temporarily. The appointment is effective until it is disapproved by the Commission on Appointments, or until the next adjournment of Congress, unless meantime, it is confirmed by the Commission. Article 7, Section 16, Paragraph 2. Q. Discuss the nature of an ad interim appointment. Is it temporary and, therefore, can be withdrawn or revoked by the President at her pleasure? A. In the case of Mattibag v. Spenopeo, 380 SCRA 49, the SC stated that an ad interim appointment is a permanent appointment because it takes effect immediately and can no longer be withdrawn by the President once the appointee has qualified into office. The fact that it is subject to confirmation by the Commission on Appointments does not alter its permanent character. The Constitution itself makes an ad interim appointment permanent in character by making it effective until disapproved by the Commission on Appointments or until the next adjournment of Congress. Q. How is an ad interim appointment terminated? Held. An ad interim appointment can be terminated for two causes specified in the Constitution. The first cause is the disapproval of his ad interim appointment by the Commission on Appointments. The second cause is the adjournment of Congress without the Commission on Appointments acting on his appointment. These two causes are resolutory conditions expressly imposed by the Constitution on all ad interim appointments. These resolutory conditions constitute, in effect, a sword of Damocles over the heads of ad interim appointees. No one, however, can complain because it is the Constitution itself that places the sword of Damocles over the heads of the ad interim appointees. Mattibag v. Spenopeo, 380 SCRA 49, April 2, 2002, and Bank Carpio. Q. How is an ad interim appointment distinguished from an appointment or designation in an acting or temporary capacity? Held. While an ad interim appointment is permanent and irrevocable except as provided by law, an appointment or designation in a temporary or acting capacity can be withdrawn or revoked at the pleasure of the appointing power. A temporary or acting appointee does not enjoy any security of tenure, no matter how briefly. Mattibag v. Spenopeo, 380 SCRA 49, April 2, 2002, and Bank Carpio. Limitations on the appointing power of the acting President. Article 7, Section 14. Appointments extended by an acting President shall remain effective unless revoked by the elected President within 90 days from his assumption or reassumption of office. The military powers of the President. Section 18, Article 7, 1987 Constitution. Section 18. The President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus or place the Philippines or any part thereof under martial law. Within 48 hours from the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus, the President shall submit a report in person or in writing to the Congress. The Congress, voting jointly, by a vote of at least a majority of all its members in regular or special session, may revoke such proclamation or suspension, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by the Congress, if the invasion or rebellion shall persist and public safety requires it. The Congress, if not in session, shall, within 24 hours following such proclamation or suspension, convene in accordance with its rules without any need of a call. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law or the suspension of the privilege of the writ or the extension thereof, and must promulgate its decision thereon within 30 days from its filing. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or the legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians where civil courts are able to function, nor automatically suspend the privilege of the writ. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent and or directly connected with the invasion. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise he shall be released. As Commander-in-Chief of all armed forces of the Philippines, the President has the following powers. A. He may call out such armed forces to prevent or suppress lawless violence, invasion or rebellion. B. He may suspend the privilege of the writ of habeas corpus, or C. He may proclaim martial law over the entire Philippines or any part thereof. Subject to Article 8, Section 1 Paragraph 2. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excessive jurisdiction on the part of any branch or instrumentality of the government. Call out the AFP to prevent lawless violence, calling out powers. This is merely a police measure meant to quell disorder. As such, the Constitution does not regulate its exercise radically. David v. Macapagal Arroyo, GR number 171396, May 3, 2006. Issue: WNPP number 1017 is a declaration of martial law or the exercise of the President of her calling out powers. Held, Section 18, Article 7 grants the President, as Commander-in-Chief, a sequence of graduated powers. From the most to the least benign, these are, the calling out power, the power to suspend the privilege of the writ of habeas corpus, and the power to declare martial law. Citing Integrated Bar of the Philippines v. Zamora, the court ruled that the only criterion for the exercise of the calling out power is that whenever it becomes necessary, the President may call the armed forces to prevent or suppress lawless violence, invasion or rebellion. Are these conditions present in the instant cases? As stated earlier, considering the circumstances then prevailing, President Arroyo found it necessary to issue pages 1017. Owing to her office's vast intelligence network, she is in the best position to determine the actual condition of the country. Under the calling out power, the President may summon the armed forces to aid him in suppressing lawless violence, invasion and rebellion. This involves ordinary police action. But every act that goes beyond the President's calling out power is considered illegal or ultra vires. For this reason, a President must be careful in the exercise of his powers. He cannot invoke a greater power when he wishes to act under a lesser power. There lies the wisdom of our Constitution: the greater the power, the greater are the limitations. In declaring a state of national emergency, President Arroyo did not only rely on Section 18, Article 7 of the Constitution, a provision calling on the AFP to prevent or suppress lawless violence, invasion or rebellion. She also relied on Section 17, Article 12, a provision on the state's extraordinary power to take over privately owned public utility and business affected with public interest. Indeed, pages 1017 calls for the exercise of an awesome power. Some of the petitioners vehemently maintain that pages 1017 is actually a declaration of martial law. It is not so. What defines the character of pages 1017 are its wordings. It is plain therein that what the President invoked was her calling out power. The declaration of martial law is a warning to citizens that the military power has been called upon by the executive to assist in the maintenance of law and order, and that, while the emergency lasts, they must, upon pain of arrest and punishment, not commit any acts which will in any way render more difficult the restoration of order and the enforcement of law. In his statement before the Senate Committee on Justice on March 13, 2006, Mr. Justice Vicente V. Mendoza, an authority in constitutional law, said that of the three powers of the President as Commander-in-Chief, the power to declare martial law poses the most severe threat to civil liberties. It is a strong medicine which should not be resorted to lightly. It cannot be used to stifle or persecute critics of the government. It is placed in the keeping of the President for the purpose of enabling him to secure the people from harm and to restore order so that they can enjoy their individual freedoms. In fact, Section 18, Article 7, provides, "A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians where civil courts are able to function, nor automatically suspend the privilege of the writ." Justice Mendoza also stated that pages 1017 is not a declaration of martial law. It is no more than a call by the President to the armed forces to prevent or suppress lawless violence. As such, it cannot be used to justify acts that only under a valid declaration of martial law can be done. Its use for any other purpose is a perversion of its nature and scope, and any act done contrary to its command is ultra vires. Justice Mendoza further stated that specifically, a. Arrests and seizures without judicial warrants, b. Ban on public assemblies, c. Takeover of news media and agencies and press censorship, and d. Issuance of presidential decrees, are powers which can be exercised by the President as Commander-in-Chief only where there is a valid declaration of martial law or suspension of the writ of habeas corpus. Based on the above disquisition, it is clear that pages 1017 is not a declaration of martial law. It is merely an exercise of President Arroyo's calling out power for the armed forces to assist her in preventing or suppressing lawless violence. The court finds and so holds that pages 1017 is constitutional insofar as it constitutes a call by the President for the AFP to prevent or suppress lawless violence. The proclamation is sustained by Section 18, Article 7 of the Constitution and the relevant jurisprudence discussed earlier. However, pp 1017's extraneous provisions giving the President express or implied power, 1. To issue decrees, 2. To direct the AFP to enforce obedience to all laws even those not related to lawless violence as well as decrees promulgated by the President, and 3. To impose standards on media or any form of prior restraint on the press, are ultra vires and unconstitutional. On the basis of the relevant and uncontested facts narrated earlier, it is also pristine clear that, 1. The warrantless arrest of petitioners Randolph S. David and Ronald Lamas, 2. The dispersal of the rallies and warrantless arrest of the KMU and NAFLU-KMU members, 3. The imposition of standards on media or any prior restraint on the press, and 4. The warrantless search of the Tribune offices and the whimsical seizures of some articles for publication and other materials, are not authorized by the Constitution, the law and jurisprudence. Not even by the valid provisions of pages 1017 and GO number 5. Q. Distinguish the President's power to call out the armed forces as their Commander-in-Chief in order to prevent or suppress lawless violence, invasion or rebellion, from his power to proclaim martial and suspend the privilege of the writ of habeas corpus. Explain why the former is not subject to judicial review while the latter two are. Held. There is a clear textual commitment under the Constitution to bestow on the President full discretionary power to call out the armed forces and to determine the necessity for the exercise of such power. Section 18, Article 7 of the Constitution, which embodies the powers of the President as Commander-in-Chief, provides in part. The President shall be the Commander-in-Chief of all armed forces of the Philippines and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion or rebellion. In case of invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus, or place the Philippines or any part thereof under martial law. The full discretionary power of the President to determine the factual basis for the exercise of the calling out power is also implied and further reinforced in the rest of Section 18, Article 7. Under the foregoing provisions, Congress may revoke such proclamations, of martial law, or suspension, of the privilege of the writ of habeas corpus, and the court may review the sufficiency of the factual basis thereof. However, there is no such equivalent provision dealing with the revocation or review of the President's action to call out the armed forces. The distinction places the calling out power in a different category from the power to declare martial law and the power to suspend the privilege of the writ of habeas corpus. Otherwise, the framers of the Constitution would have simply lumped together the three powers and provided for their revocation and review without any qualification. Expressio uniosa state exclusio alterius. That the intent of the Constitution is exactly what its letter says, that is, that the power to call is fully discretionary to the President, is extant in the deliberation of the Constitutional Commission. The reason for the difference in the treatment of the aforementioned powers highlights the intent to grant the President the widest leeway and broadest discretion in using the power to call out because it is considered as the lesser and more benign power compared to the power to suspend the privilege of the writ of habeas corpus and the power to impose martial law, both of which involve the curtailment and suppression of certain basic civil rights and individual freedoms, and thus necessitating safeguards by Congress and review by this court. Moreover, under Section 18, Article 7 of the Constitution, in the exercise of the power to suspend the privilege of the writ of habeas corpus or to impose martial law, two conditions must concur: 1. There must be an actual invasion or rebellion and, 2. Public safety must require it. These conditions are not required in the case of the power to call out the armed forces. The only criterion is that whenever it becomes necessary, the President may call the armed forces to prevent or suppress lawless violence, invasion or rebellion. The implication is that the President is given full discretion and wide latitude in the exercise of the power to call as compared to the two other powers. If the petitioner fails, by way of proof, to support the assertion that the President acted without factual basis, then this court cannot undertake an independent investigation beyond the pleadings. The factual necessity of calling out the armed forces is not easily quantifiable and cannot be objectively established since matters considered for satisfying the same is a combination of several factors which are not always accessible to the courts. Besides the absence of textual standards that the court may use to judge necessity, information necessary to arrive at such judgment might also prove unmanageable for the courts. Certain pertinent information might be difficult to verify, or wholly unavailable to the courts. In many instances, the evidence upon which the President might decide that there is a need to call out the armed forces may be of a nature not constituting technical proof. On the other hand, the President as Commander-in-Chief has a vast intelligence network to gather information, some of which may be classified as highly confidential or affecting the security of the state. In the exercise of the power to call, on-the-spot decisions may be imperatively necessary in emergency situations to avert great loss of human lives and mass destruction of property. Indeed, the decision to call out the military to prevent or suppress lawless violence must be done swiftly and decisively if it were to have any effect at all. Such a scenario is not far-fetched when we consider the present situation in Mindanao, where the insurgency problem could spill over the other parts of the country. The determination of the necessity for the calling out power if subjected to unfettered judicial scrutiny could be a veritable prescription for disaster, as such power may be unduly straitjacketed by an injunction or a temporary restraining order every time it is exercised. Thus, it is the unclouded intent of the Constitution to vest upon the President, as Commander-in-Chief of the Armed Forces, full discretion to call forth the military when in his judgment it is necessary to do so in order to prevent or suppress lawless violence, invasion, or rebellion. Unless the petitioner can show that the exercise of such discretion was gravely abused, the President's exercise of judgment deserves to be accorded respect from this court. Integrated Bar of the Philippines vs. Honorable Ronaldo B. Zamora, GR number 141284. August 15, 2000, and Bank Kapunan. Suspend the privilege of the writ of habeas corpus. A writ of habeas corpus is an order from the court commanding a detaining officer to inform the court, I, if he has the person in custody, and, 2, what his basis in detaining that person. The privilege of the writ is that portion of the writ requiring the detaining officer to show cause why he should not be tested. Note that it is the privilege that is suspended, not the writ itself. Requisites. 1. There must be an invasion or rebellion, and 2. The public safety requires the suspension. Effects of the suspension of the privilege. 1. The suspension of the privilege of the writ applies only to persons judicially charged for rebellion or offenses inherent and or directly connected with invasion, Article 7, Section 18, Paragraph 5. Such persons suspected of the above crimes can be arrested and detained without a warrant of arrest. Judicially charged as used in the Constitution is imprecise. For if one were already judicially charged, his detention would be legal and so he could no longer petition for habeas corpus. Habeas corpus precisely contemplates a situation in which a person is being detained without being charged in court. Thus, the provision should read one who is suspected of complicity in the 2 crimes above. As a general rule, no person could be arrested without a warrant of arrest, validly issued upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses, cf. Article 3, Section 2, unless, I, the arrest was made in connection with a crime committed in the presence of the detaining officer, or, 2, the privilege of the writ was suspended. If the public officer arrests him without a warrant, the officer becomes liable for arbitrary detention under Article 124 of the RPC, and a petition for habeas corpus can be filed to seek his release. The suspension of the privilege does not make the arrest without warrant legal. But the military is, in effect, enabled to make the arrest, anyway since, with the suspension of the privilege, there is no remedy available against such unlawful arrest, arbitrary detention. The arrest without warrant is justified by the emergency situation and the difficulty in applying for a warrant considering the time and the number of persons to be arrested. But the crime for which he is arrested must be one related to rebellion or the invasion. As to other crimes, the suspension of the privilege does not apply. 2. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, or otherwise he shall be released. Article 7, Section 18, Paragraph 6. In other words, the public officer can detain a person without warrant of arrest, but he can only do so for 72 hours. Before the lapse of 72 hours, an information must have been filed in the proper court charging him of the offense for which he was arrested. Under the rules of criminal procedure, if the detainee wants a preliminary investigation to be first conducted by the fiscal, he must sign a waiver of the effects of Article 125. Delay in the delivery of detained persons. The effect of the suspension of the privilege, therefore, is only to extend the periods during which he can be detained without a warrant. Under Article 125, as amended by EO 272, the public officer can only detain him for 12, 18 or 36 hours depending on the gravity of the offense of which he is charged. Within this time, he must be judicially charged, otherwise, he must be released. When the privilege is suspended, the period is extended to 72 hours. What happens if he is not judicially charged nor released after 72 hours? The public officer becomes liable under Article 125 for delay in the delivery of detained persons. As to the detainee, it is submitted that he or someone else in his behalf can file a petition for habeas corpus. For even if the suspension has a lifetime of 60 days in general, as to that person, the suspension only has an effectivity of 72 hours, so that after this time, the suspension is lifted as to him. 3. The right to bail shall not be impaired even when the privilege of the writ of habeas corpus is suspended. Article 3, Section 13. Proclaim martial law. Requisites. 1. There must be an invasion or rebellion, and 2. Public safety requires the proclamation of martial law all over the Philippines or any part thereof. Effects of the proclamation of martial law. The President can 1. Legislate. 2. Order the arrest of people who obstruct the war effort. But the following cannot be done. Article 7, Section 18, Paragraph 4. 1. Suspend the operation of the Constitution. 2. Supplant the functioning of the civil courts and the legislative assemblies. The principle is that martial law is proclaimed only because the courts and other civil institutions like Congress have been shut down. It should not happen that martial law is declared in order to shut down the civil institutions. 3. Confer jurisdiction upon military courts and agencies over civilians, where civil courts are unable to function. This is the open court doctrine, which holds that civilians cannot be tried by military courts if the civil courts are open and functioning. But if the civil courts are not functioning, then civilians can be tried by the military courts. Martial laws usually contemplates a case where the courts are already closed and the civil institutions have already crumbled, that is a theater of war. If the courts are still open, the President can just suspend the privilege and achieve the same effect. 4. Automatically suspend the privilege of the writ of habeas corpus. The role of Congress. A. When the President proclaims martial law or suspends the privilege of the writ, such proclamation or suspension shall be effective for a period of 60 days, unless sooner revoked by the Congress. B. Upon such proclamation or suspension, Congress shall convene at once. If it is not in session, it shall convene in accordance with its rules without need of a call within 24 hours following the proclamation or suspension. C. Within 48 hours from the proclamation or the suspension, the President shall submit a report, in person or in writing, to the Congress, meeting in joint session of the action he has taken. D. The Congress shall then vote jointly, by an absolute majority. It has two options. I. To revoke such proclamation or suspension. When it so revokes, the President cannot set aside, or veto, the revocation she normally would do in the case of bills. If Congress does not do anything, the measure will expire anyway in 60 days. So the revocation must be made before the lapse of 60 days from the date the measure was taken. 2. To extend it beyond the 60-day period of its validity. Congress can only so extend the proclamation or suspension upon initiative of the President. The period need not be 60 days, it could be more, as Congress would determine, based on the persistence of the emergency. If Congress fails to act before the measure expires, it can no longer extend it until the President again redeclares the measure, for how do one extend something that has already lapsed? Note that Congress cannot validate the proclamation or suspension, because it is already valid. It is thus restricted to the two measures above. If Congress extends the measure, but before the period of extension lapses, the requirements for the proclamation or suspension no longer exist, Congress can lift the extension, since the power to confer implies the power to take back. If Congress does not review or lift the order, this can be reviewed by the Supreme Court pursuant to the next section. The role of the Supreme Court. The Supreme Court may review, in an appropriate proceeding filled by any citizen, the sufficiency of the factual basis of, a. the proclamation of martial law or the suspension of the privilege of the writ, or, b. the extension thereof. It must promulgate its decision thereon within 30 days from its filing. Article 7, Section 18, Paragraph 3. This is because judicial power includes the duty to determine whether or not there has been a grave abuse of discretion amounting to lack or excessive jurisdiction on the part of any branch or instrumentality of the government. Article 8, Section 1, Paragraph 2. The jurisdiction of the SC may be invoked in a proper case. A petition for habeas corpus is one such case. When a person is arrested without a warrant for complicity in the rebellion or invasion, he or someone else in his behalf has the standing to question the validity of the proclamation or suspension. But before the SC can decide on the legality of his detention, it must first pass upon the validity of the proclamation or suspension. The test to be used by the Supreme Court in so reviewing the act of the President in proclaiming or suspending, or the act of Congress in extending, is the test of arbitrariness, which seeks to determine the sufficiency of the factual basis of the measure. The question is not whether the President or Congress acted correctly, but whether he acted arbitrarily and that the action had no basis in fact. Deciding on whether the act was arbitrary amounts to a determination of whether or not there was grave abuse of discretion amounting to lack or excessive jurisdiction, which is now made part of judicial power by Article 8, Section 1, Paragraph 2. This curbs radically the application of the political question doctrine. This test was taken from the case of Lansing v. Garcia, 42 SCRA 446, 1971. The issue there raised was whether in suspending the privilege of the writ in 1971, Marcos had a basis for doing so. The SC, in considering the fact that the President based his decision on a. the Senate report on the condition in central Luzon and b. a closed-door briefing by the military showing the extent of subversion, concluded that the President did not act arbitrarily. One may disagree with his appreciation of the facts, but one cannot say that it is without basis. In this case of Lansing v. Garcia, the SC held unanimously that it has the authority to inquire into the existence of the factual basis in order to determine the constitutional sufficiency thereof. This holding of the SC is now found in Article 7, Section 18, Paragraph 3. There are 4 ways, then, for the proclamation or suspension to be lifted. 1. Lifting by the President himself. 2. Revocation by Congress. 3. Nullification by the Supreme Court. 4. Operation of law after 60 days. Military trial of civilians void even under martial law, if civil courts are open. Article 7, Section 18, Paragraph 5. In the case of Olegre v. Military Commission No. 34, 150 SCRA 144, the Aquino v. Military Commission No. 2 decision was reversed. According to the SC, civilians who are placed on trial for civil offenses under general law are entitled to trial by judicial process. Since we are not enemy-occupied territory nor are we under a military government, and even on the premise that martial law continues in force, the military tribunals cannot try and exercise jurisdiction over civilians for civil offenses committed by them which are properly cognizable by the civil courts that have remained open and have been regularly functioning. The assertion of military authority over civilians cannot rest on the President's power as Commander-in-Chief or on any theory of martial law. As long as civil courts remain open and are regularly functioning, military tribunals cannot try and exercise jurisdiction over civilians for offenses committed by them and which are properly cognizable by civil courts. To hold otherwise is a violation of the right to due process. Declaration of war and delegation of emergency powers. The Congress, by a vote of 2/3 of both houses in joint session assembled but voting separately, shall have the sole power to declare the existence of a state of war. Article V, Section 23(1). In times of war or other national emergency, the Congress may authorize the President, for a limited period and subject to such restrictions as the law may prescribe, to exercise powers necessary and proper to carry out a declared national policy. Such powers shall cease upon the next adjournment of Congress, unless sooner withdrawn by its resolution. Article V, Section 23(2). This grant of emergency power to the President is different from the Commander-in-Chief Clause. When the President acts under the Commander-in-Chief Clause, he acts under a constitutional grant of military power, which may include the lawmaking power. But when the President acts under the emergency power, he acts under a congressional delegation of lawmaking power. The scope of the grant is such power as necessary and proper to carry out a declared national policy. This power is, 1, for a limited period, and, 2, subject to such restrictions as Congress may provide. The power ceases, a, upon being withdrawn by resolution of the Congress, or, if Congress fails to adopt such resolution, b, upon the next, voluntary, adjournment of Congress. For the fact that Congress is able to meet in session uninterruptedly and adjourn of its own will proves that the emergency no longer exists as to justify the delegation. David v. Macapagal Arroyo, GR number 171396, May 3, 2006. Held, the pertinent provision of pages 1017 states, and to enforce obedience to all the laws and to all decrees, orders, and regulations promulgated by me personally or upon my direction, and as provided in Section 17, Article 12 of the Constitution, do hereby declare a state of national emergency. The import of this provision is that President Arroyo, during the state of national emergency under pages 1017, can call the military not only to enforce obedience to all the laws and to all decrees but also to act pursuant to the provision of Section 17, Article 12, which reads, Section 17. In times of national emergency, when the public interest so requires, the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. What could be the reason of President Arroyo in invoking the above provision when she issued pages 1017? The answer is simple. During the existence of the state of national emergency, pages 1017 purports to grant the President, without any authority or delegation from Congress, to take over or direct the operation of any privately owned public utility or business affected with public interest. Petitioners, particularly the members of the House of Representatives, claim that President Arroyo's inclusion of Section 17, Article 12 in pages 1017 is an encroachment on the legislature's emergency powers. This is an area that needs delineation. A distinction must be drawn between the President's authority to declare a state of national emergency and to exercise emergency powers. To the first, as elucidated by the Court, Section 18, Article 7 grants the President such power, hence, no legitimate constitutional objection can be raised. But to the second, manifold constitutional issues arise. Section 23, Article V of the Constitution reads. Section 23. 1. The Congress, by a vote of 2/3 of both houses in joint session assembled, voting separately, shall have the sole power to declare the existence of a state of war. 2. In times of war or other national emergency, the Congress may, by law, authorize the President, for a limited period and subject to such restrictions as it may prescribe, to exercise powers necessary and proper to carry out a declared national policy. Unless sooner withdrawn by resolution of the Congress, such powers shall cease upon the next adjournment thereof. It may be pointed out that the second paragraph of the above provision refers not only to war but also to other national emergency. If the intention of the framers of our Constitution was to withhold from the President the authority to declare a state of national emergency pursuant to Section 18, Article 7, calling out power, and grant it to Congress, like the declaration of the existence of a state of war, then the framers could have provided so. Clearly, they did not intend that Congress should first authorize the President before he can declare a state of national emergency. The logical conclusion then is that President Arroyo could validly declare the existence of a state of national emergency even in the absence of a congressional enactment. But the exercise of emergency powers, such as the taking over of privately owned public utility or business affected with public interest, is a different matter. This requires a delegation from Congress. Courts have often said that constitutional provisions in pari materia are to be construed together. Otherwise stated, different clauses, sections, and provisions of a constitution which relate to the same subject matter will be construed together and considered in the light of each other. Considering that Section 17 of Article 12 and Section 23 of Article V, previously quoted, relate to national emergencies, they must be read together to determine the limitation of the exercise of emergency powers. Generally, Congress is the repository of emergency powers. This is evident in the tenor of Section 23, 2, Article V authorizing it to delegate such powers to the President. Certainly, a body cannot delegate a power not reposed upon it. However, knowing that during grave emergencies, it may not be possible or practicable for Congress to meet and exercise its powers, the framers of our Constitution deemed it wise to allow Congress to grant emergency powers to the President, subject to certain conditions, thus: 1. There must be a war or other emergency. 2. The delegation must be for a limited period only. 3. The delegation must be subject to such restrictions as the Congress may prescribe. 4. The emergency powers must be exercised to carry out a national policy declared by Congress. Section 17, Article 12 must be understood as an aspect of the Emergency Powers Clause. The taking over of private business affected with public interest is just another facet of the emergency powers generally reposed upon Congress. Thus, when Section 17 states that the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest, it refers to Congress, not the President. Now, whether or not the President may exercise such power is dependent on whether Congress may delegate it to him pursuant to a law prescribing the reasonable terms thereof. Petitioner Cacho Olivares, et al. Contends that the term emergency under Section 17, Article 12 refers to tsunami, typhoon, hurricane and similar occurrences. This is a limited view of emergency. Emergency, as a generic term, connotes the existence of conditions suddenly intensifying the degree of existing danger to life or well-being beyond that which is accepted as normal. Implicit in this definitions are the elements of intensity, variety, and perception. Emergencies, as perceived by legislature or executive in the United States since 1933, have been occasioned by a wide range of situations, classifiable under three principal heads. A. Economic, B. Natural disaster, and C. National security. Emergency, as contemplated in our Constitution, is of the same breadth. It may include rebellion, economic crisis, pestilence or epidemic, typhoon, flood, or other similar catastrophe of nationwide proportions or effect. This is evident in the records of the Constitutional Commission, thus. Mr. Gaskin. Yes. What is the committee's definition of national emergency which appears in Section 13, page 5? It reads: When the common good so requires, the state may temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. Mr. Villegas. What I mean is threat from external aggression, for example, calamities or natural disasters. Mr. Gaskin. There is a question by Commissioner de los Reyes. What about strikes and riots? Mr. Villegas. Strikes, no. Those would not be covered by the term national emergency. Mr. Bengtson. Unless they are of such proportions such that they would paralyze government service. Mr. Tingson. May I ask the committee if national emergency refers to military national emergency or could this be economic emergency? Mr. Villegas. Yes, it could refer to both military or economic dislocations. Mr. Tingson. Thank you very much. It may be argued that when there is national emergency, Congress may not be able to convene and, therefore, unable to delegate to the President the power to take over privately owned public utility or business affected with public interest. In Araneta v. Stingleson, this court emphasized that legislative power, through which extraordinary measures are exercised, remains in Congress even in times of crisis. After all the criticisms that have been made against the efficiency of the system of the separation of powers, the fact remains that the Constitution has set up this form of government, with all its defects and shortcomings, in preference to the commingling of powers in one man or group of men. The Filipino people by adopting parliamentary government have given notice that they share the faith of other democracy-loving peoples in this system, with all its faults, as the ideal. The point is, under this framework of government, legislation is preserved for Congress all the time, not excepting periods of crisis no matter how serious. Never in the history of the United States, the basic features of whose Constitution have been copied in ours, have specific functions of the legislative branch of enacting laws been surrendered to another department, unless we regard as legislating the carrying out of a legislative policy according to prescribed standards. No, not even when that republic was fighting a total war, or when it was engaged in a life-and-death struggle to preserve the Union. The truth is that under our concept of constitutional government, in times of extreme perils more than in normal circumstances, the various branches, executive, legislative, and judicial, given the ability to act, are called upon to perform the duties and discharge the responsibilities committed to them respectively. Following our interpretation of Section 17, Article 12, invoked by President Arroyo in issuing pages 1017, this court rules that such proclamation does not authorize her during the emergency to temporarily take over or direct the operation of any privately owned public utility or business affected with public interest without authority from Congress. Let it be emphasized that while the President alone can declare a state of national emergency, however, without legislation, he has no power to take over privately owned public utility or business affected with public interest. The President cannot decide whether exceptional circumstances exist warranting the takeover of privately owned public utility or business affected with public interest. Nor can he determine when such exceptional circumstances have ceased. Likewise, without legislation, the President has no power to point out the types of businesses affected with public interest that should be taken over. In short, the President has no absolute authority to exercise all the powers of the state under Section 17, Article 7 in the absence of an Emergency Powers Act passed by Congress. Although the term of duty of the Chief of Staff of the AFP should not exceed 3 years, the President may extend such term of duty in times of war or other national emergency declared by Congress. Article 16, Section 57. Executive Clemencies. Section 19, Article 7, 1987 Constitution. Section 19. Except in cases of impeachment, or as otherwise provided in this Constitution, the President may grant reprieves, commutations and pardons, and remit fines and forfeitures, after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. Reprieve is a temporary relief from or postponement of execution of criminal penalty or sentence or a stay of execution. It does not more than stay the execution of a sentence extended to a prisoner to afford him an opportunity to procure some amelioration of the sentence imposed. Black, it is the withholding of a sentence for an interval of time, a postponement of execution, a temporary suspension of execution. People v. Vera. Commutation is a reduction of sentence. Black, it is a remission of a part of the punishment, a substitution of a less penalty for the one originally imposed. People v. Vera. Pardon is a permanent cancellation of sentence. Black, it is an act of grace proceeding from the power entrusted with the execution of the laws, which exempts the individual on whom it is bestowed, from the punishment the law inflicts for the crime he has committed. It is a remission of guilt, a forgiveness of the offense. People v. Vera. Kinds of pardon. Pardon may be classified into absolute or conditional and plenary or partial. An absolute pardon is one extended without any strings attached, so to speak, whereas a conditional pardon is one under which the convict is required to comply with certain requirements. A plenary pardon extinguishes all the penalties imposed upon the offender, including accessory disabilities, whereas partial pardon does not. Where the pardon is conditional, the offender has the right to reject the same since he may feel that the condition imposed is more onerous than the penalty sought to be remitted. But in the case of an absolute pardon, the pardon has no option at all and must accept it whether he likes it or not. In this sense, an absolute pardon is similar to commutation, which is also not subject to acceptance by the offender. Amnesty is a sovereign act of oblivion for past acts, granted by government generally to a class of persons who have been guilty usually of political offenses, treason, sedition, rebellion, and who are subject to trial but have not yet been convicted, and often conditioned upon their return to obedience and duty within a prescribed time. Black, Brown v. Walker, 161 U.S. 602. Probation is a disposition under which a defendant after conviction and sentence is released subject to conditions imposed by the court and to the supervision of a probation officer. Section 3, A, PD 968. Parole is the suspension of the sentence of a convict granted by a parole board after serving the minimum term of the indeterminate sentence penalty, without granting a pardon, prescribing the terms upon which the sentence shall be suspended. Pardon distinguished from probation. Probation and pardon are not coterminous, nor are they the same. They are actually distinct and different from each other, both in origin and nature. In probation, the probationer is in no true sense, as in pardon, a free man. He is not finally and completely exonerated. He is not exempt from the entire punishment which the law inflicts. Under the Probation Act, the probationer's case is not terminated by the mere fact that he is placed on probation. The probationer, during the period of probation, remains in legal custody subject to the control of the probation officer and of the court. He may be rearrested upon the non-fulfillment of the conditions of probation and, when rearrested, may be committed to prison to serve the sentence originally imposed upon him. People v. Vera, 65 Phil. 56, 1937. Notes: in both cases, there must be a final judgment of conviction, and the convict must be exempted from service of sentence. But pardon is granted by the chief executive for any crime, while probation is granted by the court after investigation by a probation officer only for cases where the penalty imposed does not exceed 6 years and 1 day, Brazen Mayer, where the crime is not against the security of the state, where there was no previous conviction for an offense punished by arrest Mayer, and where there was no previous availment of probation. In absolute pardon, the sentence and its effects, including the accessory penalties, are abolished upon the grant of pardon. In probation, the restoration of the probationer to his civil rights takes place only after his final discharge after the period of his probation. Section 14 and 16. Pardon distinguished from parole. Pardon may be granted by the chief executive under the Constitution and formerly the Administrative Code, at any time after final judgment of conviction, even before service, while parole is granted by the Board of Pardons and parole under the indeterminate sentence law only after the convict has served the minimum term of his sentence. In pardon, the convict becomes a free man. In parole, he is not really free because although he is released from the custody of the law, he must submit to periodic examination by the Board of Parole. Pardon distinguished from amnesty. 1. Pardon is usually granted for common crimes, amnesty, for political crimes. 2. Pardon is granted to individuals, amnesty, to a group, class, or community generally. 3. Pardon can only be granted after conviction, amnesty may be granted even before trial. 4. Pardon looks forward and relieves the offender from the consequences of an offense of which he has been convicted, that is, it abolishes or forgives the punishment. Amnesty looks backward and abolishes and puts into oblivion the offense itself, that is, it overlooks and obliterates the offense with which the convict is charged. That the person released stands precisely as though he had committed no offense. Barriaquinto v. Fernandez. 5. Pardon is a private act of the President which must be pleaded and proved by the person because the courts do not take judicial notice of it. Amnesty is a public act of which the courts take judicial notice. Cruz, Philippine Political Law, 1991 ed. 6. Pardon does not require the concurrence of the Congress, amnesty requires such concurrence. Id. Echegaray v. Secretary of Justice, 301 SCRA 96, January 19, 1999, and Bank Puno. Held, Section 19, Article 7 of the 1987 Constitution is simply the source of power of the President to grant reprieves, commutations, and pardons and remit fines and forfeitures after conviction by final judgment. This provision, however, cannot be interpreted as denying the power of courts to control the enforcement of their decisions after the finality. In truth, an accused who has been convicted by final judgment still possesses collateral rights, and these rights can be claimed in the appropriate courts. For instance, a death convict who becomes insane after his final conviction cannot be executed while in a state of insanity, see Article 79 of the Revised Penal Code. The suspension of such a death sentence is undisputably an exercise of judicial power. It is not usurpation of the presidential power of reprieve, though its effect is the same, the temporary suspension of the execution of the death convict. In the same vein, it cannot be denied that Congress can at any time amend RA No. 7659 by reducing the penalty of death to life imprisonment. The effect of such an amendment is like that of commutation of sentence. But by no stretch of the imagination can the exercise by Congress of its plenary power to amend laws be considered as a violation of the President's power to commute final sentences of conviction. The powers of the executive, the legislative and the judiciary to save the life of a death convict do not exclude each other for the simple reason that there is no higher right than the right to life. Monsanto v. Factorin, 170 SCRA 190. Held, while a pardon has generally been regarded as blotting out the existence of guilt so that in the eyes of the law the offender is as innocent as though he never committed the offense, it does not operate for all purposes. The very essence of a pardon is forgiveness or remission of guilt and not forgetfulness. It does not erase the fact of the commission of the crime and the conviction thereof. Pardon frees the individual from all the penalties and legal disabilities and restores to him all his civil rights. Unless expressly grounded on the person's innocence, it cannot bring back lost reputation for honesty, integrity and fair dealing. The pardoned offender regains his eligibility for appointment to public office which was forfeited by reason of the conviction of the offense. But since pardon does not generally result in automatic reinstatement because the offender has to apply for reappointment, he is not entitled to back wages. But, stated otherwise, if the pardon is based on the innocence of the individual, it affirms this innocence and makes him a new man and as innocent as if he had not been found guilty of the offense charged. When a person is given pardon because he did not truly commit the offense, the pardon relieves the party from all punitive consequences of his criminal act, thereby restoring to him his clean name, good reputation and unstained character prior to the finding of guilt. Garcia v. Chairman, Co. Held, our Constitution reposes in the President the power and the exclusive prerogative to extend executive clemency under the following circumstances, except in cases of impeachment or as otherwise provided in this Constitution. The President may grant reprieves, commutations, and pardons, and remit fines and forfeitures, after conviction by final judgment. He shall also have the power to grant amnesty with the concurrence of a majority of all the members of the Congress. In the case at bar, petitioner was found administratively liable for dishonesty and consequently dismissed from the service. However, he was later acquitted by the trial court of the charge of qualified theft based on the very same acts for which he was dismissed. The acquittal of petitioner by the trial court was founded not on lack of proof beyond reasonable doubt but on the fact that petitioner did not commit the offense imputed to him. Aside from finding him innocent of the charge, the trial court commended petitioner for his concern and dedication as a public servant. Verily, petitioner's innocence is the primary reason behind the grant of executive clemency to him, bolstered by the favorable recommendations for his reinstatement by the Ministry of Transportation and Communications and the Civil Service Commission. The bestowal of executive clemency on petitioner in effect completely obliterated the adverse effects of the administrative decision which found him guilty of dishonesty and ordered his separation from the service. This can be inferred from the executive clemency itself exculpating petitioner from the administrative charge and thereby directing his reinstatement, which is rendered automatic by the grant of the pardon. This signifies that petitioner need no longer apply to be reinstated to his former employment. He is restored to his office ipso facto upon the issuance of the clemency. In re, Wilfredo Sumia Long Torres, 251 SCRA 709, December 29, 1995 Hermosizuma. Held, a conditional pardon is in the nature of a contract between the sovereign power or the chief executive and the convicted criminal to the effect that the former will release the latter subject to the condition that if he does not comply with the terms of the pardon, he will be recommitted to prison to serve the unexpired portion of the sentence or an additional one. Alvarez v. Director of Prisons, 80 Phil. 50. By the pardon's consent to the terms stipulated in this contract, The pardon has thereby placed himself under the supervision of the chief executive or his delegate, who is duty-bound to see to it that the pardon complies with the terms and conditions of the pardon. Under Section 64I of the Revised Administrative Code, the chief executive is authorized to order the arrest and re-incarceration of any such person who, in his judgment, shall fail to comply with the condition, or conditions of his pardon, parole, or suspension of sentence. It is now a well-entrenched rule in this jurisdiction that this exercise of presidential judgment is beyond judicial scrutiny. The determination of the violation of the conditional pardon rests exclusively in the sounded judgment of the chief executive, and the pardon, having consented to place his liberty on conditional pardon upon the judgment of the power that has granted it, cannot invoke the aid of the courts, however erroneous the findings may be upon which his recommitment was ordered. The treaty-making power of the President. Section 21, Article 7, 1987 Constitution. Section 21. No treaty or international agreement shall be valid and effective unless concurred in by at least 2/3 of all the members of the Senate. Section 25, Article 18, 1987 Constitution. Section 25. After the expiration in 1991 of the agreement between the Republic of the Philippines and the United States of America concerning military bases, foreign military bases, troops, or facilities shall not be allowed in the Philippines except under a treaty duly concurred in by the Senate and, when the Congress so requires, ratified by a majority of the votes cast by the people in a national referendum held for that purpose, and recognized as a treaty by the other contracting state. The power to ratify is vested in the President and not, as commonly believed, in the legislature. The role of the Senate is limited only to giving or withholding its consent, or concurrence, to the ratification. Bayan v. Zamora, Gr. No. 138570, October 10, 2000. By reason of the President's unique position as head of state, he is the logical choice as the nation's spokesman in foreign relations. The Senate, on the other hand, is granted the right to share in the treaty-making power of the President by concurring with him with the right to amend. Treaty distinguished from executive agreements. Executive agreements entered into by the President need no concurrence. The reason is that although executive agreements are a kind of international agreements, when the Constitution intends to include executive agreements, it says so specifically, as in Article 8, Section 5, Paragraph 2, when it speaks of the power of the SC to review final judgments of lower courts in cases in which the constitutionality or validity of any treaty, international or executive agreement, is in question. In holding that treaties are formal documents which require ratification with approval of the Senate, while executive agreements become binding through executive action without need of a vote by the Senate, the SC and Commissioner of Customs v. Eastern Sea Trading, 3 SCRA 351, 1961, said that the difference between a treaty and an executive agreement is that a treaty is an international agreement involving political issues or changes of national policy and those involving international arrangements of a permanent character, while an executive agreement is an international agreement embodying adjustments of detail carrying out well-established national policies and traditions, and those involving arrangements of a more or less temporary nature. Nature of executive agreements. There are two classes. 1. Agreements made purely as executive acts affecting external relations and independent of or without legislative authorization, which may be termed as presidential agreements, and, 2. Agreements entered into in pursuance of acts of Congress, or congressional executive agreements. USAF Veterans Association v. Treasurer, 105 Phil 1030. Bayan v. Zamora, Gr. No. 138570, October 10, 2000, and Bank Buna. Held, the Phil. Government has complied with the Constitution in that the VFA was concurred in by the Phil. Senate, thus complying with Section 21, Article 7. The Republic of the Philippines cannot require the U.S. to submit the agreement to the U.S. Senate for concurrence, for that would be giving a strict construction to the phrase, recognized as a treaty. Moreover, It is inconsequential whether the U.S. treats the VFA as merely an executive agreement because under international law, an executive agreement is just as binding as a treaty. Limon Rosendo vs. Honorable Executive Secretary, GR number 151445, April 11, 2002, and Bank de Leon. Held, Anacon vs. Hernandez, 101 Phil. 1155, 1191 1957, we ruled that provisions of a treaty are always subject to qualification or amendment by a subsequent law, or that it is subject to the police power of the state. In Gonzalez vs. Hechanova, 9 SCRA 230, 242 1963. As regards the question whether an international agreement may be invalidated by our courts, suffice it to say that the Constitution of the Philippines has clearly settled it in the affirmative, by providing, in Section 2 of Article 8 thereof, that the Supreme Court may not be deprived of its jurisdiction to review, revise, reverse, modify, or affirm on appeal, certiorari, or writ of error as the law or the rules of court may provide, final judgments and decrees of inferior courts in 1. All cases in which the constitutionality or validity of any treaty, law, ordinance, or executive order or regulation is in question. In other words, our Constitution authorizes the nullification of a treaty, not only when it conflicts with the fundamental law, but, also, when it runs counter to an act of Congress. The foregoing premises leave no doubt that U.S. forces are prohibited from engaging in an offensive war on Philippine territory. Canada vs. Ongara, 272 SCRA 18 1997, and Bank Panganiban. Held, one of the oldest and most fundamental rules in international law is pacta sunt servanda, international agreements must be performed in good faith. A treaty engagement is not a mere moral obligation but creates a legally binding obligation on the parties. A state which has contracted valid international obligations is bound to make in its legislations such modifications as may be necessary to ensure the fulfillment of the obligations undertaken. Power of impoundment. Philconsa vs. Enriquez, 235 SCRA 506, August 9, 1994 Quiescen. Held, impoundment refers to the refusal of the President, for whatever reason, to spend funds made available by Congress. It is the failure to spend or obligate budget authority of any type. Proponents of impoundment have invoked at least three principal sources of the authority of the President. 1. The authority to impound given to him either expressly or impliedly by Congress. 2. The executive power drawn from the President's role as Commander-in-Chief. 3. The Faithful Execution Clause. The proponents insist that a faithful execution of the laws requires that the President desist from implementing the law if doing so would prejudice public interest. An example given is when through efficient and prudent management of a project, substantial savings are made. In such a case, it is sheer folly to expect the President to spend the entire amount budgeted in the law. Contracting and guaranteeing foreign loans. Article 7, Section 20. The President may contract or guarantee foreign loans on behalf of the Republic of the Philippines with the prior concurrence of the Monetary Board, and subject to such limitations as may be provided by law. The Monetary Board shall, within 30 days from the end of every quarter of the calendar year, submit to Congress a complete report of its decisions on applications for loans to be contracted or guaranteed by the government, or government-owned or controlled corporations, which would have the effect of increasing the foreign debt, and containing other matters provided by law. Article 12, Section 21. Foreign loans may only be incurred in accordance with law and the regulation of the monetary authority. Information on foreign loans obtained or guaranteed by the government shall be made available to the public. Power with regard to the utilization of natural resources. The President may enter into agreements with foreign-owned corporations involving either technical or financial assistance for large-scale exploration, development, and utilization of minerals, petroleum, and other mineral oils according to the general terms and conditions provided by law. The President shall notify the Congress of every contract entered into in accordance 4 and 5. The Judicial Department. To maintain the independence of the judiciary, the following safeguards have been embodied in the Constitution. Cruz. 1. The SC is a constitutional body. It cannot be abolished, nor may its membership or the manner of its meetings be changed by mere legislation. Article 8, Section 4, 1. 2. The members of the judiciary are not subject to confirmation by the CA. 3. The members of the SC may not be removed except by impeachment. Article 9, Section 2. 4. The SC may not be deprived of its minimum original and appellate jurisdiction as prescribed in Article X, Section 5 of the Constitution. Article 8, Section 2. 5. The appellate jurisdiction of the SC may not be increased by law without its advice and concurrence. Article V, Section 30. 6. The SC now has administrative supervision over all lower courts and their personnel. Article 8, Section 6. 7. The SC has exclusive power to discipline judges of lower courts. Article 8, Section 11. 8. The members of the SC and all lower courts have security of tenure, which cannot be undermined by a law reorganizing the judiciary. Id. 9. They shall not be designated to any agency performing quasi-judicial or administrative functions. Article 8, Section 12. 10. The salaries of judges may not be reduced during their continuance in office. Article 8, Section 10. 11. The judiciary shall enjoy fiscal autonomy. Article 8, Section 3. 12. The SC alone may initiate rules of court. Article 8, Section 5, 5. 13. Only the SC may order the temporary detail of judges. Article 8, Section 5, 3. 14. The SC can appoint all officials and employees of the judiciary. Article 8, Section 5, 6. Creation. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Article 8, Section 1, Paragraph 1. The Supreme Court is a constitutional body. As such it cannot be abolished by the Congress, for the power to destroy only resides in the one who has the power to create. The lower courts, Court of Appeals, regional trial courts, municipal trial courts, metropolitan trial courts, municipal circuit trial courts, on the other hand, are established by law, and so could be abolished by law, provided the security of tenure is not undermined. Composition. The Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. Article 8, Section 4(1). Mode of sitting. It may sit en banc, or in its discretion, in divisions of 3, 5 or 7 members, or 5, 3 or 2 divisions. Article 8, Section 4(1). At present, the SC sits either en banc or in 3 divisions with 5 members each. Qualifications. 1. Natural-born citizen. Article 8, Section 7(1). 2. At least 40 years of age, id. 3. At least 15 years of experience as a judge of lower court, or practice of law in the Philippines. 4. Of proven competence, integrity, probity and independence. Article 8, Section 7(3). Salary not exempt from income tax. In Nitafan v. Commissioner of Internal Revenue, July 1987, the court ruled that under the 1987 Constitution, the salaries of members of the judiciary are not exempt from taxes. It anchored its decision on the deliberation of the Constitutional Commission, that is, on the legislative history of the present. Article 8, Section 10. Security of tenure and removal. Article 8, Section 11. The members of the Supreme Court and judges of lower courts shall hold office during good behavior until they reach the age of 70 years, or become incapacitated to discharge the duties of their office. The Supreme Court en banc shall have the power to discipline judges of lower courts, or order their dismissal by a vote of a majority of the members who actually took part in the deliberations on the issues in the case and voted thereon. Article 11, Section 2. The members of the Supreme Court may be removed from office, on impeachment for, and conviction of, culpable violation of the Constitution, treason, bribery, graft and corruption, other high crimes, or betrayal of public trust. All other public officers and employees may be removed from office as provided by law, but not by impeachment. In re. Raul Gonzalez, A.M. Nos. 88-45433. April 15, 1988. Held, a public officer who under the Constitution is required to be a member of the Philippine Bar as a qualification for the office held by him and who may be removed from office only by impeachment, cannot be charged with disbarment during the incumbency of such public officer. Further, such public officer, during his incumbency, cannot be charged criminally before the Sandiganbayan or any other court with any offense which carries with it the penalty of removal from office, or any penalty service of which would amount to removal from office. A member of the Supreme Court must first be removed from office via the constitutional route of impeachment under Sections 2 and 3 of Article 11 of the 1987 Constitution. Should the tenure of the Supreme Court justice be thus terminated by impeachment, he may then be held to answer either criminally or administratively, by disbarment proceedings, for any wrong or misbehavior that may be proven against him in appropriate proceedings. The above rule rests on the fundamental principles of judicial independence and separation of powers. The rule is important because judicial independence is important. Without the protection of this rule, members of the Supreme Court would be vulnerable to all manner of charges which might be brought against them by unsuccessful litigants or their lawyers or by other parties who, for any number of reasons, might seek to affect the exercise of judicial authority by the court. Fiscal autonomy. Article 8, Section 3. The judiciary shall enjoy fiscal autonomy. Appropriations for the judiciary may not be reduced by the legislature below the amount appropriated for the previous year and, after approval, shall be automatically and regularly released. Bengzon v. Drilon, 208 SCRA 133, 1992. Held, as envisioned in the Constitution, the fiscal autonomy enjoyed by the judiciary, the Civil Service Commission, the Commission on Audit, the Commission on Elections, and the Office of the Ombudsman contemplates a guarantee of full flexibility to allocate and utilize their resources with the wisdom and dispatch that their needs require. It recognizes the power and authority to levy, assess and collect fees, fix rates of compensation not exceeding the highest rates authorized by law for compensation and pay plans of the government and allocate and disperse such sums as may be provided by law or prescribed by them in the course of the discharge of their functions. Fiscal autonomy means freedom from outside control. The judiciary, the constitutional commissions, and the ombudsman must have the independence and flexibility needed in the discharge of their constitutional duties. The imposition of restrictions and constraints on the manner the independent constitutional offices allocate and utilize the funds appropriated for their operations is anathema to fiscal autonomy and violative not only of the express mandate of the Constitution but especially as regards the Supreme Court, of the independence and separation of powers upon which the entire fabric of our constitutional system is based. Functions of the courts. ABS-CBN Broadcasting Corporation vs. Cumlec, GR number 133486, January 28, 2000, and Bank Panganiban. Held, while the assailed resolution referred specifically to the May 11, 1998 election, its implications on the people's fundamental freedom of expression transcend the past election. The holding of periodic elections is a basic feature of our democratic government. By its very nature, exit polling is tied up with elections. To set aside the resolution of the issue now will only postpone a task that could well crop up again in future elections. In any event, in Salonga vs. Cruz Pano, 134 SCRA 438, 463, February 18, 1985, the court had occasion to reiterate that it also has the duty to formulate guiding and controlling constitutional principles, precepts, doctrines, or rules. It has the symbolic function of educating bench and bar on the extent of protection given by constitutional guarantees. Since the fundamental freedoms of speech and of the press are being invoked here, we have resolved to settle, for the guidance of posterity, whether they likewise protect the holding of exit polls and the dissemination of data derived therefrom. Judicial Power. Section 1, Article 8, 1987 Constitution. Section 1. The judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice 1. To settle actual controversies involving rights which are legally demandable and enforceable, and 2. To determine whether or not there has been a grave abuse of discretion amounting to lack or excessive jurisdiction on the part of any branch or instrumentality of the government. As early as Ongara v. Electoral Tribunal, the SC held that when it performs its checking function of the co-equal branches, it is merely performing a duty imposed upon it by the Constitution, that it acts as the mechanism that implements the supremacy of the Constitution. The extent to which it exercises this function, however, has been limited by the political question doctrine. When the court allocated constitutional boundaries, it neither asserts supremacy, nor annuls the acts of the legislature. It simply carries out the solemn and sacred obligations imposed upon it by the Constitution to determine conflicting claims and to establish for the parties the rights which the Constitution grants to them. This is in truth all that is involved in what is termed judicial supremacy, which properly is the power of judicial review under the Constitution. Ongara v. Electoral Commission, 63 Phil 139, 1936. The inherent powers of a court to amend and control its processes and orders so as to make them conformable to law and justice includes the right to reverse itself, especially when in its honest opinion it has committed an error or a mistake in judgment, and that to adhere to its decision will cause injustice to a party litigant. Tokal v. C.A., Gr. No. 127405, September 20, 2001. Drillon v. Lim, 235 SCRA 135, August 4, 1994, and Bank Gruz. Do lower courts have jurisdiction to consider the constitutionality of a law? Held, the lower court had jurisdiction to consider the constitutionality of Section 187, this authority being embraced in the general definition of the judicial power to determine what are the valid and binding laws by the criterion of their conformity to the fundamental law. Specifically, BP 129 vests in the regional trial court's jurisdiction over all civil cases in which the subject of the litigation is incapable of pecuniary estimation, Section 19(1), even as the accused in a criminal action has the right to question in his defense the constitutionality of a law he is charged with violating and of the proceedings taken against him, particularly as they contravene the Bill of Rights. Moreover, Article 8, Section 5(2), of the Constitution vests in the Supreme Court appellate jurisdiction over final judgments and orders of lower courts in all cases in which the constitutionality or validity of any treaty, international or executive agreement, law, presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. The political question doctrine. IBP v. Zamora, 338 SCRA 81, 2000. Held, as a general proposition, a controversy is justiciable if it refers to a matter which is appropriate for court review. It pertains to issues which are inherently susceptible of being decided on grounds recognized by law. Nevertheless, the court does not automatically assume jurisdiction over actual constitutional cases brought before it even in instances that are ripe for resolution. One class of cases wherein the court hesitates to rule on are political questions. The reason is that political questions are concerned with issues dependent upon the wisdom, not the legality, of a particular act or measure being assailed. Moreover, the political question being a function of the separation of powers, the courts will not normally interfere with the workings of another co-equal branch unless the case shows a clear need for the courts to step in to uphold the law in the Constitution. As Tanada v. Ongara puts it, political questions refer to those questions which, under the Constitution, are to be decided by the people in their sovereign capacity, or in regard to which full discretionary authority has been delegated to the legislative or executive branch of government. Thus, If an issue is clearly identified by the text of the Constitution as matters for discretionary action by a particular branch of government or to the people themselves, then it is held to be a political question. In the classic formulation of Justice Brennan in Baker v. Carr, predominant on the surface of any case held to involve a political question is found a textually demonstrable constitutional commitment of the issue to a coordinate political department, or a lack of judicially discoverable and manageable standards for resolving it, or the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion, or the impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government, or an unusual need for unquestioning adherence to a political decision already made, or the potentiality of embarrassment from multifarious pronouncements by various departments on the one question. The 1987 Constitution expands the concept of judicial review by providing that judicial power shall be vested in one Supreme Court and in such lower courts as may be established by law. Judicial power includes the duty of the courts of justice to settle actual controversies involving rights which are legally demandable and enforceable, and to determine whether or not there has been a grave abuse of discretion amounting to lack or excessive jurisdiction on the part of any branch or instrumentality of the government. Article 8, Section 1 of the 1987 Constitution, under this definition, the court cannot agree 30 that the issue involved is a political question beyond the jurisdiction of this court to review. When the grant of power is qualified, conditional or subject to limitations, the issue of whether the prescribed qualifications or conditions have been met or the limitations respected, is justiciable, the problem being one of legality or validity, not its wisdom. Moreover, the jurisdiction to delimit constitutional boundaries has been given to this court. When political questions are involved, the Constitution limits the determination as to whether or not there has been a grave abuse of discretion amounting to lack or excessive jurisdiction on the part of the official whose action is being questioned. By grave abuse of discretion is meant simply capricious or whimsical exercise of judgment that is patent and gross as to amount to an evasion of positive duty or a virtual refusal to perform a duty enjoined by law, or to act at all in contemplation of law, as where the power is exercised in an arbitrary and despotic manner by reason of passion or hostility. Under this definition, a court is without power to directly decide matters over which full discretionary authority has been delegated. But while this court has no power to substitute its judgment for that of Congress or of the President, it may look into the question of whether such exercise has been made in grave abuse of discretion. A showing that plenary power is granted either department of government may not be an obstacle to judicial inquiry, for the improvident exercise or abuse thereof may give rise to justiciable controversy. Estrada v. Desierto, Gr. Nos. 146,710-15, March 2, 2001, N. Bank Puno. Held, in fine, the legal distinction between EDSA People Power I and EDSA People Power II is clear. EDSA presented a political question, EDSA II involves legal questions. Needless to state, the cases at bar pose legal and not political questions. The principal issues for resolution require the proper interpretation of certain provisions in the 1987 Constitution, notably Section 1 of Article 2, and Section 8 of Article 7, and the allocation of governmental powers under Section 11 of Article 7. Requisites for the proper exercise of the power of judicial review. The time-tested standards for the exercise of judicial review are: 1. The existence of an appropriate case. 2. An interest personal and substantial by the party raising the constitutional question. 3. The plea that the function be exercised at the earliest opportunity, and 4. The necessity that the constitutional question be passed upon in order to decide the case. When questions of constitutional significance are raised, the court can exercise its power of judicial review only if the following requisites are complied with, namely: 1. The existence of an actual and appropriate case. 2. A personal and substantial interest of the party raising the constitutional question. 3. The exercise of judicial review is pleaded at the earliest opportunity, and 4. The constitutional question is the lis moda of the case. Actual case or controversy. An actual case or controversy means an existing case or controversy which is both ripe for resolution and susceptible of judicial determination, and that which is not conjectural or anticipatory, or that which seeks to resolve hypothetical or feigned constitutional problems. A petition raising a constitutional question does not present an actual controversy, unless it alleges a legal right or power. Moreover, it must show that a conflict of rights exists, for inherent in the term controversy is the presence of opposing views or contentions. Otherwise, the court will be forced to resolve issues which remain unfocused because they lack such concreteness provided when a question emerges precisely framed from a clash of adversary arguments exploring every aspect of a multifaceted situation embracing conflicting and demanding interests. The controversy must also be justiciable, that is, it must be susceptible of judicial determination. IBP vs. Zamora, 338 SCRA 81, 2000. An actual case or controversy involves a conflict of legal right, an opposite legal claim susceptible of judicial resolution. It is definite and concrete, touching the legal relations of parties having adverse legal interest, a real and substantial controversy admitting of specific relief. David vs. Macapagal Arroyo, GR number 171396, May 3, 2006. A justiciable controversy has been defined as a definite and concrete dispute touching on the legal relations of parties having adverse legal interests which may be resolved by a court of law through the application of a law. Courts have no judicial power to review cases involving political questions and as a rule, will desist from taking cognizance of speculative or hypothetical cases, advisory opinions and in cases that has become moot. Subject to certain well-defined exceptions, courts will not touch an issue involving the validity of law unless there has been a governmental act accomplished or performed that has a direct adverse effect on the legal right of the person contesting its validity. Cutran vs. Denner, 350 SCRA 697, 2001. Izagani Cruz vs. Section of Denner, GR number 135385. December 6, 2000, N. Bank, Puno, and Kapunan, separate opinions. Held, in the case at bar, there exists a live controversy involving a clash of legal rights. A law has been enacted, and the implementing rules and regulations approved. Money has been appropriated and the government agencies concerned have been directed to implement the statute. It cannot be successfully maintained that we should await the adverse consequences of the law in order to consider the controversy actual and ripe for judicial resolution. It is precisely the contention of the petitioners that the law, on its face, constitutes an unconstitutional abdication of state ownership over lands of the public domain and other natural resources. Moreover, when the state machinery is set into motion to implement an alleged unconstitutional statute, this court possesses sufficient authority to resolve and prevent imminent injury and violation of the constitutional process. Advisory opinion. General rule: a request for advisory opinion cannot come in the category of an actual case or controversy since the issue raised does not involve any conflict in law that has assumed the proportions of a full-blown dispute. The court in this case is being asked only to counsel and not to decide. Exception: when the purpose is to solicit from the court a declaratory judgment involving the interpretation of the rights and duties of a person under the provisions of a deed, will, contract, or other written instrument, or a statute or ordinance, the case is deemed an actual controversy over which the courts may validly assume jurisdiction. Moot and academic cases. An action is considered moot when it no longer presents a justiciable controversy because the issues involved have become academic or dead. Gonzalez vs. Narvasa, 337 SCRA 733. David vs. Macapagal Arroyo, GR number 171396, May 3, 2006. Held, a moot and academic case is one that ceases to present a justiciable controversy by virtue of supervening events, so that a declaration thereon would be of no practical use or value. Generally, Courts decline jurisdiction over such case or dismiss it on ground of mootness. The moot and academic principle is not a magical formula that can automatically dissuade the courts in resolving a case. Courts will decide cases, otherwise moot and academic, if, first, there is a grave violation of the Constitution, second, the exceptional character of the situation and the paramount public interest is involved, third, when constitutional issue raised requires formulation of controlling principles to guide the bench, the bar, and the public, and fourth, the case is capable of repetition yet evading review. All the foregoing exceptions are present here and justify this court's assumption of jurisdiction over the instant petitions. Petitioners allege that the issuance of pages 1017 and Geo number 5 violates the Constitution. There is no question that the issues being raised affect the public's interest, involving as they do the people's basic rights to freedom of expression, of assembly and of the press. Moreover, the court has the duty to formulate guiding and controlling constitutional precepts, doctrines or rules. It has the symbolic function of educating the bench and the bar, and in the present petitions, the military and the police, on the extent of the protection given by constitutional guarantees. And lastly, respondents' contested actions are capable of repetition. Certainly, the petitions are subject to judicial review. ABS-CBN Broadcasting Corporation vs. Kumlek, G.R. number 133486, January 28, 2000, and Bank Panganiban. Held, while the assailed resolution referred specifically to the May 11, 1998 election, its implications on the people's fundamental freedom of expression transcend the past election. The holding of periodic elections is a basic feature of our democratic government. By its very nature, exit polling is tied up with elections. To set aside the resolution of the issue now will only postpone a task that could well crop up again in future elections. In any event, in Salonga vs. Cruz Pano, the court had occasion to reiterate that it also has the duty to formulate guiding and controlling constitutional principles, precepts, doctrines, or rules. It has the symbolic function of educating bench and bar on the extent of protection given by constitutional guarantees. Since the fundamental freedoms of speech and of the press are being invoked here, we have resolved to settle, for the guidance of posterity, whether they likewise protect the holding of exit polls and the dissemination of data derived therefrom. Proper Party. IBP vs. Zamora, GR number 141284, August 15, 2000, and Bank Kapunan. Legal standing or locus standi has been defined as a personal and substantial interest in the case such that the party has sustained or will sustain direct injury as a result of the governmental act that is being challenged. The term interest means a material interest, an interest in issue affected by the decree, as distinguished from mere interest in the question involved, or a mere incidental interest. The gist of the question of standing is whether a party alleges such personal stake in the outcome of the controversy as to assure that concrete adverseness which sharpens the presentation of issues upon which the court depends for illumination of difficult constitutional questions. IBP vs. Zamora, 338 SCRA 81, 2000. David vs. Macapagal Arroyo, GR number 171396. May 3, 2006. Held, locus standi is defined as a right of appearance in a court of justice on a given question. In private suits, standing is governed by the real parties and interest rule as contained in Section 2, Rule 3 of the 1997 Rules of Civil Procedure, as amended. It provides that every action must be prosecuted or defended in the name of the real party in interest. Accordingly, the real party in interest is the party who stands to be benefited or injured by the judgment in the suit or the party entitled to the avails of the suit. Succinctly put, the plaintiff's standing is based on his own right to the relief sought. The difficulty of determining locus standi arises in public suits. Here, the plaintiff who asserts a public right in assailing an allegedly illegal official action, does so as a representative of the general public. He may be a person who is affected no differently from any other person. He could be suing as a stranger, or in the category of a citizen, or taxpayer. In neither case, he has to adequately show that he is entitled to seek judicial protection. In other words, he has to make out a sufficient interest in the vindication of the public order and the securing of relief as a citizen or taxpayer. Case law in most jurisdictions now allows both citizen and taxpayer standing in public actions. The distinction was first laid down in Beetham v. Silk, where it was held that the plaintiff in a taxpayer's suit is in a different category from the plaintiff in a citizen's suit. In the former, the plaintiff is affected by the expenditure of public funds, while in the latter, he is but the mere instrument of the public concern. As held by the New York Supreme Court in People ex rel. Case v. Collins, in matter of mere public right, however, the people are the real parties. It is at least the right, if not the duty, of every citizen to interfere and see that a public offense be properly pursued and punished, and that a public grievance be remedied. With respect to taxpayers' suits, Terrace v. Jordan held that the right of a citizen and a taxpayer to maintain an action in court to restrain the unlawful use of public funds to his injury cannot be denied. However, to prevent just about any person from seeking judicial interference in any official policy or act with which he disagreed with, and thus hinders the activities of governmental agencies engaged in public service, the United States Supreme Court laid down the more stringent direct injury test in Ex parte Levitt, later reaffirmed in Tileston v. Allman. The same court ruled that for a private individual to invoke the judicial power to determine the validity of an executive or legislative action, he must show that he has sustained a direct injury as a result of that action, and it is not sufficient that he has a general interest common to all members of the public. This court adopted the direct injury test in our jurisdiction. In People v. Vera, it held that the person who impugns the validity of a statute must have a personal and substantial interest in the case such that he has sustained, or will sustain direct injury as a result. Oposa v. Factorin, 224 SCRA 792, 1993. Held, this case, however, has a special and novel element. Petitioners' minors assert that they represent their generation as well as generations yet unborn. We find no difficulty in ruling that they can, for themselves, for others of their generation and for the succeeding generations, file a class suit. Their personality to sue in behalf of the succeeding generations can only be based on the concept of intergenerational responsibility insofar as the right to a balanced and healthful ecology is concerned. Needless to say, every generation has a responsibility to the next to preserve that rhythm and harmony for the full enjoyment of a balanced and healthful ecology. Put a little differently, the minors' assertion of their right to a sound environment constitutes, at the same time, the performance of their obligation to ensure the protection of that right for the generations to come. Liberal attitude of the Supreme Court on locus standi. IBP v. Zamora, 338 SCRA 81. 2000. Held, it must be emphasized that this court has the discretion to take cognizance of a suit which does not satisfy the requirement of legal standing when paramount interest is involved. In not a few cases, the court has adopted a liberal attitude on the locus standi of a petitioner where the petitioner is able to craft an issue of transcendental significance to the people. Thus, when the issues raised are of paramount importance to the public, the court may brush aside technicalities of procedure. David v. Macapagal Arroyo, GR number 171396, May 3, 2006. Held, however, being a mere procedural technicality, the requirement of locus standi may be waived by the court in the exercise of its discretion. This was done in the 1949 emergency powers cases, Araneta v. Stinglison, where the transcendental importance of the cases prompted the court to act liberally. Such liberality was neither a rarity nor accidental. In Aquino v. Cumlec, this court resolved to pass upon the issues raised due to the far-reaching implications of the petition notwithstanding its categorical statement that petitioner therein had no personality to file the suit. Indeed, there is a chain of cases where this liberal policy has been observed, allowing ordinary citizens, members of Congress, and civic organizations to prosecute actions involving the constitutionality or validity of laws, regulations and rulings. Thus, the court has adopted a rule that even where the petitioners have failed to show direct injury, they have been allowed to sue under the principle of transcendental importance. Pertinent are the following cases. 1. Chavez v. Public Estates Authority, where the court ruled that the enforcement of the constitutional right to information and the equitable diffusion of natural resources are matters of transcendental importance which clothe the petitioner with locus standi. 2. Bagong Allen Macabian v. Zamora, wherein the court held that given the transcendental importance of the issues involved, the court may relax the standing requirements and allow the suit to prosper despite the lack of direct injury to the parties seeking judicial review of the visiting forces agreement. 3. Lim v. Executive Secretary, while the court noted that the petitioners may not file suit in their capacity as taxpayers absent a showing that Balakat An 0201 involves the exercise of Congress taxing or spending powers, it reiterated its ruling in Bagong Allen Macabian v. Zamora, that in cases of transcendental importance, the cases must be settled promptly and definitely and standing requirements may be relaxed. By way of summary, the following rules may be culled from the cases decided by this court. Taxpayers, voters, concerned citizens, and legislators may be accorded standing to sue, provided that the following requirements are met. 1. The cases involve constitutional issues. 2. For taxpayers, there must be a claim of illegal disbursement of public funds or that the tax measure is unconstitutional. 3. For voters, there must be a showing of obvious interest in the validity of the election law in question. 4. For concerned citizens, there must be a showing that the issues raised are of transcendental importance which must be settled early, and 5. For legislators, there must be a claim that the official action complained of infringes upon their prerogatives as legislators. Significantly, recent decisions show a certain toughening in the court's attitude toward legal standing. In Kailas Bayan Incorporated v. Morato, the court ruled that the status of Kailas Bayan as a people's organization does not give it the requisite personality to question the validity of the online lottery contract, more so where it does not raise any issue of constitutionality. Moreover, it cannot sue as a taxpayer absent any allegation that public funds are being misused. Nor can it sue as a concerned citizen as it does not allege any specific injury it has suffered. In Telecommunications and Broadcast Attorneys of the Philippines Incorporated v. Cumlec, the court reiterated the direct injury test with respect to concerned citizens' cases involving constitutional issues. It held that there must be a showing that the citizen personally suffered some actual or threatened injury arising from the alleged illegal official act. In Lacson v. Perez, the court ruled that one of the petitioners, Laban Ng Demokratikong Pilipino, LDP, is not a real party in interest as it had not demonstrated any injury to itself or to its leaders, members or supporters. In San Lucas v. Executive Secretary, the court ruled that only the petitioners who are members of Congress have standing to sue, as they claim that the President's declaration of a state of rebellion is a usurpation of the emergency powers of Congress, thus impairing their legislative powers. As to petitioners San Lucas, Partido Manggagawa, and Social Justice Society, the court declared them to be devoid of standing, equating them with the LDP in Lacson. Now, the application of the above principles to the present petitions. The locus standi of petitioners in GR number 171396, particularly David and Lamas, is beyond doubt. The same holds true with petitioners in GR number 171409, Quecho Olivares and Tribune Publishing Company Incorporated. They alleged direct injury resulting from illegal arrest and unlawful search committed by police operatives pursuant to pages 1017. Rightly so, the Solicitor General does not question their legal standing. In GR number 171485, the opposition congressman alleged there was usurpation of legislative powers. They also raised the issue of whether or not the concurrence of Congress is necessary whenever the alarming powers incident to martial law are used. Moreover, it is in the interest of justice that those affected by pages 1017 can be represented by their congressmen in bringing to the attention of the court the alleged violations of their basic rights. NGR number 171400, ALGI, this court applied the liberality rule in Filconsa versus Enriquez, Kapaturan Njim Ganagliling sa Pamahalan ng Pilipinas Incorporated versus Stan, Association of Small Landowners in the Philippines Incorporated versus Secretary of Agrarian Reform, Bosco versus Philippine Amusement and Gaming Corporation, Antanada versus Tavra, that when the issue concerns a public right, it is sufficient that the petitioner is a citizen and has an interest in the execution of the laws. NGR number 171483, KMU's assertion that pages 1017 NGO number 5 violated its right to peaceful assembly may be deemed sufficient to give it legal standing. Organizations may be granted standing to assert the rights of their members. We take judicial notice of the announcement by the Office of the President banning all rallies and canceling all permits for public assemblies following the issuance of pages 1017 and NGO number 5. NGR number 171489, petitioners, Cadiz et al., who are national officers of the Integrated Bar of the Philippines, IBP, have no legal standing, having failed to allege any direct or potential injury which the IBP as an institution or its members may suffer as a consequence of the issuance of PP number 1017 and NGO number 5. In Integrated Bar of the Philippines versus Zamora, the court held that the mere invocation by the IBP of its duty to preserve the rule of law and nothing more, while undoubtedly true, is not sufficient to clothe it with standing in this case. This is too general an interest which is shared by other groups and the whole citizenry. However, in view of the transcendental importance of the issue, this court declares that petitioner have locus standi. NGR number 171424, Loren Legarda has no personality as a taxpayer to file the instant petition as there are no allegations of illegal disbursement of public funds. The fact that she is a former senator is of no consequence. She can no longer sue as a legislator on the allegation that her prerogatives as a lawmaker have been impaired by pages 1017 NGO No. 5. Her claim that she is a media personality will not likewise aid her because there was no showing that the enforcement of these issuances prevented her from pursuing her occupation. Her submission that she has pending electoral protest before the Presidential Electoral Tribunal is likewise of no relevance. She has not sufficiently shown that pages 1017 will affect the proceedings or result of her case. But considering once more the transcendental importance of the issue involved, this court may relax the standing rules. It must always be borne in mind that the question of locus standi is but corollary to the bigger question of proper exercise of judicial power. This is the underlying legal tenet of the liberality doctrine on legal standing. It cannot be doubted that the validity of PP number 1017 and NGO number 5 is a judicial question which is of paramount importance to the Filipino people. To paraphrase Justice Laurel, the whole of Philippine society now waits with bated breath the ruling of this court on this very critical matter. The petitions thus call for the application of the transcendental importance doctrine, a relaxation of the standing requirements for the petitioners in the pages 1017 cases. This court holds that all the petitioners herein have locus standi. Taxpayers suit. The Anti-Graft League of the Philippines Incorporated versus San Juan, 260 SCRA 250, August 1, 1996. To constitute a taxpayer's suit, two requisites must be met, namely, that public funds are dispersed by a political subdivision or instrumentality and in doing so, a law is violated or some irregularity is committed, and that the petitioner is directly affected by the alleged ultra vires act. Undeniably, as a taxpayer, petitioner would somehow be adversely affected by an illegal use of public money. When, however, no such unlawful spending has been shown, as in the case at bar, petitioner, even as a taxpayer, cannot question the transaction validly executed by and between the province and Ortigas for the simple reason that it is not privy to said contract. Gonzales vs. Narvasa, 337 SCRA 733, August 14, 2000, and Bank Gonzaga Reyes. A taxpayer is deemed to have the standing to raise a constitutional issue when it is established that public funds have been dispersed in alleged contravention of the law or the Constitution. Thus, a taxpayer's action is properly brought only when there is an exercise by Congress of its taxing or spending power. Earliest opportunity. Gr. If not raised in the pleadings, it cannot be considered at the trial, and if not considered at the trial, it cannot be considered on appeal. Exceptions. 1. In criminal cases, can be raised at any time in the discretion of the court. 2. In civil cases, can be raised at any stage if it is necessary to the determination of the case itself. 3. In every case, except where there is estoppel, can be raised at any stage if it involves the jurisdiction of the court. Necessity of deciding constitutional question. Laurel v. Garcia, 187 SCRA 797, 1990. Held, the court does not ordinarily pass upon constitutional questions unless these questions are properly raised in appropriate cases and their resolution is necessary for the determination of the case. People v. Vera, 65 Phil. 56 1937. The court will not pass upon a constitutional question although properly presented by the record if the case can be disposed of on some other ground such as the application of a statute or general law. Seiler v. Louisville and Nashville R. Co., 213 U.S. 175, 1909, Railroad Commission v. Pullman Co., 312 U.S. 496 1941. Lalacan v. Vergara, 276 SCRA 518, 1997. Held, thus, even if all the requisites for judicial review of a constitutional matter are present in a case, this court will not pass upon a constitutional question unless it is the lis moda of the case or if the case can be disposed of on some other grounds, such as the application of the statute or general law. Effects of Declaration of Unconstitutionality. 1. Orthodox view: an unconstitutional act is not a law, it confers no rights, it imposes no duties, it affords no protection, it creates no office. It is inoperative as if it has not been passed. Norton v. Shelby. 2. Modern view: the court in passing upon the question of constitutionality does not annul or repeal the statute if it finds it in conflict with the Constitution. It simply refuses to recognize it and determines the rights of the parties just as if such statute has no existence. Partial unconstitutionality. Requisites for declaration of partial unconstitutionality of a statute. 1. The legislature is willing to retain the valid portions even if the rest of the statute is declared illegal. 2. The valid portions can stand independently as a separate statute. Congressional power over jurisdiction of the Supreme Court. Article 8, Section 2. The Congress shall have the power to define, prescribe and apportion the jurisdiction of various courts but may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. But while the jurisdiction of courts is a matter of legislative apportionment, the Constitution sets certain limitations on this prerogative. 1. It cannot decrease the constitutionally set jurisdiction of the Supreme Court. It may not deprive the Supreme Court of its jurisdiction over cases enumerated in Section 5 hereof. 2. It cannot increase the constitutionally set appellate jurisdiction of the Supreme Court. Article V, Section 30. No law shall be passed increasing the appellate jurisdiction of the Supreme Court as provided in this Constitution without its advice and concurrence. 3. It can increase the original jurisdiction of the SC, pursuant to its general power. 4. It can make the jurisdiction of the SC concurrent with lower courts, pursuant to its general power. Thus, under the rules of court, the original jurisdiction of the SC is concurrent with the RTC and in the case of the special civil actions, with the CA. 5. It cannot pass a law reorganizing the judiciary when it undermines the security of tenure of its members. Article V, Section 2, Paragraph 2. The Supreme Court's jurisdiction. A. Original jurisdiction. Article 8, Section 5(1). 1. Cases affecting ambassadors, other public ministers and consuls. 2. Petitions for certiorari, prohibition, mandamus, quo warranto and habeas corpus. 3. Sufficiency of factual basis of proclamation of martial law and suspension of privilege of writ of habeas corpus. Note that the SC does not have jurisdiction over declaratory relief cases, which must be filed with the RTC, and re Bermudez said so too, and yet gave due course to the petition. The first case, Ambassadors, etc., is made concurrent with RTCs by law, Judiciary Act of 1948. The second case, Special Civil Actions, is concurrent with the CA and the RTC, with respect to inferior bodies. B. Appellate jurisdiction. The Supreme Court shall have the power to review, revise, reverse, modify, or affirm on I. Ordinary appeal, or 2. Petition for review on certiorari, as the law or the rules of court may provide, final judgment and orders of lower courts in the following cases. 1. Cases questioning the constitutionality or validity of any a. treaty, b. international and executive agreement, c. law or statute, d. presidential decree, e. proclamation, f. order, g. instruction, h. ordinance, or I. regulation. 2. Cases questioning the legality of an a. tax, b. impost, c. assessment, or d. toll, or e. any penalty imposed in relation thereto. 3. Cases in which the jurisdiction of lower courts is an issue. 4. Criminal cases in which the penalty imposed is reclusion perpetua or higher. 5. Cases in which only an error or question of law is involved. 6. Orders of the constitutional commissions. Appellate jurisdiction may be exercised in 2 ways. 1. Ordinary appeal. This is obligatory on the courts, so the appellant possesses this as a matter of right. Under this mode, the SC can pass on both questions of fact and law. Ordinary appeal to the SC is allowed by law in criminal cases where the penalty imposed is reclusion perpetua or higher, including those involving other offenses which, although not so punished, arose out of the same occurrence or which may have been committed by the accused on the same occasion, to ensure uniformity of decision. Section 17, Judiciary Act of 1948. The other case is the automatic review by the SC of criminal cases where the death penalty is imposed. This is unlike the ordinary appeal taken where the penalty is reclusion perpetua or higher, for in this case, the review is automatic. The reason why it is not automatic in the first case, reclusion perpetua, is that on appeal, the appellate court may increase the penalty imposed by the trial court, to death, so that the convict must first waive his right against double jeopardy, precisely by voluntarily making the appeal, before the SC can reopen the case on appeal. But the case is different when death is imposed because the worst that could happen on automatic appeal is that the judgment is affirmed. Naturalization and denaturalization cases under the Judiciary Act of 1948, Section 17, used to be directly appealable to the SC. But this is deemed to have been amended by the Judiciary Reorganization Act of 1980, BP 129, which, in Section 5.3, makes all cases decided by the RTC, appealable to the CA, except those made directly appealable to the SC by I, the Constitution. 2. BP 129 and 3. Section 17.3I and Section 17.4.4 of the Judiciary Act of 1948. Naturalization and denaturalization cases do not fall under any of the exceptions. 2. Petition for review on certiorari. This is discretionary on the SC. It has the authority not to give due course to the petition, if the petition shows no merit on its face. Thus, mode provided for in Rule 45, is limited to pure questions of law. All other cases can be appealed to the SC using this mode. The Constitution now provides that no petition for review or motion for reconsideration of a decision of the court shall be refused due course or denied without stating the legal basis therefor. Article 8, Section 14, Paragraph 2. The 4 other cases falling under the appellate jurisdiction of the SC, viz., Constitutionality, tax, jurisdiction and pure questions of law, are appealable to the SC by petition for review on certiorari. However, in cases involving constitutionality, tax, or jurisdiction, when the resolution of the main issue depends on a controverted question of fact, the case must be appealed to the CA on both questions of fact and law, and the decision of the CA is then raised to the SC by petition for review on certiorari on pure questions of law. Section 17 of the Judiciary Act of 1948. Certiorari. The certiorari referred to in 5.1, when the SC exercises original jurisdiction, is the special civil action of certiorari under Rule 65, where the question raised is a jurisdictional question, that is, a. lack of jurisdiction, b. excessive jurisdiction, or c. grave abuse of discretion amounting to lack of jurisdiction. The certiorari referred to in 5.2, when the SC exercises appellate jurisdiction, is certiorari as an ordinary mode of appeal, where the issue raised is error of judgment or error of law. Sessions of the Supreme Court. Cases to be heard by the SC and Bank. Firestone Ceramics Incorporated v. CA, 334 SCRA 465, June 28, 2000, N. Bank Purisima. Held, under Supreme Court Circular No. 289, dated February 7, 1989, as amended by the resolution of November 18, 1993. 1. Cases in which the constitutionality or validity of any treaty, international or executive agreement, law, executive order, or presidential decree, proclamation, order, instruction, ordinance, or regulation is in question. 2. Criminal cases in which the appealed decision imposes the death penalty. 3. Cases raising novel questions of law. 4. Cases affecting ambassadors, other public ministers and consuls. 5. Cases involving decisions, resolutions or orders of the Civil Service Commission, Commission on Elections, and Commission on Audit. 6. Cases where the penalty to be imposed is the dismissal of a judge, officer or employee of the judiciary, disbarment of a lawyer, or either the suspension of any of them for a period of more than 1 year or a fine exceeding 10,000.00 pesos or both. 7. Cases where a doctrine or principle laid down by the court and bank or in division may be modified or reversed. 8. Cases assigned to a division which in the opinion of at least 3 members thereof merit the attention of the court and bank and are acceptable to a majority of the actual membership of the court and bank, and 9. All other cases as the court and bank by a majority of its actual membership may deem of sufficient importance to merit its attention. Decision-making deliberations. Article 8, Section 13. The conclusions of the Supreme Court in any case submitted to it for decision and bank or in division shall be reached in consultation before the case is assigned to a member for the writing of the opinion of the court. A certification to this effect signed by the Chief Justice shall be issued and a copy thereof attached to the record of the case and served upon the parties. Any member who took no part, or dissented, or abstained from a decision or resolution must state the reason therefor. The same requirements shall be observed by all lower collegiate courts. The reason for the requirement that the decision must be reached in consulta, that is, after deliberations by the group, is to emphasize that the SC is one body, albeit collegiate, so that the decision of the case is by the court itself and not the ponente. The writer of the opinion is merely the spokesman of the body. Consing v. CA, 177 SCRA 14. 1989. Issue, when absence of certification by the Court of Appeals renders that decision invalid. Held, no. The certification requirement imposed by the 1987 Constitution was meant to ensure the implementation of the constitutional requirement that decisions of the Supreme Court and lower collegiate courts, such as the CA, Sandiganbayan and CDA, are reached after consultation with the members of the court sitting and bank or in a division before the case is assigned to a member thereof for decision writing. The absence would not necessarily mean that the case submitted for decision had not been reached in consultation before being assigned to one member for the writing of the opinion of the court, since the regular performance of official duty is presumed. The lack of certification serves as an evidence of failure to observe the certification requirement, but it would not have the effect of invalidating the decision. Prudential Bank v. Castro, 158 SCRA 646. 1988. Held, the certification requirement refers to decisions in judicial, not administrative cases. From the very beginning, resolutions, decisions of the court in administrative cases have not been accompanied by any formal certification. In fact, such a certification would be a superfluity in administrative cases, which by their very nature, have to be deliberated upon considering the collegiate composition of this court. Voting. Votes required to render a decision or resolution. A. En banc. Concurrence of a majority of the members who, I, actually took part in the deliberations, that is, the consultation, on the issues in the case, and, 2, voted thereon. Article 8, Section 4(2) and Section 11. A. The lowest possible votes needed to render a decision is 5, since quorum of 15 is 8. And majority of 8 is 5. This number may increase as the number of justices present increase. B. One who abstained is deemed to have voted for the purpose of computing the majority vote needed. For an abstention is really a form of casting a vote with its own repercussions on the outcome of the case. C. One who was present but kept silent during the deliberations and did not vote is still included in accounting for the purpose of determining the majority. For it may happen that he has already made up his mind on how to decide and influence the outcome of the case. D. But one who expressly inhibited or is disqualified from taking part, for instance because of conflict of interest, is not included. E. There must be a quorum before a valid decision can be made. Without a quorum, there can be no valid business to begin with. F. In case, the necessary majority cannot be mustered, then there is no decision rendered. See effect of failure to reach a majority below. B. In divisions. Cases or matters heard by a division shall be decided or resolved, a. with the concurrence of a majority of the members who actually took part in the deliberations on the issues in the case and voted thereon, and, b. in no case without the concurrence of at least 3 of such members. When the required number is not obtained, the case shall be decided en banc. No doctrine or principle of law laid by the court in a decision rendered en banc or in division may be modified or reversed except by the court sitting en banc. Article 8, Section 4(3). A. In a division of 7 members, the majority if all are present is 4. If only 6 are present, 4. If only 5 or 4, 3. If only 3, no quorum. B. In a division of 5 members, 3 votes are needed regardless of whether 5, 4, or 3 are present. C. In division of 3 members, 3 votes are needed. D. In any of these cases, when the votes cannot be mustered, the case must be raised to the court en banc. Effect of failure to muster the necessary majority. If the necessary majority cannot be had, the case is again reheard. If upon rehearing, no majority is still had, the following are the effects. A. If a case is on appeal, the judgment appealed from is deemed affirmed except I. Criminal cases where the judgment is that of conviction, the conviction is reversed, and the accused is acquitted. 2. Cases where the lower court declared a law, etc. unconstitutional, the judgment is reversed, and the validity of the law is deemed sustained, pursuant to the presumption of constitutionality under Section 9 of the Judiciary Act of 1948. If the lower court declared the law as not unconstitutional, this judgment is deemed affirmed pursuant to the general rule above. Thus, if 12 are present, 5 voted the law unconstitutional, 4 voted for its validity, and 3 abstained, there is no decision and so the law remains valid. B. If the case is an original petition, then the case is deemed dismissed. Writing of the decision. Section 14, Article 8, 1987 Constitution. Section 14. No decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based. No petition for review or motion for reconsideration of a decision of the court shall be refused due course or denied without stating the legal basis therefor. In the case of the SC and lower collegiate court, this rule is addressed to the one to whom the writing of the opinion was assigned after consultation, that is, the ponente. In the case by other courts, this rule is addressed to the judge. Dissenters and abstainers. In the case of a decision on the merits, if a member, A, took no part, or, B, dissented, or A, abstained from a decision or resolution, he must state his reason therefor. Article 8, Section 13. Minute Resolution. In justifying the so-called minute resolution, the SC said in Borromeo v. CA, 186 SCRA 1. The SC disposes of the bulk of its cases by minute resolutions and decrees them as final and executory, as where cases patently without merit, where the issues raised are factual in nature, where the decision appealed from is supported by substantial evidence and is in accord with the facts of the case and the applicable laws, where it is clear from the records that the petitions were filed merely to forestall the early execution of judgment and for non-compliance with the rules. The resolution denying due course or dismissing a petition always gives the legal basis. The court is not duty-bound to render signed decisions all the time. It has ample discretion to formulate decisions and/or minute resolutions, provided a legal basis is given, depending on its evaluation of a case. And neither does the rule apply to administrative cases decided by the SC itself, as it held in Prudential Bank v. Castro, 158 SCRA 646, thus. No constitutional provision is disregarded in the SC's minute resolution denying a motion for reconsideration for lack of merit, the issues raised therein having been previously duly considered and passed upon. In an administrative case, the constitutional mandate that no motion for reconsideration of a decision of the court shall be denied without stating the legal basis therefor is inapplicable. And even if it were, said resolution stated the legal basis for the denial, and, therefore, adhered faithfully to the constitutional requirement. Lack of merit, as a ground for denial is legal basis. Memorandum decisions. The distinctive features of a memorandum decision are, first, it is rendered by an appellate court, second, it incorporates by reference the findings of fact or the conclusions of law contained in the decision, order, or ruling under review. Most likely, the purpose is to affirm the decision, although it is not impossible that the approval of the findings of facts by the lower court may lead to a different conclusion of law by the higher court. At any rate, the reason for allowing the incorporation by reference is evidently to avoid the cumbersome reproduction of the decision of the lower court, or portions thereof, in the decision of the higher court. The idea is to avoid having to repeat in the body of the latter decision the findings or conclusions of the lower court since they are being approved or adopted anyway. Francisco v. Permskull, 173 SCRA 324. The memorandum decision, to be valid, cannot incorporate the findings of fact and the conclusions of law of the lower court only by remote reference, which is to say that the challenged decision is not easily and immediately available to the person reading the memorandum decision. For the incorporation by reference to be allowed, it must provide for direct access to the facts and the law being adopted, which must be contained in a statement attached to the said decision. In other words, the memorandum decision authorized under Section 40 of Batas Pambansabalang 129 should actually embody the findings of fact and conclusions of law of the lower court in an annex attached to and made an indispensable part of the decision. Oil and Natural Gas Commission v. CA, 293 SCRA 26, July 23, 1998. Martinez. Held. The constitutional mandate that no decision shall be rendered by any court without expressing therein clearly and distinctly the facts and the law on which it is based does not preclude the validity of memorandum decisions which adopt by reference the findings of fact and conclusions of law contained in the decisions of inferior tribunals. Yao v. CA, 344 SCRA 202, October 24, 2000, 1st Division Davide. Held, the memorandum decision should be sparingly used lest it become an additive excuse for judicial sloth. It is an additional condition for the validity of this kind of decision may be resorted to only in cases where the facts are in the main accepted by both parties and easily determinable by the judge and there are no doctrinal complications involved that will require an extended discussion of the laws involved. The memorandum decision may be employed in simple litigations only, such as ordinary collection cases, where the appeal is obviously groundless and deserves no more than the time needed to dismiss it. Henceforth, all memorandum decisions shall comply with the requirements herein set forth as to the form prescribed and the occasions when they may be rendered. Any deviation will summon the strict enforcement of Article 8, Section 14 of the Constitution and strike down the flawed judgment as a lawless disobedience. Period for decision-making. Section 15, Article 8, 1987 Constitution. Section 15. 1. All cases or matters filed after the effectivity of this Constitution must be decided or resolved within 24 months from date of submission for the Supreme Court, and, unless reduced by the Supreme Court, 12 months for all lower collegiate courts, and 3 months for all other lower courts. 2. A case or matter shall be deemed submitted for decision or resolution upon the filing of the last pending, brief, or memorandum required by the rules of court or by the court itself. 3. Upon the expiration of the corresponding period, a certification to this effect signed by the Chief Justice or the presiding judge shall forthwith be issued and a copy thereof attached to the record of the case or matter, and served upon the parties. The certification shall state why a decision or resolution has not been rendered or issued within said period. 4. Despite the expiration of the applicable mandatory period, the court, without prejudice to such responsibility as may have been incurred in consequence thereof, shall decide or resolve the case or matter submitted thereto for determination, without further delay. Problem of delays in cases before the Sandiganbayan, AM number 00805 SC, November 28, 2001, N. Bank Pardo. Held, the law creating the Sandiganbayan, PD number 1606 is clear on this issue. It provides, Section 6. Maximum period for termination of cases, as far as practicable, the trial of cases before the Sandiganbayan once commenced shall be continuous until terminated and the judgment shall be rendered within 3 months from the date the case was submitted for decision. On September 18, 1984, the Sandiganbayan promulgated its own rules, thus. Section 3. Maximum period to decide cases. The judgment or final order of a division of the Sandiganbayan shall be rendered within 3 months from the date the case was submitted for decision. Given the clarity of the rule that does not distinguish, we hold that the 3-month period, not the 12-month period, to decide cases applies to the Sandiganbayan. Furthermore, the Sandiganbayan presently sitting in 5 divisions, functions as a trial court. The term trial is used in its broad sense, meaning, it allows introduction of evidence by the parties in the cases before it. The Sandiganbayan, in original cases within its jurisdiction, conducts trials, has the discretion to weigh the evidence of the parties, admit the evidence it regards as credible and reject that which they consider perjurious or fabricated. The rule-making power of the Supreme Court. Section 5. Article 8, 1987 Constitution. 2. Promulgate rules concerning the protection and enforcement of constitutional rights, pleading, practice, and procedure in all courts, the admission to the practice of law, the integrated bar, and legal assistance to the underprivileged. Such rule shall provide a simplified and inexpensive procedure for the speedy disposition of cases, shall be uniform for all courts of the same grade, and shall not diminish, increase, or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the Supreme Court. Limitations to this power. Such rule shall, I, provide simplified and inexpensive procedure, for the speedy disposition of cases, 2, Be uniform for all courts of the same grade, and 3. Not diminish, increase or modify substantive rights. Rules of procedure of special courts and quasi-judicial bodies shall remain effective unless disapproved by the SC. Article 8, Section 5. No quasi-judicial and administrative work of judges. Generally, no non-judicial work for judges, no quasi-judicial and administrative work for judges. As a general rule, members of the judiciary shall only have judicial functions, in line with the separation of powers principle of the Constitution. Exceptions: constitutionally appointed non-judicial functions of the Supreme Court. A. Act as Presidential Electoral Tribunal. B. Chief Justice as presiding officer in impeachment trial of the President. Article 11, Section 36. C. Chief Justice as Chairman of the Judicial and Bar Council. Administrative powers. 1. Supervision of lower courts. Article 8, Section 6. 2. Temporarily assign judges to other stations in the public interest. Article 8, Section 5. 3. 3. Order a change of venue or place of trial to avoid miscarriage of justice. Article 8, Section 5, 4. 4. Discipline of lower court judges. Article 8, Section 11. 5. Appointment of officials and employees of entire judiciary. Article 8, Section 5-6. Power of the SC to discipline judges and order their dismissal. People v. Kekot, 246 SCRA 52, 1995. Held, the very text of the present Section 11 of Article 8 clearly shows that there are actually two situations envisaged therein. The first clause, which states that the Supreme Court and Bank shall have the power to discipline judges of lower courts, is a declaration of the grant of that disciplinary power to, and the determination of the procedure and the exercise thereof by, the court and bank. It was not therein intended that all administrative disciplinary cases should be heard and decided by the whole court, since it would result in an absurdity, as will hereafter be explained. The second clause, which refers to the second situation contemplated therein and is intentionally separated from the first by a comma, declares on the other hand that the court and bank can order their dismissal by a vote of a majority of the members who actually took part in the deliberations on the issues in the case and voted therein. Evidently, in this instance, the administrative case must be deliberated upon, decided by the full court itself. Pursuant to the first clause, which confers administrative disciplinary power to the court and bank, on February 9, 1993 a court and bank resolution was adopted, entitled Bar Matter No. 209. In the matter of the amendment and/or clarification of various Supreme Court's rules and resolutions, and providing inter alia. For said purpose, the following are considered en banc cases. 6. Cases where the penalty to be imposed is the dismissal of a judge, officer or employee of the judiciary, disbarment of a lawyer, or either the suspension of any of them for a period of more than 1 year or a fine exceeding 10,000.00 pesos, or both. This resolution was amended on March 16, 1993 and November 23, 1993, but the aforequoted provision was maintained. Indeed, to require the entire court to deliberate upon and participate in all administrative matters or cases regardless of the sanctions, imposable or imposed, would result in a congested docket and undue delay in the adjudication of cases in the court, especially in administrative matters, since even cases involving the penalty of reprimand would require action by the court and bank. This would subvert the constitutional injunction for the court to adopt a systematic plan to expedite the decision or resolution of cases or matters pending in the Supreme Court of the lower courts, and the very purpose of authorizing the court to sit en banc or in divisions of 3, 5 or 7 members. Yet, although as thus demonstrated, only cases involving dismissal of judges of lower courts are specifically required to be decided by the court en banc, in cognizance of the need for a thorough and judicious evaluation of serious charges against members of the judiciary, it is only when the penalty imposed does not exceed suspension of more than 1 year or a fine of 10,000.00 pesos, or both, that the administrative matter may be decided in division. Maceda vs. Vasquez, 221 SCRA 464 1993. Held, a judge who falsifies his certificate of service is administratively liable to the Supreme Court for serious misconduct and inefficiency under Section 1, Rule 140 of the Rules of Court, and criminally liable to the state under the revised Penal Code for his felonious act. However, we agree with petitioner that in the absence of any administrative action taken against him by this court with regard to his certificates of service, the investigation being conducted by the Ombudsman encroaches into the court's power of administrative supervision over all courts and its personnel, in violation of the doctrine of separation of powers. Thus, the Ombudsman should first refer the matter of petitioner's certificates of service to this court for determination of whether said certificates reflected the true status of his pending caseload, as the court has the necessary records to make such a determination. In fine, where a criminal complaint against a judge or other court employee arises from their administrative duties, the Ombudsman must defer action on said complaint and refer the same to this court for determination whether said judge or court employee had acted within the scope of their administrative duties. Dolaz vs. Office of the Ombudsman Mindanao, 265 SCRA 818 1996. Held, the complaint against petitioner judge before the Office of the Ombudsman is basically administrative in nature. In essence, petitioner judge is being charged with having violated Rule 1.02, Canon 1 and Rule 3.05, Canon 3 of the Code of Judicial Conduct. It must be borne in mind that the resolution of the administrative charge of unduly delaying the disposition of the said criminal case involves the determination of whether, in resolving the alarms and scandals case, petitioner judge acted in accordance with the guidelines provided in the Rules of Court and in the administrative circulars in pursuance of the ideals embodied in the Code of Judicial Conduct. Such is clearly an administrative matter. Unquestionably, this court is mandated under Section 6, Article 8 of the 1987 Constitution to assume administrative supervision over all courts and the personnel thereof. De Vera vs. Paleo, 335 SCRA 281, July 6, 2000, 1st Division Pardo. Held, before a civil or criminal action against a judge for a violation of Arts. 204 and 205, knowingly rendering an unjust judgment or order, can be entertained, there must first be a final and authoritative judicial declaration that the decision or order in question is indeed unjust. The pronouncement may result from either a. An action of certiorari or prohibition in a higher court impugning the validity of the judgment, or b. An administrative proceeding in the Supreme Court against the judge precisely for promulgating an unjust judgment or order. Likewise, the determination of whether a judge has maliciously delayed the disposition of the case is also an exclusive judicial function, in re. Borromeo, Supra, at 461. Report on the Judiciary. Article 8, Section 16. The Supreme Court shall, within 30 days from the opening of each regular session of the Congress, submit to the President and the Congress an annual report on the operations and activities of the judiciary. Lower Courts. Composition. The composition of lower courts shall be provided by law. The laws are the Judiciary Act of 1948 and BP 129. Qualifications. Lower Collegiate Court, Court of Appeals. 1. No person shall be appointed member of any lower collegiate court unless he is a natural-born citizen. Article 8, Section 7(1) and a member of Philippine Bar. 2. The Congress shall prescribe qualifications of judges of lower courts. Article 8, Section 7(2). 3. A member of the judiciary must be a person of proven competence, integrity, probity, and independence. Article 8, Section 7(3). Lower Courts. 1. The Congress shall prescribe qualifications of judges of lower courts, but no person may be appointed judge thereof unless he is a citizen of the Philippines and a member of the Philippine Bar. Article 8, Section 7(2). 2. He must be a person of proven competence, integrity, probity and independence. Article 8, Section 7(3). Qualifications of RTC judges. 1. Natural-born citizen of the Philippines. 2. At least 35 years of age. 3. For at least 10 years has been engaged in the practice of law in the Phil. Or has held public office in the Phil. Requiring admission to the practice of law as an indispensable requisite. Qualifications of MTC judges. 1. Natural-born citizen of the Philippines. 2. At least 30 years of age. 3. For at least 5 years has been engaged in the practice of law in the Phil. Or has held public office in the Phil. Requiring admission to the practice of law as an indispensable requisite. The Judicial and Bar Council. Section 8. 1. A Judicial and Bar Council is hereby created under the supervision of the Supreme Court, composed of the Chief Justice as ex officio chairman, the Secretary of Justice, and a representative of the Congress as ex officio members, a representative of the Integrated Bar, a professor of law, a retired member of the Supreme Court, and a representative of the private sector. 2. The regular members of the council shall be appointed by the President for a term of 4 years with the consent of the Commission on Appointments. Of the members first appointed, the representative of the Integrated Bar shall serve for 4 years, the professor of law for 3 years, the retired justice for 2 years, and the representative of the private sector for 1 year. 3. The clerk of the Supreme Court shall be the secretary ex officio of the council and shall keep a record of its proceedings. 4. The regular members of the council shall receive such emoluments as may be determined by the Supreme Court. The Supreme Court shall provide in its annual budget the appropriations for the council. 5. The council shall have the principal function of recommending appointees to the judiciary. It may exercise such other functions and duties as the Supreme Court may assign to it. Section 9. The members of the Supreme Court and judges of lower courts shall be appointed by the President from a list of at least 3 nominees prepared by the Judicial and Bar Council for every vacancy. Such appointments need no confirmation. For the lower courts, the President shall issue the appointments within 90 days from the submission of the list. The Constitutional Commissions. A. Common Provisions. Section 1. The Constitutional Commissions, which shall be independent, are the Civil Service Commission, the Commission on Elections, and the Commission on Audit. Section 2. No member of a Constitutional Commission shall, during his tenure, hold any other office or employment. Neither shall he engage in the practice of any profession or in the active management or control of any business which in any way be affected by the functions of his office, nor shall he be financially interested, directly or indirectly, in any contract with, or in any franchise or privilege granted by the government, any of its subdivisions, agencies, or instrumentalities, including government-owned or controlled corporation or their subsidiaries. Section 3. The salary of the chairman and the commissioner shall be fixed by law and shall not be decreased during their tenure. Section 4. The Constitutional Commissions shall appoint their officials and employees in accordance with law. Section 5. The Commissions shall enjoy fiscal autonomy. Their approved annual appropriations shall be automatically and regularly released. Section 6. Each commission and bank may promulgate its own rules concerning pleadings and practice before it or before any of its offices. Such rules, however, shall not diminish, increase, or modify substantive rights. Section 7. Each commission shall decide by a majority vote of all its members any case or matter brought before it within 60 days from the date of its submission for decision or resolution. A case or matter is deemed submitted for decision or resolution upon the filing of the last pleading, brief, or memorandum required by the rules of the Commission or by the Commission itself. Unless otherwise provided by this Constitution or by law, any decision, order, or ruling of each commission may be brought to the Supreme Court on certiorari by the aggrieved party within 30 days from receipt of a copy thereof. Section 8. Each commission shall perform such other functions as may be provided by law. Safeguards ensuring the independence of the commissions. A. They are constitutionally created, may not be abolished by statute. b. Each is expressly described as independent. c. Each is conferred certain powers and functions which cannot be reduced by statute. d. The chairman and members cannot be removed except by impeachment. e. The chairman and members are given fairly long term of office of 7 years. f. The chairman and members may not be reappointed or appointed in an acting capacity. Brilliance vs. Yorak, 192 SCRA 358. g. The salaries of the chairman and members are relatively high and may not be decreased during continuance in office. h. The commission enjoy fiscal autonomy. I. Each commission may promulgate its own procedural rules, provided they do not diminish, increase or modify substantive rights though subject to disapproval by the Supreme Court. J. The chairman and members are subject to certain disqualifications calculated to strengthen their integrity. K. The commission may appoint their own officials and employees in accordance with civil service law. Gaymind vs. Co., 347 SCRA 655, 2000. Held, in Republic vs. Imperial, 96 Phil. 770. We said that the operation of the rotational plan requires two conditions, both indispensable to its workability. 1. That the terms of the first three commissioners should start on a common date, and, 2. That any vacancy due to death, resignation or disability before the expiration of the term should only be filled only for the unexpired balance of the term. Consequently, the terms of the first chairman and commissioners of the constitutional commissions under the 1987 Constitution must start on a common date, irrespective of the variations in the dates of appointments and qualifications of the appointees, in order that the expiration of the first terms of 7, 5 and 3 years should lead to the regular recurrence of the 2-year interval between the expiration of the terms. Applying the foregoing conditions to the case at bar, we rule that the appropriate starting point of the terms of office of the first appointees to the constitutional commissions under the 1987 Constitution must be on February 2, 1987, the date of the adoption of the 1987 Constitution. In case of a belated appointment or qualification, the interval between the start of the term and the actual qualification of the appointee must be counted against the latter. In the law of public officers, there is a settled distinction between term and tenure. The term of an office must be distinguished from the tenure of the incumbent. The term means the time during the officer may claim to hold office as of right, and fixes the interval after which the several incumbents shall succeed one another. The tenure represents the term during which the incumbent actually holds the office. The term of office is not affected by the holdover. The tenure may be shorter than the term for reasons within or beyond the power of the incumbent. In concluding that February 2, 1987 is the proper starting point of the terms of office of the first appointees to the constitutional commissions of a staggered 7-5 3-year terms, we considered the plain language of Article 9, b, Section 1, 2, Article 9, c, Section 1, 2, and Article 9, d, Section 1, 2, of the 1987 Constitution that uniformly prescribed 7-year term of office for members of the constitutional commissions, without reappointment. In no case shall any member be appointed or designated in a temporary or acting capacity. There is no need to expressly state the beginning of the term of office, as this is understood to coincide. b. The Civil Service Commission. Section 1. 1. The civil service shall be administered by the Civil Service Commission, composed of a chairman and 2 commissioners who shall be natural-born citizens of the Philippines and, at the time of their appointment, at least 35 years of age, with proven capacity for public administration, and must not have been candidates for any elective position in the elections immediately preceding their appointment. 2. The chairman and the commissioners shall be appointed by the President with the consent of the Commission on appointments for a term of 7 years without reappointment. Of those first appointed, the chairman shall hold office for 7 years, a commissioner for 5 years, and another commissioner for 3 years, without reappointment. Appointment to any vacancy shall be only for the unexpired term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Section 2. 1. The civil service embraces all branches, subdivisions, instrumentalities, and agencies of the government, including government-owned or controlled corporations with original charters. 2. Appointments in the civil service shall be made only according to merit and fitness to be determined, as far as practicable, and, except as to positions which are policy-determining, primarily confidential, or highly technical, by competitive examination. 3. No officer or employee of the civil service shall be removed or suspended except for cause provided by law. 4. No officer or employee in the civil service shall engage, directly or indirectly, in any electioneering or partisan political campaign. 5. The right to self-organization shall not be denied to government employees. 6. Temporary employees of the government shall be given such protection as may be provided by law. Section 3. The Civil Service Commission, as the central personnel agency of the government, shall establish a career service and adopt measures to promote morale, efficiency, integrity, responsiveness, progressiveness, and courtesy in the civil service. It shall strengthen the merit and rewards system, integrate all human resources development programs for all levels and ranks, and institutionalize a management climate conducive to public accountability. It shall submit to the President and the Congress an annual report on its personnel programs. Section 4. All public officers and employees shall take an oath or affirmation to uphold and defend this Constitution. Section 5. The Congress shall provide for the standardization of compensation of government officials, including those in government-owned or controlled corporations with original charters, taking into account the nature of the responsibilities pertaining to, and the qualifications required for their positions. Section 6. No candidate who has lost in any election shall, within 1 year after such election, be appointed to any office in the government of any government-owned or controlled corporations or in any of its subsidiaries. Section 7. No elective official shall be eligible for appointment or designation in any capacity to any public office or position during his tenure, unless otherwise allowed by law or by the primary functions of his position. No appointive official shall hold any other office or employment in the government or any subdivision, agency or instrumentality thereof, including government-owned or controlled corporations or their subsidiaries. Section 8. No elective or appointive public officer or employee shall receive additional, double, or indirect compensation, unless specifically authorized by law, nor accept without the consent of the Congress, any present, emolument, office, or title of any kind from any foreign government. Pensions or gratuities shall not be considered as additional, double, or indirect compensation. The civil service now covers only government-owned or controlled corporations with original or legislative charters, that is those created by an act of Congress or by special law, and not those incorporated under and pursuant to a general legislation. Trade unions of the Phil. and Allied Services, TUPAS, versus NHA, 173 SCRA 33, 1989. The test to determine whether a corporation is government-owned or controlled, or private in nature is simple. Is it created by its own charter for the exercise of a public function, or by incorporation under the General Corporation Law? Those with special charters are government corporations subject to its provisions, and its employees are under the jurisdiction of the Civil Service Commission. Camp-Ardento vs. NLRC, 312 SCRA 47, 1999. The civil service does not include government-owned or controlled corporations, GOCC, which are organized as subsidiaries of GOC under the General Corporation Law. National Service Corporation vs. NLRC, 168 SCRA 125, 1988. More cases and doctrines under administrative law. C. The Commission on Elections. Section 1. 1. There shall be a commission on elections composed of a chairman and 6 commissioners who shall be natural-born citizens of the Philippines and, at the time of their appointment, at least 35 years of age, holders of a college degree, and must not have been candidates for any elective position in the immediately preceding elections. However, a majority thereof, including the chairman, shall be members of the Philippine Bar who have been engaged in the practice of law for at least 10 years. 2. The chairman and the commissioners shall be appointed by the President with the consent of the Commission on Appointments for a term of 7 years without reappointment. Of those first appointed, 3 members shall hold office for 7 years, 2 members for 5 years, and the last members for 3 years, without reappointment. Appointment to a vacancy shall be only for the unexpired term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Section 2. The Commission on Elections shall exercise the following powers and functions. 1. Enforce and administer all laws and regulations relative to the conduct of an election, plebiscite, initiative, referendum, and recall. 2. Exercise exclusive original jurisdiction over all contests relating to the elections, returns, and qualifications of all elective regional, provincial, and city officials, and appellate jurisdiction over all contests involving elective municipal officials decided by trial courts of general jurisdiction, or involving elective barangay officials decided by trial courts of limited jurisdiction. Decisions, final orders, or rulings of the Commission on Election contests involving elective municipal and barangay offices shall be final, executory, and not appealable. 3. Decide, except those involving the right to vote, all questions affecting elections, including determination of the number and location of polling places, appointment of election officials and inspectors, and registration of voters. 4. Deputize, with the concurrence of the President, law enforcement agencies and instrumentalities of the government, including the armed forces of the Philippines, for the exclusive purpose of ensuring free, orderly, honest, peaceful, and credible elections. 5. Register, after sufficient publication, political parties, organizations, or coalitions which, in addition to other requirements, must present their platform or program of government, and accredit citizens' arms of the Commission on Elections. Religious denominations and sects shall not be registered. Those which seek to achieve their goals through violence or unlawful means, or refuse to uphold and adhere to this Constitution, or which are supported by any foreign government shall likewise be refused registration. Financial contributions from foreign governments and their agencies to political parties, organizations, coalitions, or candidates related to elections constitute interference in national affairs, and, when accepted, shall be an additional ground for the cancellation of their registration with the Commission, in addition to other penalties that may be prescribed by law. 6. File, upon a verified complaint, or on its own initiative, petitions in court for inclusion or exclusion of voters, investigate and, where appropriate, prosecute cases of violations of election laws, including acts or omissions constituting election frauds, offenses, and malpractices. 7. Recommend to the Congress effective measures to minimize election spending, including limitation of places where propaganda materials shall be posted, and to prevent and penalize all forms of election frauds, offenses, malpractices, and nuisance candidates. 8. Recommend to the President the removal of any officer or employee it has deputized, or the imposition of any other disciplinary action, for violation or disregard of, or disobedience to its directive, order, or decision. 9. Submit to the President and the Congress a comprehensive report on the conduct of each election, plebiscite, initiative, referendum, or recall. Section 3. The Commission on Elections may sit en banc or in 2 divisions, and shall promulgate its rules of procedure in order to expedite disposition of election cases, including pre-proclamation controversies. All such election cases shall be heard and decided in division, provided that motions for reconsideration of decisions shall be decided by the Commission en banc. Section 4. The Commission may, during the election period, supervise or regulate the enjoyment or utilization of all franchises or permits for the operation of transportation and other public utilities, media of communication or information, all grants, special privileges, or concessions granted by the government or any subdivision, agency, or instrumentality thereof, including any government-owned or controlled corporation or its subsidiary. Such supervision or regulation shall aim to ensure equal opportunity, time and space, and the right to reply, including reasonable, equal rates therefore, for public information campaigns and forums among candidates in connection with the objective of holding free, orderly, honest, peaceful, and credible elections. Section 5. No pardon, amnesty, parole, or suspension of sentence for violation of election laws, rules, and regulations shall be granted by the President without the favorable recommendation of the Commission. Section 6. A free and open party system shall be allowed to evolve according to the free choice of the people, subject to the provisions of this article. Section 7. No votes cast in favor of a political party, organization, or coalition shall be valid, except for those registered under the party list system as provided in this Constitution. Section 8. Political parties, or organizations or coalitions registered under the party list system, shall not be represented in the voters' registration boards, boards of election inspectors, boards of canvassers, or other similar bodies. However, they shall be entitled to appoint poll watchers in accordance with law. Section 9. Unless otherwise fixed by the Commission in special cases, the election period shall commence 90 days before the day of the election and shall end 30 days after. Section 10. Bona fide candidates for any public office shall be free from any form of harassment and discrimination. Section 11. Funds certified by the Commission as necessary to defray the expenses for holding regular and special elections, plebiscites, initiatives, referenda, and recalls, shall be provided in the regular or special appropriations and, once approved, shall be released automatically upon certification by the Chairman of the Commission. Cayetano vs. Monsad, 201 SCRA 210, 1991. Facts: Monsad was nominated by President Aquino as chairman of the COMELEC. The Commission on Appointments confirmed the appointment despite Cayetano's objection. Based on Monsad's alleged lack of the required qualification of 10-year law practice, Cayetano filed this certiorari and prohibition. Issue: W.N. Monsad has been engaged in the practice of law for 10 years? Held: yes. The practice of law is not limited to the conduct of cases or litigation in court. It embraces the preparation of pleadings and other papers incident to actions and special proceedings, the management of such actions and proceedings on behalf of clients, and other works where the work done involves the determination of the trained legal mind of the legal effect of facts and conditions. PLA vs. Agrava. The records of the 1986 Constitutional Commission show that the interpretation of the term practice of law was liberal as to consider lawyers employed in a commission of audit as engaged in the practice of law provided that they use their legal knowledge or talent in their respective work. The court also cited an article in the January 11, 1989 issue of the Business Star, that lawyers nowadays have their own specialized fields such as tax lawyers, prosecutors, etc., that because of the demands of their specialization, lawyers engage in other works or functions to meet them. These days, for example, most corporation lawyers are involved in management policy formulation. Therefore, Monsad, who passed the bar in 1960, worked with the World Bank Group from 1963 to 1970, then worked for an investment bank till 1986, became member of the CONCOM in 1986, and also became a member of the Davide Commission in 1990, can be considered to have been engaged in the practice of law as lawyer-economist, lawyer-manager, lawyer-entrepreneur, etc. Brillans vs. Yorak, 192 SCRA 358, 1990. Facts: Associate Commissioner Heidi Yorak was appointed by President Aquino as acting chairman of the Commission on Elections, in place of Chairman Hilario Davide, who had been named chairman of the Fact-Finding Commission to investigate the December 1989 coup d'état attempt. Issue: 1. The appointment is unconstitutional. Held: no. Article 9A, Section 1, of the Constitution expressly describes all the constitutional commissions as independent. Although essentially executive in nature, They are not under the control of the President of the Philippines in the discharge of their respective functions. Each of these commissions conducts its own proceedings under the applicable laws and its own rules and in the exercise of its own discretion. Its decisions, orders and rulings are subject only to review on certiorari by the SC as provided by the Constitution in Article 9A, Section 7. The choice of a temporary chairman in the absence of the regular chairman comes under that discretion. That discretion cannot be exercised for it, even with its consent, by the President of the Philippines. Matibag vs. Benapeo, 380 SCRA 49, 2002. Facts: Benapeo, Tuason and Barra were appointed chairman and commissioners, respectively, of the Commission on Elections, by the President when Congress was not in session. Did their appointment violate the Section 1-2, Article 9C of the Constitution that substantially provides that no member of the Commission on Elections shall be appointed in an acting or temporary capacity? Held, in the instant case, the President did in fact appoint permanent commissioners to fill the vacancies in the COMELEC, subject only to confirmation by the Commission on Appointments. Benapeo, Barra and Tuason were extended permanent appointments during the recess of Congress. They were not appointed or designated in a temporary or acting capacity, unlike Commissioner Heidi Yorac and Brillance vs. Yorac and Solicitor General Felix Bautista in Nacionalista Party vs. Bautista. The ad interim appointments of Benapeo, Barra and Tuason are expressly allowed by the Constitution, which authorizes the President, during the recess of Congress, to make appointments that take effect immediately. While the Constitution mandates that the COMELEC shall be independent, this provision should be harmonized with the President's power to extend ad interim appointments. To hold that the independence of the COMELEC requires the Commission on Appointments to first confirm ad interim appointees before the appointees can assume office will negate the President's power to make ad interim appointments. This is contrary to the rule on statutory construction to give meaning and effect to every provision of the law. It will also run counter to the clear intent of the framers of the Constitution. The President's power to extend ad interim appointments may indeed briefly put the appointee at the mercy of both the appointing and confirming powers. This situation, however, in only for a short period, from the time of issuance of the ad interim appointment until the Commission on Appointments gives or withholds its consent. The Constitution itself sanctions this situation, as a trade-off against the evil of disruptions in vital government services. This is also part of the check and balance under the separation of powers, as a trade-off against the evil of granting the President absolute and sole power to appoint. The Constitution has wisely subjected the President's appointing power to the checking power of the legislature. This situation, however, does not compromise the independence of the COMELEC as a constitutional body. The vacancies in the COMELEC are precisely staggered to ensure that the majority of its members hold confirmed appointments, and no one president will appoint all of the COMELEC members. The special constitutional safeguards that ensure the independence of the COMELEC remain in place. See Sections 3, 4, 5 and 6, Article 9A of the Constitution. In fine, we rule that the ad interim appointments extended by the President to Benapeo, Barra, and Tuason, as COMELEC chairman and commissioners, respectively, do not constitute temporary or acting appointments prohibited by Section 1, 2, Article 9C of the Constitution. More cases and doctrines under election laws. D. Commission on Audit. Section 1. 1. There shall be a commission on audit composed of a chairman and 2 commissioners, who shall be natural-born citizens of the Philippines and, at the time of their appointment, at least 35 years of age, certified public accountants with not less than 10 years of auditing experience, or members of the Philippine Bar who have been engaged in the practice of law for at least 10 years, and must not have been candidates for any elective position in the elections immediately preceding their appointment. At no time shall all members of the commission belong to the same profession. 2. The chairman and the commissioners shall be appointed by the President with the consent of the Commission on Appointments for a term of 7 years without reappointment. Of those first appointed, the chairman shall hold office for 7 years, one commissioner for 5 years, and the other commissioner for 3 years, without reappointment. Appointment to any vacancy shall be only for the unexpired portion of the term of the predecessor. In no case shall any member be appointed or designated in a temporary or acting capacity. Section 2. 1. The Commission on Audit shall have the power, authority and duty to examine, audit, and settle all accounts pertaining to the revenue and receipts of, and expenditures or uses of funds and property, owned or held in trust by, or pertaining to, the government, or any of its subdivisions, agencies, or instrumentalities, including government-owned and controlled corporations with original charters, and on a post-audit basis, a. Constitutional bodies, commissions and offices that have been granted fiscal autonomy under this Constitution, b. Autonomous state colleges and universities, c. Other government-owned or controlled corporations and their subsidiaries, and d. Such non-governmental entities receiving subsidy or equity, directly or indirectly, from or through the government, which are required by law or the granting institution to submit to such audit as a condition of subsidy or equity. However, where the internal control system of the audited agencies is inadequate, the Commission may adopt such measures, including temporary or special pre-audit, as are necessary and appropriate to correct the deficiencies. It shall keep the general accounts of the government and, for such period as may be provided by law, preserve the vouchers and other supporting papers pertaining thereto. 2. The Commission shall have exclusive authority, subject to the limitations in this article, to define the scope of its audit and examination, establish the techniques and methods required therefor, and promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant, or unconscionable expenditures, or uses of government funds and properties. Section 3. No law shall be passed exempting any entity of the government or its subsidiary in any guise whatever, or any investment of public funds, from the jurisdiction of the Commission on Audit. Section 4. The Commission shall submit to the President and the Congress, within the time fixed by law, an annual report covering the financial condition and operation of the government, its subdivisions, agencies, and instrumentalities, including government-owned or controlled corporations, and non-governmental entities subject to its audit, and recommend measures necessary to improve their effectiveness and efficiency. It shall submit such other reports as may be required by law. Q. What is the general function of the Commission on Audit? A. It is the function of the Commission on Audit to examine the accuracy of the records kept by accountable officers and to determine whether expenditures have been made in conformity with law. It is therefore through the Commission on Audit that the people can verify whether their money has been properly spent. Q. Classify the functions of the Commission on Audit. A. They may be classified thus: 1. To examine and audit all forms of government revenues. 2. To examine and audit all forms of government expenditures. 3. To settle government accounts. 4. To promulgate accounting and auditing rules including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant, or unconscionable expenditures, and 5. To decide administrative cases involving expenditures of public funds. The Co. is clothed under Section 2.2, Article 9d of the 1987 Constitution with the exclusive authority, subject to the limitations in this article, to define the scope of its audit and examination, establish the techniques and methods required therefor, and promulgate accounting and auditing rules, and regulations including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant or unconscionable expenditures, or uses of government funds and properties. The authority granted under this constitutional provision, being broad and comprehensive enough, enables Co. to adopt as its own, simply by reiteration or by reference, without the necessity of repromulgation, already existing rules and regulations. It may also expand the coverage thereof to agencies to instrumentalities under its audit jurisdiction. Powell v. Co., 245 SCRA 39, 1995. Mamerle v. Domingo, 227 SCRA 206, 1993. Held, The responsibility for state audit is vested by the Constitution on the Commission on Audit. Under the Constitution, the CO shall have the power, authority, and duty to examine, audit, and settle all accounts, pertaining to the revenue and receipts of, and expenditures or uses of funds and property, owned or held in trust by, or pertaining to, the government, or any of its subdivisions, agencies, or instrumentalities. However, where the internal control system of the audited agencies is inadequate, the Commission may adopt such measures, including temporary or special pre-audit, as are necessary and appropriate to correct the deficiencies. It shall keep the general accounts of the government and, for such period as may be provided by law, preserve the vouchers and other supporting papers pertaining thereto. Italics supplied, Article 9d, Section 2, Paragraph 1. Section 2.2 of the above article states that the CO is given the exclusive authority, subject to the limitations in this article, to define the scope of its audit and examination, establish the technique and methods required therefor, and promulgate accounting and auditing rules and regulations. Italics supplied. As can be gleaned from the foregoing provisions of the Constitution, state audit is not limited to the auditing of the accountable officers and the settlement of accounts, but includes accounting functions and the adoption in the audited agencies of internal controls to see to it, among other matters, that the correct fees and penalties due the government are collected. The verification of the correctness of the evaluation and computation of the fees and penalties collectible under the Land Transportation Law, RA number 4136, are parts of the functions of the CO, which examines and audits revenue accounts. The Government Auditing Code of the Philippines, PD number 1445, Section 60. When any person is indebted to any government agency, the CO may direct the proper officer to withhold the payment of any money due such person or his estate to be applied in satisfaction of the indebtedness, PD number 1445, Section 37. Likewise, under the Manual on Certificate of Settlement and Balances, a government auditor is empowered to order the withholding of the payment of any money due a person determined to be liable for disallowances, suspensions, and other deficiencies in the accounts audited. Section 39. Sambuli v. Province of Isabela, 210 SCRA 80, 1992. Held, in the exercise of the regulatory power vested upon it by the Constitution, the Commission on Audit adheres to the policy the government funds and property should be fully protected and conserved, and that irregular, unnecessary, excessive or extravagant expenditures or uses of such funds and property should be prevented. On the proposition that improper or wasteful spending of public funds or immoral use of government property, for being highly irregular or unnecessary, or scandalously excessive or extravagant, offends the sovereign people's will, it behooves the Commission on Audit to put a stop thereto. Tantuico, State Audit Code Philippines, page 235. In the cases of Danville Maritime Incorporated vs. Commission on Audit, 175 SCRA 701, 1989, and Diem Consunji Incorporated vs. Commission on Audit, 199 SCRA 549, 1991, we define the role of the CO in this wise. No less than the Constitution has ordained that the CO shall have exclusive authority to define the scope of its audit and examination, establish the techniques and methods required therefor, and promulgate accounting and auditing rules and regulations, including those for the prevention and disallowance of irregular, unnecessary, excessive, extravagant or unconscionable expenditures or use of government funds and properties. Article 9d, Section 2 to 1987 Constitution of the Philippines, emphasis supplied. Indeed, not only is the Commission on Audit, COA, vested with the power and authority, but is also charged with the duty to examine, audit and settle all accounts pertaining to the expenditure or uses of funds, owned by, or pertaining to, the government or any of its subdivisions, agencies or instrumentalities. Article 9, D1, Section 21, 1987 Constitution. That authority extends to the accounts of all persons respecting funds or properties received or held by them in any accountable capacity. Section 26, PD number 1445. In the exercise of its jurisdiction, it determines whether or not the fiscal responsibility that rests directly with the head of the government agency has been properly and effectively discharged. Section 25, 1, ibid, and whether or not there has been loss or wastage of government resources. It is also empowered to review and evaluate contracts. Section 18, 4, ibid. And, after an audit has been made, its auditors issue a certificate of settlement to each officer whose account has been audited and settled in whole or in part, stating the balances found due thereon and certified, and the charges or differences arising from the settlement by reason of disallowances, charges or suspensions. Section 82, ibid, Dingkong vs. Kingona 162 SCRA 782. DBP vs. Co. 373 SCRA 356, 2002. Issue: is the constitutional power of the Co. to examine and audit government banks and agencies exclusive? Does it preclude a concurrent audit by a private external auditor? Held, manifestly, the express language of the Constitution, and the clear intent of its framers, point to only one indubitable conclusion: the Co. does not have the exclusive power to examine and audit government agencies. The framers of the Constitution were fully aware of the need to allow independent private audit of certain government agencies in addition to the co-audit, as when there is a private investment in a government-controlled corporation, or when a government corporation is privatized or publicly listed, or as in the case at bar when the government borrows money from abroad. In these instances the government enters the marketplace and competes with the rest of the world in attracting investments or loans. To succeed, the government must abide with the reasonable business practices of the marketplace. Otherwise no investor or creditor will do business with the government, frustrating government efforts to attract investments or secure loans that may be critical to stimulate moribund industries or resuscitate a badly shattered national economy, as in the case at bar. By design the Constitution is flexible enough to meet these exigencies. Any attempt to nullify this flexibility in the instances mentioned, or in similar instances, will be ultra vires, in the absence of a statute limiting or removing such flexibility. Issue: between the Co.'s findings and conclusions and that of private auditors, which should prevail. Held, moreover, as the constitutionally mandated auditor of all government agencies, the Co.'s findings and conclusions necessarily prevail over those of private auditors, at least insofar as government agencies and officials are concerned. The superiority or preponderance of the co-audit over private audit can be gleaned from the records of the Constitutional Commission. The findings and conclusions of the private auditor may guide private investors or creditors who require such private audit. Government agencies and officials, however, remain bound by the findings and conclusions of the Co., whether the matter falls under the first or second paragraph of Section 2, unless of course such findings and conclusions are modified or reversed by the courts. Issue: may the power of the Co. to examine and audit government agencies be validly taken away from it? Held, the power of the Co. to examine and audit government agencies, while non-exclusive, cannot be taken away from the Co. Section 3, Article 9C of the Constitution mandates that. Section 3. No law shall be passed exempting any entity of the government or its subsidiary in any guise whatsoever, or any investment of public funds, from the jurisdiction of the Commission on Audit. The mere fact that private auditors may audit government agencies does not divest the Co. of its power to examine and audit the same government agencies. Q. What is meant by the power of the Commission to settle accounts? A. It means the power to settle liquidated accounts, that is, those accounts which may be adjusted simply by an arithmetical process. It does not include the power to fix the amount of an unfixed or undetermined debt. Compagnie Générale de Tabacos vs. French and Unson, 39 Phil. 34, 42, 1919. Sandiganbayan. Balmadrid vs. Sandiganbayan, 195 SCRA 497, 1991. Held, The Sandiganbayan has jurisdiction over criminal and civil cases involving graft and corrupt practices and such other offenses committed by public officers and employees, including those in government-owned or controlled corporations, in relation to their office as may be determined by law. In case private individuals are charged as co-principals, accomplices or accessories with the public officers or employees, they shall be tried jointly with said public officers and employees. Section 4, PD 1606. Private persons may be charged together with public officers to avoid repeated and unnecessary presentation of witnesses and exhibits against conspirators in different venues, especially if the issues involved are the same. It follows therefore that if a private person may be tried jointly with public officers, he may also be convicted jointly with them, as in the case of the present petitioners. Lekritch vs. Sandiganbayan, 128 SCRA 324, 1984. Held, it is clear from the above-quoted constitutional provision that respondent court has jurisdictional competence not only over criminal and civil cases involving graft and corrupt practices committed by public officers and employees but also over other crimes committed by them in relation to their office, though not involving graft and corrupt practices, as may be determined by law. The intention of the framers of the new Constitution is patent from the explicit language thereof as well as from Section 1 of the same Article 13 titled Accountability of Public Officers, which provides. Section 1. Public office is a public trust. Public officers and employees shall serve with the highest degree of responsibility, integrity, loyalty, and efficiency, and shall remain accountable to the people. There is no merit in petitioner's contention that Section 4C of Presidential Decree No. 1486, as amended, is violative of the provision of Section 5 of Article 13 of the new Constitution because the former enlarges what the latter limited. Said constitutional provision delegates to the lawmaking body the determination of such other offenses committed by public officers over which the Sandiganbayan shall have jurisdiction. Accordingly, the President of the Philippines, exercising his lawmaking authority and prerogative vested in him by the Constitution, issued Presidential Decree No. 1486 which mandates in Section 4C thereof that the Sandiganbayan shall have jurisdiction over other crimes or offenses committed by public officers or employees, including those employed in government-owned or controlled corporation, in relation to their office. Emphasis supplied, when the lawmaking authority chose to include all public office-related offenses over which respondent court shall have jurisdiction, the courts will not review questions of legislative policy. It is enough that the act is within the constitutional power of the lawmaking body or authority and, if it is, the courts are bound to follow and apply. Lacson v. Executive Secretary, 301 SCRA 298, 1999. Held. A perusal of the aforequoted Section 4 of RA 8249 reveals that to fall under the exclusive original jurisdiction of the Sandiganbayan, the following requisites must concur. 1. The offense committed is a violation of a. RA 3019, as amended, the Anti-Graft and Corrupt Practices Act, b. RA 1379, the Law on Ill-Gotten Wealth, see Chapter 2. Section 2, Title 7, Book 2 of the Revised Penal Code, the Law on Bribery, d. Executive Order Nos. 1, 2, 14, and 14a, issued in 1986, sequestration cases, or, e. Other offenses or felonies whether simple or complex with other crimes. 2. The offender committing the offenses in items, a, b, c, and, e. is a public official or employee holding any of the positions enumerated in paragraph A of Section 4, and, 3, the offense committed is in relation to the office. Considering that herein petitioner and interveners are being charged with murder which is a felony punishable under Title 8 of the Revised Penal Code, the governing provision on the jurisdictional offense is not paragraph A but paragraph B, Section 4 of RA 8249. This paragraph B pertains to other offenses or felonies whether simple or complex with other crimes committed by the public officials and employees mentioned in subsection A of Section 4, RA 8249 in relation to their office. The phrase other offenses or felonies is too broad as to include the crime of murder, provided it was committed in relation to the accused's official functions. Thus, under said paragraph B, what determines the Sandiganbayan's jurisdiction is the official position or rank of the offender, that is, whether he is one of those public officers or employees enumerated in paragraph A of section 4. The offenses mentioned in paragraphs A, B and C of the same section 4 do not make any reference to the criminal participation of the accused public officer as to whether he is charged as a principal, accomplice or accessory. In enacting RA 8249, the Congress simply restored the original provisions of PD 1606, which does not mention the criminal participation of the public officer as a requisite to determine the jurisdiction of the Sandiganbayan. Bolastig v. Sandiganbayan, 235 SCRA 103, 1994. Held, it is now settled that Section 13 of Republic Act No. 3019 makes it mandatory for the Sandiganbayan to suspend any public officer against whom a valid information charging violation of that law, Book 2, Title 7 of the Revised Penal Code, or any offense involving fraud upon government or public funds or property is filed. The court trying a case has neither discretion nor duty to determine whether preventive suspension is required to prevent the accused from using his office to intimidate witnesses or frustrate his prosecution or continue committing malfeasance in office. The presumption is that unless the accused is suspended he may frustrate his prosecution or commit further acts of malfeasance or do both. In the same way that upon a finding that there is probable cause to believe that a crime has been committed and that the accused is probably guilty thereof, the law requires the judge to issue a warrant for the arrest of the accused. The law does not require the court to determine whether the accused is likely to escape or evade the jurisdiction of the court. It is indeed true that in some of our decisions the expression "the maximum period of 90 days" is used. But that is only for the purpose of emphasizing that the preventive suspension therein involved, which were for more than 90 days, were excessive and unreasonable. It is to be noted that the 90-day period of preventive suspension is not found in Section 13 of Republic Act No. 3019 but was adopted from Section 42 of the Civil Service Decree, PD No. 807. 7 which is not Section 52 of the Administrative Code of 1987. This latter provision states. Section 52. Lifting of preventive suspension pending administrative investigation. When the administrative case against the officer or employee under preventive suspension is not finally decided by the disciplining authority within the period of 90 days after the date of suspension of the respondent who is not a presidential appointee, the respondent shall be automatically reinstated in the service, provided that when the delay in the disposition of the case is due to the fault, negligence or petition of the respondent, the period of delay shall not be counted in computing the period of suspension herein provided. The duration of preventive suspension is thus coeval with the period prescribed for deciding administrative disciplinary cases. If the case is decided before 90 days, then the suspension will last less than 90 days, but if the case is not decided within 90 days, then the preventive suspension must be up to 90 days only. Similarly, as applied to criminal prosecutions under Republic Act No. 3019, preventive suspension will last for less than 90 days only if the case is decided within that period, otherwise, it will continue for 90 days. Office of the Ombudsman. Composition. Article 11, Section 5. There is hereby created the independent office of the Ombudsman, composed of the Ombudsman to be known as Tenant Bayan, one overall deputy and at least one deputy each for Luzon, Visayas, and Mindanao. A separate deputy for the military establishment may likewise be appointed. Qualifications. Article 11, Section 8. The Ombudsman and his deputy shall be natural-born citizens of the Philippines, and at the time of their appointment, at least 40 years old, of recognized probity and independence, and members of the Philippine Bar, and must not have been candidates for any elective office in the immediately preceding election. The Ombudsman must have for 10 years or more been a judge or engaged in the practice of law in the Philippines. During their tenure, they shall be subject to the same disqualifications and prohibitions as provided for in Section 2 of Article 9A of this Constitution. Appointment and term. Article 11, Section 9. The Ombudsman and his deputy shall be appointed by the President from a list of at least 6 nominees prepared by the Judicial and Bar Council, and from a list of 3 nominees for every vacancy thereafter. Such appointments shall require no confirmation. All vacancies shall be filled within 3 months after they occur. Id. Section 11. The Ombudsman and his deputy shall serve for a term of 7 years without reappointment. They shall not be qualified to run for any office in the election immediately succeeding their cessation from office. Rank and salary. Id. Section 10. The Ombudsman and his deputy shall have the rank of chairman and members, respectively, of the constitutional commissions, and they shall receive the same salary, which shall not be decreased during their term of office. Disqualifications. Article 9, Section 8. During their tenure, they shall be subject to the same disqualifications and prohibitions as provided for in Section 2 of Article 9A of this Constitution. Article 9A, Section 2. No member of a constitutional commission shall, during his tenure, hold any other office or employment. Neither shall he engage in the practice of any profession or in the active management or control of any business which in any way may be affected by the functions of his office, nor shall he be financially interested, directly or indirectly, in any contract with, or in any franchise or privilege granted by the government, any of its subdivisions, agencies or instrumentalities, including government-owned or controlled corporations or their subsidiaries. Article 11, Section 16. No loan, guarantee, or other form of financial accommodation for any business purpose may be granted, directly or indirectly by any government-owned or controlled bank or financial institution to the President, Vice President, the members of the Cabinet, the Congress, the Supreme Court, and the Constitutional Commissions, the Ombudsman, or to any firm or entity in which they have controlling interest, during their tenure. Jurisdiction. Id. Section 12. The Ombudsman and his deputies, as protectors of the people, shall act promptly on complaints filed in any form or manner against public officials or employees of the government, or any subdivision, agency or instrumentality thereof, including government-owned or controlled corporations, and shall, in appropriate cases, notify the complainants of the action taken and the result thereof. Powers and functions. Article 11, Section 13. The office of the Ombudsman shall have the following powers, functions and duties. 1. Investigate on its own or on complaint any act or omission of any public official, employee, office or agency, when such act or omission appears to be illegal, unjust, improper, or inefficient. 2. Direct, upon complaint or at its own instance, any public official or employee of the government, or any subdivision, agency or instrumentality thereof, as well as of any government-owned or controlled corporation with original charter, to perform and expedite any act or duty required by law, or to stop, prevent, and correct any abuse or impropriety in the performance of duties. 3. Direct the officer concerned to take appropriate action against a public official or employee at fault, and recommend his removal, suspension, demotion, fine, censure, or prosecution, and ensure compliance therewith. 4. Direct the officer concerned in any appropriate case, and subject to such limitations as may be provided by law, to furnish it with copies of documents relating to contracts or transactions entered into by his office involving disbursement or use of public funds or properties, and report any irregularity to the Commission on Audit for appropriate action. 5. Request any government agency for assistance and information necessary in the discharge of its responsibilities, and to examine, if necessary, pertinent records and documents. 6. Publicize matters covered by its investigation when circumstances so warrant and with due prudence. 7. Determine the causes of inefficiency, red tape, mismanagement, fraud and corruption in the government and make recommendations for their elimination and the observance of high standards of ethics and efficiency. 8. Promulgate its rules of procedure and exercise such other powers or perform such functions or duties as may be provided by law. The functions of the Ombudsman may be divided into 4, 1. Investigatory, 2. Prosecutory, 3. Disciplinary, and 4. Assistory. Delasso v. Domingo, 191 SCRA 545, 1990. Held, as protector of the people, the office of the Ombudsman has the power, function and duty to act promptly on complaints filed in any form or manner against public officials, Section 12, and to investigate any act or omission of any public official. When such act or omission appears to be illegal, unjust, improper or inefficient. Section 13(1), the Ombudsman is also empowered to direct the officer concerned, in this case the special prosecutor, to take appropriate action against a public official, and to recommend his prosecution, Section 13(3). The clause any illegal act or omission of any public official is broad enough to embrace any crime committed by a public official. The law does not qualify the nature of the illegal act or omission of the public official or employee that the Ombudsman may investigate. It does not require that the act or omission be related to or be connected with or arise from the performance of official duty. Since the law does not distinguish, neither should we. The reason for the creation of the Ombudsman and the 1987 Constitution and for the grant to it of broad investigative authority, is to insulate said office from the long tentacles of officialdom that are able to penetrate judges and fiscals' offices, and others involved in the prosecution of erring public officials, and through the exertion of official pressure and influence, quash, delay, or dismiss investigations into malfeasances and misfeasances committed by public officers. It was deemed necessary, therefore, to create a special office to investigate all criminal complaints against public officers regardless of whether or not the acts or omissions complained of are related to or arise from the performance of the duties of their office. The Ombudsman Act makes perfectly clear that the jurisdiction of the Ombudsman encompasses all kinds of malfeasance, misfeasance, and nonfeasance that have been committed by any officer or employee as mentioned in Section 13 hereof, during his tenure of office, Section 16, RA 6770. Lastimosa v. Vasquez, 243 SCRA 497, 1995. Held, the office of the Ombudsman has the power to investigate and prosecute on its own or on complaint by any person, any act or omission of any public officer or employee, office or agency, when such act or omission appears to be illegal, unjust, improper or inefficient. This power has been held to include the investigation and prosecution of any crime committed by a public official regardless of whether the acts or omissions complained of are related to, or connected with, or arise from, the performance of his official duty. It is enough that the act or omission was committed by a public official. Hence, the crime of rape, when committed by a public official like a municipal mayor, is within the power of the Ombudsman to investigate and prosecute. Buenasita v. Flavier, 226 SCRA 645, 1993. Held, the crucial issue to resolve is whether the Ombudsman has the power to suspend government officials and employees working in offices other than the office of the Ombudsman, pending the investigation of the administrative complaints filed against said officials and employees. In upholding the power of the Ombudsman to preventively suspend petitioners, respondents, urgent motion to lift status quo, etc., dated January 11, 1993, pages 10 to 11, invokes Section 24 of RA No. 6770, which provides. Section 24. Preventive suspension. The Ombudsman or his deputy may preventively suspend any officer or employee under his authority pending an investigation, if in his judgment the evidence of guilt is strong, and, a. the charge against such officer or employee involves dishonesty, oppression or grave misconduct or neglect in the performance of duty, b. the charge would warrant removal from the service, or, c. the respondent's continued stay in office may prejudice the case filed against him. The preventive suspension shall continue until the case is terminated by the Office of Ombudsman, but not more than 6 months, without pay, except when the delay in the disposition of the case by the Office of the Ombudsman is due to the fault, negligence or petition of the respondent, in which case the period of such delay shall not be counted in computing the period of suspension herein provided. When the Constitution vested on the Ombudsman the power to recommend the suspension of a public official or employees, Section 13(3), it referred to suspension, as a punitive measure. All the words associated with the word suspension in said provision referred to penalties in administrative cases, for example removal, demotion, fine, censure. Under the rule of Nociter Associates, the word suspension should be given the same sense as the other words with which it is associated. Where a particular word is equally susceptible of various meanings, its correct construction may be made specific by considering the company of terms in which it is found or with which it is associated. Ko Kim Chan vs. Valdez-Stanket, 75 Phil. 371 1945, Coltex, Phils, Incorporated vs. Palomar, 18 SCRA 247 1966. Section 24 of RA No. 6770, which grants the Ombudsman the power to preventively suspend public officials and employees facing administrative charges before him, is a procedural, not a penal statute. The preventive suspension is imposed after compliance with the requisites therein set forth, as an aid in the investigation of the administrative charges. Under the Constitution, the Ombudsman is expressly authorized to recommend to the appropriate official the discipline or prosecution of erring public officials or employees. In order to make an intelligent determination whether to recommend such actions, the Ombudsman has to conduct an investigation. In turn, in order for him to conduct such investigation in an expeditious and efficient manner, he may need to suspend the respondent. The need for the preventive suspension may arise from several causes, among them, the danger of tampering or destruction of evidence in the possession of respondent, the intimidation of witnesses, etc. The Ombudsman should be given the discretion to decide when the persons facing administrative charges should be preventively suspended. In Nera vs. Garcia, 106 Phil. 1031 1960, this court, holding that a preventive suspension is not a penalty, said, "Suspension is a preliminary step in an administrative investigation. If after such investigation, the charges are established and the person investigated is found guilty of acts warranting his removal, then he is removed or dismissed. This is the penalty." Office of the Special Prosecutor. Zaldivar vs. Sandigan-Bayan, 160 SCRA 843, 1988. Held, now then, inasmuch as the aforementioned duty is given to the Ombudsman, the incumbent Sandigan-Bayan, called Special Prosecutor under the 1987 Constitution and who is supposed to retain powers and duties not given to the Ombudsman, is clearly without authority to conduct preliminary investigations and to direct the filing of criminal cases with the Sandigan-Bayan, except upon orders of the Ombudsman. This right to do so was lost effective February 2, 1987. From that time, he has been divested of such authority. Under the present Constitution, the Special Prosecutor, Raul Gonzalez, is a mere subordinate of the Sandigan-Bayan, Ombudsman, and can investigate and prosecute cases only upon the latter's authority or orders. The Special Prosecutor cannot initiate the prosecution of cases but can only conduct the same if instructed to do so by the Ombudsman. Even his original power to issue subpoena, which he still claims under Section 10D of PD 1630, is now deemed transferred to the Ombudsman, who may, however, retain it in the Special Prosecutor in connection with the cases he is ordered to investigate. Commission on Human Rights. Composition and Qualifications. Article 13, Section 17. 1. There is hereby created an independent office called the Commission on Human Rights. 2. The Commission shall be composed of a chairman and 4 members who must be natural-born citizens of the Philippines and a majority of whom shall be members of the bar. The term of office and other qualifications and disabilities of the members of the Commission shall be provided by law. 3. Until this Commission is constituted, The existing Presidential Committee on Human Rights shall continue to exercise its present functions and powers. 4. The approved annual appropriations of the Commission shall be automatically and regularly released. Powers and Functions. Article 13, Section 18. The Commission on Human Rights shall have the following powers and functions. 1. Investigate, on its own or on complaint by any party, all forms of human rights violations involving civil and political rights. 2. Adopt its operational guidelines and rules of procedure, and cite for contempt for violations thereof in accordance with the rules of court. 3. Provide appropriate legal measures for the protection of human rights of all persons within the Philippines, as well as Filipinos residing abroad, and provide for preventive measures and legal aid services to the underprivileged whose human rights have been violated or need protection. 4. Exercise visitorial powers over jails, prisons, or detention facilities. 5. Establish a continuing program of research, education, and information to enhance respect for the primacy of human rights. 6. Recommend to the Congress effective measures to promote human rights and provide for compensation to victims of violations of human rights, or their families. 7. Monitor the Philippine government's compliance with international treaty obligations on human rights. 8. Grant immunity from prosecution to any person whose testimony or whose possession of documents or other evidence is necessary or convenient to determine the truth in any investigation conducted by it or under its authority. 9. Request the assistance of any department, bureau, office, or agency in the performance of its functions. 10. Appoint its officers and employer in accordance with law, and 11. Perform such other duties and functions as may be provided by law. Id. Section 19. The Congress may provide for other cases of violations of human rights that should fall within the authority of the Commission, taking into account its recommendations. Carino v. Commission on Human Rights, 204 SCRA 483, 1991. Held. The threshold question is whether or not the CHR has the power under the Constitution to adjudicate, whether or not, like a court of justice, or even a quasi-judicial agency, it has jurisdiction or adjudicatory powers or the power to try and decide, or hear and determine, certain specific type of cases, like alleged human rights violations involving civil or political rights. The court declares the CHR to have no such power. The most that may be conceded to the CHR in the way of adjudicative power is that it may investigate, that is, receive evidence and make findings of fact as regards claimed human rights violations involving civil and political rights. But fact-finding is not adjudication, and cannot be likened to the judicial function of a court of justice, or even a quasi-judicial agency or official. To be considered a judicial function, the faculty or receiving evidence and making factual conclusions in a controversy must be accompanied by the authority of applying the law to those factual conclusions to the end that the controversy may be decided or determined authoritatively, finally and definitely, subject to such appeals or modes of review as may be provided by law. This function, to repeat, the CHR does not have. IPSA v. CHR, 208 SCRA 125, 1992. Issue: does the CHR have jurisdiction to issue a writ of injunction or restraining order against supposed violators of human rights, to compel them to cease and desist from continuing the acts complained of? Held: no. The constitutional provision directing the CHR to provide for preventive measures and legal aid services to the underprivileged whose human rights have been violated or need protection may not be construed to confer jurisdiction on the CHR to issue a restraining order or a writ of injunction for, if that were the intention, the Constitution would have expressly said so. Jurisdiction is only conferred by the Constitution or by law. Evidently, the preventive measures and legal aid services mentioned in the Constitution refer to extrajudicial and judicial remedies, including preliminary writ of injunction, which the CHR may seek from the proper courts on behalf of the victims of human rights violations. Not being a court of justice, the CHR itself has not jurisdiction to issue the writ, for a writ of preliminary injunction may only be issued by the judge of any court in which the action is pending, w. in his district, or by a justice of the CA, or of the SC. It may also be granted by a judge of a RTC in any action pending in an inferior court within his district. Constitutional law. Constitutional law, definition, the study of the maintenance of the proper balance between authority as represented by the three inherent powers of the state and liberty as guaranteed by the Bill of Rights. Manila Prince vs. Xis, 267 SCRA 408, 1997. Held. A constitution is a system of fundamental laws for the governance and administration of a nation. It is supreme, imperious, absolute and unalterable except by the authority from which it emanates. It has been defined as the fundamental and paramount law of the nation. It prescribes the permanent framework of a system of government, assigns to the different departments their respective powers and duties, and establishes certain fixed principles on which government is founded. The fundamental conception in other words is that it is a supreme law to which all other laws must conform and in accordance with which all private rights must be determined and all public authority administered. What is the doctrine of constitutional supremacy? Under the doctrine of constitutional supremacy, if a law or contract violates any norm of the Constitution, that law or contract, whether promulgated by the legislative or by the executive branch or entered into by private persons for private purposes, is null and void and without any force and effect. Thus, since the Constitution is the fundamental, paramount and supreme law of the nation, it is deemed written in every statute and contract. Manila Prince Hotel vs. Xis, 267 SCRA 408 1997 Belozolo. Classification. I. Written versus unwritten. 1. Written, one whose precepts are embodied in one document or set of documents. 2. Unwritten, consists of rules which have not been integrated into a single, concrete form but are scattered in various sources, such as statutes of fundamental character, judicial decisions, commentaries of publicists, customs and traditions, and certain common law principles. 2. Conventional versus cumulative. 1. Conventional, an enacted constitution, formally struck off at a definite time and place following a conscious or deliberate effort taken by a constituent body or ruler. 2. Cumulative, result of political evolution, not inaugurated at any specific time but changing by accretion rather than by any systematic method. 3. Rigid versus flexible. 1. Rigid, one that can be amended only by a formal and usually difficult process. 2. Flexible, one that can be changed by ordinary legislation. The Constitution of the Philippines is written, conventional and rigid. Essential qualities of the written constitution. 1. Broad. 2. Brief. Not only because it provides for the organization of the entire government and covers all persons and things within the territory of the state but more so because it is supposed to embody the past, to reflect the present and to anticipate the future. The Constitution must be comprehensive enough to provide for every contingency. It must be brief and confine itself to basic principles to be implemented with legislative details more adjustable to change and easier to amend. 3. Definite. Ambiguity in its provisions will result in confusion and divisiveness among the people, and perhaps even physical conflict. Exception, found only in those cases where the rules are deliberately worded in a vague manner, like the Due Process Clause, to make them more malleable to judicial interpretation in the light of new conditions and circumstances. Essential parts of the written Constitution. 1. Constitution of Liberty. Series of prescriptions setting forth the fundamental civil and political rights of the citizens and imposing limitations on the powers of government as a means of securing the enjoyment of these rights. Articles 2, 3, 4, 5, and 12. 2. Constitution of Government. Series of provisions outlining the organization of the government, enumerating its powers, laying down certain rules relative to its administration and defining the electorate. Articles V to 11. 3. Constitution of Sovereignty. consists of provisions pointing out the mode or procedure in accordance with which formal changes in the fundamental law may be brought about. Article 17. Inherent powers of the state. Definition. Taxation. Power of the state to demand enforced contributions for public purposes. Police power. Power of the state to enact such laws in relation to persons and property as may promote public health, safety, morals, and the general welfare of the public. Eminent domain. Power of the state to take private property for public use upon paying to the owner a just compensation to be ascertained according to law. Authority exercising the power. Taxation. Only the government or its political subdivisions. Police power. Only the government and its political subdivisions. Eminent domain. May be granted to public service or public utility. Companies. Purpose. Taxation. Enforced contribution is demanded for the support of the government. Police power. Use of property is regulated for the purpose of promoting the general welfare. Eminent domain. Property is taken for public use. Persons affected. Taxation. Operates upon a community, a class of individuals or their property. Police power. Operates upon a community, a class of individuals or their property. Eminent domain. Operates on an individual as the owner of a particular property. Effect. Taxation. Money contributed in the concept of taxes becomes part of public funds. Police power. No transfer of ownership of the property seized, at most there is restraint on the injurious use of the property. Restraint on the exercise of a right. Eminent domain. There is transfer of ownership or a lesser right, for example lease, of the property. Benefits received. Taxation. Presumed that the taxpayer receives the equivalent of what he contributed in the form of protection from the government, and the enjoyment of living in a civilized society. Police power. Persons affected receives no direct benefit but only as such as may arise from the maintenance of the healthy economic standard of society. Eminent domain. Person affected receives just compensation for the property taken from him. Amount of imposition. Taxation. Generally no limit as to the amount of tax to be imposed. Police power. Amount imposed should not be more than that sufficient to cover the cost of the license and the necessary expenses of regulation. Eminent domain. No amount imposed, since it is property which is taken. Relationship to the Constitution. Taxation. Subject to certain constitutional limitations. Police power. Relatively free from constitutional limitations and is superior to the non-impairment provisions. Eminent domain. Subject to certain constitutional limitations, for example inferior to the non-impairment of contract clause. Police power. MMDA vs. Belair Village Association Incorporated, 328 SCRA 836, March 27, 2000, 1st Division Puno. Held, police power is an inherent attribute of sovereignty. It has been defined as the power vested by the Constitution in the legislature to make, ordain, and establish all manner of wholesome and reasonable laws, statutes and ordinances, either with penalties or without, not repugnant to the Constitution, as they shall judge to be for the good and welfare of the Commonwealth, and for the subjects of the same. It bears stressing that police power is lodged primarily in the national legislature. It cannot be exercised by any group or body of individuals not possessing legislative power. The national legislature, however, may delegate this power to the president and administrative boards as well as the lawmaking bodies of municipal corporations or local government units. Once delegated, the agents can exercise only such legislative powers as are conferred on them by the national lawmaking body. The exercise of the police power lies in the discretion of the legislative department. No mandamus is available to coerce the exercise of the police power. The only remedy against legislative inaction is a resort to the bar of public opinion, the refusal of the electorate to return to the legislature members who, in their view, have been remiss in the discharge of their duties. Binay v. Domingo, 201 SCRA 508, 1991. Held, the police power is a governmental function, an inherent attribute of sovereignty, which was born with civilized government. It is founded largely on the maxims, Secutortio et alienem non nidus and Salus populi state suprema lex. Its fundamental purpose is securing the general welfare, comfort and convenience of the people. Police power is the power to prescribe regulations to promote the health, morals, peace, education, good order or safety and general welfare of the people. It is the most essential, insistent, and illimitable of powers. In a sense it is the greatest and most powerful attribute of the government. It is elastic and must be responsive to various social conditions. Sengalang, et al. Versus IAC, 176 SCRA 719. On it depends the security of social order, the life and health of the citizen, the comfort of an existence in a thickly populated community, the enjoyment of private and social life, and the beneficial use of property, and it has been said to be the very foundation on which our social system rests. 16 CJS, p. 896, however, it is not confined within narrow circumstances of precedents resting on past conditions, it must follow the legal progress of a democratic way of life. Sengalang, et al. Versus Lac, Supra. Paisai vs. Drilon, 163 SCRA 386, 1988. Held, the concept of police power is well established in this jurisdiction. It has been defined as the state authority to enact legislation that may interfere with personal liberty or property in order to promote the general welfare. As defined, it consists of 1. An imposition of restraint upon liberty or property, 2. In order to foster the common good. It is not capable of an exact definition but has been, purposely, veiled in general terms to underscore its all-comprehensive embrace. Its scope, ever expanding to meet the exigencies of the times, even to anticipate the future where it could be done, provides enough room for an efficient and flexible response to conditions and circumstances, thus assuring the greatest benefits. It finds no specific constitutional grant for the plain reason that it does not owe its origin to the Charter. Along with the taxing power and eminent domain, it is inborn in the very fact of statehood and sovereignty. It is a fundamental attribute of government that has enabled it to perform the most vital functions of governance. Marshall, to whom the expression has been credited, refers to it succinctly as the plenary power of the state to govern its citizens. The police power of the state is a power coextensive with self-protection, and it is not inaptly termed the law of overwhelming necessity. It may be said to be that inherent and plenary power in the state which enables it to prohibit all things hurtful to the comfort, safety, and welfare of society. It constitutes an implied limitation on the Bill of Rights. According to Fernando, it is rooted in the conception that man in organizing the state and imposing upon its government limitations to safeguard constitutional rights did not intend thereby to enable an individual citizen or group of citizens to obstruct unreasonably the enactment of such salutary measures calculated to ensure communal peace, safety, good order, and welfare. Significantly, the Bill of Rights itself does not purport to be an absolute guarantee of individual rights and liberties. Even liberty itself, the greatest of all rights, is not unrestricted license to act according to one's will. It is subject to the far more overriding demands and requirements of the greater number. Notwithstanding its extensive sweep, police power is not without its own limitations. For all its awesome consequences, it may not be exercised arbitrarily or unreasonably. Otherwise, and in that event, it defeats the purpose for which it is exercised, that is, to advance the public good. Thus, when the power is used to further private interests at the expense of the citizenry, there is a clear misuse of the power. Police power may sometimes use the taxing power as an implement for the attainment of a legitimate police objective. Shio vs. VRB, 151 SCRA 208, 1987. Held, The public purpose of a tax may legally exist even if the motive which impelled the legislature to impose the tax was to favor one industry over another. It is inherent in the power to tax that a state be free to select the subjects of taxation, and it has been repeatedly held that inequities which result from a singling out of one particular class for taxation or exemption infringe no constitutional limitation. Taxation has been made the implement of the state's police power. The power of eminent domain could also be used as an implement of the police power. Roxas and Company Incorporated vs. C.A. 321 SCRA 106, 1999. Q. What powers of the state are involved in the implementation of the Comprehensive Agrarian Reform Law, CARL? Discuss. Held. The implementation of the CARL is an exercise of the state's police power and the power of eminent domain. To the extent that the CARL prescribes retention limits to the landowners, there is an exercise of police power for the regulation of private property in accordance with the Constitution. But where, to carry out such regulation, the owners are deprived of lands they own in excess of the maximum area allowed, there is also a taking under the power of eminent domain. The taking contemplated is not a mere limitation of the use of the land. What is required is the surrender of the title to and physical possession of the said excess and all beneficial rights accruing to the owner in favor of the farmer beneficiary. The Bill of Rights provides that no person shall be deprived of life, liberty or property without due process of law. The CARL was not intended to take away property without due process of law. The exercise of the power of eminent domain requires that due process be observed in the taking of private property. Republic vs. Meralco, 391 SCRA 700, 2002. Q. Discuss why rates to be charged by public utilities like Meralco are subject to state regulation. Held. The regulation of rates to be charged by public utilities is founded upon the police power of the state and statutes prescribing rules for the control and regulations of public utilities are a valid exercise thereof. When private property is used for a public purpose and is affected with public interest, it ceases to be juris privati only and becomes subject to regulation. The regulation is to promote the common good. Submission to regulation may be withdrawn by the owner by discontinuing use, but as long as the use of the property is continued, the same is subject to public regulation. In regulating rates charged by public utilities, the state protects the public against arbitrary and excessive rates while maintaining the efficiency and quality of services rendered. However, the power to regulate rates does not give the state the right to prescribe rates which are so low as to deprive the public utility of a reasonable return on investment. Thus, the rates prescribed by the state must be one that yields a fair return on the public utility upon the value of the property performing the service and one that is reasonable to the public for the service rendered. The fixing of just and reasonable rates involves a balancing of the investor and the consumer interests. Aspito Optical Company Incorporated vs. CA, 329 SCRA 314, 2000. Q. Discuss the nature of the authority of local government units to issue or grant licenses or permits. Held. The issuance of business licenses and permits by a municipality or city is essentially regulatory in nature. The authority, which devolved upon local government units to issue or grant such licenses or permits, is essentially in the exercise of the police power of the state within the contemplation of the General Welfare Clause of the Local Government Code. Binet vs. Domingo, 201 SCRA 508, 1991. Held. Police power is inherent in the state but not in municipal corporations. Balacuit vs. CFI of Agustín del Norte, 163 SCRA 182. Before a municipal corporation may exercise such power, there must be a valid delegation of such power by the legislature, which is the repository of the inherent powers of the state. A valid delegation of police power may arise from express delegation, or be inferred from the mere fact of the creation of the municipal corporation, and as a general rule, municipal corporations may exercise police powers within the fair intent and purpose of their creation which are reasonably proper to give effect to the powers expressly granted. and statutes conferring powers on public corporations have been construed as empowering them to do the things essential to the enjoyment of life and desirable for the safety of the people. 62 CJS, p. 277. The so-called inferred police powers of such corporations are as much delegated powers as are those conferred in express terms, the inference of their delegation growing out of the fact of the creation of the municipal corporation and the additional fact that the corporation can only fully accomplish the objects of its creation by exercising such powers. Crawfordsville v. Braden, 28 NE 849. Furthermore, municipal corporations, as governmental agencies, must have such measures of the power as are necessary to enable them to perform their governmental functions. The power is a continuing one, founded on public necessity. 62 CJS, p. 273. Thus, not only does the state effectuate its purposes through the exercise of the police power but the municipality does also. U.S. v. Salavria, 39 Phil. 102. Municipal governments exercise this power under the General Welfare Clause. Pursuant thereto they are clothed with authority to enact such ordinances and issue such regulations as may be necessary to carry out and discharge the responsibilities conferred upon it by law, and such as shall be necessary and proper to provide for the health, safety, comfort and convenience, maintain peace and order, improve public morals, promote the prosperity and general welfare of the municipality and the inhabitants thereof, and ensure the protection of property therein. Sections 91, 149, 177 and 208, BP 337. And under Section 7 of BP 337, every local government unit shall exercise the powers expressly granted, those necessarily implied therefrom, as well as powers necessary and proper for governance such as to promote health and safety, enhance prosperity, improve morals, and maintain peace and order in the local government unit, and preserve the comfort and convenience of the inhabitants therein. The police power of a municipal corporation is broad, and has been said to be commensurate with, but not to exceed, the duty to provide for the real needs of the people in their health, safety, comfort, and convenience as consistently as may be with private rights. It extends to all the great public needs, and, in a broad sense includes all legislation and almost every function of the municipal government. It covers a wide scope of subjects, and, while it is especially occupied with whatever affects the peace, security, health, morals, and general welfare of the community, it is not limited thereto, but is broadened to deal with conditions which exist so as to bring out of them the greatest welfare of the people by promoting public convenience or general prosperity, and to everything worthwhile for the preservation of comfort of the inhabitants of the corporation. 62 CJS Section 128. Thus, it is deemed inadvisable to attempt to frame any definition which shall absolutely indicate the limits of police power. Filtreg Workers Union PTWU vs. Confzer, 269 SCRA 393, March 12, 1997. Held, Article 263G of the Labor Code, vesting upon the Secretary of Labor the discretion to determine what industries are indispensable to the national interest and thereafter, assume jurisdiction over disputes in said industries, does not interfere with the workers' right to strike but merely regulates it. When in the exercise of such right, national interests will be affected. The rights granted by the Constitution are not absolute. They are still subject to control and limitation to ensure that they are not exercised arbitrarily. The interests of both the employers and the employees are intended to be protected and not one of them is given undue preference. The Labor Code vests upon the Secretary of Labor the discretion to determine what industries are indispensable to national interest. Thus, upon the determination of the Secretary of Labor that such industry is indispensable to the national interest, it will assume jurisdiction over the labor dispute of said industry. The assumption of jurisdiction is in the nature of police power measure. This is done for the promotion of the common good, considering that a prolonged strike or lockout can be inimical to the national economy. Requisites. Lawful subject, the interests of the public generally, as distinguished from those of a particular class, require the exercise of the police power. Lawful means, the means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive upon individuals. The first requisite simply means that the subject of the measure is within the scope of the police power, that is, that the activity or property sought to be regulated affects the public welfare. As long as the object is the public welfare and the subject of regulation may be properly related thereto, there is compliance with the first test requiring the primacy of the welfare of the many over the interests of the few. Even if the purpose be within the scope of the police power, the law will still be annulled if the subject is sought to be regulated in violation of the second requirement. In constitutional law, the end does not justify the means. The lawful objective, in other words, must be pursued through a lawful method, that is, both the end and the means must be legitimate. Lacking such concurrence, the police measure shall be struck down as an arbitrary intrusion into private rights. Churchill and Tate vs. Rafferty, 32 Phil 580, 1915. Held, there can be no doubt that the exercise of the police power of the Philippine government belongs to the legislature and that this power is limited only by the acts of Congress and those fundamental principles which lie at the foundation of all republican forms of government. An act of the legislature which is obviously and undoubtedly foreign to any of the purposes of the police power and interferes with the ordinary enjoyment of property would, without doubt, be held to be invalid. But where the act is reasonably within a proper consideration of and care for the public health, safety, or comfort, it should not be disturbed by the courts. The courts cannot substitute their own views for what is proper and the premises for those of the legislature. If a law relates to the public health, safety, morals, comfort, or general welfare of the community, it is within the scope of the police power of the state. Within such bounds the wisdom, expediency, or necessity of the law does not concern the courts. It is the police power has for its object the improvement of social and economic conditions affecting the community at large and collectively with a view to bring about the greatest good of the greatest number. Courts have consistently and wisely declined to set any fixed limitations upon subjects calling for the exercise of this power. It is elastic and is exercised from time to time as varying social conditions demand correction. From whatever direction the social, economic, or general welfare of the people is menaced, there is legal justification for the exercise of the police power, and the use of private property may be regulated or restricted to whatever extent may be necessary to preserve inviolate these declared essentials to the well-being of the public. It has long been recognized that uses of private property which are offensive to the senses of smell of hearing may be so regulated or segregated as to disturb as little as possible the pursuits of other persons. It is not the adoption of a new principle but simply the extension of a well-established principle to hold that the police power may also regulate and restrict uses of private property when devoted to advertising which is offensive to the sight. The indiscriminate use of outdoor advertising tends to mar not only natural outdoor landscapes but whatever of civic beauty has been attained by the expenditure of public monies for parks, boulevards, and buildings. The widespread agitation in many European countries, as well as in the United States, against the so-called billboards, the most common form of this kind of advertising, shows that they are a source of annoyance and irritation to the public and interfere with the proper enjoyment of outdoor life by the general public. This justifies their suppression or regulation to the extent that they interfere with the right of the public. Taxicab operators of vs. Spot, 117 SCRA 597, 1982. Held, petitioners farther take the position that fixing the ceiling at 6 years is arbitrary and oppressive because of roadworthiness of taxicabs depends upon their kind of maintenance and the use to which they are subjected, and, therefore, their actual physical condition should be taken into consideration at the time of registration. As public respondents contend, however, it is impractical to subject every taxicab to constant and recurring evaluation, not to speak of the fact that it can open the door to the adoption of multiple standards, possible collusion, and even graft and corruption. A reasonable standard must be adopted to apply to all vehicles affected uniformly, fairly, and justly. The span of 6 years supplies that reasonable standard. The product of experience shows that by the time taxis have fully depreciated, their cost recovered, and a fair return on investment obtained. At the outset it should be pointed out that implementation outside Metro Manila is also envisioned in Memorandum Circular No. 7742. The board's reason for enforcing the circular initially in Metro Manila is that taxicabs in this city, compared to those of other places, are subjected to heavier traffic pressure and more constant use. This is of common knowledge. Considering that traffic conditions are not the same in every city, a substantial distinction exists so that infringement of the Equal Protection Clause can hardly be successfully claimed. As enunciated in the preambular clauses of the challenged BOT circular, the overriding consideration is the safety and comfort of the riding public from the dangers posed by old and dilapidated taxis. The state, in the exercise of its police power, can prescribe regulations to promote the health, morals, peace, good order, safety and general welfare of the people. It can prohibit all things hurtful to comfort, safety and welfare of society. Edu vs. Ericta, 35 SCRA 48 1970. It may also regulate property rights. Sampson vs. Mayor of Bacolod City, 60 SCRA 267 1974. In the language of Chief Justice Enrique M. Fernando, the necessities imposed by public welfare may justify the exercise of governmental authority to regulate even if thereby certain groups may plausibly assert that their interests are disregarded. The Constitution of the Philippines, 2nd edition, page 548. Lozano vs. Martinez, 146 SCRA 324, 1986. Held. The gravamen of the offense punished by BP 22 is the act of making and issuing a worthless check or a check that is dishonored upon its presentation for payment. It is not the non-payment of an obligation which the law punishes. The law is not intended or designed to coerce a debtor to pay his debt. The thrust of the law is to prohibit, under pain of sanctions, the making of worthless checks and putting them in circulation. Because of its deleterious effects on the public interest, the practice is prescribed by the law. The law punishes the act not as an offense against property, but an offense against public order. It may be constitutionally impermissible for the legislature to penalize a person for non-payment of a debt ex contractu. But certainly it is within the prerogative of the lawmaking body to proscribe certain acts deemed pernicious and inimical to public welfare. Acts mala and se are not the only facts which the law can punish. An act may not be considered by society as inherently wrong, hence not malum in se, but because of the harm that it inflicts on the community, it can be outlawed and criminally punished as malum prohibitum. The state can do this in the exercise of its police power. Deeks vs. San Diego, 180 SCRA 533, 1989. Facts. The question is whether a person who has thrice failed the National Medical Admission Test, NMAT, is entitled to take it again. The petitioner contends he may not, under its rule that a student shall be allowed only 3 chances to take the NMAT. After 3 successive failures, a student shall not be allowed to take the NMAT for the 4th time. Held. The proper exercise of the police power requires the concurrence of a lawful subject and a lawful method. The subject of the challenged regulation is certainly within the ambit of the police power. It is the right and indeed the responsibility of the state to ensure that the medical profession is not infiltrated by incompetents to whom patients may unwarily entrust their lives and health. The method employed by the challenged regulation is not irrelevant to the purpose of the law, nor is it arbitrary or oppressive. The 3-flunk rule is intended to insulate the medical schools and ultimately the medical profession from the intrusion of those not qualified to be doctors. While every person is entitled to aspire to be a doctor, he does not have a constitutional right to be a doctor. This is true of any other calling in which the public interest is involved, and the closer the link, the longer the bridge to one's ambition. The state has the responsibility to harness its human resources and to see to it that they are not dissipated or, no less worse, not used at all. These resources must be applied in a manner that will best promote the common good while also giving the individual a sense of satisfaction. A person cannot insist on being a physician if he will be a menace to his patients. If one who wants to be a lawyer may prove better as a plumber, he should be so advised and advised. Of course, he may not be forced to be a plumber, but on the other hand he may not force his entry into the bar. By the same token, a student who has demonstrated promise as a pianist cannot be shunted aside to take a course in nursing, however appropriate this career may be for others. The right to quality education invoked by the private respondent is not absolute. The Constitution also provides that every citizen has the right to choose a profession or course of study, subject to fair, reasonable and equitable admission and academic requirements. The private respondent must yield to the challenged rule and give way to those better prepared. Where even those who have qualified may still not be accommodated in our already crowded medical schools, there is all the more reason to bar those who, like him, have been tested and found wanting. Sengalang vs. IAC, 176 SCRA 719, 1989. Issue: whether or not the mayor of Makati could have validly opened Jupiter and Orbit streets to vehicular traffic? Held: there is no merit in Bava's claims that the demolition of the gates at Orbit and Jupiter streets amounts to deprivation of property without due process of law or expropriation without just compensation. There is no taking of property involved here. The act of the mayor now challenged is, rather, in the concept of police power. Unlike the power of eminent domain, police power is exercised without provision for just compensation. However, it may not be done arbitrarily or unreasonably. But the burden of showing that it is unjustified lies on the aggrieved party. Our considered opinion is that Bava has failed to show that the opening up of Orbit Street was unjustified, or that the mayor acted unreasonably. The fact that it has led to the loss of privacy of Bava residents is no argument against the municipality's effort to ease vehicular traffic in Makati. Certainly, the duty of a local executive is to take care of the needs of the greater number, in many cases, at the expense of the minority. Centeno vs. Villalan Pornos, 236 SCRA 197, 1994. May solicitation for religious purposes be subject to proper regulation by the state in the exercise of police power? Held: whence, even the exercise of religion may be regulated, at some slight inconvenience, in order that the state may protect its citizens from injury. Without doubt, a state may protect its citizens from fraudulent solicitation by requiring a stranger in the community, before permitting him publicly to solicit funds for any purpose, to establish his identity and his authority to act for the cause which he purports to represent. The state is likewise free to regulate the time and manner of solicitation generally, in the interest of public safety, peace, comfort, or convenience. It does not follow, therefore, from the constitutional guarantees of the free exercise of religion that everything which may be so called can be tolerated. It has been said that a law advancing a legitimate governmental interest is not necessarily invalid as one interfering with the free exercise of religion merely because it also incidentally has a detrimental effect on the adherents of one or more religion. Thus, the general regulation, in the public interest, of solicitation, which does not involve any religious test and does not unreasonably obstruct or delay the collection of funds, is not open to any constitutional objection, even though the collection be for a religious purpose. Such regulation would not constitute a prohibited previous restraint on the free exercise of religion or interpose an inadmissible obstacle to its exercise. Villacorta vs. Bernardo, 143 SCRA 480, 1986. Held: regulation is a fact of life in any well-ordered community. As society becomes more and more complex, the police power becomes correspondingly ubiquitous. This has to be so, for the individual must subordinate his interests to the common good, on the time-honored justification of salus populi estate suprema lex. In this prolix age, practically everything a person does and owns affects the public interest directly or at least vicariously, unavoidably drawing him within the embrace of the police power. Increasingly, he is hemmed in by all manner of statutory, administrative and municipal requirements and restrictions that he may find officious and even oppressive. It is necessary to stress that unless the creeping interference of the government in essentially private matters is moderated, it is likely to destroy that prized and peculiar virtue of the free society, individualism. Every member of society, while paying proper deference to the general welfare, must not be deprived of the right to be left alone or, in the idiom of the day, to do his thing. As long as he does not prejudice others, his freedom as an individual must not be unduly curtailed. We therefore urge that proper care attend the exercise of the police power lest it deteriorate into an unreasonable intrusion into the purely private affairs of the individual. The so-called general welfare is too amorphous and convenient an excuse for official arbitrariness. Let it always be remembered that in the truly democratic state, protecting the rights of the individual is as important as, if not more so than, protecting the rights of the public. This advice is especially addressed to the local governments which exercise the police power only by virtue of a valid delegation from the national legislature under the General Welfare Clause. David v. Macapagal Arroyo, GR number 171396, May 3, 2006. May a law be declared unconstitutional because of the illegal acts done in pursuant of its implementation? Facts: of the 7 petitions, 3 indicate direct injury. In GR number 171396, petitioners David and Lamas alleged that, on February 24, 2006, they were arrested without warrants on their way to EDSA to celebrate the 20th anniversary of People Power I. The arresting officer cited pages 1017 as basis of the arrest. In GR number 171409, petitioners Quecho Olivares and Tribune Publishing Company Incorporated claimed that on February 25, 2006, the SIG operatives raided and ransacked without warrant their office. 3 policemen were assigned to guard their office as a possible source of destabilization. Again, the basis was pages 1017. And in GR number 171483, petitioners KMU and Naflu KMU et al. Alleged that their members were turned away and dispersed when they went to EDSA and later, to Ayala Avenue, to celebrate the 20th anniversary of People Power I. A perusal of the direct injuries allegedly suffered by the said petitioner shows that they resulted from the implementation, pursuant to GO number 5, of pages 1017. Issue: can this court adjudge as unconstitutional pages 1017 and GO no 5 on the basis of these illegal acts? In general, does the illegal implementation of a law render it unconstitutional? Held, settled is the rule that courts are not at liberty to declare statutes invalid although they may be abused and misused and may afford an opportunity for abuse in the manner of application. The validity of a statute or ordinance is to be determined from its general purpose and its efficiency to accomplish the end desired, not from its effects in a particular case. Pages 1017 is merely an invocation of the President's calling out power. Its general purpose is to command the AFP to suppress all forms of lawless violence, invasion or rebellion. It had accomplished the end desired which prompted President Arroyo to issue pages 1021. But there is nothing in pages 1017 allowing the police, expressly or impliedly, to conduct illegal arrest, search or violate the citizens' constitutional rights. Now, may this court adjudge a law or ordinance unconstitutional on the ground that its implementer committed illegal acts? The answer is no. The criterion by which the validity of the statute or ordinance is to be measured is the essential basis for the exercise of power, and not a mere incidental result arising from its exertion. This is logical. Just imagine the absurdity of situations when laws may be declared unconstitutional just because the officers implementing them have acted arbitrarily. If this were so, judging from the blunders committed by policemen in the cases passed upon by the court, majority of the provisions of the revised penal code would have been declared unconstitutional a long time ago. Delmar v. Pagker, 346 SCRA 485, 2000. Q. How should laws that grant the right to exercise a part of the police power of the state be construed? Held, lest the idea gets lost in the shoals of our subconsciousness, Let us not forget that Pagcur is engaged in business affected with public interest. The phrase affected with public interest means that an industry is subject to control for the public good. It has been considered as the equivalent of subject to the exercise of the police power. Perforce, a legislative franchise to operate Jai-Alai is imbued with public interest and involves an exercise of police power. The familiar rule is that laws which grant the right to exercise a part of the police power of the state are to be construed strictly and any doubt must be resolved against the grant. The legislature is regarded as the guardian of society, and therefore is not presumed to disable itself or abandon the discharge of its duty. Thus, courts do not assume that the legislature intended to part away with its power to regulate public morals. The presumption is influenced by constitutional considerations. Constitutions are widely understood to withhold from legislatures any authority to bargain away their police power, for the power to protect the public interest is beyond abnegation. It is stressed that the case at bar does not involve a franchise to operate a public utility, such as water, transportation, communication or electricity, the operation of which undoubtedly redounds to the benefit of the general public. What is claimed is an alleged legislative grant of a gambling franchise, a franchise to operate Jai-Alai. A statute which legalizes a gambling activity or business should be strictly construed, and every reasonable doubt must be resolved to limit the powers and rights claimed under its authority. Power of eminent domain. Who may exercise? Heirs of Alberto Sagayan v. City of Mandaluyong, 328 SCRA 137. March 14, 2000. The exercise of the right of eminent domain, whether directly by the state, or by its authorized agents, is necessarily in derogation of private rights, and the rule in that case is that the authority must be strictly construed. No species of property is held by individuals with greater tenacity, and none is guarded by the Constitution and the laws more sedulously, than the right to the freehold of inhabitants. When the legislature interferes with that right, and, for greater public purposes, appropriates the land of an individual without his consent, the plain meaning of the law should not be enlarged by doubtful interpretation. Exercise of eminent domain by LGUs. Municipality of Parañaque vs. M Realty Corporation, 292 SCRA 678, July 20, 1998 Panganiban. The power of eminent domain is lodged in the legislative branch of government, which may delegate the exercise thereof to LGUs, other public entities and public utilities. An LGU may therefore exercise the power to expropriate private property only when authorized by Congress and subject to the latter's control and restraints imposed through the law conferring the power or in other legislations. In this case, Section 19 of RA 7160, which delegates to LGUs the power of eminent domain, also lays down the parameters for its exercise. Thus, the following essential requisites must concur before an LGU can exercise the power of eminent domain. 1. An ordinance is enacted by the local legislative council authorizing the local chief executive, in behalf of the LGU, to exercise the power of eminent domain or pursue expropriation proceedings over a particular private property. 2. The power of eminent domain is exercised for public use, purpose or welfare, or for the benefit of the poor and the landless. 3. There is payment of just compensation, as required under Section 9, Article 3 of the Constitution, and other pertinent laws. 4. A valid and definite offer has been previously made to the owner of the property sought to be expropriated, but said offer was not accepted. In the case at bar, the local chief executive sought to exercise the power of eminent domain pursuant to a resolution of the municipal council. Thus, there was no compliance with the first requisite that the mayor be authorized through an ordinance. A municipal ordinance is different from a resolution. An ordinance is a law, but a resolution is merely a declaration of the sentiment or opinion of a lawmaking body on a specific matter. An ordinance possesses a general and permanent character, but a resolution is temporary in nature. Additionally, the two are enacted differently. A third reading is necessary for an ordinance, but not for a resolution. unless decided otherwise by a majority of all the sanguinian members. Requisites for proper exercise. 1. Taking of private property. 2. Public use, purpose. 3. Payment of just compensation. 4. A valid offer to buy and refusal of offer. Taking in the constitutional sense may include trespass without actual eviction of the owner, material impairment of the value of the property or prevention of the ordinary uses for which the property was intended. Requisites for a valid taking. 1. Expropriator must enter a private property. 2. Entry must be for more than a momentary period. 3. Entry must be under warrant or color of authority. 4. Property must be devoted to public use or otherwise informally appropriated or injuriously affected. 5. Utilization of the property must be in such a way as to oust the owner and deprive him of beneficial enjoyment. Taking under eminent domain distinguished from taking under the police power. PPI vs. Kumlek, GR number 119694. May 22, 1995. To compel print media companies to donate Kumlek space of the dimensions specified in Section 2 of Resolution number 2722, amounts to taking of private personal property for public use or purposes. The extent of the taking or deprivation is not insubstantial. This is not a case of a de minimis temporary limitation or restraint upon the use of private property. The monetary value of the compulsory donation, measured by the advertising rates ordinarily charged by newspaper publishers whether in cities or in non-urban areas, may be very substantial indeed. The taking of private property for public use is, of course, authorized by the Constitution, but not without payment of just compensation, Article 3, Section 9. And apparently the necessity of paying compensation for Kumlek space is precisely what is sought to be avoided by Respondent Commission, whether Section 2 of Resolution number 2772 is read as petitioner PPI reads it, as an assertion of authority to require newspaper publishers to donate free print space for Kumlek purposes, or as an exhortation, or perhaps an appeal, to publishers to donate free print space, as Section 1 of Resolution number 2772A attempts to suggest. The threshold requisites for lawful taking of private property for public use need to be examined here. One is the necessity for the taking, another is the legal authority to effect the taking. The element of necessity for the taking has not been shown by Respondent Kumlek. Similarly, it has not been suggested, let alone demonstrated, that Kumlek has been granted the power of eminent domain either by the Constitution or by the legislative authority. A reasonable relationship between that power and the enforcement and administration of election laws by Kumlek must be shown. It is not casually to be assumed Section 2 does not constitute a valid exercise of the power of eminent domain. Telebap Incorporated vs. Kumlek, 289 SCRA 337. April 21, 1998 Mendoza. In truth, radio and television broadcasting companies, which are given franchises, do not own the airwaves and frequencies through which they transmit broadcast signals and images. They are merely given the temporary privilege of using them. Since a franchise is a mere privilege, the exercise of the privilege may reasonably be burdened with the performance by the grantee of some form of public service. Consequently, a license permits broadcasting, but the licensee has no constitutional right to be the one who holds the license or to monopolize a radio frequency to the exclusion of his fellow citizens. There is nothing in the First Amendment which prevents the government from requiring a licensee to share his frequency with others and to conduct himself as a proxy or fiduciary with obligations to present those views and voices which are representative of his community and which would otherwise, by necessity, be barred from the airwaves. As radio and television broadcast stations do not own the airwaves, no private property is taken by the requirement that they provide airtime to the Kumlek. Meaning of public use. Traditional concept, the number of actual beneficiaries determines public purpose. If the benefits redound in favor of individuals, then the purpose is not public. Concept of vicarious benefit. abandons the traditional concept. The purpose is public as long as the society in general is indirectly benefited, that is, conversion of a slum area into a model housing community. There is a vicarious advantage to the society. Filstream International Incorporated vs. CA, 284 SCRA 716, January 23, 1998. Francisco. The City of Manila, acting through its legislative branch, has the express power to acquire private lands in the city and subdivide these lands into home lots for sale to bona fide tenants or occupants thereof, and to laborers and low-salaried employees of the city. That only a few could actually benefit from the expropriation of the property does not diminish its public character. It is simply not possible to provide all at once land and shelter for all who need them. Through the years, the public use requirement in eminent domain has evolved into a flexible concept, influenced by changing conditions. Public use now includes the broader notion of indirect public benefit or advantage, including in particular, urban land reform and housing. Estate of Ciudad Jimenez vs. Peza, 349 SCRA 240, January 16, 2001, Public use requirement, payment of just compensation. In the exercise of eminent domain, only as much land can be taken as is necessary for the legitimate purpose of the condemnation. The term necessary, in this connection, does not mean absolutely indispensable but requires only a reasonable necessity of the taking for the stated purpose, growth and future needs of the enterprise. The respondent cannot attain a self-sustaining and viable ecozone if inevitable needs and the expansion in the surrounding areas are hampered by the mere refusal of the private landowners to part with their properties. The purpose of creating an ecozone and other facilities is better served if respondent directly owns the areas subject of the expansion program. The legislature may directly determine the necessity for appropriating private property for a particular improvement for public use, and it may select the exact location of the improvement. In such a case, it is well settled that the utility of the proposed improvement, the existence of the public necessity for its construction, the expediency of constructing it, the suitableness of the location selected, are all questions exclusively for the legislature to determine, and the courts have no power to interfere or to substitute their own views for those of the representatives of the people. In the absence of some constitutional or statutory provision to the contrary, the necessity and expediency of exercising the right of eminent domain are questions essentially political and not judicial in their character. The concept of just compensation embraces not only the correct determination of the amount to be paid to the owners of the land, but also the payment of the land within a reasonable time from its taking. Without prompt payment, compensation cannot be considered just inasmuch as the property owner is made to suffer the consequences of being immediately deprived of his land while being made to wait for a decade or more before actually receiving the amount necessary to cope with his loss. 46. Payment of just compensation should follow as a matter of right immediately after the order of expropriation is issued. Any delay in payment must be counted from said order. However, the delay to constitute a violation of due process must be unreasonable and inexcusable. It must be deliberately done by a party in order to defeat the ends of justice. Payment of just compensation. Just compensation is described as a full and fair equivalent of the property taken from the private owner by the expropriator. This is intended to indemnify the owner fully for the loss he has sustained as a result of the expropriation. Just compensation equals actual or basic value of the property, plus consequential damages. Consequential benefits, which should not exceed the consequential damages. The basic or market value of the property is the price that may be agreed upon by parties willing but not compelled to enter into a contract of sale. Acquisition of easement of right-of-way. The exercise of the power of eminent domain does not always result in the taking or appropriation of title to the expropriated property. It may only result in the imposition of a burden upon the owner of the condemned property, without loss or title or possession. In this case, while it is true that the plaintiff is only after a right-of-way easement, it nevertheless perpetually deprives defendants of their proprietary rights as manifested by the imposition by the plaintiff upon the defendants that below said transmission lines, No plant higher than 3 meters is allowed. MPC vs. Gutierrez, 193 SCRA 1. How expropriation may be initiated. 2 stages. An expropriation of land. Republic vs. Salem Investment Corporation, GR number 137569, June 23, 2000. The first is concerned with the determination of the authority of the plaintiff to exercise the power of eminent domain and the propriety of its exercise in the context of the facts involved in the suit. It ends with an order, if not dismissal of the action, of condemnation declaring that the plaintiff has a lawful right to take the property sought to be condemned, for the public use or purpose declared in the complaint, upon the payment of just compensation to be determined as of the date of the filing of the complaint. The second phase of the eminent domain action is concerned with the determination by the court of the just compensation for the property sought to be taken. This is done by the court with the assistance of not more than three commissioners. It is only upon the completion of these 2 stages that expropriation is said to have been completed. Moreover, it is only upon payment of just compensation that title over the property passes to the government. Therefore, until the action for expropriation has been completed and terminated, ownership over the property being expropriated remains with the registered owner. Consequently, the latter can exercise all rights pertaining to an owner, including the right to dispose of his property, subject to the power of the state ultimately to acquire it through expropriation. Is prior unsuccessful negotiation a condition precedent for the exercise of eminent domain? SMI Development Corporation vs. Republic, 323 SCRA 862, January 28, 2000. Current effective law on delegated authority to exercise the power of eminent domain is found in Section 12, Book 3 of the Revised Administrative Code, which provides: Section 12, Power of eminent domain. The President shall determine when it is necessary or advantageous to exercise the power of eminent domain in behalf of the national government, and direct the Solicitor General, whenever he deems the action advisable, to institute expropriation proceedings in the proper court. The foregoing provision does not require prior unsuccessful negotiation as a condition precedent for the exercise of eminent domain. In Iron and Steel Authority vs. Court of Appeals, the President chose to prescribe this condition as an additional requirement instead. In the instant case, however, no such voluntary restriction was imposed. When ownership transferred to expropriator. Republic vs. Salem Investment Corporation, GR number 137569, June 23, 2000. The recognized rule, indeed, is that title to the property expropriated shall pass from the owner to the expropriator only upon full payment of the just compensation. Jurisprudence on this settled principle is consistent both here and in other democratic jurisdictions. When may the expropriator enter the property? Upon a receipt of the landowner of the corresponding payment or, in case of rejection or no response from the landowner, upon the deposit with an accessible bank designated by DAR of the compensation in cash or in land bank bonds. In accordance with this act, the DAR shall take immediate possession of the land, Land Bank vs. CA and DAR vs. CA. When used as implement of police power. Power of eminent domain is utilized as an implement of police power to promote the welfare of the people. It is the Constitution itself which mandated the pursuit of agrarian reform program to address once and for all the plight of the landless and the poor, which for centuries has been the source of discontent and unrest. ASLP vs. Section DAR. Power of taxation. Does the power to tax include the power to destroy? The power to tax includes the power to destroy if it is used as an implement of the police power, regulatory, of the state. However, it does not include the power to destroy if it is used solely for the purpose of raising revenue. Roxas vs. CTA. Notes. If the purpose of taxation is regulatory in character, taxation is used to implement the police power of the state. If the power of taxation is used to destroy things, businesses, or enterprises and the purpose is to raise revenue, the court will come in because there will be violation of the inherent and constitutional limitations and it will be declared invalid. Taxes distinguished from licenses. Aspida Optical Company Incorporated vs. CA, 329 SCRA 314, March 31, 2000, N-Bank Purisima. The scope of police power has been held to be so comprehensive as to encompass almost all matters affecting the health, safety, peace, order, morals, comfort and convenience of the community. Police power is essentially regulatory in nature, and the power to issue licenses or grant business permits, if exercised for a regulatory and not revenue-raising purpose, is within the ambit of this power. The power to grant or issue licenses or business permits must always be exercised in accordance with law, with the utmost observance of the rights of all concerned to due process and equal protection of the law. Distinction must be made between the grant of a license or permit to do business and the issuance of a license to engage in the practice of a particular profession. The first is usually granted by the local authorities and the second is issued by the board or commission tasked to regulate the particular profession. A business permit authorizes the person, natural or otherwise, to engage in business or some form of commercial activity. A professional license, on the other hand, is the grant of authority to a natural person to engage in the practice or exercise of his or her profession. The lifeblood doctrine. Taxes are the lifeblood of the government and their prompt and certain availability are an imperious need. Sir vs. Pineda, 21 SCRA 105. The existence of the government is a necessity. The main source of the government is taxes. These are the lifeblood of the government. The government will not be able to survive and continue to perform its functions without taxes. Sir vs. Alg Incorporated, 158 SCRA 8. Can taxes be subject to offsetting or compensation? Philex Mining Corporation vs. Sir, 294 SCRA 687, August 28, 1998. Romero. Taxes cannot be subject to compensation for the simple reason that the government and the taxpayer are not creditors and debtors of each other. There is a material distinction between a tax and debt. Debts are due to the government in its corporate capacity, while taxes are due to the government in its sovereign capacity. It must be noted that a distinguishing feature of a tax is that it is compulsory rather than a matter of bargain. Hence, a tax does not depend upon the consent of the taxpayer. If any taxpayer can defer the payment of taxes by raising the defense that it still has a pending claim for refund or credit, this would adversely affect the government revenue system. A taxpayer cannot refuse to pay his taxes when they fall due simply because he has a claim against the government or that the collection of a tax is contingent on the result of the lawsuit it filed against the government. Tax exemptions. Section 28(3), Article Vi, 1987 Constitution. Section 28(3), Charitable institutions, churches and parsonages or convents appertinent thereto, mosques, non-profit cemeteries, and all lands, buildings, and improvements, actually, directly, and exclusively used for religious, charitable, or educational purposes shall be exempt from taxation. Section 4(3), Article 14, 1987 Constitution. Section 4(3), all revenues and assets of non-stock, non-profit educational institutions used actually, directly, and exclusively for educational purposes shall be exempt from taxes and duties. Upon the dissolution or cessation of the corporate existence of such institutions, their assets shall be disposed of in the manner provided by law. Proprietary educational institutions, including those cooperatively owned, may likewise be entitled to such exemptions subject to the limitations provided by law, including restrictions on dividends and provisions for reinvestment. Sir vs. CA, 298 SCRA 83, October 14, 1998. Panganiban. Laws allowing tax exemption are construed strictissimi juris. Hence, for the YMCA to be granted the exemption it claims under the above-cited provision, it must prove with substantial evidence that, 1. It falls under the classification non-stock, non-profit educational institution, and, 2. The income it seeks to be exempted from taxation is used actually, directly, and exclusively for educational purposes. However, The court notes that not a scintilla of evidence was submitted by private respondent to prove that it met the said requisites. Who may grant tax exemptions? Chavez v. PCGG, 299 SCRA 744, December 9, 1998. Panganiban. The power to tax and to grant exemptions is vested in the Congress and, to a certain extent, in the local legislative bodies. Section 28(4). Article V of the Constitution, specifically provides, no law granting any tax exemption shall be passed without the concurrence of a majority of all the members of the Congress. The PCGG has absolutely no power to grant tax exemptions, even under the cover of its authority to compromise ill-gotten wealth cases. Tax treaties, international juridical double taxation. Sir vs. S.C. Johnson & Son Incorporated. 309 SCRA 87, June 25, 1999, 3rd Division Gonzaga Reyes. The RPUS tax treaty is just one of a number of bilateral treaties which the Philippines has entered into for the avoidance of double taxation. The purpose of these international agreements is to reconcile the national fiscal legislations of the contracting parties in order to help the taxpayer avoid simultaneous taxation in two different jurisdictions. More precisely, the tax conventions are drafted with a view towards the elimination of international juridical double taxation. International juridical double taxation is defined as the imposition of comparable taxes in two or more states on the same taxpayer in respect of the same subject matter and for identical periods. The apparent rationale for doing away with double taxation is to encourage the free flow of goods and services and the movement of capital, technology and persons between countries, conditions deemed vital in creating robust and dynamic economies. Foreign investments will only thrive in a fairly predictable and reasonable international investment climate, and the protection against double taxation is crucial in creating such a climate. The Bill of Rights. The right to due process. Section 1, Article 3, 1987 Constitution. Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Corona vs. United Harbor Pilots Association of the Phils, 283 SCRA 31, December 12, 1997. Romero. When one speaks of due process of law, however, a distinction must be made between matters of procedure and matters of substance. In essence, procedural due process refers to the method or manner by which the law is enforced, while substantive due process requires that the law itself, not merely the procedures by which the law would be enforced, is fair, reasonable, and just. Secretary of Justice vs. Lanchin, GR number 139465, January 18, 2000, and Bank Puno, dissenting opinion. Proceeding from this premise of relativism of rights, I venture the view that even assuming arguendo respondents' weak claim, still, the degree of denial of private respondents' rights to due process and to information is too slight to warrant the interposition of judicial power. As admitted in the Ponencia itself, an extradition proceeding is sui generis. It is, thus, futile to determine what it is. What is certain is that it is not a criminal proceeding where there is an accused who can claim the entire array of rights guaranteed by the Bill of Rights. Let it be stressed that in an extradition proceeding, there is no accused and the guilt or innocence of the extraditee will not be passed upon by our executive officials nor by the extradition judge. Hence, constitutional rights that are only relevant to determine the guilt or innocence of an accused cannot be invoked by an extraditee. Indeed, an extradition proceeding is summary in nature, which is untrue of criminal proceedings. 18. Even the rules of evidence are different in an extradition proceeding. Admission of evidence is less stringent, again because the guilt of the extraditee is not under litigation. It is not only the quality but even the quantum of evidence an extradition proceeding is different. In a criminal case, an accused can only be convicted by proof beyond reasonable doubt. In an extradition proceeding, an extraditee can be ordered extradited upon showing of the existence of a prima facie case. If more need be said, The nature of an extradition decision is different from a judicial decision whose finality cannot be changed by executive fiat. Secretary of Justice vs. Lanchin, GR number 139465, October 17, 2000, N. Bank Punna. Procedural due process requires a determination of what process is due, when it is due, and the degree of what is due. Stated otherwise, a prior determination should be made as to whether procedural protections are at all due and when they are due, which in turn depends on the extent to which an individual will be condemned to suffer grievous loss. We have explained why an extraditee has no right to notice and hearing during the evaluation stage of the extradition process. As aforesaid, PD number 1069, which implements the RP-US extradition treaty, affords an extraditee sufficient opportunity to meet the evidence against him once the petition is filed in court. The time for the extraditee to know the basis of the request for his extradition is merely moved to the filing in court of the formal petition for extradition. The extraditee's right to know is momentarily withheld during the evaluation stage of the extradition process to accommodate the more compelling interest of the state to prevent escape of potential extraditees, which can be precipitated by premature information of the basis of the request for his extradition. No less compelling at that stage of the extradition proceedings is the need to be more deferential to the judgment of a co-equal branch of the government, the executive, which has been endowed by our Constitution with greater power over matters involving our foreign relations. Needless to state, this balance of interests is not a static but a moving balance which can be adjusted as the extradition process moves from the administrative stage to the judicial stage and to the execution stage, depending on factors that will come into play. In sum, we rule that the temporary hold on private respondent's privilege of notice and hearing is a soft restraint on his right to due process which will not deprive him of fundamental fairness should he decide to resist the request for his extradition to the United States. There is no denial of due process as long as fundamental fairness is assured a party. People v. Della Piedra, 350 SCRA 163, January 24, 2001, 1st Division Capun and void for vagueness doctrine. Due process requires that the terms of a penal statute must be sufficiently explicit to inform those who are subject to it what conduct on their part will render them liable to its penalties. A criminal statute that fails to give a person of ordinary intelligence fair notice that his contemplated conduct is forbidden by the statute, or is so indefinite that it encourages arbitrary and erratic arrests and convictions, is void for vagueness. The constitutional vice in a vague or indefinite statute is the injustice to the accused in placing him on trial for an offense, the nature of which he is given no fair warning. We reiterated these principles in People v. Nazario. As a rule, a statute or act may be said to be vague when it lacks comprehensible standards that men of common intelligence must necessarily guess at its meaning and differ as to its application. It is repugnant to the Constitution in two respects. 1. It violates due process for failure to accord persons, especially the parties targeted by it, fair notice of the conduct to avoid, and, 2. It leaves law enforcers unbridled discretion in carrying out its provisions and become an arbitrary flexing of the government muscle. Lumicht v. Exvia, 282 SCRA 125, November 18, 1997. Romero. The right to counsel, which cannot be waived unless the waiver is in writing and in the presence of counsel, is a right afforded a suspect or an accused during custodial investigation. It is not an absolute right and may, thus, be invoked or rejected in a criminal proceeding and, with more reason, in an administrative inquiry. While investigations conducted by an administrative body may at times be akin to a criminal proceeding, the fact remains that under existing laws, a party in an administrative inquiry may or may not be assisted by counsel, irrespective of the nature of the charges and of the respondent's capacity to represent himself. And no duty rests on such a body to furnish the person being investigated with counsel. The right to counsel is not indispensable to due process unless required by the Constitution or the law. Fabella v. C.A., 282 SCRA 256, November 28, 1998. Panganiban. In administrative proceedings, due process has been recognized to include the following. 1. The right to actual or constructive notice of the institution of proceedings which may affect a respondent's legal rights. 2. A real opportunity to be heard personally or with the assistance of counsel, to present witnesses and evidence in one's favor, and to defend one's rights. 3. A tribunal vested with competent jurisdiction and so constituted as to afford a person charged administratively a reasonable guarantee of honesty as well as impartiality, and 4. A finding by said tribunal which is supported by substantial evidence submitted for consideration during the hearing or contained in the records or made known to the parties affected. Indeed, in any proceeding, the essence of procedural due process is embodied in the basic requirement of notice and a real opportunity to be heard. Central Bank of the Philippines vs. CA, 220 SCRA 536, March 30, 1993, and Bank Belozalo, when prior notice and hearing may be dispensed with. We held that a previous hearing is nowhere required in Section 29, nor does the constitutional requirement of due process demand that the correctness of the Monetary Board's resolution to stop operation and proceed to liquidation of first adjudged before making the resolution effective. One can just imagine the dire consequences of a prior hearing. Bank runs would be the order of the day, resulting in panic and hysteria. In the process, fortunes may be wiped out and disillusionment will run the gamut of the entire banking community. Admittedly, the mere filing of a case for receivership by the central bank can trigger a bank run and drain its assets in days or even hours, leading to insolvency even if the bank be actually solvent. The procedure prescribed in Section 29 is truly designed to protect the interest of all concerned, that is, the depositors, creditors and stockholders, the bank itself, and the general public, and the summary closure pales in comparison to the protection afforded public interest. At any rate, the bank is given full opportunity to prove arbitrariness and bad faith in placing the bank under receivership, in which event, the resolution may properly nullified and the receivership lifted as the trial court may determine. Tan vs. Barrios, Gr. Nos. 85,481-82. October 18, 1990. In the interest of justice and consistency, we hold that Olegor should, in principle, be applied prospectively only to future cases and cases still ongoing or not yet final when that decision was promulgated. Hence, there should be no retroactive nullification of final judgments, whether of conviction or acquittal, rendered by military courts against civilians before the promulgation of the Olegor decision. Such final sentences should not be disturbed by the state. Only in particular cases where the convicted person or the state shows that there was serious denial of the constitutional rights of the accused should the nullity of the sentence be declared and a retrial be ordered based on the violation of the constitutional rights of the accused, and not on the Olegor doctrine. If a retrial is no longer possible, the accused should be released since the judgment against him is null on account of the violation of his constitutional rights and denial of due process. The public respondents gravely abused their discretion and acted without or in excess of their jurisdiction in misconstruing the third paragraph of the dispositive portion of this court's decision in Cruz vs. Enrile as their authority to refile in the civil court the criminal actions against petitioners who had been tried and acquitted by Military Commission No. 1 during the period of martial law. It is an unreasonable application of Cruz vs. Enrile, for the decision therein will be searched in vain for such authority to re-prosecute every civilian who had ever faced a court-martial, much less those who had been acquitted by such bodies more than a decade ago like the petitioners Tan, et al. Herein, the doctrine of operative facts applies to the proceedings against the petitioners and their co-accused before Military Commission No. 1. The principle of absolute invalidity of the jurisdiction of the military courts over civilians should not be allowed to obliterate the operative facts that in the particular case of the petitioners, the proceedings were fair, that there were no serious violations of their constitutional right to due process, and that the jurisdiction of the military commission that heard and decided the charges against them during the period of martial law, had been affirmed by this court, Aquino vs. Military Commission No. 2. 63 SCRA 546, years before the Olegor case arose and came before us. Because of these established operative facts, The refiling of the information against the petitioners would place them in double jeopardy, in hard fact if not in constitutional logic. The Equal Protection Clause. Section 1, Article 3, 1987 Constitution. Section 1. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the laws. Telebap Incorporated vs. Cumlec, 289 SCRA 337, April 21, 1998 Mendoza. There are important differences in the characteristics of the two media which justify their differential treatment for free speech purposes. Because of the physical limitations of the broadcast spectrum, the government must, of necessity, allocate broadcast frequencies to those wishing to use them. There is no similar justification for government allocation and regulation of the print media. From another point of view, the SC has also held that because of the unique and pervasive influence of the broadcast media, necessarily the freedom of television and radio broadcasting is somewhat lesser in scope than the freedom accorded to newspaper and print media. Zhang vs. Quijuming, GR number 128845, June 1, 2000, First Div Kapunan discrimination, particularly in terms of wages, is frowned upon by the Labor Code. Article 135, for example, prohibits and penalizes the payment of lesser compensation to a female employee as against a male employee for work of equal value. Article 248 declares it an unfair labor practice for an employer to discriminate in regards to wages in order to encourage or discourage membership in any labor organization. The foregoing provisions impregnably institutionalize in this jurisdiction the long-honored legal truism of equal pay for equal work. Persons who work with substantially equal qualifications, skill, effort and responsibility, under similar conditions, should be paid similar salaries. This rule applies to the school, International School Incorporated, its international character notwithstanding. People vs. Della Piedra, 350 SCRA 163, January 24, 2001, First Div Kapunan. A statute non-discriminatory on its face may be grossly discriminatory in its operation. Though the law itself be fair on its face and impartial in appearance, yet, if it is applied and administered by public authority with an evil eye and unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances, material to their rights, the denial of equal justice is still within the prohibition of the Constitution. The prosecution of one guilty person while others equally guilty are not prosecuted, however, is not, by itself, a denial of the equal protection of the laws. Where the official action purports to be in conformity to the statutory classification, an erroneous or mistaken performance of the statutory duty, although a violation of the statute, is not without more a denial of the equal protection of the laws. The unlawful administration by officers of a statute fair on its face, resulting in its unequal application to those who are entitled to be treated alike, is not a denial of equal protection unless there is shown to be present in it an element of intentional or purposeful discrimination. This may appear on the face of the action taken with respect to a particular class or person, or it may only be shown by extrinsic evidence showing a discriminatory design over another not to be inferred from the action itself. But a discriminatory purpose is not presumed, there must be a showing of clear and intentional discrimination. People vs. Giles Joes, 324 SCRA 689, February 3, 2000, and Banquiners Santiago. We, therefore, find that election to the position of congressman is not a reasonable classification in criminal law enforcement. The functions and duties of the office are not substantial distinctions which lift him from the class of prisoners interrupted in their freedom and restricted in liberty of movement. Lawful arrest and confinement are germane to the purposes of the law and apply to all those belonging to the same class. The right against unreasonable searches and seizures. Section 2, Article 3, 1987 Constitution. Section 2. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures of whatever nature and for any purpose shall be inviolable, and no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. Section 3, second paragraph, Article 3, 1987 Constitution. Section 3. 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Requisites of valid search warrant and warrant of arrest. Government of the USA v. Perganon, GR number 148571, September 24, 2002, Bank Panganiban Vitug, dissenting opinion. Is prior notice and hearing required before judge issues warrant of arrest and extradition proceeding? 1. On the basis of the extradition law. It is significant to note that Section 6 of PD 1069, our extradition law, uses the word immediate to qualify the arrest of the accused. This qualification would be rendered nugatory by setting for hearing the issuance of the arrest warrant. Hearing entails sending notices to the opposing parties, receiving facts and arguments from them, and giving them time to prepare and present such facts and arguments. Arrest subsequent to a hearing can no longer be considered immediate. The law could not have intended the word as a mere superfluity but, on the whole, as a means of impairing a sense of urgency and swiftness in the determination of whether a warrant of arrest should be issued. By using the phrase "if it appears," the law further conveys that accuracy is not as important as speed at such early stage. The trial court is not expected to make an exhaustive determination to ferret out the true and actual situation, immediately upon the filing of the petition. From the knowledge and the material then available to it, the court is expected merely to get a good first impression, a prima facie finding, sufficient to make a speedy initial determination as regards the arrest and detention of the accused. It is evident that respondent judge could have already gotten an impression from these records adequate for him to make an initial determination of whether the accused was someone who should immediately be arrested in order to best serve the ends of justice. He could have determined whether such facts and circumstances existed as would lead a reasonably discreet and prudent person to believe that the extradition request was prima facie meritorious. In point of fact, he actually concluded from these supporting documents that probable cause did exist. We stress that the prima facie existence of probable cause for hearing the petition and, a priori, for issuing an arrest warrant was already evident from the petition itself and its supporting documents. Hence, after having already determined therefrom that a prima facie finding did exist, respondent judge gravely abused his discretion when he set the matter for hearing upon motion of Jimenez. Moreover, the law specifies that the court sets a hearing upon receipt of the answer or upon failure of the accused to answer after receiving the summons. In connection with the matter of immediate arrest, however, the word hearing is notably absent from the provision. Evidently, had the holding of a hearing at that stage been intended, the law could have easily so provided. It also bears emphasizing at this point that extradition proceedings are summary, see Section 9. PD 1069, in nature. Hence, the silence of the law in the treaty leads to the more reasonable interpretation that there is no intention to punctuate with a hearing every little step in the entire proceedings. Verily, sending to persons sought to be extradited a notice of the request for their arrest and setting it for hearing at some future date would give them ample opportunity to prepare and execute an escape. Neither the treaty nor the law could have intended that consequence, for the very purpose of both would have been defeated by the escape of the accused from the requested state. 2. On the basis of the Constitution. Even Section 2 of Article 3 of our Constitution, which is invoked by Jimenez, does not require a notice or a hearing before the issuance of a warrant of arrest. To determine probable cause for the issuance of arrest warrants, the Constitution itself requires only the examination, under oath or affirmation, of complainants and the witnesses they may produce. There is no requirement to notify and hear the accused before the issuance of warrants of arrest. In Ho v. People, 280 SCRA 365, October 9, 1997, and in all the cases cited therein, never was a judge required to go to the extent of conducting a hearing just for the purpose of personally determining probable cause for the issuance of a warrant of arrest. All we required was that the judge must have sufficient supporting documents upon which to make his independent judgment, or at the very least, upon which to verify the findings of the prosecutor as to the existence of probable cause. In Webb v. De Leon, 247 SCRA 652, 680, Perpuno, J., the court categorically stated that a judge was not supposed to conduct a hearing before issuing a warrant of arrest. At most, in cases of clear insufficiency of evidence on record, judges merely further examine complainants and their witnesses. Ibid, citing Ilato v. Diano. 233 SCRA 192, May 5, 1994. In the present case, validating the act of respondent judge and instituting the practice of hearing the accused and his witnesses at this early stage would be discordant with the rationale for the entire system. If the accused were allowed to be heard and necessarily to present evidence during the prima facie determination for the issuance of a warrant of arrest, what would stop him from presenting his entire plethora of defenses at this stage, if he so desires, in his effort to negate a prima facie finding? Such a procedure could convert the determination of a prima facie case into a full-blown trial of the entire proceedings and possibly make trial of the main case superfluous. This scenario is also anathema to the summary nature of extraditions. That the case under consideration is an extradition and not a criminal action is not sufficient to justify the adoption of a set of procedures more protective of the accused. If a different procedure were called for at all, a more restrictive one, not the opposite, would be justified in view of respondents' demonstrated predisposition to flee. Determination of probable cause is a judicial function. Abdullah v. Skiani, 326 SCRA 1, February 18, 2000, 3rd Division Gonzagares. The determination of probable cause by the prosecutor is for a purpose different from that which is to be made by the judge. Whether there is reasonable ground to believe that the accused is guilty of the offense charged and should be held for trial is what the prosecutor passes upon. The judge, on the other hand, determines whether a warrant of arrest should be issued against the accused, that is, whether there is a necessity for placing him under immediate custody in order not to frustrate the ends of justice. Thus, even if both should base their findings on one and the same proceeding or evidence, there should be no confusion as to their distinct objectives. Second, since their objectives are different, the judge cannot rely solely on the report of the prosecutor in finding probable cause to justify the issuance of a warrant of arrest. Obviously and understandably, the contents of the prosecutor's report will support his own conclusion that there is reason to charge the accused for an offense and hold him for trial. However, the judge must decide independently. Hence, he must have supporting evidence, other than the prosecutor's bare report, upon which to legally sustain his own findings on the existence, or non-existence, of probable cause to issue an arrest order. This responsibility of determining personally and independently the existence or non-existence of probable cause is lodged in him by no less than the most basic law of the land. Parenthetically, the prosecutor could ease the burden of the judge and speed up the litigation process by forwarding to the latter not only the information in his bare resolution finding probable cause, but also so much of the records and the evidence on hand as to enable His Honor to make his personal and separate judicial finding on whether to issue a warrant of arrest. The point is, he cannot rely solely and entirely on the prosecutor's recommendation, as respondent court did in this case. Although the prosecutor enjoys the legal presumption of regularity in the performance of his official duties and functions, which in turn gives his report the presumption of accuracy, the Constitution, we repeat, commands the judge to personally determine probable cause in the issuance of warrants of arrest. This court has consistently held that a judge fails in his bounden duty if he relies merely on the certification or the report of the investigating officer. Particular description of place to be searched or persons or things to be seized. People v. Estrada, 296 SCRA 383 Martinez. The applicant should particularly describe the place to be searched and the person or things to be seized, wherever and whenever it is feasible. In the present case, it must be noted that the application for a search warrant was accompanied by a sketch of the compound at 516 San Jose de Lane Montana Street, Mabolo, Cebu City. The sketch indicated the two-story residential house of private respondent with a large X enclosed in a square. With this sketch as the guide, it could have been very easy to describe the residential house of private respondent with sufficient particularity so as to segregate it from the other buildings or structures inside the same compound. But the search warrant merely indicated the address of the compound, which is 516 San Jose de Lane Montana Street, Mabolo, Cebu City. This description of the place to be searched is too general and does not pinpoint the specific house of private respondent. Thus, the inadequacy of the description of the residence of private respondent sought to be searched has characterized the questioned search warrant as a general warrant, which is violative of the constitutional requirement. People v. C.A., 291 SCRA 400, June 26, 1998 Narvasa. It is neither fair nor licit to allow police officers to search a place different from that stated in the warrant on the claim that the place actually searched, although not that specified in the warrant, is exactly what they had in view when they applied for the warrant and had demarcated in their supporting evidence. What is material in determining the validity of a search is the place stated in the warrant itself, not what applicants had in their thoughts, or had represented in the proofs they submitted to the court issuing the warrant. Instances of valid warrantless searches. 1. Search incidental to a lawful arrest. 2. Consented search. 3. Stop and frisk. 4. Plain view. 5. Search on a moving vehicle. 6. Customs search. 7. Checkpoints. Search incidental to a lawful arrest. People v. Cuijo-San, 308 SCRA 432, June 17, 1999, and Bank Davide. While a contemporaneous search of a person arrested may be effected to discover dangerous weapons or proofs or implements used in the commission of the crime, and which search may extend to the area within his immediate control where he might gain possession of a weapon or evidence he can destroy, a valid arrest must precede the search. The process cannot be reversed. In a search incidental to a lawful arrest, as the precedent arrest determines the validity of the incidental search, the legality of the arrest is questioned in a large majority of these cases. For example, whether an arrest was merely used as a pretext for conducting a search. In this instance, the law requires that there be first a lawful arrest before a search can be made. The process cannot be reversed. Consented search. People v. Layla Johnson, GR number 138881, December 18, 2000, 2nd Division Mendoza. Persons may lose the protection of the search and seizure clause by exposure of their persons or property to the public in a manner reflecting a lack of subjective expectation of privacy, which expectation society is prepared to recognize as reasonable. Such recognition is implicit in airport security procedures. With increased concern over airplane hijacking and terrorism has come increased security at the nation's airports. Passengers attempting to board an aircraft routinely pass through metal detectors, their carry-on baggage as well as checked luggage are routinely subjected to X-ray scans. Should these procedures suggest the presence of suspicious objects, physical searches are conducted to determine what the objects are. There is little question that such searches are reasonable, given their minimal intrusiveness, the gravity of the safety interests involved, and the reduced privacy expectations associated with airline travel. Indeed, travelers are often notified through airport public address systems, signs, and notices in their airline tickets that they are subject to search and, if any prohibited materials or substances are found, such would be subject to seizure. These announcements place passengers on notice that ordinary constitutional protections against warrantless searches and seizures do not apply to routine airport procedures. Her subsequent arrest, although likewise without warrant, was justified since it was effected upon the discovery and recovery of shabu in her person in flagrante delicto. Plain view search. People v. Storia, 301 SCRA 668, January 22, 1999, and Bank Puno. The law enforcement officer must lawfully make an initial intrusion or properly be in a position from which he can particularly view the area. In the course of such lawful intrusion, he came inadvertently across a piece of evidence incriminating the accused. The object must be open to eye and hand and its discovery inadvertent. It is clear that an object is in plain view if the object itself is plainly exposed to sight. The difficulty arises when the object is inside a closed container. Where the object seized was inside a closed package, the object itself is not in plain view and therefore cannot be seized without a warrant. However, if the package proclaims its contents, whether by its distinctive configuration, its transparency, or if its contents are obvious to an observer, then the contents are in plain view and may be seized. People vs. A. Valdez, GR number 129296, September 25, 2000, and Bank Quijamin. For the doctrine to apply, the following elements must be present. A prior valid intrusion based on the valid warrantless arrest in which the police are legally present in the pursuit of their official duties. B. The evidence was inadvertently discovered by the police who have the right to be where they are, and C. The evidence must be immediately apparent, and D. Plain view justified mere seizure of evidence without further search. Stop and frisk search. Manililai vs. CA, 280 SCRA 400, October 9, 1997. Panganiban. In the landmark case of Terry vs. Ohio, a stop and frisk was defined as the vernacular designation of the right of a police officer to stop a citizen on the street, interrogate him, and pat him for weapons, where a police officer observes an unusual conduct which leads him reasonably to conclude in light of his experience that criminal activity may be afoot and that the persons with whom he is dealing may be armed and presently dangerous, where in the course of investigating this behavior he identified himself as a policeman and make reasonable inquiries, and where nothing in the initial stages of the encounter serves to dispel his reasonable fear for his own or others' safety, he is entitled for the protection of himself or others in the area to conduct a carefully limited search of the outer clothing of such persons in an attempt to discover weapons which might be used to assault him. Malakot vs. CA, 283 SCRA 159, December 12, 1997. Davide. Other notable points of Terry are that while probable cause is not required to conduct a stop and frisk, it nevertheless holds that mere suspicion or a hunch will not validate a stop and frisk. A genuine reason must exist, in light of the police officer's experience and surrounding conditions, to warrant the belief that the person detained has weapons concealed about him. Finally, a stop and frisk serves a twofold interest: 1. The general interest of effective crime prevention and detection, which underlies the recognition that a police officer may, under appropriate circumstances and in an appropriate manner, approach a person for purposes of investigating possible criminal behavior even without probable cause, and, 2, the more pressing interest of safety and self-preservation which permit the police officer to take steps to assure himself that the person with whom he deals is not armed with a deadly weapon that could unexpectedly and fatally be used against the police officer. Searches at checkpoints. People vs. Usanna, 323 SCRA 754, January 28, 2000, 1st Division Davide. This court has ruled that not all checkpoints are illegal. Those which are warranted by the exigencies of public order and are conducted in a way least intrusive to motorists are allowed. For, admittedly, routine checkpoints do intrude, to a certain extent, on motorists' right to free passage without interruption, but it cannot be denied that, as a rule, it involves only a brief detention of travelers during which the vehicle's occupants are required to answer a brief question or two. For as long as the vehicle is neither searched nor its occupants subjected to a body search, and the inspection of the vehicle is limited to a visual search, said routine checks cannot be regarded as violative of an individual's right against unreasonable search. In fact, these routine checks, when conducted in a fixed area, are even less intrusive. Instances of valid warrantless arrests. Section 5, Rule 113, Rules of Court. A. when the person to be arrested has committed, is actually committing, or is attempting to commit an offense in his presence. In flagrante delicto. b. When an offense had just been committed and there is probable cause to believe, based on his personal knowledge or of other circumstances, that the person to be arrested committed the offense. Hot pursuit. c. When the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. Escapee. In flagrante delicto arrest. People v. Molina, 352 SCRA 174, February 19, 2001, and Banquiners Santiago. Clearly, to constitute a valid in flagrante delicto arrest, two requisites must concur. 1. The person to be arrested must execute an overt act indicating that he has just committed, is actually committing, or is attempting to commit a crime, and, 2. Such overt act is done in the presence or within the view of the arresting officer. Arrest in hot pursuit. When an offense had just been committed and there is probable cause to believe, based on his personal knowledge or of other circumstances, that the person to be arrested committed the offense. Under this paragraph, two stringent requirements must be complied with, namely, 1. An offense had just been committed, and 2. There is probable cause, based on his personal knowledge of the person making the arrest or of other circumstances, that the person to be arrested committed the offense. Nakura, Outline Reviewer in Political Law. Can the place to be searched, as set out in the warrant, be amplified or modified by the officer's own personal knowledge of the premises, or the evidence they adduce in support of their application for the warrant? Held, such a change is prescribed by the Constitution, which requires inter alia the search warrant to particularly describe the place to be searched as well as the persons or things to be seized. It would concede to police officers the power of choosing the place to be searched, even if it not be that delineated in the warrant. It would open wide the door to abuse of the search process, and grant to officers executing a search warrant that discretion which the Constitution has precisely removed from them. The particularization of the description of the place to be searched may properly be done only by the judge, and only in the warrant itself. It cannot be left to the discretion of the police officers conducting the search. It is neither fair nor licit to allow police officers to search a place different from that stated in the warrant on the claim that the place actually searched, although not that specified in the warrant, is exactly what they had in view when they applied for the warrant and had demarcated in their supporting evidence. What is material in determining the validity of a search is the place stated in the warrant itself, not what applicants had in their thoughts, or had represented in the proofs they submitted to the court issuing the warrant. People v. Court of Appeals, 291 SCRA 400, June 26, 1998. Narvasa. The right to privacy of communications and correspondence. Section 3, Article 3, 1987 Constitution. Section 3. 1. The privacy of communication and correspondence shall be inviolable except upon lawful order of the court, or when public safety or order requires otherwise as prescribed by law. 2. Any evidence obtained in violation of this or the preceding section shall be inadmissible for any purpose in any proceeding. Zulueta v. C.A., 253 SCRA 699. The right may be invoked against the wife who went to the clinic of her husband and there took documents consisting of private communications between her husband and paramour. RA No. 4200. Republic Act No. 4200. An act to prohibit and penalize wiretapping and other related violations of the privacy of communication, and for other purposes. Section 1. It shall be unlawful for any person, not being authorized by all the parties to any private communication or spoken word, to tap any wire or cable, or by using any other device or arrangement, to secretly overhear, intercept, or record such communication or spoken word by using a device commonly known as a dictaphone or dictograph or detectaphone or walkie-talkie or tape recorder, or however otherwise described. It shall also be unlawful for any person, be he a participant or not in the act or acts penalized in the next preceding sentence, to knowingly possess any tape record, wire record, disc record, or any other such record, or copies thereof, of any communication or spoken word secured either before or after the effective date of this act in the manner prohibited by this law, or to replay the same for any other person or persons, or to communicate the contents thereof, either verbally or in writing, or to furnish transcriptions thereof, whether complete or partial, to any other person, provided that the use of such record or any copies thereof as evidence in any civil, criminal investigation or trial of offenses mentioned in Section 3 hereof, shall not be covered by this prohibition. Section 2. Any person who willfully or knowingly does or who shall aid, permit, or cause to be done any of the acts declared to be unlawful in the preceding section or who violates the provisions of the following section or of any order issued thereunder, or aids, permits, or causes such violation shall, upon conviction thereof, be punished by imprisonment for not less than 6 months or more than 6 years and with the accessory penalty of perpetual absolute disqualification from public office if the offender be a public official at the time of the commission of the offense, and, if the offender is an alien he shall be subject to deportation proceedings. Section 3. Nothing contained in this act, however, shall render it unlawful or punishable for any peace officer, who is authorized by a written order of the court, to execute any of the acts declared to be unlawful in the 2 preceding sections in cases involving the crimes of treason, espionage, provoking war and disloyalty in case of war, piracy, mutiny in the high seas, rebellion, conspiracy and proposal to commit rebellion, inciting to rebellion, sedition, conspiracy to commit sedition, inciting to sedition, kidnapping as defined by the Revised Penal Code, and violations of Commonwealth Act No. 616, punishing espionage and other offenses against national security, provided that such written order shall only be issued or granted upon written application and the examination under oath or affirmation of the applicant and the witnesses he may produce and a showing, 1. That there are reasonable grounds to believe that any of the crimes enumerated herein above has been committed or is being committed or is about to be committed, provided, however, that in cases involving the offenses of rebellion, conspiracy and proposal to commit rebellion, inciting to rebellion, sedition, conspiracy to commit sedition, and inciting to sedition, such authority shall be granted only upon prior proof that a rebellion or acts of sedition, as the case may be, have actually been or are being committed. 2. That there are reasonable grounds to believe that evidence will be obtained essential to the conviction of any person for, or to the solution of, or to the prevention of, any such crimes, and, 3. That there are no other means readily available for obtaining such evidence. The order granted or issued shall specify, 1. The identity of the person or persons whose communications, conversations, discussions, or spoken words are to be overheard, intercepted, or recorded and, in the case of telegraphic or telephonic communications, the telegraph line or the telephone number involved and its location. 2. The identity of the peace officer authorized to overhear, intercept, or record the communications, conversations, discussions, or spoken words. 3. The offense or offenses committed or sought to be prevented, and, 4. The period of the authorization. The authorization shall be effective for the period specified in the order which shall not exceed 60 days from the date of issuance of the order, unless extended or renewed by the court upon being satisfied that such extension or renewal is in the public interest. All recordings made under court authorization shall, within 48 hours after the expiration of the period fixed in the order, be deposited with the court in a sealed envelope or sealed package, and shall be accompanied by an affidavit of the peace officer granted such authority stating the number of recordings made, the dates and times covered by each recording, the number of tapes, discs, or records included in the deposit, and certifying that no duplicates or copies of the whole or any part thereof have been made, or if made, that all such duplicates or copies are included in the envelope or package deposited with the court. The envelope or package so deposited shall not be opened, or the recordings replayed, or used in evidence, or their contents revealed, except upon order of the court, which shall not be granted except upon motion, with due notice and opportunity to be heard to the person or persons whose conversation or communications have been recorded. The court referred to in this section shall be understood to mean the court of first instance within whose territorial jurisdiction the acts for which authority is applied for are to be executed. Section 4. Any communication or spoken word, or the existence, contents, substance, purport, effect, or meaning of the same or any part thereof, or any information therein contained obtained or secured by any person in violation of the preceding sections of this act shall not be admissible in evidence in any judicial, quasi-judicial, legislative or administrative hearing or investigation. Section 5. All laws inconsistent with the provisions of this act are hereby repealed or accordingly amended. Section 6. This act shall take effect upon its approval. Salcedo Ortiz vs. C.A., 235 SCRA 111, August 4, 1994 Padilla. Absent a clear showing that both parties to the telephone conversations allow the recording of the same, the inadmissibility of the subject tapes is mandatory under Republic Act No. 4200. Navarro vs. C.A., GR No. 121087. August 26, 1999. Indeed, Jalbeween's testimony is confirmed by the voice recording he had made. It may be asked whether the tape is admissible in view of RA No. 4200, which prohibits wiretapping. The answer is in the affirmative. Thus, the law prohibits the overhearing, intercepting, or recording of private communications. Since the exchange between Petitioner Navarro and Lingan was not private, its tape recording is not prohibited. The right to privacy. Is there a constitutional right to privacy? Opel vs. Torres, GR No. 127685, July 23, 1998. The essence of privacy is the right to be let alone. The SC clarified that the right of privacy is recognized and enshrined in several provisions of our Constitution. It is expressly recognized in Section 3(1) of the Bill of Rights. Other facets of the right to privacy are protected in various provisions of the Bill of Rights, that is, Section 1, 2, 6, 8, and 17. Marquez vs. Desierto, GR No. 135882, June 27, 2001, and Bank Pardo. Section 2 of the Law on Secrecy of Bank Deposits, as amended, declares bank deposits to be absolutely confidential except 1. In an examination made in the course of a special or general examination of a bank that is specifically authorized by the Monetary Board after being satisfied that there is reasonable ground to believe that a bank fraud or serious irregularity has been or is being committed and that it is necessary to look into the deposit to establish such fraud or irregularity. 2. In an examination made by an independent auditor hired by the bank to conduct its regular audit provided that the examination is for audit purposes only and the results thereof shall be for the exclusive use of the bank. 3. Upon written permission of the depositor. 4. In cases of impeachment. 5. Upon order of a competent court in cases of bribery or dereliction of duty of public officials, or 6. In cases where the money deposited or invested is the subject matter of the litigation. Zones of privacy are recognized and protected in our laws. The Civil Code provides that every person shall respect the dignity, personality, privacy and peace of mind of his neighbors and other persons and punishes as actionable towards several acts for meddling and prying into the privacy of another. It also holds public officer or employee or any private individual liable for damages for any violation of the rights and liberties of another person, and recognizes the privacy of letters and other private communications. The revised Penal Code makes a crime of the violation of secrets by an officer, revelation of trade and industrial secrets, and trespass to dwelling. Invasion of privacy is an offense in special laws like the Anti-Wiretapping Law, the Secrecy of Bank Deposits Act, and the Intellectual Property Code. Freedom of Expression. Section 4, Article 3, 1987 Constitution. Section 4. No law shall be passed abridging the freedom of speech, of expression, or of the press, or the right of the people peaceably to assemble and petition the government for redress of grievances. ABS-CBN Broadcasting Corporation vs. Cumlec, G.R. number 133486, January 28, 2000, and Bank Pangandi ban. The absolute ban imposed by the Cumlec cannot, therefore, be justified. It does not leave open any alternative channel of communication to gather the type of information obtained through exit polling. On the other hand, there are other valid and reasonable ways and means to achieve the Cumlec end of avoiding or minimizing disorder and confusion that may be brought about by exit surveys. It is concluded that the interest of the state in reducing disruption is outweighed by the drastic abridgment of the constitutionally guaranteed rights of the media and the electorate. Quite the contrary, instead of disrupting elections, exit polls, properly conducted and publicized, can be vital tools for the holding of honest, orderly, peaceful and credible elections, and for the elimination of election fixing, fraud and other electoral ills. Content-based and content-neutral restrictions on free speech. Osmein vs. Cumlec, 288 SCRA 447, March 31, 1998 Mendoza. Content-based restrictions are imposed because of the content of the speech and are, therefore, subject to the clear and present danger test. For example, a rule such as that involved in Sanidad vs. Cumlec, 181 SCRA 529 1990, prohibiting columnists, commentators, and announcers from campaigning either for or against an issue in a plebiscite must have compelling reason to support it, or it will not pass muster under strict scrutiny. These restrictions are censorial and therefore they bear a heavy presumption of constitutional invalidity. In addition, they will be tested for possible overbreadth and vagueness. Content-neutral restrictions, on the other hand, like Section 11B of RA number 6646, which prohibits the sale or donation of print space and airtime to political candidates during the campaign period, are not concerned with the content of the speech. These regulations need only a substantial governmental interest to support them. A deferential standard of review will suffice to test their validity. The clear and present danger rule is inappropriate as a test for determining the constitutional validity of laws, like Section 11B of RA number 6646, which are not concerned with the content of political ads but only with their incidents. To apply the clear and present danger test to such regulatory measures would be like using a sledgehammer to drive a nail when a regular hammer is all that is needed. SWS Incorporated vs. Cumlec, GR number 147571, May 5, 2001, and Bank Mendoza. Section 5.4 of RA number 9006 constitutes an unconstitutional abridgment of freedom of speech, expression, and the press. To be sure, Section 5.4 lays a prior restraint on freedom of speech, expression, and the press by prohibiting the publication of election survey results affecting candidates within the prescribed periods of 15 days immediately preceding a national election and 7 days before a local election. Because of the preferred status of the constitutional rights of speech, expression, and the press, such a measure is vitiated by a weighty presumption of invalidity. A Bryan test should then be employed to determine the constitutional validity of Section 5.4, United States vs. O'Brien. A government regulation is sufficiently justified. 1. If it is within the constitutional power of the government. 2. If it furthers an important or substantial governmental interest. 3. If the governmental interest is unrelated to the suppression of free expression, and 4. If the incidental restriction on alleged First Amendment freedoms, of speech, expression and press, is no greater than is essential to the furtherance of that interest. Under this test, even if a law furthers an important or substantial governmental interest, it should be invalidated if such governmental interest is not unrelated to the suppression of free expression. Moreover, even if the purpose is unrelated to the suppression of free speech, the law should nevertheless be invalidated if the restriction on freedom of expression is greater than is necessary to achieve the governmental purpose in question. Live media coverage of court proceedings. Supreme Court and Bank Resolution Re, live TV and radio coverage of the hearing of President Corazon C. Aquino's libel case, dated October 22, 1991. The propriety of granting or denying permission to the media to broadcast, record, or photograph court proceedings involves weighing the constitutional guarantees of freedom of the press, the right of the public to information and the right to public trial, on the one hand, and on the other hand, the due process rights of the defendant and the inherent and constitutional power of the courts to control their proceedings in order to permit the fair and impartial administration of justice. Considering the prejudice it poses to the defendant's right to due process as well as to the fair and orderly administration of justice, and considering further that the freedom of the press and the right of the people to information may be served and satisfied by less distracting, degrading and prejudicial means, live radio and television coverage of court proceedings shall not be allowed. Video footages of court hearings for news purposes shall be restricted and limited to shots of the courtroom, the judicial officers, the parties and their counsel taken prior to the commencement of official proceedings. No video shots or photographs shall be permitted during the trial proper. Request radio-TV coverage of the trial in the Sandiganbayan of the plunder cases against former President Joseph E. Estrada, AM number 01403 SC, June 29, 2001, and Bank Vitug. The propriety of granting or denying the instant petition involved the weighing out of the constitutional guarantees of freedom of the press and the right to public information, on the one hand, and the fundamental rights of the accused, on the other hand, along with the constitutional power of a court to control its proceedings and ensuring a fair and impartial trial. An accused has a right to a public trial, but it is a right that belongs to him, more than anyone else, where his life or liberty can be held critically in balance. A public trial aims to ensure that he is fairly dealt with and would not be unjustly condemned and that his rights are not compromised in secret conclaves of long ago. A public trial is not synonymous with publicized trial, it only implies that the court doors must be open to those who wish to come, sit in the available seats, conduct themselves with decorum and observe the trial process. The doctrine of fair comment. Borgel v. C.A., 301 SCRA 1, January 14, 1999, 2nd Division Bellozello. Fair commentaries on matters of public interest are privileged and constitute a valid defense in an action for libel or slander. The doctrine of fair comment means that while in general every discreditable imputation publicly made is deemed false, because every man is presumed innocent until his guilt is judicially proved, and every false imputation is deemed malicious, nevertheless, when the discreditable imputation is directed against a public person in his public capacity, it is not necessarily actionable. In order that such discreditable imputation to a public official may be actionable, it must either be a false allegation of fact or a comment based on a false supposition. If the comment is an expression of opinion, based on established facts, then it is immaterial that the opinion happens to be mistaken, as long as it might reasonably be inferred from the facts. Vasquez v. C.A., 314 SCRA 460, September 15, 1999, and Bank Mendoza. Even if the defamatory statement is false, no liability can attach if it relates to official conduct, unless the public official concerned proves that the statement was made with actual malice, that is, with knowledge that it was false or with reckless disregard of whether it was false or not. This is the gist of the ruling in the landmark case of New York Times v. Sullivan, which this court has cited with approval in several of its own decisions. 26. This is the rule of actual malice. In this case, the prosecution failed to prove not only that the charges made by petitioner were false but also that petitioner made them with knowledge of their falsity or with reckless disregard of whether they were false or not. A rule placing on the accused the burden of showing the truth of allegations of official misconduct and/or good motives and justifiable ends for making such allegations would not only be contrary to Article 361 of the Revised Penal Code. It would, above all, infringe on the constitutionally guaranteed freedom of expression. Such a rule would deter citizens from performing their duties as members of a self-governing community. Without free speech and assembly, discussions of our most abiding concerns as a nation would be stifled. As Justice Brandeis has said, public discussion is a political duty and the greatest menace to freedom is an inert people. Right to peaceably assemble. Jacinto vs. CA, 281 SCRA 657, November 14, 1997, and Bank Panganiban. The exercise of the rights of free speech and of peaceful assembly to petition the government for redress of grievances is not absolute, for it may be so regulated that it shall not be injurious to the equal enjoyment of others having equal rights, nor injurious to the rights of the community or society. Regulation was limited to the mayor's reasonable discretion in issuing a permit to determine or specify only the streets or public places to be used for the purpose and to provide adequate and proper policing to minimize the risk of disorder. In re. Petition to annul N-Bank Resolution AM 98702 SC, Ricardo C. Valmonte and Union of Lawyers and Advocates for Transparency in Government ULT, GR number 134621. September 29, 1998. But as Pambansabalang 880 did not establish streets and sidewalks, among other places, as public fora. A close look at the law will reveal that it in fact prescribes reasonable time, place, and manner regulations. Thus, it requires a written permit for the holding of public assemblies in public places subject, even, to the right of the mayor to modify the place and time of the public assembly, to impose a rerouting of the parade or street march, to limit the volume of loudspeakers or sound system and to prescribe other appropriate restrictions on the conduct of the public assembly. To insulate the judiciary from mob pressure, friendly or otherwise, and isolate it from public hysteria, this court merely moved away the seizures of mass actions within a 200-meter radius from every courthouse. In fine, but as Pambansabalang 880 imposes general restrictions to the time, place and manner of conducting concerted actions. On the other hand, the resolution of this court regulating demonstrations adds specific restrictions as they involve judicial independence and the orderly administration of justice. There is thus no discrepancy between the two sets of regulatory measures. Simply put, but as Pambansabalang 880 and the assailed resolution complement each other. Freedom of Association. Section 8, Article 3, 1987 Constitution. Section 8. The right of the people, including those employed in the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. Jacinto vs. CA, 281 SCRA 657, November 14, 1997, and Bank Panganiban. Does the right of civil servants to organize include their right to strike? Clarify. Held, specifically, the right of civil servants to organize themselves was positively recognized in Association of Court of Appeals Employees, ACAE, versus Farrakhalaya, 203 SCRA 596, November 15, 1991. But, as in the exercise of the rights of free expression and of assembly, there are standards for allowable limitations such as the legitimacy of the purposes of the association, the overriding considerations of national security and the preservation of democratic institutions. People vs. Farrer, 48 SCRA 382, December 27, 1972, per Castro, J., where the court, while upholding the validity of the Anti-Subversion Act which outlawed the Communist Party of the Philippines and other subversive organizations, clarified, whatever interest in freedom of speech and freedom of association is infringed by the prohibition against knowing membership in the Communist Party of the Philippines, is so indirect and so insubstantial as to be clearly and heavily outweighed by the overriding considerations of national security and the preservation of democratic institutions in this country. It cautioned, though, that the need for prudence and circumspection cannot be overemphasized in the law's enforcement, operating as it does in the sensitive area of freedom of expression and belief. As regards the right to strike, the Constitution itself qualifies its exercise with the proviso, in accordance with law. This is a clear manifestation that the state may, by law, regulate the use of this right, or even deny certain sectors such right. Executive Order No. 180, issued by former President Corazon C. Aquino on June 1, 1987, which provides guidelines for the exercise of the right of government workers to organize, for instance, implicitly endorsed an earlier CSC circular which enjoins under pain of administrative sanctions, all government officers and employees from staging strikes, demonstrations, mass leaves, walkouts and other forms of mass action which will result in temporary stoppage or disruption of public service. CSC Memorandum Circular No. 6, S. 1987, dated April 21, 1987, by stating that the civil service law and rules governing concerted activities and strikes in the government service shall be observed. It is also settled in jurisprudence that, in general, workers in the public sector do not enjoy the right to strike. Alliance of Concerned Government Workers vs. Minister of Labor and Employment, 124 SCRA 1, August 3, 1983, also per Gutierrez Jr., J., rationalized the prescription thus. The general rule in the past and up to the present is that the terms and conditions of employment in the government, including any political subdivision or instrumentality thereof, are governed by law. Since the terms and conditions of government employment are fixed by law, government workers cannot use the same weapons employed by the workers in the private sector to secure concessions from their employers. The principle behind labor unionism in private industry is that industrial peace cannot be secured through compulsion by law. Relations between private employers and their employees rest on an essentially voluntary basis. Subject to the minimum requirements of wage laws and other labor and welfare legislation, the terms and conditions of employment in the unionized private sector are settled through the process of collective bargaining. In government employment, however, it is the legislature and, where properly given delegated power, the administrative heads of government which fix the terms and conditions of employment. And this is effected through statutes or administrative circulars, rules, and regulations, not through collective bargaining agreements. Ibid, page 13. After delving into the intent of the framers of the Constitution, the court affirmed the above rule in Social Security System Employees Association, C. versus Court of Appeals, 175 SCRA 686, July 28, 1989, and explained. Government employees may, therefore, through their unions or associations, either petition the Congress for the betterment of the terms and conditions of employment which are within the ambit of legislation or negotiate with the appropriate government agencies for the improvement of those which are not fixed by law. If there be any unresolved grievances, the dispute may be referred to the Public Sector Labor Management Council for appropriate action. But employees in the civil service may not resort to strikes, walkouts and other temporary work stoppages, like workers in the private sector, to pressure the government to accede to their demands. As now provided under Section 4, Rule 3 of the Rules and Regulations to govern the exercise of the right of government employees to self-organization, which took effect after the instant dispute arose, the terms and conditions of employment in the government, including any political subdivision or instrumentality thereof in government-owned and controlled corporations with original charters, are governed by law, and employees therein shall not strike for the purpose of securing changes thereto. Ibid, p. 698. Petitioners' public school teachers walked out of their classes and engaged in mass actions during certain dates in September 1990 protesting the alleged unlawful withholding of their salaries and other economic benefits. They also raised national issues, such as the removal of U.S. bases and the repudiation of foreign debts, in their mass actions. They refused to return to work despite orders to do so and subsequently were found guilty of conduct prejudicial to the best interests of the service for having absented themselves without proper authority from their schools during regular school days, and penalized. They denied that they engaged in strike but claimed that they merely exercised a constitutionally guaranteed right, the right to peaceably assemble and petition the government for redress of grievances, and, therefore, should not have been penalized. Should their contention be upheld? Petitioners, who are public school teachers and thus government employees, do not seek to establish that they have a right to strike. Rather, They tenaciously insist that their absences during certain dates in September 1990 were a valid exercise of their constitutional right to engage in peaceful assembly to petition the government for a redress of grievances. They claim that their gathering was not a strike, therefore, their participation therein did not constitute any offense. Msta vs. Slagio, Supra, Pranarvasa, J., now CJ, and Act vs. Carino, Ibid, in which this court declared that these mass actions were to all intents and purposes a strike. They constituted a concerted and unauthorized stoppage of, or absence from, work which it was the teacher's duty to perform, undertaken for essentially economic reasons, should not principally resolve the present case, as the underlying facts are allegedly not identical. Strike, as defined by law, means any temporary stoppage of work done by the concerted action of employees as a result of an industrial or labor dispute. A labor dispute includes any controversy or matter concerning terms and conditions of employment, or the association or representation of persons in negotiating, fixing, maintaining, changing or arranging the terms and conditions of employment, regardless of whether the disputants stand in the proximate relation of employers and employees. With these premises, we now evaluate the circumstances of the instant petition. It cannot be denied that the mass action or assembly staged by the petitioners resulted in the non-holding of classes in several public schools during the corresponding period. Petitioners do not dispute that the grievances for which they sought redress concerned the alleged failure of public authorities, essentially, their employers, to fully and justly implement certain laws and measures intended to benefit them materially, and probably to clothe their action with permissible character. In justifying their mass actions, petitioners liken their activity to the pro-bases rally led by former President Corazon C. Aquino on September 10, 1991, participated in, as well, by public school teachers who consequently absented themselves from their classes. No administrative charges were allegedly instituted against any of the participants. They also raised national issues such as the removal of the U.S. bases and the repudiation of foreign debt. In Bollinguson v. Court of Appeals, GR number 124678, July 31, 1997, per Regalado, J., however, this court said that the fact that the conventional term strike was not used by the participants to describe their common course of action was insignificant, since the substance of the situation, and not its appearance, was deemed controlling. Moreover, the petitioners here were not penalized for the exercise of their right to assemble peacefully and to petition the government for a redress of grievances. Rather, the Civil Service Commission found them guilty of conduct prejudicial to the best interest of the service for having absented themselves without proper authority, from their schools during regular school days, in order to participate in the mass protest, their absence ineluctably resulting in the non-holding of classes and in the deprivation of students of education, for which they were responsible. Had petitioners availed themselves of their free time, recess, after classes, weekends or holidays, to dramatize their grievances and to dialogue with the proper authorities within the bounds of law, no one, not the DEECs, the CSC or even this court, could have held them liable for the valid exercise of their constitutionally guaranteed rights. As it was, the temporary stoppage of classes resulting from their activity necessarily disrupted public services, the very evil sought to be forestalled by the prohibition against strikes by government workers. Their act by their nature was enjoined by the civil service law, rules and regulations, for which they must, therefore, be made answerable. Freedom of religion. Section V, Article 3, 1987 Constitution. Section 5. No law shall be made respecting an establishment of religion, or prohibiting the free exercise thereof. The free exercise and enjoyment of religious profession and worship, without discrimination or preference, shall forever be allowed. No religious test shall be required for the exercise of civil or political rights. Section 6, Article 2, 1987 Constitution. Section 6. The separation of church and state shall be inviolable. Section 29-2, Article Vi, 1987 Constitution. Section 29. 2. No public money or property shall be appropriated, applied, paid, or employed, directly or indirectly, for the use, benefit, or support of any sect, church, denomination, sectarian institution, or system of religion, or of any priest, preacher, minister, or other religious teacher, or dignitary as such, except when such priest, preacher, minister, or dignitary is assigned to the armed forces, or to any penal institution, or government orphanage or leprosarium. Section 3.3, Article 14, 1987 Constitution. Section 3. At the option expressed in writing by the parents or guardians, religion shall be allowed to be taught to their children or wards in public elementary and high schools within the regular class hours by instructors designated or approved by the religious authorities of the religion to which the children or wards belong, without additional cost to the government. The two aspects of freedom of religion. The right to religious profession and worship has a twofold aspect, viz., freedom to believe and freedom to act on one's belief. The first is absolute as long as the belief is confined within the realm of thought. The second is subject to regulation where the belief is translated into external acts that affect the public welfare. J. Cruz, Constitutional Law, 1991 ed., pages 176 to 177. Ebrelonag v. Division Superintendent of Schools of Cebu, 219 SCRA 256, March 1, 1993, and Bank Grano Aquino. While the highest regard must be afforded their right to the free exercise of their religion, this should not be taken to mean that school authorities are powerless to discipline them if they should commit breaches of the peace by actions that offend the sensibilities, both religious and patriotic, of other persons. If they quietly stand at attention during the flag ceremony while their classmates and teachers salute the flag, sing the national anthem and recite the patriotic pledge, we do not see how such conduct may possibly disturb the peace, or pose a grave and present danger of a serious evil to public safety, public morals, public health or any other legitimate public interest that the state has a right, and duty, to prevent. Incorporated vs. C.A., 259 SCRA 529, July 26, 1996 Puno. The right to religious profession and worship has a twofold aspect, viz., freedom to believe and freedom to act on one's belief. The first is absolute as long as the belief is confined within the realm of thought. The second is subject to regulation where the belief is translated into external acts that affect the public welfare. The Iglesia Ni Cristo's postulate that its religious freedom is per se beyond review by the MTRCB should be rejected. Its public broadcast on TV of its religious programs brings it out of the bosom of internal belief. Television is a medium that reaches even the eyes and ears of children. The exercise of religious freedom can be regulated by the state when it will bring about the clear and present danger of a substantive evil which the state is duty-bound to prevent, that is, serious detriment to the more overriding interest of public health, public morals, or public welfare. A laissez-faire policy on the exercise of religion can be seductive to the liberal mind, but history counsels the court against its blind adoption as religion is and continues to be a volatile area of concern in our society today. For sure, we shall continue to subject any act pinching the space for the free exercise of religion to a heightened scrutiny, but we shall not leave its rational exercise to the irrationality of man. For when religion divides and its exercise destroys, the state should not stand still. Did the MTRCB act correctly when it raided the Iglesia Ni Cristo's pre-taped TV program simply because it was found to be attacking another religion? Held. The MTRCB may disagree with the criticisms of other religions by the Iglesia Ni Cristo, but that gives it no excuse to interdict such criticisms, however unclean they may be. Under our constitutional scheme, it is not the task of the state to favor any religion by protecting it against an attack by another religion. Religious dogma and beliefs are often at war, and to preserve peace among their followers, especially the fanatics, the Establishment Clause of freedom of religion prohibits the state from leaning towards any religion. Vis-à-vis religious differences, the state enjoys no banquet of options. Neutrality alone is its fixed and immovable stance. In fine, The NTRCB cannot squelch the speech of the incorporated simply because it attacks another religion. In a state where there ought to be no difference between the appearance and the reality of freedom of religion, the remedy against bad theology is better theology. The bedrock of freedom of religion is freedom of thought, and it is best served by encouraging the marketplace of dueling ideas. When the luxury of time permits, the marketplace of ideas demands that speech should be met by more speech, for it is the spark of opposite speech, the heat of colliding ideas, that can fan the embers of truth. Centeno vs. Villalon-Porños, 236 SCRA 197, September 1, 1994. Regalado. Solicitation of contributions for the construction of a church is not solicitation for charitable or public welfare purpose but for a religious purpose, and a religious purpose is not necessarily a charitable or public welfare purpose. Such solicitation calls upon the virtue of faith, not of charity, save as those solicited for money or aid may not belong to the same religion as the solicitor. Such solicitation does not engage the philanthropic as much as the religious fervor of the person who is solicited for contribution. To require a government permit before solicitation for religious purpose may be allowed is to lay a prior restraint on the free exercise of religion. Such restraint, if allowed, may well justify requiring a permit before a church can make Sunday collections or enforce tithing. Austria vs. NLRC, GR number 124382, August 16, 1999, 1st Division Kapunen. An ecclesiastical affair is one that concerns doctrine, creed, or form of worship of the Church, or the adoption and enforcement within a religious association of needful laws and regulations for the government of the membership, and the power of excluding from such associations those deemed not worthy of membership. Based on this definition, an ecclesiastical affair involves the relationship between the Church and its members and relate to matters of faith, religious doctrines, worship and governance of the congregation. To be concrete, examples of this so-called ecclesiastical affairs to which the state cannot meddle are proceedings for excommunication, ordinations of religious ministers, administration of sacraments and other activities with attached religious significance. Where what is involved is the relationship of the Church as an employer and the minister as an employee and has no relation whatsoever with the practice of faith, worship or doctrines of the Church, that is, the minister was not excommunicated or expelled from the membership of the congregation but was terminated from employment, it is a purely secular affair. Consequently, the suit may not be dismissed invoking the doctrine of separation of Church and the state. The liberty of abode and the right to travel. Section 6, Article 3, 1987 Constitution. Section 6. The liberty of abode and of changing the same within the limits prescribed by law shall not be impaired except upon lawful order of the court. Neither shall the right to travel be impaired except in the interest of national security, public safety, or public health, as may be provided by law. The right of the people to information on matters of public concern. Section 7, Article 3, 1987 Constitution. Section 7. The right of the people to information on matters of public concern shall be recognized. Access to official records, and to documents, and papers pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizen, subject to such limitations as may be provided by law. Chavez vs. PCGG, 299 SCRA 744. December 9, 1998 Panganiban. Some of the recognized restrictions to the right of the people to information on matters of public concern. 1. National security matters and intelligence information. 2. Trade or industrial secrets, pursuant to the Intellectual Property Code RA No. 8293, approved on June 6, 1997 and other related laws, and banking transactions, pursuant to the Secrecy of Bank Deposits Act RA No. 1405, as amended. 3. Criminal matters, such as those relating to the apprehension, the prosecution and the detention of criminals, which courts may not inquire into prior to such arrest, detention and prosecution. 4. Other confidential information. The Ethical Standards Act, RA No. 6713, enacted on February 20, 1989, further prohibits public officials and employees from using or divulging confidential or classified information officially known to them by reason of their office and not made available to the public. Section 7C, Ibid. 5. Other acknowledged limitations to information access include diplomatic correspondence, closed-door cabinet meetings and executive sessions of either House of Congress, as well as the internal deliberations of the Supreme Court. As to the meanings of the terms public interest and public concern, the Court, in Legazpi v. Civil Service Commission, elucidated. In determining whether or not a particular information is of public concern, there is no rigid test which can be applied. Public concern, like public interest, is a term that eludes exact definition. Both terms embrace a broad spectrum of subjects which the public may want to know, either because these directly affect their lives, or simply because such matters naturally arouse the interest of an ordinary citizen. In the final analysis, it is for the courts to determine on a case-by-case basis whether the matter at issue is of interest or importance, as it relates to or affects the public. The Non-Impairment Clause. Section 10, Article 3, 1987 Constitution. Section 10. No law impairing the obligation of contracts shall be passed. Is the constitutional prohibition against impairing contractual obligations absolute? Held, nor is there merit in the claim that the resolution and memorandum circular violate the contract clause of the Bill of Rights. The executive order creating the POIA was enacted to further implement the social justice provisions of the 1973 Constitution, which have been greatly enhanced and expanded in the 1987 Constitution by placing them under a separate article, Article 13. The article on social justice was aptly described as the heart of the new charter by the President of the 1986 Constitutional Commission, retired Justice Cecilia Munoz Palma. Social justice is identified with the broad scope of the police power of the state and requires the extensive use of such power. The constitutional prohibition against impairing contractual obligations is not absolute and is not to be read with literal exactness. It is restricted to contracts with respect to property or some object of value and which confer rights that may be asserted in a court of justice. It has no application to statutes relating to public subjects within the domain of the general legislative powers of the state and involving the public rights and public welfare of the entire community affected by it. It does not prevent a proper exercise by the state of its police power by enacting regulations reasonably necessary to secure the health, safety, morals, comfort, or general welfare of the community, even though contracts may thereby be affected, for such matters cannot be placed by contract beyond the power of the state to regulate and control them. Verily, the freedom to contract is not absolute. All contracts and all rights are subject to the police power of the state, and not only may regulations which affect them be established by the state, but all such regulations must be subject to change from time to time, as the general well-being of the community may require, or as the circumstances may change, or as experience may demonstrate the necessity. And under the Civil Code, contracts of labor are explicitly subject to the police power of the state because they are not ordinary contracts but are impressed with public interest. Article 1700 thereof expressly provides. Article 1700. The relations between capital and labor are not merely contractual. They are so impressed with public interest that labor contracts must yield to the common good. Therefore, such contracts are subject to the special laws on labor unions, collective bargaining, strikes and lockouts, closed shop, wages, working conditions, hours of labor and similar subjects. The challenged resolution and memorandum circular being valid implementations of EO No. 797, creating the POIA, which was enacted under the police power of the state, they cannot be struck down on the ground that they violate the contract clause. To hold otherwise is to alter long-established constitutional doctrine and to subordinate the police power to the contract clause. The Conference of Maritime Manning Agencies Incorporated vs. POIA, 243 SCRA 666, April 21, 1995. Davide Jr. Petitioners pray that the present action should be barred, because private respondents have voluntarily executed quitclaims and releases and received their separation pay. Petitioners claim that the present suit is a grave derogation of the fundamental principle that obligations arising from a valid contract have the force of law between the parties and must be complied with in good faith. The court disagrees. Jurisprudence holds that the constitutional guarantee of non-impairment of contract is subject to the police power of the state and to reasonable legislative regulations promoting health, morals, safety and welfare. Not all quitclaims are per se invalid or against public policy, except, 1, where there is clear proof that the waiver was wangled from an unsuspecting or gullible person, or, 2, where the terms of settlement are unconscionable on their face. In these cases, the law will step in to annul the questionable transactions. Such quitclaim and release agreements are regarded as ineffective to bar the workers from claiming the full measure of their legal rights. In the case at bar, the private respondents agreed to the quitclaim and release in consideration of their separation pay. Since they were dismissed allegedly for business losses, they are entitled to separation pay under Article 283 of the Labor Code. And since there was thus no extra consideration for the private respondents to give up their employment, such undertakings cannot be allowed to bar the action for illegal dismissal. Bogo Medellin Sugarcane Planters Association Incorporated vs. NLRC, 296 SCRA 108, 124, Panganiban. The Custodial Investigation, Rights of an Accused. Section 12, Article 3, 1987 Constitution. Section 12. 1. Any person under investigation for the commission of an offense shall have the right to be informed of his right to remain silent and to have competent and independent counsel, preferably of his own choice. If the person cannot afford the services of counsel, he must be provided with one. These rights cannot be waived except in writing and in the presence of counsel. 2. No torture, force, violence, threat, intimidation, or any other means which vitiate the free will shall be used against him. Secret detention places, solitary, incommunicado, or other similar forms of detention are prohibited. 3. Any confession or admission obtained in violation of this or Section 17 hereof shall be inadmissible in evidence against him. 4. The law shall provide for penal and civil sanctions for violations of this section as well as compensation to and rehabilitation of victims of torture or similar practices, and their families. People v. Mahoney, 302 SCRA 455, February 1, 1999, and Bank per curiam. Procedure, guidelines and duties which the arresting, detaining, inviting, or investigating officer or his companions must do and observe at the time of making an arrest and again at and during the time of the custodial interrogation in accordance with the Constitution, Jurisprudence and Republic Act No. 7438, an act defining certain rights of person arrested, detained or under custodial investigation as well as the duties of the arresting, detaining, and investigating officers and providing penalties for violations thereof. 1. The person arrested, detained, invited or under custodial investigation must be informed in a language known to and understood by him of the reason for the arrest and he must be shown the warrant of arrest, if any. Every other warnings, information or communication must be in a language known to and understood by said person. 2. He must be warned that he has the right to remain silent and that any statement he makes may be used as evidence against him. 3. He must be informed that he has the right to be assisted at all times and have the presence of an independent and competent lawyer, preferably of his own choice. 4. He must be informed that if he has no lawyer or cannot afford the services of a lawyer, one will be provided for him, and that a lawyer may also be engaged by any person in his behalf, or may be appointed by the court upon petition of the person arrested or one acting on his behalf. 5. That whether or not the person arrested has a lawyer, he must be informed that no custodial investigation in any form shall be conducted except in the presence of his counsel after a valid waiver has been made. 6. The person arrested must be informed that, at any time, he has the right to communicate or confer by the most expedient means, telephone, radio, letter or messenger, with his lawyer, either retained or appointed, any member of his immediate family, or any medical doctor, priest or minister chosen by him or by any one from his immediate family or by his council, or be visited by, confer with duly accredited national or international non-government organization. It shall be the responsibility of the officer to ensure that this is accomplished. 7. He must be informed that he has the right to waive any of said rights provided it is made voluntarily, knowingly and intelligently, and ensure that he understood the same. 8. In addition, if the person arrested waives his right to a lawyer, he must be informed that it must be done in writing and in the presence of counsel, otherwise, he must be warned that the waiver is void even if he insists on his waiver and chooses to speak. 9. That the person arrested must be informed that he may indicate in any manner at any time or stage of the process that he does not wish to be questioned, with warning that once he makes such indication, the police may not interrogate him if the same had not yet commenced, or the interrogation must cease if it has already begun. 10. The person arrested must be informed that his initial waiver of his right to remain silent, the right to counsel or any of his rights does not bar him from invoking it at any time during the process, regardless of whether he may have answered some questions or volunteered some statements. 11. He must also be informed that any statement or evidence, as the case may be, obtained in violation of any of the foregoing, whether inculpatory or exculpatory, in whole or in part, shall be admissible in evidence. People v. Abrero, 332 SCRA 190, May 17, 2000, 2nd Division Mendoza. There are two kinds of involuntary or coerced confessions treated in this constitutional provision. 1. Those which are the product of third-degree methods such as torture, force, violence, threat, intimidation, which are dealt with in paragraph 2 of section 12, and, 2. Those which are given without the benefit of Miranda warnings, which are the subject of paragraph 1 of the same section 12. Extrajudicial confessions are presumed voluntary, and, in the absence of conclusive evidence showing the declarant's consent in executing the same has been vitiated, such confession will be sustained.